என்ற தகவல்கள். ಸರ್ ಸರ್ ಇದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಸರ್ ಇದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಯಾವಾಗ ಬರೋದು ಸರ್ ಅದು
ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ
Matter, my lords, notice was ordered to the respondent. Just one consider my representation to for Kautik Khata of a farmer. My lords.
24. 24.
8 ವರ್ಷದಿಂದಾನು ಕೌತಿಕ್ ಜಸ್ಟ್ ಕೌತಿಕ್ ಖಾತೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ನಾನು ಮಾಡಿದ್ದೀನಿ ನೋಟಿಸ್.
My lords.
For disposition, request for 230.
My lords, last on 21st, my matter was listed in preliminary B group, my lord, at serial number 92. We had made a mention at the time of 5 o'clock, and my lords had directed the directorate to be listed the matter in preliminary hearing. But today also it is listed on preliminary B group.
The respondent.
I am the respondent.
Who's for the petition?
I don't know, my lord, but the urgency is for me. That's why I'm.
Serial number?
Serial number 72, 77, 77, my lord. Extremely sorry.
You are for respondent.
Yes, my lord. Fourth respondent.
Is there an interim order in this case?
No, my lords. No, it should be considered for interim orders. We had promised the court we would come up with a table of what had happened in the civil court for all this time. So we have the table in hand. That's why it has to be considered for our preliminary hearing, my lord.
Let it be in the list. Come at 4:30. If it's not reached, I'll take it up at 4:30.
4:30, my lord. Today it's grateful, my lord.
From 20807 of 25 ಇದು ಅರ್ಲಿ ಹಿಯರಿಂಗ್
Memo? In it one? Friday ಬರುತ್ತೆ.
My lords, 2023 matter. Spot inspections were directed by this honorable court in a different bench.
B group.
Yes, my lords, it's not being listed. The court had directed a solution to be found on the spot inspection before monsoons because the entire farmers area has been inundated with water. I'm requesting any date, my lords. The solution is ready.
B group matter, my lord. In spite order of DC, my lord, Tahsildar not reflecting my name, 2023, my lord, not reflecting my name in revenue records, my lord.
We'll try to get it posted this week or next week. No guarantee.
Okay, my lord.
My lord, serial number 14th, my lord. Serial number 14th. Admission matter, my lord.
Yes.
Preliminary.
New
I am for the petitioner, my lord.
ವಿರೂಪಾಕ್ಷ.
Please, my lord. ಎಷ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್
ನೀವು ವಿರೂಪಾಕ್ಷ ಅವ್ರ ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ಇಲ್ಲ ನಾನು ಅವ್ರಿಗೆ ಅದರ್ ಸೈಡ್ಗೆ ನಾನು ಅದರ್ ಸೈಡ್
ನೀವು ವಿರೂಪಾಕ್ಷ ಅವ್ರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ಹೌದು.
ನೀವೇ ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಅವ್ರಿಗೆ ಬೆಳಗ್ಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹಾಸ್ಪಿಟಲ್ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಲಿಸ್ಟ್
ಫಾರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಪೇಜ್ ನಂಬರ್ 20 seal number 67 to 72, page number 18 seal number 73 to 80.
Serial number 62. I had to sit like this. Next week.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್?
Before parties to sell it again. The document
released.
Next week.
First page number 19 seal number 81 and 82 for preliminary hearing.
My lordship, may I mention serial number 53, my lord. Ramnagar Deputy Commissioner is present here, my lord. That is my lord, pertaining to Manchena Bele project, my lord, irrigation project. He was appearing, my lord. And as per my instructions, my lord, on the day, my lord, litigation conducting officer was Assistant Commissioner, my lord. Deputy Commissioner has directed to Assistant Commissioner to file an affidavit regarding status of the whatever alternative lands we have allotted, my lord. And that is the affidavit filed, my lord. And we have allotted same previous affidavit, my lord. Yes, once. If court permits, my lord, Deputy Commissioner wants to.
Sir, the alternate lands which are proposed to be given are in Bangalore urban, 6 acres in Kadapgere. Bangalore urban DC is here. I've just discussed with him. He says the land has been given and they'll file an affidavit to that extent. So I request time, another 15 days, we'll file an affidavit to that extent.
Are you saying that you have allotted or you will allot?
Land has been allotted.
Al-
That is
already-
what the,
Already we have been allotted, we have got all the
No,
records, my lord.
I haven't received anything.
No.
I am before the court for 40 years. I've been representing before the court.
You allotted to the persons who claimed or what?
to the
exactly?
persons who are claimed, my lord.
I have also claimed from
Claim-
1984.
My lord, their claim in the last, in the order 2922, the honorable judge has asked to examine their claim also. As per the original GU, six beneficiaries were supposed to be given, my lord. 2 acres each. We are complied with that, my lord.
What about their claim? Did you examine their claim?
We'll examine their claim. We require time for
My
it.
lord, urban DC, what my instructions, my lord, last week it is allotted, it seems. I'll produce, my lord, whatever the lands we have allotted, my lord.
It gives us no pleasure to call both of you here and keep you pending here. 3 years ago, this order was passed.
Yes,
And until this order is passed, until you are forced to come, none of you respond.
yes, my lord. Unfortunately, it falls in that domain. We'll pursue it and we'll finish it.
And 15
you-
days time, my lord, and we'll,
The petition itself, I have stated.
15 days will complete it.
Are you sure? Again, you don't want me to pass one more order asking
No, my
building
lord.
commissioner to come?
No, my lord. Urban DC is here and they said they have already allotted the land.
The deputy commissioner, Ramnagara,
Thank you.
president, so also.
ಇಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ,
The
my lord,
deputy
we'll complain.
urban district is present. They submit that they would file
Last week, my lord.
bits indicating the steps that they have taken regarding allotment of land. As a last chance, release all. So,
My lord,
7th, madam.
7th,
don't make me pass an order asking you to come once again.
15th. My lordship, 15th April, my lord. Grateful.
Thankful.
For preliminary hearing, seal number 1, Shri Gopal KV.
Dispense presence of the deputy commissioner, may be affidavit.
I have not asked.
Yes,
ಪೆಟಿಷನ್ ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗು WP 10732 ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂತ ಕೇಳಿದ್ವಿ. ಅಲ್ಲಿ ಐ ಆಮ್ ನಾಟ್ ದ ಪಾರ್ಟಿ ಇನ್ ದಟ್ ಪೆಟಿಷನ್.
What is RA?
That's
What is the next surety?
next year.
ಇದ್ರ ಮೇಲೆ DC ಗೆ ಇದಿಲ್ವಾ?
Lots.
DC ಗೆ ರಿವಿಷನ್ ಇಲ್ವಾ?
DC revision ಇದೆ ಸರ್,
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇನೆ. Annexure page number 51.
Yes.
ಇದರಲ್ಲಿ WP ನಂಬರ್
10732.
10732 ಅಲ್ಲಿ I am not the party in that petition.
What is the order?
Order is possible.
PWD ಅವರದೇನ್ ಮಾಡ್ಲಿ? PWD ಅವರದೇನ್ ಮಾಡ್ಲಿ?
Petition is
We'll proceed.
imposed order dated annexure E and M, annexure M are hereby quashed and writ of mandamus is given to Tahsildar, Shimoga, reading the order passed by the Deputy Commissioner dated 5/4/1988 to accept the fee levied in pursuant of the said order. ಅದರಲ್ಲಿ the petitioner's party, only 4 members, that is state of Karnataka, Deputy Commissioner, Tahsildar and Town Municipal Council. And one Good Day Mardi Raita Youth Sangha. They are only the parties. but mutation and RTC are in my name also. I am the grantee of the property.
What is the order of the AC?
AC also same directing that. MR ಅನ್ನು ರದ್ದುಗೊಳಿಸಿ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗಳ ಮರುಪರಿಶೀಲಿಸಿ ನಿವೇಶನ ಎಂದು ದಾಖಲಿಸುವ ಬಗ್ಗೆ ತಹಶೀಲ್ದಾರ್ ಅವರಿಗೆ ಶಿವಮೊಗ್ಗ ಸೂಚಿಸಲಾಗಿದೆ.
Whether you are a party to this order or not. There was some order of the deputy commissioner to implement the earlier order.
Yes,
If you have not challenged it, how can you?
I'm not the party and the
Not be party, but what about the proceedings have taken place so far?
my lords, I'm not aware of the proceedings, but I am the kindly peruse the annexure A. It is annexure A ನಲ್ಲಿ 23 ನಲ್ಲಿ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂತೀನಿ. ಅದರಲ್ಲಿ ಸಹಿತ ನನಗೆ ಸುಳೇಬೆಲೆ ಇದರಲ್ಲಿ LRF ಫಂಡ್ ಮಂಜೂರಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ನನಗೆ ಅವಾಗಿಂದ ಮಂಜೂರಾಗಿ ಐ ಆಮ್ ಇನ್ ಪೊಸಿಷನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
ಅಲ್ಲ ಮನೆ ಕಟ್ಟಿದಲ್ರಿ ಪೂರ್ತಿ ಹೆಂಗೆ?
ಅಲ್ಲ ನಮ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಕಟ್ಟಿಲ್ಲ, ಅದು ಅವರು ಇದ್ರಲ್ಲಿ ಕೈಂಡ್ಲಿ ಪೆರುಸ್ ದ ಪೇಜ್ ನಂಬರ್ 50 ಮೇಡಮ್ಸ್. 50 ನಲ್ಲಿ ಅರ್ಜಿದಾರರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಕೋರಿರುವಂತೆ ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ದೂರುದಾರರು ಅಂದರೆ ಸರ್ವೆ ನಂಬರ್ 299ರಲ್ಲಿ 39 ಗುಂಟೆ, 1ನೇ ಎದುರುದಾರರಿಂದ 4ನೇ ದಾರವರೆಗೆ, ಸರ್ವೆ ನಂಬರ್ 300ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ 5ನೇ ಎದುರುದಾರರಿಗೂ, ಮತ್ತು ಆ ಸರ್ವೆ ನಂಬರ್ 105ರಲ್ಲಿ 1 ಎಕರೆ 12 ಗುಂಟೆ 6 ಮತ್ತು 6ರಿಂದ 9ನೇ ಎದುರುದಾರರಿಗೆ ಪೌತಿ ಖಾತಾ ಬದಲಾವಣೆ ಆಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಈ ಹಿಂದೆ ಊರಗಡೂರು ಸೂಳಬೈಲು ನಿವೇಶನದಾರರ ಸಂಘದ ಸದಸ್ಯರುಗಳಿಗೆ ಹಕ್ಕುಪತ್ರ ನೀಡಿ ನಿವೇಶನ ಮನೆ ಮಾಡಿಕೊಂಡಿರುವುದು ಸಹ ವ್ಯಕ್ತವಾಗಿರುತ್ತದೆ. ದಿಶಾಂಕ ನಮ್ಮ ಮುಖಾಂತರ ಸರ್ವೆ ಸ್ಕೆಚ್ ಅನ್ನು ಅವಲೋಕಿಸಿದಾಗ ಸದರಿ ಜಾಗದಲ್ಲಿ ಸಂಪೂರ್ಣವಾಗಿ ಮನೆಗಳನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿಕೊಂಡು ಊರಗಡೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 290, 300ರಲ್ಲಿ ನಿರ್ಮಾಣ ಆಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಹಾಗೂ ಸೂಳೆಬೇರು ಪ್ರಶ್ನಿತ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲೂ ಮನೆ ನಿವೇಶನಗಳು ಮಾಡಿದ್ದು ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿ ನಿವೇಶನದಾರರಿಗೆ ತೊಂದರೆ ಆಗುತ್ತಿರುವುದು ಸಹ ಕಂಡುಬರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 299, 300ರಲ್ಲಿ ಸಂಪೂರ್ಣ ಮನೆ ಕಟ್ಟಿರೋದು ಹೌದು ಸ್ವಾಮಿ. ನಮ್ಮ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ನಾವು ಕೆಲವರಿಗೆ ಪ್ರಾಪರ್ಟಿನ ನಮ್ಮ ರಿಲೇಷನ್ಗಳಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದರಲ್ಲಿ ಒಂದು 4-5 ಮನೆ ಮಾತ್ರ ಇದೆ.
ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, ನಾವು ಬೈ ಸೇಲ್ ಕೊಟ್ಟಿರೋದು, ಬಟ್ ಅದರಲ್ಲಿ ನಮ್ದು ಏನಿದೆ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ ಇರೋದ್ರಿಂದ
ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ how can you maintain this petition?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನಮ್ಮ ಇದರಲ್ಲಿ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ ಆಗಿರೋದ್ರಿಂದ ನಮಗೆ ಮಾಡ್ಲಿ ಪೂರ್ತಿ ಕೆಲವೊಂದು ಸೈಟ್ಗಳು ಮಾಡಿ ಕೊಡ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ, ಬಿಟ್ರೆ ನಮ್ಗೆ ಇದರಲ್ಲಿ
ನೀವು ಯಾವ ತರ ಸೈಟ್ ಮಾಡ್ಕೊಡಕ್ಕಾಗತ್ತೆ? ಕನ್ವರ್ಷನ್ ಆಗ್ಬೇಕು ತಾನೆ?
ಕನ್ವರ್ಷನ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ಕನ್ವರ್ಷನ್
ಆಗ್ಬೇಕು ತಾನೆ?
ಹೌದು ಸ್ವಾಮಿ.
ಅವೆರಡು ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಕನ್ವರ್ಷನ್ ಸೆಲ್ಡಿಡ್ ಆಗಿಲ್ಲ. ಕನ್ವರ್ಷನ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಇವತ್ತರೆಗೂ ಕನ್ವರ್ಷನ್ ಆಗಿಲ್ಲ. ನಮ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಈ ತರ ಇರೋದ್ರಿಂದಾನೇ ಕನ್ವರ್ಷನ್ ಆಗ್ತಾ ಇಲ್ಲ. ಹಂಗೆ ನಮ್ಗೆ ಕೆಲವೊಂದು ಇದಕ್ಕೋಸ್ಕರ ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ, ಬಿಟ್ರೆ ಇದ್ರಲ್ಲಿ ನಮ್ದು
this order dated 5/4/1988 is not challenged.
is not challenged. ಅಲ್ಲ, ನಾನು ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿನೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅದು.
ಪಾರ್ಟಿನೂ ಇಲ್ವೋ? ನಿಮ್ಮ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ that is become final.
ಅಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅದು ಆದೇಶ ಆಗಿದೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡೋದು?
It is past
I'm
37
not,
years ago.
notice also not issued mine.
Then you challenge it. So long as that order remains unchallenged, you can't get the kata in your name.
Alaka. Already I am in a position and RTC
Not
ಸಹಿತ
talking
ನನ್ನ
about-
ಹೆಸರಲ್ಲೇ ಇದೆ.
We are not talking about possession. We are talking about your entry in the RTC, correct?
I am also position is also my hand.
We are not, DC is not talking about possession. You want the name of yours to continue in the RTC.
ಹೌದು.
Suppose in 5488, the DC has passed an order to give the sites to somebody else and you have not challenged that order. How can you get the kata done in your name?
ಅಲ್ಲ DC ಆರ್ಡರ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಅವಾಗಿನ ಅದು ಚಾಲ ಇದರಲ್ಲಿ ಅವರು ಇದು ಆರ್ಡರ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದ್ದಕ್ಕೆ ಅವ್ರ ಹೈಕೋರ್ಟಿಗೆ ಬಂದು ಅಪೀಲ್ ಆಗಿರ್ತಕ್ಕಂಥ ಸರ್ ಅವಾಗ 88 ಅಲ್ಲಿ ಅದು
High Court has upheld the order of the Deputy Commissioner at 5488.
ಹೌದು.
If that order is not challenged.
ಅದ್ರಲ್ಲೂ ಹೈಕೋರ್ಟ್ ಅಲ್ಲೂ ಸಹಿತ ಸಮಯದಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಇದು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು. ನೀವು ಇದ್ರ ಏನ್ ಮಾಡೋದು ಎಷ್ಟು ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
ಪೇಜ್ ನಂಬರ್ 11 ಅಲ್ಲಿ ಯಾರು ಸಹಿತ ಅದರಲ್ಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 1, 2, 3 and 5.
See, there is an order of regularization passed by the Deputy Commissioner in the year 1988. He has collected fees.
ಅಲ್ಲ ಆರ್ಡರ್
Come and say that land granted to you without there being a challenge to that order.
ನಮಗೆ ಎಲ್ಲ ರೆಫಲ್ ನಮಗೆ ಅದೇ ಆದೇಶ ಆದ್ಮೇಲೆ ಅವ್ರು ನಮಗೆ ನೋಟಿಸ್ ಕೊಡದೆ ಆದೇಶ ಮಾಡಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಎನ್ಕ್ರೋಚ್ ಇದನ್ನ ಪ್ರಾಪರ್ಟಿನ ಅವರು ತಗೊಂಡೇ ಇದ್ರೆ ನಾವು ಹೆಂಗೆ ಅವ್ರನ್ನ ಇದು ಮಾಡ್ತೀವಿ?
ನೀವು ನಿಮ್ಗೆಲ್ಲ ಗೊತ್ತಿದೆ ಆದ್ರೂ 54/1988 there's an order passed by Deputy Commissioner regularizing the possession of those site holders. He has collected fees from them. That was rescinded. Therefore, like a matter came up before this court. This court upheld the order of the Deputy Commissioner. Pursuant to which they have made out the kata in their name. Now you are coming and said that you have ordered the land tribunal. So long as this order is not challenged, what is that you can do? They'll be in contempt if they disobey this order. There's nothing that we can do in the light of this particular order.
ಒಂದು ಡೇಟ್ ಕೊಡೋ ಸಮಯ ಇದು ನೋಡ್ರಿ ಆರ್ಡರ್ ನೋಡಿ ಹೇಳ್ತೀನಿ ನಾನು ಶಾರ್ಟ್ ಡೇಟ್ ಮಾಡಬೇಕು.
ನೀವೇನೋ ಖಾತೆ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನೀವು ಸ್ವಾಧೀನ ತಗೊಳ್ಬೋದು ಅಂತ ಅನ್ಕೊಂಡು.
ಅಲ್ಲ ನಾನೇ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೀನಿ, ತಗೊಳೋದೇನಿಲ್ಲ ಸಮಯದಲ್ಲಿ. ಐ ಆಮ್ ಆಲ್ರೆಡಿ ಇನ್ ಪೊಸಿಷನ್. ನನ್ನ ಮನೆ ಸಹಿತ ಅಲ್ಲೇ ಇದೆ.
ಐ ಹ್ಯಾವ್ ಟು ಡಿಸ್ಮಿಸ್ ಯುವರ್ ರೆಪ್ಯುಟೇಷನ್.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅದು ಆದೇಶ ನೋಡ್ಬಿಟ್ಟು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂತೀವಿ.
First April. Seal number 2, Shri Devaraj S.
My lords, I appear for the petitioner. May I ask for a passover, my lord?
What is the matter about?
Lords, I'm not the counsel on record.
Order has been changed. Annexure A, my lord, the order passed by the Karnataka.
KT order.
KT order. Page 30, my lord. In page 30, it was remanded, my lord. He states that that survey conducted by the ADLR is false survey and it was not conducted in his presence, and states that he has not signed in the master.
Much obliged.
Seal number 3, Shri Ajay Kumar N.
Here, after the filing of the writ petition, a survey has been conducted by the Tahsildar. In fact, my lords, in the memo. Filing the memo.
ಆಗಿದೆಯಾ? Recorded. Service conducted?
Survey has been conducted by the Tahsildar, but not in consonance with the representation. They say whether the government.
Challenge this survey. How can you keep this petition careful?
My lords, what has happened is that because of the emission of the order, my lords, because it is within 30 meters from the property. And my lords, section 58 of the Gram Panchayat Act. Statement has been recorded wherein the statement recorded by the Tahsildar says that it is not a government property. But my representation is what is the distance between the survey number 4 and where the poultry farms have been located. And section 58 clause 6
I
of
have my doubts whether such kind of a prayer can be made at all in the first place.
My lords.
How can you make such a prayer, asking them to conduct a survey to determine the distance?
That case, my lords, I'll submit representation to the Gram Panchayat and seek to withdraw the petition.
And consequently, petitioner submits that since a survey has been conducted, though not in accordance with the representation submitted by the petitioner proposes to submit a representation to the Panchayat and to the authorities conveying his actual grievance. So in light of the above, the petition is dismissed as withdrawn. granting liberty to the petitioner to submit a representation to the concerned authority.
Seal number 4, Sri Venugopal MS.
In this matter, my lord, it seeks 1 week's time, my lord. The deputy commissioner is considering his request, my lord. They are seeking to farm a road, my lord. It is under consideration, my lord. Survey is conducting. The set land has been reserved for the graveyard. They are seeking for the road, my lord.
Relist.
2 weeks.
7. Seal number 5, Sri Janardana Ji.
Aswar.
ಇದರಲ್ಲಿ 2 ಸರ್ವೆ ನಂಬರ್ ಮೊದಲು ಬಿಟ್ಟು ಹೋಗಿತ್ತು, ಆರ್ಡರ್ ಕವರ್ ಆಗಿದೆ.
Aswar ಅಂತ ಹೇಳ್ತಾರೆ. ನೀವು ವಿಡ್ರಾ ಮಾಡಂಗಿದ್ರೆ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಅಲ್ಲ ಅದು ಆರ್ಡರ್ ಆಗ್ಬೇಕಿದ್ 2 ಬಿಟ್ಟು ಹೋಗಿದ್ದು, ಮೊದಲು ಆರ್ಡರ್ ಆದಾಗ 2 ಸರ್ವೆ ನಂಬರ್ ಬಿಟ್ಟು ಹೋಗಿತ್ತು. ಅದು
Seal number 6.
213.
Seal number 6, Sri Mutation.
Consent decrees, my lord, it is a mutation.
This is arising out of this compromise decree, my lord. Last occasion, my lord, this court directed to keep the presence of the responsible officers. My lord, the revenue commissioner and deputy commissioner is present before this court. My lord, while arguing the matter, my lord, this court noticed that in compromise decree, that the obtained the decree in respect of roads also, my lord. In writ petition number, my lord, 27492, my lord. Lord, page 15, my lord.
Page number?
Revenue commissioner and deputy. Page number 15, my lord. The compromise decree, my lord.
Page number?
Page number 15, my lord.
15.
15. Paragraph 9, my lord. This is the compromise decree.
ಯಾವ ಕೇಸಲ್ಲಿ ನೀವು ನೋಡ್ತಾ ಇರೋದು?
27492. Page 15, 9 paragraph. My lord. That in the middle of the shares allotted to the plaintiff and the defendant number 2 in survey number 21/1 of Chikka Banawara village, Yashwantpura Obli, Bangalore North Taluk, there exists a road measuring 10 feet in width runs in north to south direction which meant for joint use of both the plaintiff and the defendants for their ingress and egress purpose.
ಈ ರೋಡ್ ಪಬ್ಲಿಕ್ ರೋಡ್ ಇದು.
As public road ಅಂತ ಅವ್ರ roads ಗೆಲ್ಲ ಹೇಗೆ compromise decree, therefore my lord, this court directed to keep the.
This is a private
Because
road between the parties.
After obtaining the compromise decree, my lord, they give representation to the Tahsildar to effect the kata. My lord, in the compromise decree, my lord, there will be the roads, government lands. Government will be not the parties before the trial court, my lord.
This is one our their property, my lord. This is the road only the
The road is found in the village map.
This is out of 20 guntas, my lord. They are for utilizing their. This is not the road for the public purpose.
It is in village map. My instructions, sir, it is in village map.
This is why I said we'll integrate the system so that the court will know what exactly.
Therefore, my lord, this court directed to keep the presence of the responsible.
Is it possible, will you people be agreeable to integrate your systems with our system?
Your Honor, there are 2 ways to do, if we have to integrate with the e-courts. We have to integrate with the Bhumi system. We'll need some coordination, we'll be able to develop that. That's one way. Other one is in the Bhumi system itself, we can give login to all the courts where they can.
Logging is one thing. Suppose a litigation comes in respect of one particular land. And if our systems just indicate the survey numbers and the village, every revenue document pertaining to that particular land should be pulled into our system automatically and should become a part of the record of the court. So this kind of problems will be resolved.
Yes, Your Honor, it's possible, we can do it. But then there's like, you have to link with e-courts system. So that's where we need to work with the developers of e-court system. We have Bhumi system, we need to link both permanently.
Is it technically possible?
It's possible. Yes, Your Honor.
Have you ever done it in any other system amongst your departments? Is Bhumi linked to any other government department?
Yes, Your Honor. Now sub-registrars, they pull the Bhumi data.
That is by login, right? You give them a login, they enter.
No, Your Honor, if in SRO office, if some transaction is happening, they can enter the survey number and the owner number. and then it goes to Bhumi system where you have maintained the land records. That data will be pulled by SRO office. They will cross check whether he's the same owner who is selling the land and then proceed with the further transaction. It is possible. The difficulties we have to see, Your Honor, like how exactly we have to do with e-courts. Or the other solution is if the civil court, judges before filing a case, they want to see what is there in the Bhumi, we can give logins as well. And no further action will be there. I mean, they will only access the data and take further action on the e-courts
Then
system.
the problem is it's like the court collecting evidence that may not be the appropriate thing to do. See, the court is supposed to be neutral, isn't it? They are supposed to give us documents on the basis of which we decide. Now, we become parties to this compromise by accepting the compromise without knowing the factual aspects.
Yes, sir.
Suppose it's only 10 acres and they have divided 12 acres amongst themselves. We have no ideas whether it's right or wrong. So we want some kind of a safeguard so that we are not used in this particular scene. So suppose they were to file a suit instead of one particular survey number. The court should have details about the extent, the akar ban, who are the revenues, the categorizers, so that the court can decide whether this is to be accepted or not.
Yes, sir.
That we have no idea as of now as to whether how exactly we can secure all that information.
We'll work out if you
Sir,
give us
if you
some.
permit me, sir. Sir, good morning, sir. I'm Rajendra Kataria, Principal Secretary Revenue, sir. If you permit me, I'll just add, sir.
Yes.
Sir, as Sunil is mentioning, sir, my commissioner, Bhumi system is available, sir. Software is available, sir. That data we can fetch in and we can provide the connectivity, sir. So I don't think technically there's any issue, sir. Second issue is, sir, about the survey and Akarban, sir. We have the whole thing is digitized now. Even that can also be fetched, sir. So the survey records as well as Bhumi record can be fetched online. Technically, the department will be keen to work with the court system and we can provide that connectivity, sir. As far as the third issue is concerned about the original records. So that exercise going on, sir, that may take some time, sir. That is the, other than these two records, the old files on the basis of which we are giving grants and converting RTC. So that record is, the process is going on, sir. So that may take some time, sir. But technically, sir, I don't find any issue in connecting, sir. Government will be willing to do that, sir.
Your Honor, if may I submit? If it is only with regard to the accessing the data of Bhumi before filing the case, that's a simple solution. We'll make access possible with the Bhumi system. If you are directing us to have a system like this, that you enter through e-courts, and whenever I enter the survey number, you have to fetch from the Bhumi system, and then further actions will be required from the judge. And he will generate the notice to government, implead the government as a party, and then also push the final order to Bhumi system for the implementation. So that kind of integration is actually ultimate solution, but that takes some time, and we can work with the developers of e-court system and Bhumi system.
As of now, I pass a judicial order saying that all revenue records relating to any land which is subject to litigation should be integrated with us so that all the records are automatically pulled into our system and becomes a part of the court record. There's no difficulty in implementing.
No, there is no difficulty.
You are sure about it?
Yes, yes.
This is a case in which a compromise was entered into between the parties, in which a road which is supposed to exist has also been earmarked for the joint use of the parties to the suit. Learned AGA points out that this road is in fact a public road and is also indicated in the village map as a public road. Consequently, the public road cannot be the subject matter of compromise, and the prayer made for registering the kata as per the compromise decree would lead to an anomalous result whereby a public road would be indicated as private property. Next. This court has noticed that in several matters, the process of the court is used to tamper with the public records and to create records in favor of the private parties. This is essentially because the courts which are dealing with the litigation are unaware of the actual details of the lands as per these revenue records. Since the courts decide the issue on the basis of the materials produced by the parties, and they have no independent means of verifying the authenticity or the credibility of the entire records relating to the lands assessed to revenue, the problem is compounded and leads to unnecessary confusion and further litigation. In this yoga matter, the learned AGA was directed to secure the presence of the concern, to explain the situation and also provide a solution. Next, accordingly, the Principal Secretary Revenue and NIM designation
Revenue Commissioners.
and Revenue Commissioner are present. So both of them submit that it is possible for the Bhumi system and the digitized survey records to be integrated with the court systems so as to enable the courts to have access to all the revenue records relating to the land, which is subject matter of litigation before it. They submit that these systems can be integrated so as to provide access to the courts, to provide, to be furnished with all the necessary documents so as to make an effective and comprehensive decision in the litigation before it. It is to be noticed here that under the provisions of the Land Revenue Act, there is a statutory need / obligation for the plaintiff to annex a copy of the record of rights along with the plaint. This indicates that the intent of the law was always to ensure that the court is aware of the revenue records before it decides on any litigation before it. I am in regard to this intent, in my view, it would be appropriate to direct the, shall I say the Principal Secretary or the state?
State.
The
You
state
can say
law.
Principal Secretary, sir.
Direct the Principal Secretary to ensure that all the revenue records relating to any land assessed by the government is integrated with our system, with the systems of the court, so as to enable the court to have complete access of all the revenue documents relating to the said land. So, to illustrate, if a suit is filed in respect of a particular survey number, the registry of the trial court would have to necessarily enter the survey number and the village into the system. And if the systems of the government are integrated with the systems of the court, all the revenue documents relating to that land should automatically pulled into the database of the court, and all the revenue records should become a part of the court record so as to enable the courts to adjudicate upon the dispute with an informed decision regarding the records available in the government system. The Principal Secretary is therefore directed to ensure that there's a comprehensive system which would enable this process to be facilitated. So it is also to be stated here that this would also ensure that the government would also be aware about any litigation or any attempt being made in respect of a change or a modification of the revenue records that is sought for by the parties. And this would also greatly enhance the ability of the government to make appropriate decisions in this regard. How much time shall I say, Mr. Katare?
Sir, I think my commissioner is here, sir, is a technical person. He will be in a position to answer, sir.
Your Honor, we need to, as I already said, we need to work with the e-courts developers, maybe NIC or some systems. That may take some time. So I would request 4 to 5 months, Your Honor.
Up to 5 months.
That's a maximum, Your Honor.
The Revenue Commissioner submits that this exercise would probably require the consultation with several authorities, and therefore about 5 months time be granted to submit a proposal to the submit the scheme that can be implemented. As requested, release the matter on so and so for further consideration.
Sir, my request, one request, sir. Sir, a lot of cases at the lower court are passed where the government public properties are involved without the state being party, or I mean kind of ex parte orders are passed. where the public land, lake and parks are involved, sir. So if some direction can be issued by your lordship, where at least public assets are involved, public properties are involved in nature of land, which is
No.
used by public for roads,
That's why I said,
lakes.
Mr. Secretary, the court will not be aware as to whether it is public property or private property. Just as in this instant case, they simply may make an innocuous statement that there's a road which exists, we will use it jointly. There is no way that the court will know whether it's public road or private road. And to expect the court to go through each paragraph and then it becoming a party to the litigation by itself. So if this system is evolved, the court will at least have records to indicate or to at least examine as to what is to be done. There is no way that the court will know whether it's a public property or private property unless it is informed.
No, sir, my request, sir, when the matter heard at the lower court in another case which is linked with this case, the land was Gomala. So it is known that Gomala is a public land as per there are a number of Supreme Court reportable judgments where in case of Injalal Tiwari 2001, and then Jakpal Singh 2011 and Joginder Singh 2021, where there's a public assets, public properties, common land shall not be allotted to private person. At least in those cases where when the trial court, when they know that the land is in a public nature or for public use, are under litigation. So such cases, at least the ex parte order against the state shall not be made. That is my request, sir.
Give me an example as to how exactly this is can be.
Sir, this particular case is linked with another case, sir. I have this 1466. There's another writ petition before you, sir, in the same very case. So where the assistant commissioner the special deputy commissioner has referred to, has passed an order restoring the land back to the state, sir. The land was actually a Gomala land, sir, and then civil court, having known that this is a Gomala land, without even involving the state, the concerned Tahsildar or Revenue Authority as party, ex parte order has been passed against the state, and Gomala land is given to a private person.
But the problem is in a suit against the Tahsildar, if he has been served and he chooses to remain absent, and the government pleader also does not come and appear, what is it that you expect the court to do?
Not examine.
Sir, we are willing that let the state be made party, sir, because I verified this particular case, the notice was not served to any of the state authorities, sir.
Which case are you talking about?
Sir, this is-
Petition number
It's a connected case here only before you only, sir.
Connected matter.
1466. 1466.
1 for the petitioner in case you want.
Idರಲ್ಲಿ ಏನಾಗಿದೆ?
The suit for declaration has been filed. My lord, it has been
Declaration
declared.
ಆಗಿದೆ ಸ್ವಾಮಿ.
Suit is filed against the state of Karnataka on special deputy commissioner. Page.
Kindly consider. my
Annexure G, page
presentation.
41.
No, ADGP had appeared in this case.
But he has not chosen.
Without evidence, order was passed against us.
Now,
Written statement is also filed, my lord, in that matter.
see, now the government advocate is here.
Sir,
Suppose he does not take any steps. He says, I have nothing to say to you. And I pass an order. How is it that we can prevent that it is reflecting on the
Witness.
people that you appoint?
Not to the good purpose.
Isn't it? The lawyer that you appoint does not contest the case. You want the court to argue on your behalf.
it's like defending the public properties, sir.
No, I understand, but you will have to appoint much more
Now we
competent
have started monitoring cases, sir. For the last 6-8 months, we have been monitoring very strictly and putting the LCO responsible for any property going away from the government, especially the public asset, common asset, community assets.
When is this suit filed?
So this is of the year, my lord, 2011.
Appeal ಆಗ್ಲಿಲ್ವಾ?
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
See, the suspicion that we get is everything is stage managed. Deliberately documents are not given, deliberately the matter is not contested, and even after a decree, no steps are taken to file an appeal. The inference that I would draw as a judge is that you people want to help him.
I agree, sir. Few of our authorities are also involved, sir. I don't, dispute. We have started taking actions also against a few of our revenue officers. Which means we have started invoking 257 of BNS against few of our officers for not defending or passing proper quasi-judicial orders. But then there are, the litigations are going on the higher side.
No, if you think that the officers are not being informed about the occurrence of the orders passed by the court, then if you suggest system where every order that we passed is communicated to you directly to the concerned officer. It is a nodal officer. And we can communicate the orders and also indicate, just like that court management system. If you can integrate and follow it up, maybe that's a better solution than such kind of orders.
Sir, CCMS is really helping us, sir. CCMS now from High Court, I get all the orders and we monitor regularly, sir. Every week we have a review. But from the civil court, from the district court, we are not getting anything. Some connectivity, if your lordship can order, where because our major cases where we are not properly defended or not, we are not able to review properly because I don't have data as to which court, how many cases against the state are on. Now I know about high courts, all repetitions, writ appeal, contempt cases, I know, I have fair idea. So so on a fingertip, I get that information. But sir, about the district court, I don't get to know if some system, your lordship can evolve by which the litigants are made aware, especially the state, so that we can defend these cases properly, sir, and we can also minimize the litigations.
The principal secretary also brings to the notice of the court that the litigation that has been initiated against the state is being conducted in a very haphazardly manner, and there is a sense of no communication at all between the court and the department. He points out that in WP 1466/2025, though the government was appointed and the written statement was filed, no evidence was laid, as a consequence of which an ex parte decree has been passed against the state. So he therefore submits that if there could be a system evolved which would keep the government informed about the pending litigation and ensure that the systems are created in such a way that every stage of the proceedings of the litigation are informed to the concerned departments, and would greatly enhance the ability of the state to defend the suits that have been filed against it, and also produce all documents necessary and take such action which are necessary to assist the court in giving an effective judgment. So, having regard to this submission, the registry of this court is directed to engage in deliberations with the IT department of the government and ensure that the court case management system of the court is integrated with that of the state government systems, at least insofar as litigation relating to the state government is concerned, so that the concerned officials are aware of the day-to-day proceedings being conducted in the court regarding the litigation pertaining to the department on a real-time basis. So this scheme shall also be examined and a proposal be submitted to this court on the next date of hearing, that is on so. Let them sit with our registry and then decide as how exactly you want it to be done.
Yes, sir. Yes, sir. So my only request that you can mention about the district court, sir, because High Court is already
That's
connected.
what I've said. I've said
Yes,
district courts. I specifically said district courts.
Yes, sir. Thank you, sir. Thank you, sir.
24th July.
Yes, sir.
Sit with our department and see what exactly can be done.
Yes, Your Honor.
That 6.1 are different issues, my lord. 6, my lord, it is an, they are seeking a restoration of government land as per the decree. 6.1 is the compromise decree as a private property as property. Pre-existing
6 is what? 6 is what?
6 is, my lord, the restoration of the government land in their power by virtue of the decree of the civil code. On 6.1 is, my lord, it is a.
This is the ex parte order.
That is the ex parte order, 6, my lord. In 6.1 is a different issue. That is
6 ಏನ್ ಮಾಡ್ತೀರಾ ಇವಾಗ?
dealing, my lord, that is, please.
Maybe called together, my lord.
6.1 is the compromise
Because
decree of
when
pre-existing rights.
ಇವಾಗ how do you explain this road?
Road, it is a private, my lord, it is in 20 kuntas, we have leave the road between the.
No,
private
you're saying it is private. They're saying it's public.
But if any documents produced, my lord, for the government.
They kindly appreciate the difficulty.
Yes,
Now there is a decree of the court.
yes,
They are not parties to the decree.
yes. That is
And
compromise
you
decree.
have got a decree from the court saying it's a private road.
I will.
How do you resolve this dispute?
And in the 20 guntas, I will produce the sketch, my lord, for the 20 guntas. What we have the 10 guntas, 10 the feet between the private parties. We have not the taking the land of the government. It is in the, within the 20 guntas. of the land.
That is what he's saying. In the village map, it is shown as a road and you appropriate it to as a private road.
Produce the sketch, my lord, the tippany and the sketch, whether the government land in my 20 guntas, we will given up the government land. There is no government land in 20 guntas.
Decree modify ಮಾಡಕ್ಕಾಗತ್ತಾ?
In my 20 guntas, there is no government land. There is no.
ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ, ಅವ್ರು ಇಲ್ಲ ಅಂತಾರೆ. ಇದು ಯಾವ ರೀತಿ ಅರ್ಥ ಮಾಡೋದು?
And we will produce the 20 guntas of the survey sketch, my lord. Tippany and Akarpan we will produce.
And moreover, my lord, as per the decree, my lord, out of 20 guntas, they are seeking kata in respect of 5 guntas, my lord. To effect that kata is also, my lord, Lebanese sketch is required. Therefore, my lord, we are directed to produce the Lebanese sketch. Against that, my lord, without producing the Lebanese sketch, my lord, they approached the authority, my lord, by giving representation. Now they are seeking for direction to effect the kata. Without Lebanese sketch, my lord, the authority cannot effect kata, my lord.
Sir, if you permit me, sir, about this 11E, I'll just like to submit your lordship, sir. Sir, that 11 is why is the state mandated was, sir, to put some control on this illegal layout, sir, revenue layout, sir. So in our Karnataka Land Revenue Act, sir, there's a provision that the state can put a restriction of minimum size of a plot, which can be registered or which can be given a separate survey number. So our, as per our record, sir, if the property is a minimum of 5 gunta, then we can give a new revenue survey number, sir. Now, this is basically to control the illegal layout, which are mushrooming in most of the urban places in Karnataka, sir. So now what is happening, sir, in this case, what road they are talking also, if you want a layout plan, then you have to approach to the Urban Development Authority and get the layout plan, sir. Then automatically all these roads and other thing will come back to the state. 45 to 50% of the common properties, they are supposed to surrender to the state, sir, where the state will maintain in future, sir. But in this particular case, sir, 11 is mandatory because to have a proper road and to proper planning, 11 is mandated under the our statute, sir. So that is a minimum requirement, sir. So without 11E, if there is no 11E, the survey number cannot be assigned, and hence the property cannot be mutated, sir. That is the rule position, sir.
The point is that the.
How will the courts know all this? How will the civil court know? Because like I told you, we're only deciding this suit for partition. They decide to partition their family property. And you come in the side and say that this can't be done. How do we resolve this issue?
So the only resolution according to me, sir, like at the civil court level, proper representation by the state, sir, and active participation of the state authorities, including the advocates representing the state, sir. So that we are ensuring, sir. Now we have started monitoring the court cases in the district court, sir.
If you were to go to the civil court, get this compromise decree modified and resolve this issue regarding the road, then I ask him to consider representation.
And the road is, kindly see the RTC, I produced 21 bar the 1. That is.
Or else if you want, I'll ask them to consider representation and make it clear that they cannot make out the kata in this particular property because of XYZ reasons, notwithstanding the compromise decree. If that is okay.
Please, necessary direction.
Without Lebanese sketch, my lord, it is impossible, my lord, to effect.
No, you reject it only on that ground if you want. You highlight as to why you can't do it.
Yes,
and why Lebanese sketch is necessary. Therefore, even if you have a decree of the court, until these formalities are completed, you can't do it.
Please.
Do it. I'll keep the petition pending.
Please,
Then a DGA submits.
Your Honor, in serial number 6.
Nimshar submits that the request of the petitioners to consider effecting mutation, notwithstanding the order passed today, will be considered, and an appropriate endorsement would be given to the petitioner, highlighting as to reasons for which the mutation as sought for cannot be granted.
In serial number 6, as per declaration order, we requesting to the respondent number 2 to make RTC nalli kata madkodi anta kelidhi swami. I furnished copy of annexure H and H1. ನಮಗೆ ಖಾತಾ ಮಾಡ್ಕೊಡಿ ಅಂತ
They have taken steps, my lord, to prepare an appeal against this judgment, my lord. 2 acres of
Kindly consider my
formal land.
representation, Your Honor.
ಅವ್ರು ಅಪೀಲ್ ಆಗ್ತಾರೆ ಅಂತ ಆದ್ಮೇಲೆ ನೀವು ಗವರ್ಮೆಂಟ್ ಮೇಲೆ ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಪಾರ್ಟಿ ಮಾಡಿದೀವಿ ಸರ್ 2011 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು ಇದು 2011 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು ಡೆಫಿನೆಟ್ ನಂಬರ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ಎಲ್ಲ ನಾವು ಪಾರ್ಟಿ ಮಾಡಿದೀವಿ
Government made in
Not
the
so
statement. Page 45, my lord. Page 45 in writ petition number 1466 of 25. The written statement filed by that has been. The defendants have appeared through AGP. The defendant number 2 as per written statement, it is stated that plaintiff has no legal right or possession over the suit scheduled property or any portion of the scheduled suit property. The defendants dispute the correctness of the pleading averments. Hence, suit is not maintainable. The suit property is a government Goma land. The suit property was not granted to the Appaswamy. The allegation made by the plaintiff is false and imaginary. So on, so on, so. Specifically taken contention in the written
Prefer an
statement.
appeal and give me the appeal number, I'll say.
Therefore, my lord, no, my instructions from my lord, they have taken steps to prepare an appeal, my lord.
ಈ ಎರಡು ಕೇಸಲ್ಲಿ released on so for the review of the AGA on the merits of the cases. Released on, I inundated them for further consideration regarding the above direction. The 2 weeks
Seal number 7,
Shri,
Petitioner in this matter.
or these matters are. pertaining to-
Serial number, my lordship, serial number 7. Those matters, my matters are 13 matters out of that. Serial number 7.22 to serial number 7.28 and 7.32, 39. Sanjay engaged the senior counsel is appeared last time also. End up in another court. May kindly pass out,
ಇಷ್ಟೊಂದು ಜನ ಇದಾರಲ್ಲ ನೋಡ
please.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನಿದೆ?
Matters pertaining to Hemavati Reservoir project, my lord. May I make a small submission, my lord. In first matter, my lord, writ petition number 2959 of 25. All the matters, my lord, the common issues has been raised, my lord, in the orders it indicated, my lord. Page annexure H, page 28, my lord. Writ petition number 2959 of 25. My lord, based on the complaints, my lord, may I read, my lord, Prastavane. ಜಿಲ್ಲಾಧಿಕಾರಿ ಹಾಸನ ಜಿಲ್ಲೆ so my lord. Second one, ಕರ್ನಾಟಕ ರಾಜ್ಯ ರೈತರ ಸಂಘ ಹಾಸನ.
This is a proceeding initiated under which say
On the base of the complaints, my lord, given by the, that is indicated, my lord, in the order. 3, my lord, ಶ್ರೀ ಪೂರ್ಣಚಂದ್ರ ತೇಜಸ್ವಿ, ಶ್ರೀ ಲೋಕೇಶ್ so and so. ಇವರುಗಳು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ಮನವಿಗಳು so and so. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ next, my lord. These matters are coming, my lord, page 30, my lord. On the base of the complaint, my lord, there are under the 10 categories, my lord, it was divided. ಅನುಬಂಧ 1 ಈಗ ಇರೋ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಟೋಟಲ್ ಪರ್ಟೈನಿಂಗ್ ಟು HR ಪ್ರಾಜೆಕ್ಟ್, my lord. ಅನುಬಂಧ 1 ತಾಲೂಕು ಕಚೇರಿಗಳಲ್ಲಿ ನೇರವಾಗಿ ಅಧಿಕೃತ ಜ್ಞಾಪನವನ್ನು ಸ್ವೀಕರಿಸಿ ಭೂಮಿ ಮಂಜೂರಾತಿ ಮಾಡಿರುವ 414 ಪ್ರಕರಣಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಸೆಕೆಂಡ್ ಒನ್, ಒಂದೇ ನಕಲು ಅವಾರ್ಡ್ ಪ್ರತಿ ಮತ್ತು ಪೇಮೆಂಟ್ ವೋಚರ್ ಬಳಸಿ 2 ಜನರಿಗೆ ಅಧಿಕೃತ ಜ್ಞಾಪನ ನೀಡಿ ಜಮೀನು ಅಕ್ರಮ ಮಂಜೂರಾತಿ ಮಾಡಿರುವ 41 ಭೂ ಮಂಜೂರಾತಿ ಪ್ರಕರಣಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಅನುಬಂಧ 2 76 ರಿಂದ 2015 ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರ ದಾಖಲೆಗಳನ್ನು ಬಳಸಿಕೊಂಡು ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿಸಿಕೊಂಡಿದ್ದು, ಅದೇ ಸಂತ್ರಸ್ತರು ನಕಲು ಮುಳುಗಡೆ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು 2ನೇ ಬಾರಿಗೆ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿಕೊಂಡಿರುವ 62 ಪ್ರಕರಣಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಅನುಬಂಧ 3, ಮರಮಾಲ್ಕಿ ನಿಗದಿಯಾಗದೆ 14 ಪ್ರಕರಣಗಳಲ್ಲಿ ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಿಸಿ ಪೋಡಿ ಖಾತೆ ಮಾಡಿರುವ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಿ 14 ಪ್ರಕರಣಗಳ ಮರ ಮಾಲ್ಕಿ ನಿಗದಿಪಡಿಸುವ ಬಗ್ಗೆ. ಅನುಬಂಧ 4, ಮರ ಮಾಲ್ಕಿ ನಿಗದಿಯಾಗದೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವ ಒಟ್ಟು 837 ಅಧಿಕೃತ ಜ್ಞಾಪನಗಳನ್ನು ರದ್ದುಪಡಿಸಿ ಸಕಲೇಶ್ಪುರ, ಬೇಲೂರು, ಆಲೂರು, ಹಾಸನ, ಆಲೂರು ಮರ ಮಾಲ್ಕಿ ನಿಗದಿಪಡಿಸಿದ ನಂತರ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುವ ಕುರಿತು. ಅನುಬಂಧ ಶ್ರೀ ಕ್ಯಾಪ್ಟನ್ ಶ್ರೀನಿವಾಸ್ ಗೌಡರವರು ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ದಿನಾಂಕ 1-12-2018 ರಿಂದ 24/10/2019 ನಕಲು ದಾಖಲಾತಿ ಹಾಗೂ ಸೃಷ್ಟಿಕೃತ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆಧಾರದ ಮೇಲೆ ಮಂಜೂರು ಮಾಡಿರುವ 591 ಮತ್ತು 57 ಒಟ್ಟು 648 ಪ್ರಕರಣಗಳು ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರ ಜಮೀನಿನ ಅಧಿಕೃತ ಜ್ಞಾಪನಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಅನುಬಂಧ 6, ಶ್ರೀ BA ಜಗದೀಶ್ ಅವರು ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿ. ಇವರು ಒಟ್ಟು 40 ಪ್ರಕರಣಗಳಲ್ಲಿ ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರಿಂದ ಮಂಜೂರಾತಿ ಮಾಡಿರುವ 40 ಅಧಿಕೃತ ಜ್ಞಾಪನಗಳನ್ನು ಮತ್ತು ತಹಸೀಲ್ದಾರ್ ಸಕಲೇಶ್ಪುರ ಅವರು ವಿತರಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ರದ್ದುಪಡಿಸುವ ಕುರಿತು. ಅನುಬಂಧ 7, ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆ ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತಲ್ಲದವರಿಗೆ ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆ ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರೆಂದು 32 ಜನರನ್ನು ಪರಿಗಣಿಸಿ ನಕಲಿ ಮುಳುಗಡೆ ದಾಖಲೆಗಳನ್ನು ಆಧಾರದ ಮೇಲೆ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿರುವ ಪ್ರಕರಣಗಳನ್ನು ರದ್ದು ಮಾಡುವ ಕುರಿತು. ಅರಣ್ಯ ಇಲಾಖೆ ವಶದಲ್ಲಿರುವ ಮತ್ತು ಸರ್ಕಾರಿ ಗೋಮಾಳವೆಂದು ಪಹಣಿಯಲ್ಲಿ ನಮೂದಾಗಿದ್ದರೂ ಸಹ ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆ ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರಿಗೆ ಮಂಜೂರಾತಿ ಮಾಡಿರುವ 226 ಪ್ರಕರಣಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಪೂರ್ಣ ದಾಖಲೆಗಳನ್ನು ಪಡೆಯದೆ ಬೇನಾಮಿಯಾಗಿ ಕೇವಲ ಅಧಿಕೃತ ಜ್ಞಾಪನ ವಿತರಿಸುವ ಮೂಲಕ ಜಮೀನು ಮಂಜೂರಾತಿ ಮಾಡಿ ಹೊರಡಿಸಿರುವ 56 ಅಧಿಕೃತ ಜ್ಞಾಪನಗಳನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. Under these 10 categories, my lord, these cases are falling, my lord. And against this, my lord, the case was also registered in crime number crime number, my lord, 157 of 2019, my lord. Now the entire grant certificates are sent to the FSL, my lord. Now we are shortly getting the FSL report.
Not entire. Only 294.
ಹೇಳ್ಬಿಟ್ಟು
Now we are shortly getting the report from the FSL.
But what is the order that is passed?
My lord, the grants were cancelled, my lord. In all these matters, my lord, the common issue, my lord, in all the matters, the persons who are claiming the compensation, my lord, or many of the lands, my lord, are not reserved for the HRP, Amavati Reservoir project. And the parties are not produced any submersion certificate also before the special land acquisition officer to prove their case. And
Now, by the impugned order, the Assistant Commissioner has
it is
cancelled the
observed, my
grant.
lord. SLO, it is observed, my lord. SLO recommended to cancel the grant, my lord. That these documents are not produced by the parties to establish their case. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಕಳ್ಕೊಂಡಿರೋರ್ ಬದಲು ಬೇರೆ ಯಾರ್ಯಾರೋ ಬಂದ್ಬಿಟ್ಟು ಕಾಂಪನ್ಸೇಷನ್ಗಳು ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಷ್ಟೊಂದು ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಮಾಡಿ. Now the enquiry is also initiated against the SLO and the Tahsildar also, my lord.
Such kind of orders are passed in each case.
Yes, my lord.
Individually, separate.
Individual orders is passed, my lord.
So all of them have been heard and
No, my lord, again,
Not
8%,
heard, my
my
lord.
lord.
No, my lord.
8% possible.
No, my lord, the report has been secured, my lord. Now the enquiry is also initiated against the SLO, my lord. If the matters are sent back to the special land acquisition officer, my lord, while the order passing at that time, my lord, these documents are not available, my lord. Therefore, only on the ground that, my lord, the documents, my lord, that are submersion certificate, original genealogical tree, and grant certificate has not produced, these orders came to be passed. They have not appeared before the special land acquisition officer, my lord. Therefore, the orders are passed against them and directed the Tahsildar to cancel the grant, my lord. Now the reports are already with the special land acquisition officer, my lord. If the matters are remanded back to the special land acquisition officer, my lord, if the petitions represent before the special land acquisition officer by producing these documents to establish their case, my lord, orders will be passed, my lord.
Well, that has happened in almost every case. These cases are disposed of by this honorable court last 2 years. There are, I think, nearly 500 cases already disposed. Now submission is before this honorable court. This honorable court in almost all cases remanded for fresh consideration. But this honorable court has made classification into two. But as submitted by the learned government advocate, that there are two types of cases. One is only on the ground of non-payment of the cost of the tree. That is 835 cases as per Annexure A4. And other cases are based on land is not reserved, applications was not properly submitted, or order was not issued by the SLO, that was categorized into one by this honorable court. But in there are number of cases. The first case decided by this honorable court is in writ petition number 628 of 2023, dated 25 March 2024. What is in this honorable? Sir, please. Lord, this honorable court in particular judgment came to the conclusion that non-payment of the cost of the tree, where it is alleged in 835 cases, is not a ground to reject, cancel the very grant. It's a curable debt. Therefore, in those cases, this honorable court has remitted the matter back to assess the cost of the tree and direct the petitioner to pay the cost of the tree. In other cases, this honorable court set aside the SLO as order and remitted for fresh consideration.
In all your cases,
Yes,
before this court,
yes, ma'am.
the grant is not in question?
Grant was questioned on the basis of other grounds and non-payment of the cost of.
So until that first issue is decided
Please.
as to whether the grants that you claim are genuine or not, can the proceedings go?
In 835 cases, grant is not in question. The only question.
That's why I said, in the cases before this court now,
Please.
what is the question? Are they accepting the grant?
Yes, ma'am, they accepted the grant, but grant was cancelled on the basis of non-payment of the cost of the tree. Lord, kindly consider one of the impugned.
How many ಎಲ್ಲ ಒಂದೇ category ಬೇರೆ ಬೇರೆ category?
ಅವರು ಹೇಳಿದ್ರು 10
10 categories ಇದೆ.
Just a minute.
10 categories ಇದೆ.
10 category. My lord, kindly consider
Total 43 cases are today listed, my lord.
First case is my lord's
One category, different category.
Different categories.
different categories.
Classification is ಯಾವ case ಏನೇನ್ category ಅಂತ.
Yes, my lord.
Sir, if you permit me, sir, can I add something since I'm still here attending this hearing, sir? Sir, in this particular case, sir, this complaint of double grants or double claims or bogus claims or grants were made, sir. So at the state level, this matter was discussed in the assembly and also in one of the committee meetings. Then state government appointed a senior level IS officer of the rank of secretary to conduct inquiry, sir. The then Commissioner R&R was appointed, sir. So he conducted a comprehensive inquiry and he's visited Hassan a number of days. And then he examined all the documents, sir. On the basis of his report, some 800 and odd cases in the first batch were recommended for cancellation, sir. There are grounds for each case, sir, actually. Why the cancellation order was made, and subsequently, even assistant commissioner, the SLO, who is assistant commissioner rank officer, without, not only on the basis of this report, he gave notice, heard the parties, and passed the order, sir. And most of these people have also appealed before the deputy commissioner. Deputy commissioner also had heard these cases and passed order rejecting their claims because of the policy then at that time, sir. So it is not just offhand cases. There's a comprehensive inquiry was carried out by the state government, sir.
No, that report was not challenged by anybody, that comprehensive report. Has it been challenged by anybody?
I don't think, sir, there's anybody has
No one
challenged
has
that report, sir.
This is the first time we are hearing, my lord.
No one has
There
charged.
is such report.
Because that report is known to everybody, sir. That report is known to everybody, sir.
This is the first time we are hearing there is comprehensive report because till today, because I'm conducting these cases for last 2 years, but we have not heard any such comprehensive one report is there. We heard only that individual orders were passed cancelling the grant orders and challenged before this. We have not heard any such report.
There are 45 cases here, correct?
Yes.
Apart from this, in other cases, Manjuna,
There are other.
Inno ಇದೆ.
ಎಷ್ಟಿದೆ?
I will give the list.
Now, if you were to categorize these cases,
Yes, my lord.
you said there are 10 kind of categories,
Yes,
isn't
my
it? You categorize those cases, we'll
Please, madam.
consider each category separately so that they'll also be able to
Please. my lord.
appreciate as to, like you said,
Yes.
if the grant is not in question, only the value of the trees, that can be segregated and a separate order can be passed.
Yes, my lord.
So if you give me the correct list,
Please.
in some cases, they say that they have not been heard in the matter.
I will provide.
The records are not considered. Those cases we will remind.
I will
But
for-
until you
yes, madam.
categorize them,
Please,
and
madam, I
can
will
you
carry.
please that record, that comprehensive report that is,
I will secure.
when a DGA submits that,
And
the categories of different the categories under which the dispute can be resolved will be indicated, and those writ petitions can be considered proof wise depending on the category involved in that particular case. He is granted a week's time to furnish the set list. He shall also furnish a list of other cases pending in this regard. The list of.
My lord, if I
Ah.
can make a submission.
Weeks time.
My lord, though my lord has directed the categories, my lord, I will just bring out one point. Wherein even the categories, my lord, like in my case, my particular case, there are 3 categories, 3 anubandhas that have been invoked. 1A, 4 and 8, and they're all very different from each other. So even if they are categories, my lord, they may be overlapping. Anubandha 4 with respect to Mara Malki.
How many such cases? In how many such cases?
My lord, in my.
All the cases. my
In
lords.
all the cases, they are not
They are
specified.
specified.
This is the.
Violation.
Classified comes and I am rejecting the claim. There is no specific
case.
only 10.
They passed common order, my lords.
classification was,
In case in a particular case, the categorization can be more than one. The list should also indicate the categories to which that particular case is involved. Like she said, there are 3 categories.
Yes, ma'am.
Mentioned in that column, category 1, 2,
Please.
3 are involved.
Please,
So that all 3 of them can be considered together.
please, madam.
this
That should solve your problem, isn't it?
And this honorable code, if it will come in one more than one category, apart from Annex 4, my lord, then consider that it is a case for remitting for fresh consideration.
I'll first categorize it, then see what is to be done.
Yes, ma'am.
If
Each category.
principally the grant is under question, the other questions become subsidiary. Isn't it? The first question will be as to whether the grant is genuine or not. If the grant is genuine, then the second or the third category. So what is the base principle? I'll examine. If people are unable to establish that base principle, you obviously will have no right. That will be a better way of doing this stepwise rather than going category wise.
Maybe consider, because we have submitted almost all the document. Submerged.
How many cases you said are there together?
So around 150 cases are pending before this court. My lord.
Are they aware about the categories?
Yes, my lord.
The very
Special and
critical-
acquisition officer is also present. They are aware, my lord.
Because your order says 800 case, 200 cases.
ಅವ್ರು ಯಾರು ಬಂದಿಲ್ಲ ಇಲ್ಲಿ ಕೋರ್ಟಿಗೆ ಬಂದಿರೋರು ಮಾತ್ರ 150
ಬರ್ತಾರೆ
cases.
ಇವಾಗ ಏನಾರ ಆದ್ರೆ ಬಂದೇ ಬರ್ತಾರೆ ಅವರು.
ಅದ್ರಲ್ಲಿ
Already 600 cases.
ಒಟ್ಟು ಎಷ್ಟು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ SLA?
1842.
Out of which about 300 people are here.
Please, my lord. 150 people are here.
No, already 600 cases are disposed. These are pending.
Disposed of ಅಂದ್ರೆ sending it back?
Yes, ma'am.
Few cases are-
Matters are
My lordship, category wise, this honorable court to examine the matter and some of the matter is remitted to the SLO for fix the valuations of the trees and some of the matter for reconsideration.
ಇಲ್ಲ ಟ್ರೀಸ್ ಒಂದಾಯ್ತು. ಗ್ರಾಂಟ್ ಔಟ್ರದ್ದು ಎಷ್ಟಿದೆ? ಬೋಗಸ್ ಗ್ರಾಂಟ್.
My lord,
ಅದ್ಯಾವ್ದು
my lord,
dispose
the
ಆಗಿಲ್ಲ.
coordinate bench of this particular court, in one of the matters, I will produce the order. They have said that in case a grant is in question, like with respect to fraudulent documents or
In res-
duplication of the application that has been filed, they have directed that the parties, the concerned petitioners, go back to the SLA or the matter has been remitted.
That is what he is suggesting.
Based on the documents provided, then the decision may be taken.
What he suggested in the outset was let all the matters go back. They will reconsider the entire
ma'am.
matter and pass a fresh order. But he is saying that in some cases, the only question is as to whether the value of the trees or whatever.
Yes.
So should all of them go back or only some of them should go back? If all of you agree that the matter can go back, he is also with
Only-
you. You will
After-
consider the entire matter afresh.
No, my
After-
lord, 4 matters needs to be sent back for press consideration.
See,
Annexure 4 is for only assessment.
there is no
of the-
consensus among you. If all of you agree for the matter to
that
go
is the-
back, it will go back.
My lordship, this
May I make
honorable
one
court
submission,
has
madam?
passed orders on the basis of annexure which is mentioned in the particular case.
In respect,
That's why I am trying to give
Please,
a
please,
comprehensive solution.
Please.
If there are 10 categories,
The categorization will be done and on next date of hearing.
and then it will be easier for them also to resolve the dispute, you will also have a clear idea as to what exactly you are faced with.
Please.
Until then, again, it will be
Please,
sent
please,
back,
I kindly be heard individual cases because of these are.
the individual ಮಾಡ್ತೀನಿ, but first
Please,
categories ಮಾಡ್ಕೊಳ್ಳೋಣ.
Please, my lord.
ಅದ್ category ಯಾವ್ದು ಅಂತ ಆಮೇಲೆ I'll consider each case individual.
yes, ma'am.
Please, please.
15
Because
days time
they
may
are
be granted,
stating
my
in.
lord. 15 days time may be granted, my lord, to categorize it.
Relist on. ನೀವ್ ಎಷ್ಟು ಜನ categorize ಮಾಡ್ಕೊಡ್ತೀರೋ ಅಷ್ಟು ಈಸಿ ಆಗುತ್ತೆ ಕೆಲಸ.
Yes,
So
ma'am.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ?
Yes,
The.
ಈಗ out of, in respect of grants is concerned, my lord, out of 450 cases, my lord, we have received the FSL report in respect of 250 cases. All are fabricated, my lord. We have received the positive report.
ಅಲ್ಲ ಆ ಕೇಸಸ್ ಸಪರೇಟ್ ಒಂದು ಕ್ಯಾಟಗರಿ ಮಾಡಿ.
Please, madam.
ನೀವು ಎಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಕ್ಯಾಟಗರೈಸ್ ಮಾಡ್ಕೊಡ್ತೀರೋ ಡಿಸಿಷನ್
Please,
ವಿಲ್ ಬಿ ದಟ್ ಮೋರ್.
Please, ma'am.
ಇಲ್ಲ ಸುಮ್ಮನೆ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ನೀವು
ಇಲ್ಲ.
ಹೇಳ್ತೀರಾ
Next
10
date-
ಜನ
ಇಲ್ಲ, next date we will produce this, my lord, category.
and if you give it to them in advance,
Please, my lord.
maybe it's easier for them to
Please, my lord.
get ready.
Please, my lord.
ಇಲ್ಲ ಅವತ್ತು ಬಂದ್ಬಿಟ್ಟು
ಇಲ್ಲ.
ಕೌನ್ಸಿಲ್ ಇಲ್ಲ ಅದು ಇದ್ರ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ.
May grant 20 days time, my lord. Before 5 days early, my lord, we will provide the list for them.
List
also.
on so. The list
days.
of the categorization to be made by the AGA will be furnished to the council for the petitioners at least 5 days in advance.
Please, my lord.
Along with these matters,
15.
other pending matters,
15 April.
other pending matters.
I will give all the list.
They are list ಕೊಡ್ತಾರೆ.
List code.
Like.
The interim order granted on the last occasion may kindly be extended, my lord.
Wherever the entry models extend order.
At 7.3, my lord, amendment of
81,
cost.
82 ಏನೋ?
That is also
23 also, my lord.
The same 81, 82.
Serial number 23 also, my lord.
20?
3, my lord.
23. ಅಷ್ಟೇನಾ?
Yes, my lord. Lord, I here in 7.14, my lord. Same Hemavati Reserve. My case is slightly different, my lord. Land was allotted to me. They take away the land stating that it belongs to the forest department.
So they say doubting your grant.
No, land is not doubted. Just that the land that was allotted to me has now been taken away. Now, my
Which
lord, I
category? He said there are 10 categories. Does your case fall within any of the 10
No, none of
categories?
the categories, my lord. But a blanket order is issued that certain documents have been fabricated, but my grant is of the year 1974, I have participated in the procedure. That is not in challenge at all. May be called that day on the. 7.14. I pray for an interim order, my lord. till then.
In interim order.
not to act upon annexure. Annexure is the order that is now challenged before this honorable court.
What is annexure done?
So annexure is, my lord, they have cancelled the allotment of the land for me. It's at running page number 33.
10.1. What is the interim order in the other cases? 7.1.
In all the cases, my lordship, this honorable court directed to the respondents not to participate at the possessions of the petition.
Interim order, Saka.
Please.
And there are chances they may re-allot it, but even if they don't precipitate regarding the possession, we will not precipitate.
In all these cases, it is made clear that the authorities shall not take any precipitative action pursuant to the impugned orders. That should satisfy all of you.
Possession, as regards possession.
Precipitative action, I don't know what exactly the situation
See,
is.
the problem, my lordship, in all the annexures cancellation order, they're giving same reasons. That is the problem.
Cut copy.
Did not
Therefore,
categorize
my lord, I made
the
a
cases.
submission that in all the matters, my lord, the operative portion says, my lord, the parties are not represented and not produced any documents before the SLO. Therefore, my lord, it was recommended to cancel the grant. No, therefore, my lord, I was made a
No, no,
submission to
fine.
send back to the SLO. Now, my lord, we have positive, my lord, we have received the FSL report in respect of 250 cases.
So your SLA was not ready to pass the order, so he passed one order, no one.
ಇಲ್ಲ ಇಲ್ಲ ಅವಾಗ ಇನ್ನ ಇದೆಲ್ಲ ಆಗಿರ್ಲಿಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಆಗಿರ್ಲಿಲ್ಲ
So why did he pass the order then?
ಅದೇ ಪ್ರಾಬ್ಲಮ್.
So waited for getting the report,
And
isn't
they have not also obtained the report from the forest department also, my lord. In some matters, my lord, the land was granted in the forest department without. We have not been made parties to any of this. We are alien to it.
Only dragging the proceedings, my lordship, last 1 year. This honorable court passed the order in some matters, but till now they are not complied the order.
There must be something more than. ನೀವು ಕ್ಲೀನ್ ಕ್ಯಾಟಗರಿ ಮಾಡಿಕೊಟ್ರೆ ಐ ವಿಲ್ ಟ್ರೈ ಟು
Yes,
ಡಿಸೈಡ್
my lord,
everything.
I will give the list. Great.
Right. Hemant Bharadwaj.
My lords, I appear for the petitioner in serial number 8, my lords. And we seek a week's accommodation to produce certain documents, my lords. We are awaiting certain instructions and documents.
What is the
Pray for
matter?
a week's. My lords, the matter pertains to, I'm an educational institution. I'm running 5 colleges and the land was granted to me by the state government on a lease basis. However, in this very same survey number, the lease granted to other lessees, the lease amount is is lesser and the extent of land that is granted to them is also higher. I'm paying about 50,000 per acre. I'm only granted 2 acres, whereas the other grantees, they're for 13 acres, they're paying a mere sum of 5,000. My requisitions to the state have also been rejected, and the impugned order has been passed, asking me to vacate. I'm running 5 colleges at the moment
No, how much
and
have
other
you,
institutions.
when was the last time you paid the rents?
My lords, I've paid my lords, on the last date of occasion, there was a conditional order passed by this court stating that 10 lakhs was ordered to be paid, on the basis of which a stay was granted. That amount has been deposited by the petitioners, my lords.
You deposited this amount.
Please, my lords.
As requested, relist.
First April.
Please.
Seal number 9, Shri Somsekhar came.
Lord, I appear for the petition. Lord, petitioner is seeking writ of mandamus for issuance of Sakavali cheat
In
by
this
virtue
matter,
of
no?
the order passed by the committee.
In this matter, my lord, the land is not yet granted to the petitioner, my lord. My lord, now the report has been obtained, my lord. If the 3 months time is granted, my lord, we will consider the petitioner's application for.
Lord,
grant,
your
my lord.
lordship, kindly see the annexure C, page 29. The committee is regularized so far as there are 7 applications. A typed copy, your lordship, kindly see. 99 al kotidaru. He is now aged about 71 years. He is not approached. He is an illiterate.
Now the report has been
29, my
secured,
lord, your lordship, kindly see. They have to act it upon by virtue of subsection 3A of 108 of the Karnataka Land Revenue Rules. Page 30, typed copy, my lord. Only 2 applications were allowed and 3 were, other 5 were rejected. ಉಳಿದ ಗಂಗಮ್ಮ ಸಿದ್ದಣ್ಣ ಉಳಿದ NT ಮೂಡಲಗಿರಿಗೌಡ ಇವರಿಗೆ ಸರ್ವೆ ಸ್ಕೆಚ್ ನಂತೆ ಜಮೀನು ಸಕ್ರಮಗೊಳಿಸುವ ಬಾಬ್ತು ನಮೂನೆ 52
ಹೆಸರೇನು?
ಸಿದ್ದಣ್ಣ
Gaurama ಮತ್ತೆ Modlagiri Goda, they have filed a husband and wife, therefore they have to consider one.
My lord, thereafter, my lord, the objections were called for, my lord. No one has filed an objections, my lord. They have also not approached the authority for 8 years, my lord. Now it is processed, my lord. Report has been obtained. And now it will be considered, my lord. My instructions are
The positive order ಮಾಡಲಾ?
positive ಮಾಡ್ತಾರ. Report has been secured. No one has filed an objections, my lord. If 3 months time is granted, my lord.
Where in the state petition is to direct the Tahsildar to collect the TD amount and thereafter issue a certificate grant or sagod purchase in the petitioner. Rest of sub number 183 measuring 2 acres situated at Netkere village, Upi Taluk, Tumkur district. As recommended by the committee on 22/1989 and as requested by the petitioner, whose representation dated 7/11/2024. So that council points out the committee in its deliberations on 22/1989 made a specific and positive recommendation that the lands measuring 2 acres as per the survey sketch be regularized in favor of the petitioner and 2 others. Despite the lapse of 26 years, no steps have been taken. Then DGS submits that objections were called for, and since no objections were received, steps are being taken to implement the decision of the committee. He submits that if 3 months time is granted, a certificate of rent
It will be issued, it will be placed before the committee and the committee will take
3 months
the
time is granted. The recommendation of committee ಮುಂದೆ ತಿರ್ಗಾ ಏನಕ್ಕೆ?
ಅಲ್ಲ ಫಸ್ಟ್ ಕಮಿಟಿಯಲ್ಲಿ ಇಟ್ಟಾಗ ಏನಾಯ್ತು ರಿಪೋರ್ಟ್ಸ್ ಎಲ್ಲ ಸೆಕ್ಯೂರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಡೈರೆಕ್ಷನ್
ಎಲ್ಲಿದೆ? ಸರ್ವೆ sketch ಏನಂತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
I produce your lordship, kindly see survey sketch
That is
page
the
20.
instructions, my lord. That is
Page?
that is the instructions, my lord. I have
What is the rule?
Rule your,
Says the moment recommendation is made,
Yes, my lord.
Tahsildar shall issue.
Yes, my lord.
Then how
Tahsildar-
can you once again send it to the committee?
Now the report has been obtained, my lord. We will consider, my lord.
Steps should be taken to consider the representation of the petitioner. In my view, since the recommendation is made by the committee to regularize the unauthorized occupation of the petitioner, the Tahsildar will have to take steps to issue a certificate of grant or a sagod. And therefore, the Tahsildar is directed to take necessary steps to issue a certificate of grant or sagod to the petitioner as per the recommendation of the committee within a period of 3 months. Date of receipt of copy of this order.
See number 10, Shri Ramesh K.R.
I am appealing for the petitioner, but the petitioner seeking.
See number 11, Shri Chakra Reddy.
Purchase land, my lord, the mutation was not affected, even their vendor and the present petitioner.
In this matter,
And
my lord, I
Sagwali
for
cheat-
1 week time, my lord. Today morning I secured the instructions.
Sagwali cheat also
I
produced.
have to place before.
See number 12, Shri Srinivas V.
This matter, my lord, they are seeking for 40 and duress, my lord. They have given a representation on 7/8/24. Seeking to effect 40 and duress, my lord. If reasonable time is granted, my lord, we will consider the petition's request. my lord.
The prayer in this petition is to issue a direction to response 3 to 5. Consider the representation dated 7/8/2024, by which the petitioners are seeking for durasti work to be conducted in respect of land bill number 200 bar B6, measuring 4 acres, situated at Karigala village, Mapuri Hubli, HD Kote Taluk. Then AGA admits that if reasonable time is granted, the have respondent
Lord, the respondent number 3 and 4, my lord.
3 and 4 will consider the request of the petitioner and conduct the durasti work. In light of the above submission, WP is disposed of by directing respondents 3 and 4 to conduct the durasti work as requested the petitioner within a period of 3 months.
By considering representation, my lord, in accordance with. By considering the representation in accordance with.
ಮಾಡ್ಬಿಡಿ ದುರಸ್ತಿ ಇನ್ನೇನು ಮಾಡಲ್ಲ ಅಂತೀರ.
Please.
Is there any reason why you can reject a durasti work?
ಅಲ್ಲ ಏನಕ್ಕಂದ್ರೆ ಕೆಲವು ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ಸ್ ಬರ್ತಾ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಅದನ್ನೆಲ್ಲ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ.
You will conduct durasti and say that you will not grant it, isn't it?
Please, we'll pass.
So what is the difference?
Yes.
See number 13, Chandra.
ನಾನು ಏನಕ್ಕೆ ಅದು why I don't do that is they will use that one word to reject and once again make them come to the court. Let them do the durasti.
Please, madam.
Whatever they wanted to, let them do.
Please.
Serial number 13.
My lord, except for the petitioner, my lord, junior, my lord, she has already argued. Only thing is that, my lord, there are 3 suits, my lord. 3 suits. I'm sorry, sale deeds. In that, my lord, the 2 sale deeds, my lord, are in respect of 1 acre 20 guntas, 1 acre 20 guntas. Which according to us, my lord, could not have been sold by Boregowda alias Siddegowda. That is one aspect. The second sale deed, my lord, is in respect of 3 acres, my lord, 14 guntas. That, my lord, actually, we are not disputing.
What is it that the Tahsildar can do? ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅದಕ್ಕೆ. ನಿಮ್ ಕೊಲೆಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಇಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಇವಾಗ ನಮ್ದು ಇವಾಗ ಆನ್ ದಿ ಬೇಸಿಸ್ ಆಫ್ ದಿ claim of the parties, my lord, Tahsildar has passed an order as per Annexure A. ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಆದೇಶಿಸಿದೆ.
So the Kata was standing in the name of Rangegowda.
Rangegowda and Janegowda, my lord, both together.
The request was by Rangegowda.
Request was by Rangegowda.
For what?
Yes. To the extent of 1 acre 20 guntas, my lord. But here he claims 3 acres 9 guntas.
No. The only consideration was to conduct inheritance proceedings and decide.
True.
Read page 22.
Yes, ಕೃಷ್ಣರಾಜಪೇಟೆ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 47/1 ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ 3 ಎಕರೆ 9 ಗುಂಟೆಗೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡುವ ಸಂಬಂಧ ಪ್ರಕರಣದ ತಕರಾರುದಾರರಿಗೆ ಹಕ್ಕು ಬಾಧ್ಯತೆ ಇದ್ದಲ್ಲಿ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿಕೊಳ್ಳಲು ತಿಳಿಸಿ ವಹಿವಾಟು ಸಂಖ್ಯೆ 22/2021 MRH 9/21/2021 ಚೆಕ್ ಲಿಸ್ಟ್ ನಂತೆ ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಆದೇಶಿಸಿದೆ.
So he said if you are agreed by any inheritance rights, you can go to the civil court.
Yes.
Isn't it?
Yes.
Then why should we?
ಅಲ್ಲ ಇದು ನಮ್ಮ ಪಾರ್ಟಿ ತಾಯಮ್ಮ ಶಿ ಇಸ್ ಅ ಪಾರ್ಟಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
Correct. If you have any dispute regarding the entitlement of the applicant therein, you can go to the civil court and get it determined.
ಅಲ್ಲ ಹೌದು, but he has to first of all, my lord, Rangegowda first of all should say that I have secured a decree or a title, my lord, by way of a regular registered sale deed to the extent of 3 acres 9 guntas. ಇವಾಗ ಏನ್ ಮಾಡಿದಾರೆ ಅವರು ಅಂತಂದ್ರೆ that as against that, my lord, he himself went to
read the first paragraph in page 21.
Yes. ಕೃಷ್ಣರಾಜಪೇಟೆ ತಾಲೂಕಾ ಸೋಣಸೋ 3 ಎಕರೆ 9 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ನಮೂನೆ 19 ಕೋರಿಕೆಯಂತೆ ನಿಂಗೇಗೌಡ ಬಿನ್ ಬೋರೇಗೌಡ ರವರಿಂದ ತಾಯಮ್ಮ ಕೋಮ್ ಲೇಟ್ ನಿಂಗಪ್ಪ, ಮಂಜುನಾಥ್ ಬಿನ್ ಲೇಟ್ ನಿಂಗಪ್ಪ, ಸೋಮು ಬಿನ್ ಲೇಟ್ ನಿಂಗಪ್ಪ, ಮಂಜುಳಾ ಸೋಣಸೋ ಹೆಸರಿಗೆ ಜಂಟಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ದಿನಾಂಕ 23/2/21 ಚೆಕ್ ಲಿಸ್ಟ್ ಹೊರಡಿಸಿರುತ್ತಾರೆ.
So it was your name was also included there.
Yes.
Now read the next paragraph.
ಕಿಕ್ಕೇರಿ ಸೋಣಸೋ ದಿನಾಂಕ 23/3/21 ಕರ್ನಾಟಕ ಭೂಕಂದೆ ಅಧಿನಿಯಮ 84 ನಿಯಮ 46/85 ನಮೂನೆ 12 ನಮೂನೆ 21 ಗ್ರಾಮ ಲೆಕ್ಕಕರು ಪ್ರಚುರಪಡಿಸಿದ್ದು ಹಿತಾಸಕ್ತಿಯಿಂದ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಲು 30 ದಿನದೊಳಗೆ ಸಮಯವನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ಪ್ರಕರಣದ ಜಮೀನನ್ನು ನಿಂಗೇಗೌಡ ಬಿನ್ ಬೋರೇಗೌಡ ರವರಿಂದ ತಾಯಮ್ಮ ಕೋಮ್ ಲೇಟ್ ನಿಂಗಪ್ಪ, ಮಂಜುನಾಥ್ ಬಿನ್ ಲೇಟ್ ನಿಂಗಪ್ಪ, ಸೋಮು ಲೇಟ್ ನಿಂಗಪ್ಪ, ಮಂಜುಳಾ ಕೋಮ್ ಸೋಣಸೋ ನಿಂಗೇಗೌಡ ರವರ ಹೆಸರಿಗೆ ಜಂಟಿ ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಹೊರಡಿಸಿರುವ ಚೆಕ್ ಲಿಸ್ಟಿಯಂತೆ ಬದಲಾವಣೆ ಮಾಡಬಾರದೆಂದು ರಂಗೇಗೌಡ ಬಿನ್ ಜಾಣೇಗೌಡ ರವರು ತಕರಾರು ಸಲ್ಲಿಸಿರುವುದಾಗಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಕಿಕ್ಕೇರಿ ಹೋಬಳಿಯರವರು ತಕರಾರು ಪ್ರಕರಣವೆಂದು ಪರಿಗಣಿಸುವಂತೆ ವರದಿ ನೀಡಿರುವ ಮೇರೆ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು ಆಗಿರುತ್ತದೆ. ಪ್ರಕರಣದ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಿಕ್ಕೇರಿ ಸೋಣಸೋ ವರದಿಯ ಮೇರೆಗೆ ರಾಜ್ಯ ನಿರೀಕ್ಷಕರ ವರದಿಯ ಮೇರೆಗೆ ಪ್ರಕರಣದ ಉಭಯತರಿಗೂ ದಿನಾಂಕ 7/8 ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗುವಂತೆ ನೋಟಿಸ್ ಅನ್ನು ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಲಾಗಿರುತ್ತದೆ. ಕಿಕ್ಕೇರಿ ಸೋಣಸೋಗ್ನಲ್ಲಿ 6 ಎಕರೆ 23 ಗಂಟೆ ವಿಸ್ತೀರ್ಣ ನಿಂಗೇಗೌಡ ಬಿನ್ ಬೋರೇಗೌಡರವರಿಗೆ 3 ಎಕರೆ 9 ಗುಂಟೆ, ಜಾನೇಗೌಡ ಬಿನ್ ಸೋಣಸೋ ರವರಿಗೆ 3 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನು ಖಾತೆಯಾಗಿರುತ್ತದೆ. ವಿಸ್ತೀರ್ಣ ನೋಂದಣಿಯ ಕ್ರಯ ನಿಧಿ ಬಸವನಹಳ್ಳಿ ಮಾರೇಗೌಡ ಉತ್ತರೇಗೌಡರ ಮಗ ಜಾಣೇಗೌಡರಿಗೆ ಕ್ರಯಕ್ಕೆ ಆದ್ದರಿಂದ ಎದುರುದಾರರು ಕೋರಿಕೆಯಂತೆ ಪೌತಿ ಖಾತೆ ಕೋರಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಮಾಡಲು ಹೊರಡಿಸಿರುವ MR ಅನ್ನು ರಾಜ್ಯ ನಿರೀಕ್ಷಕರು ತಿರಸ್ಕರಿಸ ಅಂತೆ ಲಭ್ಯ ದಾಖಲಾತಿಗಳ ಆಧಾರದ ಮೇಲೆ ಹಾಗೂ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 64 ಕಲಂ 129(4) ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಆದೇಶಿಸಿದೆ.
The objection was that that sale deed will have to be taken into consideration.
Cannot take into
No,
consideration.
that was that should be taken. 1 ಎಕರೆ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವನ್ನು ನೋಂದಣಿ ಕ್ರಯ ಪತ್ರ ನಂಬರ್ ಸೋಣಿಸಂತೆ ಬಸವನಹಳ್ಳಿ ಸೋಣಿಸೋ ಜಾನೇಗೌಡರಿಗೆ ಕ್ರಯಕ್ಕೆ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಎದುರುದಾರರು ಕೋರಿರುವಂತೆ ಪೌತಿ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಬಾರದೆಂದು ಅರ್ಜಿದಾರ ಪರ ವಕೀಲರು ಕೋರಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ you claimed under that sale deed. That sale deed never saw the light of the day from 1770.
No, that is because 1 acre 20 guntas, 1 acre 20 guntas was sold by Boregowda, my lord, in their favor. That is 1 acre 20 guntas, 1 acre 2. It was not to be acted upon, and it is not acted upon. This was taken up in appeal by Rangegowda. He passes an order, my lord, upon which I went up in appeal to the Deputy Commissioner under 136(3).
Read the AC's order.
Yes. ಆದೇಶ ಮಾತ್ರ ಓದ್ಲಾ ಅಥವಾ ಪೂರ್ತಿ?
ಮೇಲ್ಮನವಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ.
ಮೇಲ್ಮನವಿ ಅಂಗೀಕರಿಸಿದಾಗಿದೆ. KR ಪೇಟೆ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ
from page 24. ಮೇಲ್ಮನವಿದಾರರ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸುವ
Page 24, last paragraph.
ಪ್ರಶ್ನಿತ page 24.
Yes. ಪ್ರಶ್ನಿತ ಮೇಲ್ಮನವಿದಾರರು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಪ್ರಶ್ನಿತ MR TSR ಆದೇಶವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ KR ಪೇಟ್ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 3 ಎಕರೆ 9 ಗುಂಟೆ ಜಮೀನನ್ನು ನಿಂಗೇಗೌಡ ಬಿನ್ ಬೋರೇಗೌಡರವರಿಂದ ತಾಯಮ್ಮ ಕೋಮ್, ನಿಂಗಪ್ಪ, ಮಂಜುನಾಥ, ಸೋಮು, ಮಂಜುಳಾ, ಕೋಮ್, ಸೋಣಸೋ, ಬಸವಣ್ಣ, ಬಸಮ್ಮ ನಿಂಗೇಗೌಡರು ರವರು ನಮೂನೆ 19ರಲ್ಲಿ ಪೌತಿ ಖಾತೆ ವಾರಸು ಮೇರೆಗೆ ಖಾತೆ ಮಾಡಲು ಕೋರಲಾಗಿ ರಂಗೇಗೌಡ ಬಿನ್ ಜಾಣೇಗೌಡರವರಿಂದ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 47/1ರಲ್ಲಿ 1 ಎಕರೆ 20 ಗುಂಟೆ 70/71 ಜಮೀನನ್ನು ಸಂಖ್ಯೆ 1107 70/71 ರೀತಿ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿದ್ದು ಪೌತಿ ಖಾತೆ ಮಾಡದಂತೆ ತಕರಾರು ಸ್ವೀಕೃತವಾದ ಕಾರಣ ತಹಸೀಲ್ದಾರ್ KR ಪೇಟೆ ತಾಲೂಕರವರು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದು ಕ್ರಯದಂತೆ ಖಾತೆ ಅಂಗೀಕೃತವಾಗಿರುವುದಿಲ್ಲ, ತಿರಸ್ಕೃತ ಆಗಿರುತ್ತದೆ. ತಿರಸ್ಕೃತ ಮುಟೇಶನ್ ರೀತಿ ಖಾತೆ ಮಾಡಲು ಸಹ ಇರುವುದಿಲ್ಲ. ಇದರಂತೆ ಪೌತಿ ವಾರಸು ಮೇರೆಗೆ ಖಾತೆ ಅಂಗೀಕರಿಸುವಂತೆ ದಿನಾಂಕ 3/10/21 ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. MRM ನಂಬರ್ 9/21/22 ಮ್ಯುಟೇಷನ್ ಪರಿಶೀಲಿಸಲಾಗಿ KR ಪೇಟೆ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ
ಸರ್ವೆ ನಂಬರ್ 47/1ರಲ್ಲಿ 3 ಎಕರೆ 9 ಗುಂಟೆ ಜಮೀನನ್ನು ನಿಂಗೇಗೌಡ ಬಿನ್ ಬೋರೇಗೌಡರವರಿಂದ ತಾಯಮ್ಮ ಕೋಮ್ ನಿಂಗಪ್ಪ ಮಂಜುನಾಥ ಸೋಮ ಮಂಜುಳಾ ಕೋಮ್ ನಿಂಗಪ್ಪ ಬಸಮ್ಮ ಬಿನ್ ಲೇಟ್ ನಿಂಗೇಗೌಡರವರಿಗೆ ಪೌತಿ ವಾರಸು ಮೇರೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. 21-22ನೇ ಸಾಲಿನ KR ಪೇಟ್ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 47/1 ಪಹಣಿ ಪರಿಶೀಲಿಸಲಾಗಿ 6 ಎಕರೆ 30 ಗುಂಟೆ 7 ಗುಂಟೆ ಖರಾಬ್ ಉಳಿಕೆ 6 ಎಕರೆ 23 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಈ ಪೈಕಿ ಜಾನೇಗೌಡ ಬಿನ್ ಮಾದೇಗೌಡ ಮತ್ತು ರಂಗೇಗೌಡ ಬಿನ್ ಜಾನೇಗೌಡರವರಿಗೆ 3 ಎಕರೆ 14 ಗುಂಟೆ 82-83 ರೀತಿ ಹಾಗೂ ತಾಯಮ್ಮ ಕೋಮ್ ನಿಂಗಪ್ಪ ಮಂಜುನಾಥ ಸೋಮ್ ಮಂಜುಳಾ ಕೋಮ್ ಲಿಂಗಪ್ಪ ಬಸಮ್ಮ ರವರಿಗೆ 3 ಎಕರೆ 9 ಗುಂಟೆ ಪೌತಿ ಮೂಲಕ ಎಂಬುದಾಗಿ ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನಕಲು ಕ್ರಯ ಪತ್ರದ ಸಂಖ್ಯೆ 70-71ರಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ KR ಪೇಟ್ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ರಂಗೇಗೌಡ ಬಿನ್ ಜಾನೇಗೌಡರವರಿಗೆ ಬೋರೇಗೌಡ ಮತ್ತು ಸಿದ್ದೇಗೌಡ ಮತ್ತು ಇವರ ಮಗ ನಿಂಗಪ್ಪರವರಿಗೆ ಕ್ರಯಪತ್ರ ನೀಡಿರುವುದಾಗಿ ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನಕಲಿ ಪತ್ರದ ಸಂಖ್ಯೆ ಪರಿಶೀಲಿಸಲಾಗಿ KR ಪೇಟ್ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಜಾಣೇಗೌಡರವರಿಗೆ ಬೋರೇಗೌಡರ ಮಗ ಸಿದ್ದೇಗೌಡ ಮತ್ತು ಇವರ ಮಗ ನಿಂಗಪ್ಪರವರು ಕ್ರಯಕ್ಕೆ ನೀಡಿರುವುದಾಗಿ ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನಕಲು ಕ್ರಯ ಪತ್ರದ 28/3/83 ಪರಿಶೀಲಿಸಲಾಗಿ KR ಪೇಟ್ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 47 ಸರ್ವೆ ನಂಬರ್ 47/1ರಲ್ಲಿ 3 ಎಕರೆ 14 ಎಕರೆ ಗುಂಟೆ ಜಮೀನನ್ನು ಜಾಣೇಗೌಡ ಬಿನ್ ಮಾದೇಗೌಡ ಮತ್ತು ರಂಗೇಗೌಡ ಬಿನ್ ಜಾಣೇಗೌಡರವರಿಗೆ ಸಿದ್ದೇಗೌಡರ ಮಗ ನಿಂಗಪ್ಪ ಮತ್ತು ಇವರ ಮೈನರ್ ಮಕ್ಕಳಾದ ಮಂಜುನಾಥ ಚಂದ್ರಶೇಖರ್ ರಮೇಶ ರವರು ಕ್ರಯಕ್ಕೆ ನೀಡಿರುವುದಾಗಿ ನಮೂದಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಈ ಮೇಲಿನ ಎಲ್ಲ ಕೆಳಗಿನಂತೆ ತೀರ್ಮಾನ ಬರಲಾಗಿರುತ್ತದೆ. KR ಪೇಟೆ ತಾಲೂಕಾ ಕಿಕ್ಕೇರಿ ಹೋಬಳಿ ಜಮೀನು ಕ್ರಯಪತ್ರದ ಸಂಖ್ಯೆ 71 ಹಾಗೂ 3 ಎಕರೆ 14 ಎಕರೆ ಜಮೀನು ಕ್ರಯಪತ್ರದ 83 ರೀತಿ ಒಟ್ಟು 6 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನು ಕ್ರಯ ಬಂದಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಕ್ರಯದಂತೆ ಸದರಿ ಜಮೀನನ್ನು 3 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನು ಅಂಗೀಕಾರವಾಗಿದ್ದು ಉಳಿಕೆ 3 ಎಕರೆ ಜಮೀನು ಖಾತೆ ಅಂಗೀಕಾರವಾಗಿರುವುದಿಲ್ಲ. ಇದರಂತೆ ಪ್ರಶ್ನಿತ ಜಮೀನು ಪ್ರಕರಣದ 1ರಿಂದ 3ನೇ ಎದುರುಗಾರರಿಗೆ ಹೆಸರಿಗೆ ತಹಸೀಲ್ದಾರ್ KR ಪೇಟೆ ತಾಲೂಕರವರು ಆದೇಶದಂತೆ ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು KR MR ನಂಬರ್ H 9/20-21 ಮ್ಯುಟೇಷನ್ ರೀತಿ ಭೌತಿಕ ಖಾತೆ ಅಂಗೀಕರಿಸುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ 47/1ರಲ್ಲಿ 3 ಎಕರೆ 9 ಗುಂಟೆ ಜಮೀನಿನ ಪೈಕಿ 3 ಎಕರೆಗೆ ಜಮೀನನ್ನು ನೋಂದಾಯಿತ ಕ್ರಯ ಪತ್ರದಂತೆ ಮತ್ತು ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರು JMFC ನ್ಯಾಯಾಲಯದ OS 4/21 ಮತ್ತು OS 5/21 ಆದೇಶದಂತೆ ರಂಗೇಗೌಡ ಬಿನ್ ನಂಜೇಗೌಡ ರವರಿಗೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಲಲಿತಮ್ಮ ಕೋಮ್ ಕಾಳೇಗೌಡ ಕಮಲಾ ಕೋಮ ಅಪ್ಪಸ್ವಾಮಿ ಜಾನೇಗೌಡ ಬಿನ್ ಜಾನೇಗೌಡ ರಂಗೇಗೌಡ ಬಿನ್ ಜಾನೇಗೌಡ ಗೋಪಾಲ ರವರಿಗೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಖಾತೆ ಅಂಗೀಕರಿಸಿ ಉಳಿಕೆ 9 ಗುಂಟೆ ಜಮೀನು ಎದುರುದಾರರ ಹೆಸರಿಗೆ ಪಹಣಿ ಮುಂದುವರೆಸಲು ತಹಸೀಲ್ದಾರ್ KR ಪೇಟೆ ತಾಲೂಕರವರಿಗೆ ಸೂಚಿಸುವಂತೆ ಅಭಿಪ್ರಾಯಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಾಯ್ದೆ ನಂಬರ್ 64/136 ರೀತಿಯ ಈ ಕೆಳಗಿನಂತ ಆದೇಶಿಸಲಾಗಿದೆ. ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಹೌದು, ಬಟ್ ಆ ಸೂಟ್ ನಾವು ಪಾರ್ಟಿ ಇಲ್ಲ.
But there are sale deeds. There are 2 sale deeds.
Yes.
So should not be in accordance with the sale deeds.
ಅಲ್ಲ 1 ಎಕರೆ 20 ಗುಂಟೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ನಮ್ಮ ಇವನು ಬೋರೇಗೌಡ ನಮ್ಮ ಕ್ಲೈಂಟ್ ನಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದಾನೆ ಅಂದ್ರೆ ಬೋರೇಗೌಡ ಸಿದ್ದೇಗೌಡ ಇಬ್ರು ಒಂದೇನೆ. ಯಾಕೆಂದ್ರೆ
ಅದನ್ನ ತಹಸೀಲ್ದಾರ್ can decide that. There's a registered sale deed, so.
ಡಿಸೈಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಬಟ್ 1 ಎಕರೆ 20 ಗುಂಟೆ 1 ಎಕರೆ 20 ಗುಂಟೆ ಅವ್ರಿಗೆ ಕೊಡಕ್ಕೆ ಹಕ್ಕೇ ಇಲ್ಲ. ಬೋರೇಗೌಡ ಸಿದ್ದೇಗೌಡನ್ ಕೊಡಕ್ಕೆ ಹಕ್ಕೇ ಇಲ್ಲ. ನಿಂಗಪ್ಪ ಕೊಟ್ಟಿದ್ದು ನಮ್ಮಪ್ಪ ಕೊಟ್ಟಿದ್ದು.
That is a matter that you have established in the civil court, isn't it?
ಅಲ್ಲ ಇವಾಗ that has happened long back, my lord, in
No, you'll have to file a suit for declaration. Only then this can be resolved. Until those sale deeds stand, what is it that can be done?
but here he says, my lord, that on the basis of the decree in OS numbers, in which
No,
I am not
we
a
will-
party.
We will eschew the decree, but the sale deeds still remain. How will you get over those sale deeds?
There are 2 sales in deeds, my lord.
Annexure D says,
Admittedly-
my lord, the suit for declaration is pending between the parties, my lord. Annexure D. page
Allah,
30.
he has one thing, my lord, it is necessary to
The
bring.
petition is the different number
notice.
1, page 31, Annexure D.
That Rangegowda, my lord, has filed a suit for declaration in respect of 1 acre
He
20.
has a sale deed, isn't it, in his favor?
1 acre 20 guntas Rangegowda sold it down favor agide. But he makes me a party, Tayama, and files a suit for declaration that he is the owner of that.
But on the basis of sale deed is claimant declaration because you are setting up title in yourself.
That it has not happened since then.
You
till
are
date.
counterclaim ಹಾಕ್ಕೊಡಿ. In a request for mutation on inheritance proceedings. The Tahsildar proceed to pass an order to mutate the names, the base of inheritance being aggrieved. The respondent Rangegowda preferred an appeal to the assistant commissioner, and the assistant commissioner, after taking note of the 2 sale deeds executed in favor of Rangegowda, directed the mutation to be made in accordance with the sale deeds of the year 1771. This order of the assistant commissioner has been confirmed in revision, as against which the present petition is filed. As already noticed above, the assistant commissioner has basically directed the kata to be made out in accordance with the terms of 3 registered sale deeds. 1 in respect of 3 acres 9 guntas and 2 in respect of 1 acre 20 guntas each. In my view, since the authorities have only acted in terms of the registered sale deed and ordered resolution of kata accordingly, no fault can be found with the orders passed by the authorities. It is also forthcoming from the material record, that is Annexure D, that Rangegowda, the person who claimed title under the 2 sale deeds, has also filed a suit for declaration in this very same property in question. It is therefore clear that the entitlement of Rangegowda over 1 acre 20 guntas will ultimately be decided in OS 638/2021, and the revenue entries would accordingly be mutated on the basis of the said decree. So I therefore find no reason to entertain this petition. Petition is dismissed. However, making it clear that the registration of kata will be subject to the result of OS 638/2021. On this suit,
ಅಲ್ಲ ಅವ್ರು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಈಗ ನಾವೇನಾದ್ರು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ
ಅಲ್ಲೇ ಕೌಂಟ್ ಕ್ಲೇಮ್ ಹಾಕಿ ತಿರ್ಗಿ ನೀವೇ ಬೇರೆ ಯಾಕೆ ಮಾಡೋ ಹೋಗ್ತೀರಾ?
ಅಲ್ಲ ನಮ್ಗೆ ಲಿಬರ್ಟಿ ಕೊಟ್ರೆ
It is also open, it is also made clear that in the event the petitioners were to institute a suit seeking for an appropriate decree of declaration in their favor from us, the revenue entries would also be counted that the decree that may be passed in such a suit.
would your lordships, my lord, observe that all the contentions are kept open?
Needless to state that all the contentions of either of the parties are left open to be adjudicated before the appropriate civil.
Seal number 14 adjourned. Seal number 15, Srimati Mamta Kulkarni.
My lord, I'm praying for 3 days' time.
Saturday's
Lot
matter,
of confusion has crept into this file, your lordship. I need to have some instructions from the party. Yesterday, they could not meet.
Released.
28. Number 16, Shri Ajay Prabhu M.
Ashocation, they have been directed to produce MR records and the L&D grant records.
Yes, sir. Bill number 17, Shri Raghuram Kadam.
I'm led by Mr. Nandakumar. I'm led by Mr. Nandakumar, senior counsel. There's a difficulty today, my personal difficulty. It may be had tomorrow, my lords. Just one day's accommodation.
ಇನ್ನು ನೋಡಿದಿರಾ?
ಇದು Saturday's matter, ಅದೇ KT order, DDLR order.
This is a matter in which the corrigendum under section 58.
Only
has been-
corrigendum has been, entire order has been changed.
Tomorrow, my lords, there's some personal difficulty. Great.
Bill number 18, Shri Bojaraja. Yes.
The first respondent has passed an order without made a petitioner as a party to before the second respondent. Lordship, kindly see annexure G, page 81,
What are you challenging? Order of
order of
136.3.
annexure J and N, my lord.
136.3, na?
Please. For the moment, my lord, kindly see the annexure G, my lord. As per the endorsement issued by the third respondent herein. Page 81. On 6/10/2022, my lord, the third respondent has issued an endorsement saying that, Lordship, permit to read the
Yes.
endorsement. ಶಿರಾತ್ ತಾಲೂಕು ಹುಡುಗೆರೆ ಹೋಬಳಿ ಪಿನ್ನನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 34/1 ಬಾಬ್ತು ಪಾಣಿ ಕಾಲಂ 9ರಲ್ಲಿ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದಂತೆ ಎಂಆರ್ನಂತೆ ತಿದ್ದುಪಡಿ ಮಾಡುವ ಬಗ್ಗೆ. ಲಾರ್ಡ್ಶಿಪ್, ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಿತ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀಮತಿ ಚಂದ್ರಕಲಾ ಕೋಂ ಎಚ್ ರಂಗಸ್ವಾಮಿ ಆದ ನಾನು ಗೌಡಗೆರೆ ಹೋಬಳಿ ಪಿನ್ನನಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 34/1 ಬಾಬ್ತು ಪಾಣಿ ಕಾಲಂ 9ರಲ್ಲಿ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದಂತೆ ಮತ್ತು ಎಂಆರ್ನಂತೆ ತಿದ್ದುಪಡಿ ಮಾಡುವ ಬಗ್ಗೆ 2ರಂತೆ ಮನವಿಯನ್ನು ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಮಧುಗಿರಿ ವಿಭಾಗ ಮಧುಗಿರಿಯವರಿಗೆ ಸಲ್ಲಿಸಿದ್ದು, ಅದರಂತೆ ಉಲ್ಲೇಖ 1ರಂತೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ಈ ಕಚೇರಿಯಿಂದ ರವಾನಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಶಿರಾ ತಾಲೂಕು ಗೌಡಗೆರೆ ಹೋಬಳಿ ಪಿನ್ನನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34/1ರಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಬಾಲಪ್ಪ ರವರಿಂದ MR A 1189/1964-65 ದಿನಾಂಕ 19/8/94ರಂತೆ ರಂಗಪ್ಪರವರಿಗೆ 1 ಎಕರೆ 30 ಗುಂಟೆ ಕ್ರಯಪತ್ರ ಆಗಿರುತ್ತದೆ. ಅದರಂತೆ MR 24/66-67 ಸದರಿ ಪತ್ರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಿಟೇಷನ್ ಆಗಿದ್ದು, ಸದರಿ ಮಿಟೇಷನ್ನಲ್ಲಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ಆದೇಶದಲ್ಲಿ ನಾಟ್ ಟ್ಯಾಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಎಂದು ನಮೂದು ಇರುತ್ತದೆ. ಸದರಿ ಕ್ರಯಪತ್ರದಂತೆ MR 24/67-68 ಅಂಗೀಕಾರವಾಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ಮಿಟೇಷನ್ ವಿರುದ್ಧ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಲು ತಿಳಿಸಿ ನಿಮ್ಮ ಮನವಿಯನ್ನು ವಿಲೇಪಡಿಸಿ ತಿಳಿಸಲಾಗಿದೆ. Subsequently, my lord, on 6/10/2022, the endorsement has been issued. Subsequently, on 12/10/2022, the fifth respondent herein made an application before the second respondent. 12/10/2022. Subsequently, my lord, on 19/10/2022, annexure J order has been passed by the second respondent without made as a party to the petitioner. Till 1967 to 2022, my grandfather was entered in the revenue records. I have produced the RTC extract, my lord. Kindly see page RTC extract, annexure F, my lord.
ಇದ್ರ ಮೇಲೆ ನೀವು ರಿವಿಷನ್ ಹಾಕಿದ್ರಾ?
Please, my lord.
ರಿವಿಷನ್ ಹಾಕಿದ್ರಾ?
We are seeking the leave of the court, my lord. The petitioner herein approached the first respondent, and first respondent, without asserting any merits of the case, dismissed the appeal.
Please read page 103.
ಶಿರಾ ತಾಲೂಕು ಗೌಡಗೆರೆ ಹೋಬಳಿ ಪಿನ್ನನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34/1ರಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು ಸಂಬಂಧ ತಹಶೀಲ್ದಾರ್ ಶಿರಾ ತಾಲೂಕರವರ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಕ್ರಯದಂತೆ MR 24/67-66-67 ವಜಾ ಮಾಡಿರುವ ಹಕ್ಕು ಬದಲಾವಣೆ ಆದೇಶವನ್ನು ಪ್ರಶ್ನಿಸಿ 4ನೇ ಎದುರುದಾರರ ಚಂದ್ರಕಲಾ ಕೋಂ ರಂಗಸ್ವಾಮಿರವರು 1ನೇ ಎದುರುದಾರರಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮಧುಗಿರಿ ಉಪವಿಭಾಗ ಇವರ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನೋಂದಾಯಿತ ಸಂಖ್ಯೆ 11-89-64-65 ಕ್ರಯಪತ್ರದಂತೆ ಬಾಲಜ್ಜನ ಮಕ್ಕಳಾದ ರಂಗಪ್ಪ ಮತ್ತು ಬಾಲಪ್ಪನವರು ಆರ್ ರಂಗಪ್ಪ ಬಿನ್ ರಂಗಪ್ಪರವರಿಗೆ ಪಿನ್ನನಹೊಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಕ್ರಯಕ್ಕೆ ನೀಡಿದ್ದು, ಕ್ರಯಪತ್ರದಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಸಂಬಂಧ MR 24/67/62ರಲ್ಲಿ ರಂತೆ ನಾಟ್ ಟ್ಯಾಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಎಂದು ನಮೂದಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ 26/9/2029 EC ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ RR 102ರಂತೆ ಸಿದ್ದಪ್ಪ ಬಿನ್ ಚಿಲ್ರೆ ಸಿದ್ದಪ್ಪರವರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಎಂದು RR 118ರಂತೆ ಬಾಲಪ್ಪ ಬಿನ್ ಗುಂಡಪ್ಪರವರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಎಂದು ಇಂಡೆಕ್ಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರಂತೆ ಸರ್ವೆ ನಂಬರ್ 34/1ರಲ್ಲಿ ಬಾಲಪ್ಪ ಬಿನ್ ಗುಂಡಪ್ಪ ಎಂಬ ನಮೂದಿಸಿರುತ್ತದೆ. ಪಿನ್ನನಹೊಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34/1ರ ಕೈಬರಹದ ಪಾಣಿಯಲ್ಲಿ ಬಾಲಪ್ಪ ಬಿನ್ ಗುಂಡಪ್ಪ ಎಂದು, ಹಾಲಿ ಪಾಣಿಯಲ್ಲಿ ಬಾಲಪ್ಪ ಬಿನ್ ಗುಂಡಪ್ಪ ಎಂದು 1 ಎಕರೆ 28 ಗುಂಟೆ MR 24/76/77 ಕ್ರಯ ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸದರಿ ನೋಂದಣಿ ಸಂಖ್ಯೆ 1189/1964-65 ಕ್ರಯಪತ್ರದಂತೆ ಬಾಲಜನ ಮಕ್ಕಳಾದ ರಂಗಪ್ಪ ಮತ್ತು ಬಾಲಪ್ಪರವರು ರಂಗಪ್ಪ ಬಿನ್ ರಂಗಪ್ಪರವರಿಗೆ ಪಿನ್ನನಹೊಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನನ್ನು ಕ್ರಯಕ್ಕೆ ನೀಡಿದ್ದು, ಸದರಿ ಕ್ರಯದಂತೆ ಖಾತಾ ಬದಲಾವಣೆ ಸಂಬಂಧ 24/76/77ರಂತೆ ಅಂಗೀಕಾರ ಆಗಿರುವುದಿಲ್ಲ. ಹಾಲಿ ಸರ್ವೆ ನಂಬರ್ 34/1ರಲ್ಲಿ ಕ್ರಯಕ್ಕೆ ನೀಡಿರುವ ಬಾಲಪ್ಪ ಬಿನ್ ಗುಂಡಜ್ಜನವರಿಗೆ 1 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನು ನಮೂದಿಸಿರುತ್ತದೆ. ಆದ್ದರಿಂದ MR 24/66/67 ರದ್ದುಪಡಿಸಿ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಬೇಕಾಗಿ, ಆದ್ದರಿಂದ ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಪ್ರಶ್ನಿತ ಪಿನ್ನನಹೊಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34/1ರ ಜಮೀನಿನ ಬಾಬ್ತು ಆದೇಶ MR 24/67/66/67 ರದ್ದುಪಡಿಸಿ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದಂತೆ 1189/64-65 ಕ್ರಯದನ್ವಯ ದುರಸ್ತಿ ಅನ್ವಯ ಪಿನ್ನನಹೊಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34/1ರಲ್ಲಿ 1 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನನ್ನು ಬಾಬ್ತು ರಂಗಪ್ಪ ಬಿನ್ ರಂಗಪ್ಪರವರಿಗೆ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ತಹಶೀಲ್ದಾರ್ ಶಿರಾರ್ ಅವರಿಗೆ ತಾಲೂಕರವರಿಗೆ ನಿರ್ದೇಶಿಸಿ ಎಂದು ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಈ ಆದೇಶದ ವಿರುದ್ಧ ಪ್ರಸಕ್ತ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನೋಂದಾಯಿತ ದಾಖಲೆಯ ಆಧಾರದ ಮೇಲೆ ಕಂದಾಯ ನಮೂದುಗಳನ್ನು ಬದಲಾಯಿಸುವುದು ಕಂದಾಯ ಅಧಿಕಾರಿಗಳ ಕರ್ತವ್ಯವಾಗಿರುತ್ತದೆ. ನೋಂದಾಯಿತ ದಾಖಲೆಗಳ ನೈಜತೆ ಮತ್ತು ಸಿಂಧುತ್ವವನ್ನು ಪರಿಶೀಲಿಸುವ ಅಧಿಕಾರ ಕಂದಾಯ ನ್ಯಾಯಾಲಯಗಳಿಗೆ ಇರುವುದಿಲ್ಲ. ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಆದೇಶವು ಕ್ರಮಬದ್ಧವಾಗಿದ್ದು, ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶದ ಮಧ್ಯೆ ಪ್ರವೇಶಿಸುವ ಯಾವುದೇ ಸಬಲ ಕಾರಣ ಕಂಡು ಬಂದಿಲ್ಲವಾದ್ದರಿಂದ ಕೆಳಗಿನ ಆದೇಶ. Since from 1967 till 2022, my grandfather was in the RTC, my lord. Your lordship, kindly see annexure F.
Who executed the sale deed then?
Some fictitious persons have created the alleged sale deed, my lord. On the basis of the alleged sale deed, the revenue authority has mutated after lapse of 58 years. Khata has been transferred.
But how can they get over the sale deed?
Your lordship, kindly see the sale deed, my lord. Balappa and one Balappa and another Rangappa has executed a sale deed. Lord, the real owner is Balappa bin Gundappa, original owner, as per the revenue record. That's why in the year 1967, no.
The Tahsildar give that finding.
Please, my lord.
No, can the Tahsildar give the finding that the sale deed executed by Balappa is of no consequence because the real owner was so and so? Balappa son of so.
That's why, my lord, the revenue inspector has not tally issue notice in the year 1967-68. The MR has been not.
No, but ultimately, if your argument is accepted, you'll have to give a finding, isn't it? That the sale deed is executed by a person who had no title.
The revenue inspector has.
Ultimately, if he accepts your argument, that is what the Tahsildar would do.
Within a span of 20 days, my lord, pass in a 3 order. On 6/10/2022, my lord, the fifth respondent made an application before the for third respondent. Third respondent issued an on 12/10.
In Manjunath, how do you explain that the first rejection of his claim for registration MR 24/6667? He accepts notice of respondents 1 to 4. Issue notice to R5. Status quo regarding entries be maintained. But Tahsildar idu kotre
Lord, in the meanwhile, my lord, the entries.
status quo anta helidini. Status quo regarding entries.
Please.
But I don't know how exactly you will resolve this dispute.
But
Can the Tahsildar record a finding that the sale deed is of no consequence?
liberty may be given, my lord. I will approach this competent civil court to declare it.
ಅದೇ ಬೆಟ್ರ್ ಸುಮ್ಮನೆ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ?
Consequently, my lord, the both orders has been set aside.
Then I will dismiss the petition granting you liberty to
No,
go.
my lord, but without made the
Ultimately, ಅದೇ
petitioner
order.
as a party to the proceedings, my lord, pass an order,
Ultimately, ಅದೇ order ಆಗೋದು. ಇವಾಗ ಸದ್ಯಕ್ಕೆ ನೋಟಿಸ್ ನಿಮ್ಗೆ ಅಷ್ಟೇ ಬೀಸೋದನ್ನೇ ತಪ್ಪಿಸ್ತದೆ ಅಷ್ಟೇ.
please.
Number 19, Somshekara KL.
ಮಾಡಿದ್ರ ಅದು?
This case, my lords, I'm seeking the permission to December court to implead me as impleading a respondent, my lords. I'm filing application for impleading.
Who are you?
I'm the villages, my lords.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
Copy, sir.
Just now I
ಸ್ಕೆಚ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Before that, I'd like to present the human facts.
Where is his house?
This is the wide, this is the currently encroachment. RTC is running currently.
This is the map that village map that is.
Yes. This is the map that is enlarged. ಇಲ್ಲಿ 3 ಅಂತಿದೆ. ಈ 3 ಪಕ್ಕದಲ್ಲಿರುವಂತ 11 ಸರ್ವೆ ನಂಬರ್ 11 ಇದು ಊರು ಬೌಂಡ್ರಿ ಬರುತ್ತೆ. One that is, this is Gramthana. This black color line. ಈ ಕಡೆಗೆ ಬರೋದು ಕಂಪ್ಲೀಟ್ ಆಗಿ 711 ಇದೆಲ್ಲ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ಗೆ ಬರುತ್ತೆ. ಈಗ this is
No, with reference to the village map,
yes.
where is that pathway?
ನೋಡಿ ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11 ಅಲ್ಲಿ ಪಾಸ್ ಆಗಿದೆ.
Reference to this.
Hello,
Where
this
is
is
it?
the
Where is-
pathway, this is the dotted line. It has passed over his house also. The dotted line is the path that Kaldari that we are currently talking about. My lord has.
The village map was this, right? In the village map, this is the
Yes,
pathway.
ma'am. Yes, ma'am.
So there are structures already put up.
Yes, ma'am. ಇದೇನಾಗಿದೆ ಗೊತ್ತಾ ಮೇಡಮ್, ಇದು ಆಗಿರೋದು 1912 ಅಲ್ಲಿ. ಈ ಕಂಪ್ಲೀಟ್ ಈ ರೋಡ್ ಏನಿದೆ ಅದನ್ನ ಮೇಲ್ಗಡೆಗೆ ಶಿಫ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅಂಡ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಈ ಜಮೀನ್ ಇಬ್ಬಾಗ ಆಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಒಂದ್ ಸೈಡ್ಗೆ ಜಾಗ ಬಿಟ್ಕೊಳ್ತಾರೆ. ಇದು ಆಲ್ಮೋಸ್ಟ್ 100 years ಇಂದಾನು ಈ ರೋಡ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಎಲ್ಲ ಇದೆ. ಇದೇನು ಇವ್ರು ಜಮೀನ್ ಈ ಜಮೀನ್ ಈ ರೀತಿ ಡಿವೈಡ್ ಆಗುತ್ತೆ, ಏನು ಬೆಳ್ಕೊಳಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಇವ್ರೆ ಒಂದ್ ಸೈಡ್ ಬಿಡ್ತಾರೆ. ಗ್ರಾಮಸ್ಥರ ಹೇಳಿಕೆಯಿಂದ ಅದೇ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಲಾಸ್ಟ್ 6 months ಅಲ್ಲಿ ಅವರು ಈ ರೀತಿ ಇಲ್ಲಿ ಒಂದು ಶೆಡ್ ಹಾಕೊಳ್ತಾರೆ ನೋಡಿ. ಈ ರೀತಿ ಇದು ಹೆಂಗಿದೆ ಅಂತಂದ್ರೆ, ಮನೆ ಕಟ್ಬೇಕಾದ್ರೆ ಸೈಡ್ ಅಲ್ಲಿ ಅವರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ವರ್ಕರ್ಸ್ ಒಂದು ರೂಮ್ ಹಾಕೊಳ್ಳಲ್ಲ, ಆ ರೀತಿ ಇದೆ. ಇದು ಕಂಪ್ಲೀಟ್ಲಿ ಪ್ಯೂರ್ಲಿ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಗೋ ಮೈ ಲಾರ್ಡ್. ಹಿ ಡಸಂಟ್ ವಾಂಟ್ ದ ವಿಲೇಜ್ ಫೆಸ್ಟಿವಲ್ ಟು ಹ್ಯಾಪನ್. ಇಲ್ಲಿ ಇಲ್ಲಿ ದೇವಸ್ಥಾನ ಅನ್ಸುತ್ತೆ ಮನೆ. ಈ ರಸ್ತೆಯಿಂದ ಬಂದು ಮೆರವಣಿಗೆ ಇಲ್ಲಿ ಬಂದು ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲಿ ಕೊಂಡ ಮತ್ತೆ ಜಾತ್ರಾ ಉತ್ಸವಗಳೆಲ್ಲ ನಡೆಯುತ್ತೆ ಪ್ರತಿ ವರ್ಷ. ಅದನ್ನ ಈ ಸತಿ ಇವ್ರಿಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ he is being honest and he is also making fun of the whole procedure, due process of law that we have followed. And apart from that, my lord, since this is agricultural land, the building constructed itself is illegal. He has not done any conversion of the land. This is the entry that is there in the PDO's book. There is just his name in the demand register and ಅದ್ರಲ್ಲೂ ಕೂಡ ಖಾತೆ ಆಗಿದೆಯಲ್ಲ my lord, ಅದು ಬಂದು ಜಸ್ಟ್ ಅರ್ಧ ಗುಂಟೆ ಇದೆ. ಅವರ ಚೆಕ್ ಬಂದಿಲ್ಲೂ ಕೂಡ ಇಲ್ಲಿ ಒಂದ್ ಕಡೆ ಗಲ್ಲಿ, ಒಂದ್ ಕಡೆ ರಸ್ತೆ, ಇನ್ನೊಂದ್ ಕಡೆ ಗಲ್ಲಿ ಅಂತ ಬರೀತಾರೆ ಬಿಟ್ರೆ ಅಲ್ಲೆಲ್ಲೂ ಕೂಡ ಕಂಪ್ಲೀಟ್ ಪ್ರಾಪರ್ಟಿ ಅವ್ರದೇ ಅಂತ ಎಲ್ಲೂ ಬರಲ್ಲ. ಪಾಣಿ ಅಂತ ಅವ್ರದ್ದು ಎಕ್ಸ್ಟೆಂಟ್ 1.25 ಗುಂಟೆ, 1.25 ಗುಂಟೆ ಬರುತ್ತೆ.
ಸೋಮಶೇಖರ್. if you are going to say that you'll have to go by the village map, then this is the pathway that is shown in the village map. If that is so, your house itself will go. Your house is constructed on the pathway. This is the village map and the Google map juxtaposed for one another. ತಲೆ ಹೇಳ್ತಿದ್ದೀನಿ. ಇದು ಪಾತ್ವೆ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ. ಈ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ತಗೊಂಡ್ರೆ ನೀವು ಇದು ಕರೆಕ್ಟ್ ಅಂತ ತಗೊಂಡ್ರೆ ನಿಮ್ ಮನೆನೇ ಅರ್ಧ ಆಗ್ಬಿಡುತ್ತೆ. ಇವಾಗ ಪುಟ ಬಿಕಾಸ್ ಸಿ ಇಲ್ಲಿಂದ ರೋಡ್ ಇದೆ ಪೂರ್ತಿ. ಇದು ಇಲ್ಲಿ ಯಾರು ಸುಮ್ಮನೆ ಇಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟು ಈ ರೋಡ್ ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಹಂಗಾರೆ ನೀವು ಇಲ್ಲಿ ಬ್ಲಾಕ್ ಮಾಡಿದ್ರೆ?
ಈ ರೋಡ್ ಸಿಂಪಲ್ ನಾನ್ ಹೇಳ್ತಾ ಇರೋದು ಈ ಕಡೆಯಿಂದ ಬಂದ್ರೆ ಹಿಂಗೆ ನನ್ನ ಮನೆ ಬ್ಯಾಕ್ ಸೈಡ್ ಬರುತ್ತೆ ಅಂತ ನಾನು
ಇನ್ನೊಬ್ಬರ ಜಾಗದಲ್ಲಿ ಹೋಗಿ ರೋಡ್ ಅಂತ ಹೇಳ್ತಾರೆ ನೀವು. ಆ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಈ ಮನೆ ಹೊಡೆದಾಕು ಅಂತ ಹೇಳ್ಬೇಕಾಗತ್ತೆ. ಇಲ್ಲಿ ಅವ್ರ ಪ್ರಕಾರ ಬಂದಿದೆ, ಅವರು ಹೋಗಿ ಈ ಮನೆನೇ ಹೋಗ್ಬಿಡುತ್ತೆ. ನಿಮ್ ಮನೆನೇ ಹೋದ್ರೆ ಅದು ಬೆಟ್ರಾ ಇಲ್ಲ ನೀವು ಸುಮ್ಮನೆ ಜಾಗ ಬಿಟ್ಕೊಡೋದು? ವಿಲೇಜ್ ಮ್ಯಾಪ್ ನ ಇದನ್ನ ಸೂಪರ್ ಇಂಪೋಸ್
ನಾವು ಮಾಡಿ ಪ್ರಾಪರ್ಲಿ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಅಪ್ ಟು ಸ್ಕೇಲ್ ಮಾಡೋಣ. ಅಂಡ್ ಇಲ್ಲಿ ನಾವೇನ್ ಹೇಳ್ತಿದ್ವಿ ಮಾಡೋಣ ಸೇಮ್
ನಾನು ಹೇಳ್ತಾ ಇರೋ ನನ್ನ ಮನೆ ಬರುತ್ತೆ.
ಅವ್ರು ಅದನ್ನೇ ವಿಲೇಜ್ ಮ್ಯಾಪ್
ಯಾವ ಮ್ಯಾಪ್ ತಂದ್ರು ನಮ್ಮ ಮನೆ ಈ ಕಡೆ ಬರುತ್ತೆ ಆ ಕಡೆ ಬರುತ್ತೆ ಅಂದ್ರೆ
ಮ್ಯಾಪ್ ಇದೆ ಅಂದ್ರೆ ಗೂಗಲ್ ಮ್ಯಾಪ್ ನಾವು ಗೂಗಲ್ ಮ್ಯಾಪ್
ಇದು ಗೂಗಲ್ ಮ್ಯಾಪ್.
I had requested them so that I'll understand what is the problem. If this is correct, prima facie, if the pathway, on the pathway if you have constructed, according to her, this is the boundary of Gramtana. All these houses are constructed on agricultural lands. So all of them are illegally constructed on agricultural land. No, then the question of this pathway would become irrelevant if all of them have put up structures. The pathways are meant to have access to agricultural lands. If everything is built up, then the question of pathway would not arise. If ನೀವೇ ಸುಮ್ಮನೆ ಬಿಟ್ಕೊಳ್ಳೋದು
So the same exact sketch is superimposed on the.
ಇಲ್ಲೇ ಬರುತ್ತೆ.
Sir, we are not technically competent to.
ನಾನು ನಿಮಗೆ ಸುಮ್ಮನೆ ಇದು ಇಷ್ಟುದ್ದ ರೋಡ್ ಇದ್ದು ನೀವು ಒಬ್ಬರೇ
ಇಲ್ಲ ಅದು ಇಲ್ಲಿಂದ ಬರುತ್ತೆ ಅಂತ ತಮ್ಮ ಅದನ್ನೇ ನಾನು ಹೇಳ್ತೇನೆ. ನಮ್ಮ ಮನೆ ಇಲ್ಲಿ ಬರುತ್ತೆ.
ಈ ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಇದು ಒಂದು ನಿಮ್ಮ ಮನೆಯಿಂದನೇ ರೋಡ್ ಹಂಗೆ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದ್ರೆ I am prepared to hold that there is a road. Therefore, your
ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಂದ್ರೆ ಈ 3 ಅಡಿ ರಸ್ತೆ
ಈ ರೋಡ್ ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಸೋಮಶೇಖರ್ ಹಂಗಿದ್ರೆ? ಇಷ್ಟು
ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗುತ್ತೆ.
ಮತ್ತೆ ಹೆಂಗ್ ಹೋಗ್ತಾರೆ ದೇವಸ್ಥಾನಕ್ಕೆ?
ನಾವ್ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿಂದ ಮೇಲ್ ಬಂದ್ರೆ ನಮ್ಮ ಮನೆ ತುಂಬಾ
ಸೊ ಅವಾಗ ಎಲ್ಲಾನು ಹೊಡೆದಾಕ್ಬೇಕು ತಾನೆ ನಿಮ್ ಪ್ರಕಾರ ಅಲ್ವಾ? ಹಂಗಾರ ಅಲ್ಲ ಹಂಗಾರೆ ನಿಮ್ಮ ಮನೇನು ಹೊಡೆದಾಕ ನಿಮ್ಮ ಮನೇನು
ಬಂದ್ರೆ
ನಾನು ಇಲ್ಲಿದೆ ನಾನು ಐ ವಿಲ್ ಗಿವ್ ಎ ಫೈಂಡಿಂಗ್ ದಟ್ ಯುವರ್ ಹೌಸ್ ಶುಡ್ ಬಿ ಡಿಮಾಲಿಶ್ಡ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಆನ್ ಅ ಪಾತ್ವೇ. If this is the argument that you want to advance, I will decide. Don't try to push it too much. ಇದು ಏನೋ ಒಂದು ನಿಮ್ಗೇನ ಜೆನ್ವಿನ್ ತೊಂದರೆ ಇದ್ರೆ ಈ ಸುಮ್ಮನೆ ಬಿಡೋದು ವಾಸಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಇದು ಸಮಥಿಂಗ್ ನಿಮ್ಗೆ ಏನಾದ್ರು ಅನ್ಯಾಯ ಆಗಿದ್ರೆ ಐ ವಿಲ್ ಸಪೋರ್ಟ್ ಯು. ಬಟ್ ಇಫ್ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಮೇಕ್ ಯೂಸ್ ಆಫ್ ದಿಸ್ ನೋಡಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ. What is the suit that he has filed?
They filed a suit against impeding applicants for seeking a permanent injunction. The dispute arose, my lords, after the death of petitioner father.
Somshekar, have you indicated the filing of the suit in the writ petition?
Yes, stated.
ಹೇಳಿದ್ದೀರಾ?
Private property is not against the.
ಇಲ್ಲ writ petition ಹೇಳಿದ್ದೀರಾ?
Have stated.
Also, advise your party unnecessarily don't
I will.
his house will be in danger.
I will get this.
If you want the pathways to be in accordance with village map, you will not only put your house in trouble, you will put everybody's house there in trouble. And I will hold you to your village map and saying that if you want to maintain pathways, you will lose your house as well as the house of the neighbors. You think about whether that's a better choice or this is a better choice. ಅಷ್ಟು ಜಾಗದಲ್ಲಿ ನೀವೇನೇನು ಅಂಬಾನಿನೋ ಅದಾನಿನೋ ಆಗಲ್ಲ ನೀವು. ಊರಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಇದ್ ಮಾಡ್ಕೊಳ್ಳಿ, why do you want to unnecessarily fight?
ಅಲ್ಲಿ ನಮ್ಮದ್ರಲ್ಲಿ ಹೋಗಿದ್ರೆ ದೇ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ಬಟ್ ಅವ್ರು ಏನಂದ್ರೆ ಡಿವಿಯೇಷನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಅಷ್ಟೇ.
The problem arose, my lords, of the death of petitioner father, my lords.
Don't unnecessarily fight, you have to live in the village. Be practical.
I will get instructions now. How to consonants with this map and this sketch.
The fact that the road goes beyond your, that sketch, that go down, that you have constructed, prima facie to my mind is proof of the fact that there was a road and you are blocking the road.
I will
If
get
I
this.
record a finding in the writ petition, your suit, everything will go.
But ನಾನು ಇವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ಡೆಮಾಲಿಷನ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಇದೆ, ಡಿ ಸಿ
I will-
ಕ್ಯಾನ್
I will
ಅಡ್ಜುಡಿಕೇಟ್
record a-
ಅಂದ್ರೆ 104 ಅಲ್ಲಿ ಡಿ ಸಿ ಅಡ್ಜುಡಿಕೇಟ್
I will
ಮಾಡಿ.
record a finding in the writ petition itself.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾರೆ ಡಿ ಸಿ ಅವರು ಇಸ್ ಕಾಂಪಿಟೆಂಟ್ ಅಂತ ಟು ಡಿಸೈಡ್.
I will record. Then you
ನೀವು
take it
ರೆಕಾರ್ಡ್
up.
ಮಾಡಿದ್ರೆ
Now the circular is
I'm
there, my
telling
lord.
Either you do it voluntarily so that the problem is solved.
ಅಲ್ಲ ಸಮ್ಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡಿ ಸಿ ಪವರ್ ಇದೆ, ಇವ್ರಿಗೆ ಪವರ್ ಇಲ್ಲ. There is no
Circular is
authority,
government circular.
ತಹಶೀಲ್ದಾರ್.
ನನಗೆ ಪವರ್ ಇದೆ ತಾನೆ,
ನಿಮ್ಗಿದೆ something.
ನಾನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳೋಣ.
ಅಲ್ಲ ಅದ್ಮೇಲೆ ಅವ್ರು ಸಮ್ಮರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ ಬೇಕಾದ್ರೆ.
Advise him not to do this and remove it.
I will
so
get
that
this.
From tomorrow onwards, my lord, the
2:30.
Tomorrow, my lords, Jatra is
2:30.
Number 20, Shri Prasanna VR.
But my lord wanted to know whether the predecessor of the respondent number 5 to 7 was a party to the proceedings of the year 1959, where, my lord, I have filed an appeal, annexure D, my lords. There were proceedings, my lords, which is referred in the annexure D, my lords. Kindly see annexure D, my lords. Page number 79, my lords. Both husband and wife, my lords, were granted with, my lords, assigned with the 68 acre, 99 cents, my lords. And now, my lord, the father of the respondent number 5 to 7 wanted to get the ownership right on the assigned lands without evicting these petitioners, my lord, who are admittedly in possession, which are recorded by the revenue officials, my lords, in the year 1961 itself, my lords. And the lands were not sought to be acquired, utilized for the purpose of rehabilitation due to Mulki Dam. Then, my lords, the reports were submitted noting the petitioner's possession. In spite of that, my lords, petitioners were not arrayed as a party before the revenue authorities as well as before the Karnataka Appellate Tribunal and in the before this honorable court in the previous writ petition.
You are claiming under whom?
My lord, I am claiming, my lords, as announced occupant since 1958. I have sought for assignment of land for cashew cultivation.
ಯಾವ್ದು ನೀವು?
Annexure D. That is an order in an appeal filed by the petitioner's predecessor, Chandu Pujari, page number 79, my lords. The original document, my lords, copy of the same is at page number 74.
70?
74, my lords, typed copy is at 79. 74 is the original order.
ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡ್ಕೊಡು ಅಂತ ಹೇಳಿ.
ಹೌದು. ಅದರಲ್ಲಿ previous owners were, my lord, assignee were arrayed as party, my lords, in the sense they were summoned the opinion, explanations from the assignees. Kindly see, my lords, page number 17, item number 2, 3 and 4, my lords. Item number 2, 3 and 4. This office proceeding so and so, dated, addressed to so and so, and the predecessor of the petitioners. Then, my lords, letter dated so and so, of so and so. This is the, my lords, person who claims ownership right on the assigned land. My lord, her wife, my lord, has already secured, my lords, 42 acre 11 cents.
ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ.
ಆಯ್ತು, ಅವರನ್ನು ಬಿಟ್ಬಿಡೋಣ. ಈಗ 26 ಎಕರೆ 87 ಸೆಂಟ್ಸ್ ಇದೆ. ಅದರಲ್ಲಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ notified that we are in possession of 2 acre 26 cents. Subsequently, my lords, proceedings were initiated. Kindly see, my lords, annexure E. The Tashildar himself issued notice us to make an application. We have, my lord, our predecessor made an application. Subsequently, revenue assessments have been collected by the revenue officials. I have produced the documents.
TB Shetty is not relinquished.
My lord, he has not relinquished, but on the other hand, he has sought for confirmation of ownership right on the land without evicting me. My lords, he should have initiated a proceedings to evict me. Admittedly, my lords, we are in possession as per the report of the revenue. Please.
If this order is taken into consideration, you are
Yeah.
aware of the fact that the land was granted to PB Shetty.
Yes, my lords. Yes.
Challenge that at all. How do you get over that?
my lord, kindly see, my lords, kindly see. I am, my lord, ignoring the said order, my lords. I am in settled possession.
I can't ignore this order. That is a problem.
Suppose, my lords,
You cannot ignore this order.
my lord, that order, my lords, that order says, that annexure D says, I should be conferred with the right on the land 2.26 acres.
Subject to BB Shetty relinquishing his rights.
Yes, that is, my lords,
Suppose-
kindly, he was,
Suppose it is not done.
my lord, kindly see,
You
my
can
lords,
never get title.
my lord,
You can never get title.
my lord, I will get the title because
Okay,
continuous possession.
He may even now file a suit for possession and maybe succeed.
Yes, yes,
First,
yes,
but you will never get title.
yes. My lord,
In
if
which
he
question of-
files a suit, I have my own defense, my lords knows. Oh, I can resist the suit. On the other hand, kindly see the steps taken by the revenue officials, my lords, revenue department. Kindly see, I will point out, my lords.
You are seeking for review of an order passed by this court.
Yes, my lords.
What does this order
My lords,
score?
that is, my lords, by virtue of that, my lords, now the deputy commissioner is evicting me
That's why I
by
said,
implementing the order.
until that order, the deputy commissioner was challenged. You had no right at all.
Kindly see, my lords, subsequently there are proceedings. That is why, my lords, I am come up with the records, my lords, before this on court. Kindly see, annexure, my lord, E1, page number 86. It is the application filed by the person in possession, my predecessor, in terms of the notice issued by the Tashildar, my lords, way back in the year 1975. Then, my lord, the Tashildar used to collect the
We are talking about 61.
61,
The order is BB Shetty was granted land way back in the 61.
61.
And you are aware about this.
Yes.
And yet you don't challenge this order.
My lord,
You thereafter
my lord,
make
I
an-
have challenged the order. Deputy Commissioner directed the Tashildar to secure the assignment, my lord, secure the my lord, relinquishment deed from the assignee, but his ownership right is not confirmed. Now, my lord, he will be conferred with the ownership right with the possession. Therefore, my lord, before passing such an order, I should be heard, because kindly see, my lords, other documents, annexure H for a kind perusal, my lords, kindly see annexure H, page number 133. 133. Page number 133, my lords. The land was sought to be reserved for, my lords, rehabilitation of the Mulki Dam property losers, my lords, where the official says that, my lords, these properties are the very same 868 acres, my lords, 97 cents, 99 cents, assigned in favor of husband and wife. Then, my lords, the revenue officials noted that ಸದರಿ ಭೂಮಿ ಗೇಣಿಗೆ ಪಡೆಕೊಂಡವರು ಒಬ್ಬರು ತೀರಿಕೊಂಡಿದ್ದು, ಅವರ ಹೆಂಡತಿ ಇನ್ನೊಬ್ಬ ಗೇಣಿದಾರರಾಗಿದ್ದು, ಅವರು ಊರಲ್ಲಿ ವಾಸ್ತವ್ಯ ಇಲ್ಲದೆ ಗೇಣಿ ಕೊಟ್ಟ ಸ್ಥಳವನ್ನು ಈಗಾಗಲೇ ಬೇರೆಯವರು ಆಕ್ರಮಣ ಮಾಡಿದ್ದು, ಅಲ್ಲದೆ ಗೇಣಿ ಷರತ್ತದಂತೆ ಗೇರು ಮರ ಬೆಳೆಸದೆ ಷರತ್ತ ಉಲ್ಲಂಘಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಗೇಣಿಯನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ. The assignments were cancelled. Subsequently, my lords, the annexure your lords may kindly see page number 160. 160, my lords. This is the report submitted by the Tashildar when, my lords, so the respondent number 5 sought for confirmation of ownership right based on the assignment. Page number 160, my lords. Relevant para, my lords, page number 161. Middle portion. ದಿನಾಂಕ 12/6.
ಪೂರ್ತಿ ಓದ್ಬೇಡಿ 160.
Please, my lords.
ಪೂರ್ತಿ ಓದಿ page 160.
Please. Page 160. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಗೌರವಾನ್ವಿತ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಬಿಬಿ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಗೇರು ಕೃಷಿಗೆ ನೀಡಲಾದ ನಿಟ್ಟೆ ಗ್ರಾಮದ 361 ಹಾಗೂ ಇತರ ಬಾಬ್ತು ಖಾತಾ ಬದಲಾವಣೆ ಮಾಡಲು ಈ ಕೆಳಗೆ ತಿಳಿಸಿದ ಕಾರಣಗಳಿಂದ ಪ್ರಕೃತ ತೊಡಕಾಗಿದೆ ಎಂದು ಕಡತ ಪರಿಶೀಲನೆ ಕಂಡು ಬಂದಿದೆ. ಸೊ ಅಂಡ್ ಸೊ ನಿಟ್ಟೆ ಗ್ರಾಮದಲ್ಲಿ ಈ ಕೆಳಗೆ ತಿಳಿಸಿದ ಜಮೀನನ್ನು ಗೇರು ಕೃಷಿಗೆ ನೀಡಿರುವುದು ಕಂಡು ಬಂದಿದೆ. 26 ಎಕರೆ 87 ಸೆಂಟ್ಸ್. ಸದರಿ ಜಮೀನುಗಳಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡದೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಅಸಾಧ್ಯವಾಗಿದೆ. ಉಲ್ಲೇಖ 1ರ ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 28/8/2008 ಆದೇಶದಲ್ಲಿ 28/2/2002 ಶ್ರೀಮತಿ ಗುಲಾಬಿ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿ 6 ತಿಂಗಳೊಳಗೆ ಇತ್ಯರ್ಥಗೊಳಿಸಬೇಕೆಂದು ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. 28/2/2002 ಮನವಿ ಬಗ್ಗೆ ದಿನಾಂಕ 35/2002 ಈ ಕಚೇರಿಯಿಂದ ಉತ್ತರ ನೀಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಅಲ್ಲದೆ 26/4/2007 ತಮಗೆ ಈ ಕಚೇರಿಯಿಂದ ಪತ್ರ ಬರೆದಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ದಿನಾಂಕ 5/5/2007 ಈ ಕಚೇರಿಯಿಂದ ಭೂಮಾಪಕರಿಗೆ ಜಮೀನಿನ ಅಳತೆ ನಡೆಸಲು ಜ್ಞಾಪನ ಪತ್ರ ನೀಡಿ ಪ್ರತಿಯನ್ನು ತಮಗೆ ಕಳುಹಿಸಿ ತಮಗೆ ಮಂಜೂರಾದ ಜಮೀನಿನ ಗಡಿ ಗುರುತಿಸಲು ಸಹಕರಿಸುವಂತೆ ವಿನಂತಿಸಲಾಗಿರುತ್ತದೆ. ಸೂಚನಾ ಪತ್ರ ನೀಡಿ ದಿನಾಂಕ 12/6/2007 ತಮ್ಮ ಸಮಕ್ಷಮದಲ್ಲಿ ನಡೆಸಿದ ಅಳತೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಕಂಡು ಬಂದಂತೆ ಮೇಲ್ಕಂಡ ಜಮೀನುಗಳು ಬಗ್ಗೆ ಶ್ರೀಮತಿ ಶೋಭಾ ದ ಪಿಟಿಷನ್ ನಂಬರ್ 1, ಶ್ರೀಮತಿ ಸುನಂದ ಪಿಟಿಷನ್ ನಂಬರ್ 2 ಹಾಗೂ ಗಿರಿಜಾ ಪೂಜಾರ್ತಿಯವರು ಎಂಬುವರು ಆಕ್ರಮಣ ಮಾಡಿ ವಾಸದ ಮನೆ, ತೆಂಗು, ಭತ್ತದ ಕೃಷಿ ಮುಂತಾದ ಅಭಿವೃದ್ಧಿ ಮಾಡಿ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಕಾಯ್ದೆಯಲ್ಲಿ 94A ಅನ್ವಯ ಆಕ್ರಮಣ ಸಕ್ರಮಣಕ್ಕಾಗಿ ನಮೂನ 50ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಅದು ತನಿಖಾ ಹಂತದಲ್ಲಿ ಇರುವುದು ಕಂಡುಬಂದಿದೆ. ಈ ಆಕ್ರಮಣಗಳಿಗೆ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ಕಾನೂನಿನ ರೀತಿಯಲ್ಲಿ ನೀವು ಈ ಕಚೇರಿಗೆ ಬರೆದ ಪತ್ರದಲ್ಲಿ ಆಪಾದನೆ ಮಾಡಿರುತ್ತೀರಿ. ಆದರೆ ಸದರಿ ಜಮೀನನ್ನು ಯಾವ ಉದ್ದೇಶಕ್ಕಾಗಿ ತಮ್ಮ ತಂದೆಯವರಿಗೆ ಮಂಜೂರಾತಿ ಮಾಡಲಾಗಿತ್ತು ಆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸಮರ್ಪಕವಾಗಿ ಬೇಲಿ ಆವರಣ ಹಾಕಿಕೊಂಡು ಗೇರು ಕೃಷಿ ಮಾಡುತ್ತಿದ್ದಲ್ಲಿ ಈ ರೀತಿಯ ಆಕ್ರಮಣವಾಗಲು ಸಾಧ್ಯವಾಗುತ್ತಿರಲಿಲ್ಲ. ಗೇಣಿಗೆ ಪಡೆದ ಜಮೀನು ನಿಮಗೆ ಕಾಯಂ ಆಗಿ ಸಾಗುವಳಿ ಚೀಟಿ ಪಡೆಯುವವರೆಗೆ ಅದನ್ನು ಆಕ್ರಮಣವಾಗದಂತೆ ರಕ್ಷಿಸುವ ಜವಾಬ್ದಾರಿ ತಮ್ಮದು ಕೂಡ ಆಗಿರುತ್ತದೆ. ಹೀಗೆ ಏನಿದ್ದರೂ ನಮೂನ 50ರ ಅರ್ಜಿ ಅಕ್ರಮ ಸಕ್ರಮಣ ಸಮಿತಿಯಲ್ಲಿ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೆ ಮೇಲೆ ತಿಳಿಸಿದ ಜಮೀನುಗಳ ಸಾಗುವಳಿ ಚೀಟಿ ತಮ್ಮ ತಂದೆಯವರ ಅಥವಾ ವಾರಸುದಾರರ ಹೆಸರಿಗೆ ಮಂಜೂರು ಮಾಡಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ತೊಡಕಾಗಿದೆ. Therefore, not
So you are basically now seeking for regularization of a land which is assigned to BB Shetty.
assigned,
So
but
can
prior to that, not we were in possession. Yes, yes, I understand.
And how can you get that regularization done?
Lord,
If it's already granted to somebody,
Lord,
unoccupied lands can be granted.
kindly see, Lord, the finding of the revenue officials is that,
By accepted argument from what I understand.
yes,
If the application for regularization is granted,
yes.
it virtually amounts to nullifying the grant made in favor of BB Shetty.
No, Lords, kindly see, Lords, 30 years assignment, it is a temporary grant.
How can the committee
Yes,
consider regularization of a land
yes,
which is already assigned to somebody else?
that is cancelled.
Basically, you are asking for regulation of your unauthorized occupation in respect of somebody else's land, not.
That is
somebody-
cancelled. Assignment was cancelled. That was called in question before the KAT. KAT allowed the appeal.
What is the effect of the KAT allowing the appeal?
Lords, in the sense, Lords confirm, that is also questioned in this present writ petition because we are not the party. The said order is not binding on us. Kindly, however, Lords, we have challenged the same order in the present writ petition because we were never arrayed as a party, though the successors of the assignee were well within the knowledge of the fact that we are in possession. Therefore, Lord, our protection should be protected. Suppose, Lord, all,
Argument held against you. You were aware the land was being assigned to BB Shetty.
yes,
There was an order of the Deputy Commissioner year 61.
yes,
Thereby, the special action was to relinquish.
we were not dispossessed.
You were a party, so then same argument can be held
Yes,
against
Lord,
you.
we have been, Lord, it is my appeal before the Deputy Commissioner earlier in the year 1961. The Deputy Commissioner found that I am in possession. But as before confirmation of the assignment, granting ownership right, I should be evicted, number one. Number two, or else the assignment cannot be made as a permanent assignment. Therefore, my possession should be protected, not till disposal of our application.
The orders of the KAT
Yes,
and which was confirmed by this court
yes.
are not actually challenged.
Lord,
What you are ultimately doing now is you are challenging the last of the orders.
No,
Ultimately
no, no,
directing
Lord,
the implementation.
No,
of-
there was no order of this honorable court directing, Lords, earlier there was no order, only mandamus to consider the representations.
The order that you are seeking for review is this.
Yes,
The respondent state cannot circumvent the order of the KAT
yes,
in appeal number so and so in taking shelter under draft rules.
yes,
Thus petitioners have made out a case so as to interfere with the orders of the Deputy Commissioner Udupi, bearing number so and so.
yes,
Accordingly, they are set aside. Respondent one Deputy Commissioner is hereby directed to implement the order
yes,
dated 23/2015
yes.
passed with the KAT.
That is
So you
challenge.
are in effect challenging the order of the KAT.
Yes, I have challenged it, Lords. The second prayer is annexure, Lord, annexure B, the order of the KAT, where we are not the parties. Therefore, Lords, kindly see, Lords, prayer, my prayer, Lords. Annexure A, Lords, annexure B, certiorari quashing the order dated so and so, passed by the Karnataka Appellate Tribunal. Kindly see the order of the Karnataka Appellate Tribunal. Since, Lords, the other applicant assignee was conferred with the ownership right, in the sense mother of the respondent number 5 and 7, the father of the respondent number 5 and 7 also required to be issued with the permanent ownership right. That is the finding of the KAT, Lords. There is no, virtually there is no reasoning because there are two assignment. One assignment is made as a permanent in respect of mother. Yes,
Assuming KAT's order is set aside,
yes.
the temporary grant which BB Shetty revives.
No, it is cancelled, Lords. By that is why, Lords.
No, the prayer is
Yes,
where the respondent has rejected the application filed by the first applicant for permanent grant, the respective land bearing number so and so.
yes.
That is page number 31.
30 minutes, sir. page number 30. Yes, Manoj, yes.
So basically BB
So
Shetty.
in the sense, the deputy commissioner has cancelled the assignment. That was called in question before the KET.
Deputy Commissioner rejected the plea for a permanent grant. Even if that is, if that appeal is dismissed,
No.
the temporary grant would revive.
No. Temporary grant is cancelled because there was no proper cultivation and allowed the other persons to occupy. That is the finding of the deputy commissioner in refusing to, it is already cancelled. The deputy commissioner holds that he has no right to continue. He has no right to seek any permanent ownership because the assignment spent itself. Because there was no cultivation. A person who has to cultivate the land to which not it was granted, assigned. He has not cultivated. He has not raised any cultivation. Therefore, he has allowed us to continue in possession. It is not after 1990 or 1995 or 2000. It is way back in the year 1958. My father's application was.
My
Yes,
difficulty that I think will happen is you were in occupation of a land which was temporarily assigned in favor of somebody.
Yes.
So it is not a government land that you are in unauthorized occupation for you to get the benefit of regularization. Seek for regularization. Seek for regularization of government land.
Yes.
Which is in the.
It is cancelled. It is vested with the government. Kindly see the order of the deputy commissioner cancelling the assignment.
Don't appreciate.
Please.
Your application for regularization is in respect of a land which is assigned to somebody else already.
That is my application. As on the date of application, the assignment was cancelled based on my possession. Assignment was cancelled. Therefore, the deputy commissioner refused to.
Ultimately, that order.
Now it is revived by virtue of the order of the KAT.
Year 2015.
Yes, it is revived.
So therefore.
Where we are not the parties. The delay, limitation, we are not the parties.
You don't say. ನೀವು ರೆಗ್ಯುಲೈಸೇಷನ್ ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ.
ಅಲ್ಲಲ್ಲ, ನಾನು ರೆಗ್ಯುಲರೇಷನ್ ಮಾಡಬಹುದು. ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಅಸೈನ್ಮೆಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ. ಅಸೈನ್ಮೆಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಗಿರೋದ್ರಿಂದ ಪರ್ಮನೆಂಟ್ ಅಸೈನ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಡಿ ಸಿ ಅವರು ಹೇಳ್ತಾರೆ. ದಟ್ ವಾಸ್ ರಿವರ್ಸ್ಡ್ ಬೈ ದಿ ಕರ್ನಾಟಕ ಅಪೆಲೇಟ್ ಟ್ರೈಬ್ಯುನಲ್, followed with the order of this honorable court to implement the order of the Karnataka Appellate Tribunal. Once I challenged the order.
You're basically trying to set aside an order passed near 2015.
Yes, because we are not the parties. See, the delay may not arise. Having noticed that we are in possession, the revenue officials have reported that these properties are with the persons who are occupied and filed applications. Should he not made us as a party before the tribunal? I am raising a question to me.
It was open for the deputy commissioner to have made you a party in those proceedings.
Deputy commissioner should have brought to the notice of the revenue tribunal that these properties never not appeared. Virtually,
the total extent of granted to him.
26 acres 87 cents. We are in 2 acre 26 cents. Of course, our application is for higher extent. Of course, we can protect our possession with respect to 2 acre 26 cents. Even the other side, who has got 42 acre 11 cents in the name of mother, 26 acre 87 cents.
ನೀವು ಯಾರ್ದೋ ನೀವು ಕೂತ್ಕೊಂಡಿಲ್ವಾ?
ಅಲ್ಲ, ಯಾರ್ದೋ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿದ್ರೆ provision is made, section 94A, 94B, 94C. Now, we are made to file form number 57. Government from time to time amending the laws. Therefore, to protect the interest of live and let live ಬೇಕು ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. Kindly see the photographs I have produced.
Issue notice to R5 to R7. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಗೊತ್ತಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ, ಪೊಸಿಷನ್ ಡೆಲಿವರಿ ಆಗಿಲ್ಲ. ನಮಗೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಮನ್ನು ಡಿಸ್ಪೋಸಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ನಾವು, ಯಾಕಂದ್ರೆ ನಿಮಗೆ ಗ್ರಾಂಟ್ ಇಲ್ಲ, ಅವರಿಗೆ ಗ್ರಾಂಟ್ ಆಗ್ಲಿಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಬಂದಿದೆ, ಅದರ್ವೈಸ್ ವಿ ಮೇ ಹ್ಯಾವ್ ಟು ಫೇಸ್ ಕಂಟೆಂಪ್ಟ್ ಅಂತ.
Have it next week. Get instruction with them. Release on so and so.
Till then,
take out
on
respondents 5 to 7 personally in addition to payment of process.
Number 21.
Day of disposition ಅಲ್ಲಿ ತನಕ ಬೇರೆ ಏನು ನಾನು ಕೇಳಲ್ಲ ಅಷ್ಟೇ.
I want to know what exactly is the status, and if they are prepared to give them title deeds to the exclusion of this 2 acres 27 acres, I'll consider.
Please.
So next week I'll ask them at what stage that is.
Please.
I'll pass an order.
Please. Because we were not the parties in all the procedures. ಅದಕ್ಕೋಸ್ಕರ
Yeah, the-
ಬೇರೆ ನಮಗೆ ಬೇರೆ ಮಾಹಿತಿ ಕೊಡಲ್ಲ ಅವರು.
I'm not very impressed with that.
ಇಲ್ಲ ಇಲ್ಲ
My only concern is that 2 acres somehow you
ಆಗ್ಬೋದು,
possession.
ಆಗ್ಬೋದು.
ಅವ್ರ ಪರ್ಸನಲ್ ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡು ತಗೊಂಡ್ ಬನ್ನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡೋಣ ಅವ್ರು.
ಆಗ್ಬೋದು.
So number 21,
Observe.
Sriram.
ಮಚ್ಚ.
Because I'm a medical institute. I have provided service to
What
the
is the next
government.
one?
Mullets, I have provided services to the government during COVID, Mullets. I had conducted COVID tests, total amounting to rupees 11 crores odd. 7 crores has been paid by the government, but 4 crores till now has not been paid. Annexure A is the letter sent by the District Surveillance Office, Mandya.
Remove the encroachment.
Mullets,
Remove the encroachment.
encroachment.
ಯಾವ್ದು ಕೊಟ್ರು?
Writ petition number 8564 of 25,
ಯಾವ್ದು ಕೊಟ್ರು?
serial number 21,
8613.
8564.
There is a confusion.
Matter,
Mullets.
8613 next.
8564.
Writ petition 8564.
Rajman. 8564.
8564 of 25.
It is Adichunchanagiri Institute of Medical Sciences.
Petitioner.
P. Venugopal.
There is a caveator also, but I am not able to understand because it is a GM rest matter.
8564. Here it is shown as P. Venugopal is the petitioner.
Illa sir. Petitioner is Adichunchanagiri Institute of Medical Sciences.
They'll verify because the number, the names don't tally.
Yes,
You have the same number 8564 given.
I
to you?
have the same
Yes,
number
madam.
bullets, but the
I am also saying 8564, madam.
These four. Paper number ಏನಿದೆಯಾ?
FR number 8561 months.
You got the wrong file.
Yes, ma'am.
It has to be classified as GM RS, madam.
Like,
It has to be GM rest.
Yeah.
months.
8564.
like there are P. Venugopal and other, it relates to KLR only. Removal of some encroachment on a pathway.
ಅದು ಗೊತ್ತಿಲ್ಲ, ಇದು writ petition number 8564, they are
Mostly ಈ
seeking for
number-
payment of bills.
ಈ ನಂಬರ್ ತಪ್ಪು ಕೊಟ್ಟಿದ್ದಾರೆ.
Number ತಪ್ಪು.
I'll call it at 2:30. We'll sort out this.
Please.
Till number 22, Sri Vijay Krishna Bhatt.
Krishna. For order. But for mandamus mill. But annexure B is the order passed by the special deputy commissioner.
Intended. AJ accept notice for respondents released.
To implement their own order. mill.
Let me get instructions.
23 adjourned, number 24. Sarvana S.
Password, madam. Please. Watch.
For orders, seal number 25, Sri RB Sadashivappa.
Lord, subject matter may not be land bearing survey number 21.
ಯಾರಿಗೂ ಸರ್ವೆ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, ಇದು 1975 ಅಲ್ಲಿ land tribunal granted occupancy right. Thereafter, my lord, the revenue records affected in favor of the petitioners after, my lord, issuance of the form number 10. All of a sudden, my lord, on the instigation of the respondent 4 to 7, the revenue records, my lord, without issuing any notice to the petitioners, it was affected in favor of the temple. That the same has been called in question before the assistant commissioner, my lord. Assistant commissioner.
They not served.
ಅದೇ ಅದು ನೋಟಿಸ್ ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಏನೋ ಹಿಯರಿಂಗ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಅಂತ ನನ್ನ ಕೊಲಿಗ್ ಹೇಳಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರೋಸೆಸ್ ಐ ಹ್ಯಾವ್ ಪೇಡ್ ಲಾಂಗ್ ಆನ್ ದಿ ಫಸ್ಟ್ ಡೇಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಮೈ ಲಾರ್ಡ್.
What is annexure F?
Annexure F, ಇಲ್ಲಿ ಏನು annexure B, my lord, the appeal filed before the assistant commissioner. The findings recorded by the assistant, annexure B, ink page number 18, my lord, for a moment kindly turn into internal page 5. Last para, ಮೇಲ್ಮನವಿದಾರರು ತಹಸೀಲ್ದಾರ್ ಅವರ ಸದರಿ ಆದೇಶ ಅಂದ್ರೆ ನಾನೇ ಪೆಟಿಷನರ್ಸೆ ಸದರಿ ಆದೇಶವನ್ನು ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಪ್ರಶ್ನಿಸಿದ್ದು ಅಂದರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 18 ಇಂಟರ್ನಲ್ ಪೇಜ್ 5 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. ಮೇಲ್ಮನವಿದಾರರು ತಹಸೀಲ್ದಾರರ ಸದರಿ ಆದೇಶವನ್ನು ಈ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಪ್ರಶ್ನಿಸಿದ್ದು ಅಂದರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ನಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ದಾವಾ ಜಮೀನಿನ ಹಕ್ಕು ನೀಡದೇ ಇದ್ದರೂ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿದ್ದನ್ನು ತಹಸೀಲ್ದಾರರು ತಿದ್ದುಪಡಿ ಆದೇಶದ ಮೂಲಕ ಸರಿಪಡಿಸಿರುವುದು ತಾಂತ್ರಿಕವಾಗಿ ಸರಿಯಾಗಿದ್ದರೂ ನಿಯಮಾನುಸಾರ ಮ್ಯೂಟೇಷನ್ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳೇ ಸೂಕ್ತ ಪ್ರಸ್ತಾಪನೆಯನ್ನು ಸಲ್ಲಿಸಿ ಆದೇಶವಾದ ನಂತರ ಮ್ಯೂಟೇಷನ್ ಕ್ರಮ ಜರುಗಿಸಬೇಕಾಗಿತ್ತು. ಅದಾಗೂ ಹಕ್ಕು ಹೊಂದಿರದ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ದಾವಾ ಜಮೀನಿನ ಖಾತೆ ಆಗಿದ್ದನ್ನು ಈಗಾಗಲೇ ತಹಸೀಲ್ದಾರರು ವಜಾಗೊಳಿಸಿ ಮೂಲ ದಾಖಲೆಯಂತೆ RTCಯಲ್ಲಿ ನಮೂದಿಸಿರುವುದು ಆಡಳಿತಾತ್ಮಕ ದೃಷ್ಟಿಯಿಂದ ಅಂಗೀಕರಿಸಿ ತಹಸೀಲ್ದಾರ್ ಆದೇಶವನ್ನು ಎತ್ತಿ ಹಿಡಿಯುವುದು ಸೂಕ್ತವಾಗಿದೆ. My lord, the order passed by the Tahsildar, revenue entries, without issuing any notice, without holding any inquiry, my lord, the affected in favor of the temple. The same has been called in question before the third respondent, though the third respondent, my lord, the findings recorded, it is not correct. But it is for the administrative reason, my lord, the order passed by the Tahsildar is correct.
But he says that you were granted land.
Illa, grant agide, my lord, based on the grant itself, my lord, the revenue records were effective.
ಅಲ್ಲ, he has recorded ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ದಾವಾ ಜಮೀನು ಹಕ್ಕು ನೀಡದೇ ಇದ್ದರೂ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿದ್ದನ್ನು ತಹಸೀಲ್ದಾರ್ ತಿದ್ದುಪಡಿ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ,
ವೇರ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್?
It is not in a position to, I may permitted to pass both the order as well as the form number 10. ಫಾರ್ಮ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಈಗ ಏನ್ ಮಾಡ್ತಾರೆ, ನಂದು 21 ರೌಂಡ್ ಅಪ್ ಮಾಡಿ 17 ಅಂತ ಬರೀತಾರೆ ಅವರು. ನನಗೆ ಇಶ್ಯೂಯನ್ಸ್ ಆಗಿರೋದೇ ಅವೆರಡು ಸರ್ವೆ ನಂಬರ್ 5 and 21.
ಏನ್ ತಿದ್ದುಪಡಿ ಆದಂಗಿದೆ ಇದು?
ತಿದ್ದುಪಡಿ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಈಗ ನಾವು ಆಫ್ಟರ್ ದಿ ಪರ್ಸೆಂಟ್ ಟು ದಿ ಆರ್ಡರ್, now it is a round off, my lord, by the office of the Tahsildar, by the original land tribunal order. It is not in a readable, my lord. The original order passed by the land tribunal.
Tahsildar order, my lord, it says it has been rejected, no grant.
Anyhow, my lord, the revenue records, my lord, stood in the name of the petitioners. Father of the name of the father of the petitioner, after his demise, my lord, in the name of the petitioner.
Petition copy on vacant and appeal, sir.
ಏನಿಲ್ಲ, ರಿಮ್ಯಾಂಡ್ my lord, if the matter is remanded before the very same Tahsildar, my lord, they will place all the material.
Yes. Yes.
Or my lord, the directly, my lord, the secure the original records, my lord.
ಆರ್ಡರ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 5 and 17 ಅಂತ ಇದೆ ಮೇಡಮ್.
We don't know, my lord, it is Tahsildar.
To secure the land tribunal records in case number
164/75-76.
decided by the land tribunal of HT Kota village. List.
Notice, my lord, already, my lord, the process has paid.
Number 26.
I appear for the petitioner, my lord. My lord, the petition,
Objections.
office objection ಅಂದ್ರೆ annexure A, ಅದ್ application it has been granted as per annexure B. Typed copy ಕೊಡ್ತೇನೆ, but annexure D original ಹಾಜರ್ ಮಾಡಿಲ್ಲ ಅಂತಾರೆ. annexure D merged with annexure F, my lord. Joint registrar ಮುನ್ನ ರಿವಿಷನ್ ಹೋದೆ, ಅಲ್ಲಿ ಮರ್ಜ್ ಆಗಿದೆ. annexure D I can't produce it, my lord. annexure D ನಲ್ಲಿ, my lord, what happened, my lord, as per annexure B, land has been granted to me, and then survey was done.
What is the order that you are challenging?
ಯಾವುದು?
What is the order that you are challenging?
annexure D and E.
D and F, my lord. Annexure D is order passed by the second respondent, cancelling the survey made by the Taluka surveyor without hearing the parties who are who have been benefited by that survey. This order I have challenged. The ground mentioned in the impugned order is that while Taluka surveyor surveying the land made a mention application number 883, which is referable to survey number 25. Annexure D, page number 26, minute. Order, impugned order.
This without notice to them?
Without notice, sir. Annexure C ನನ್ನ ಹೆಸರಿದೆ. He presumed, my lord, what happened? Application number 883 mention ಆಗಿದೆ.
What does the deputy commissioner do?
ಯಾವುದು?
Deputy commissioner ಏನ್ ಮಾಡಿದಾರೆ?
ಅಲ್ಲ, ಇದು ಆರ್ಡರ್ ಆಗಿದ್ದು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫಸ್ಟ್.
How does the DC deal with this? How does the DC deal with this particular point that you had not been notified?
ನೆಕ್ಸ್ಟ್ ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಮುಂದೆ ರಿವಿಷನ್ ಬಂದಾಗ ಮತ್ತು ಅವರು ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಮುಂದೆ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಲ್ಯಾಂಡ್ ರೆಕಾರ್ಡ್ಸು ಅವ್ರು ಕೊಡೋ ರೀಸನ್ ಏನಂದರೆ ದೇ ನೆವರ್ ಆನ್ಸರ್ ಮೈ ಪಾಯಿಂಟ್, ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಬೀನ್ ನೋಟಿಫೈಡ್. But they say that, my lord, the earlier survey done in response to an application number 883 in respect of survey number 25. Therefore, that order is wrong. They never understood the annexure G is my application is there for 24 hours.
Take notice.
AG accepts notice for respondents. 1 to 3. Issue notice to R4.
Annexure D to be stayed, my lord.
What is annexure D? Cancelling?
D cancelling the earlier survey. While
If I do
doing
that-
annexure D,
If I do that, the further directions for them to conduct an investigation.
ಅಲ್ಲ, ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ದಿಸಾಂಬಲ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಇಶ್ಯೂಡ್ ಡೈರೆಕ್ಷನ್ ಟು ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ಆಲ್ ಪೀಪಲ್ ಅಂಡ್ ಕಂಡಕ್ಟ್ ದಿ ಸರ್ವೆ. ಅದು ಆಗ್ತಾ ಇದೆ, ನಮಗೂ ತೊಂದರೆ ಇಲ್ಲ. ಈ ಅನ್ನೆಕ್ಷರ್ ಡಿ ಪ್ರಕಾರ ಆ ಹಳೆ ದಟ್ ಆರ್ಡರ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಮೇಲೆ ದಿಸಾಂಬಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ 48 ಮೇಲೆ.
ಮತ್ತೆ ಸ್ಟೇ ಮಾಡೋದು ಬೇಡ ಬಿಡಿ, ಅದು ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಇದು ನಿಲ್ತೋಗುತ್ತೆ.
ಆಯ್ತು, ಈಗ ತಾವು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರಾದ್ರೂ ನನ್ಗೆ ಅಷ್ಟೇ ಸಾಕು. ಏನಂತ ಅಂದ್ರೆ ಸಿನ್ಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ಲೆಟ್ ದಿ ಸರ್ವೆ ಬಿ ಕಂಡಕ್ಟೆಡ್ ಅಂತ ಹೇಳಿದ್ರು ಸಾಕಾಗುತ್ತೆ.
Why are you filing the writ petition?
ಅಲ್ಲ, ನನಗೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈ ಆರ್ಡರ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತಾರೆ. ಅನ್ನೆಕ್ಷರ್ ಡಿನೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬೇಕು ಅಂತಿದ್ದಾರೆ ಅವರು, ವಿತೌಟ್ ರೆಫರಿಂಗ್ ಟು ಆರ್ಡರ್ ಆಫ್ ದಿಸಾಂಬಲ್ ಕೋರ್ಟ್.
If a fresh survey is being conducted as per annexure J.
ಈಗ ತಾವು ನೋಟಿಸ್ ಕೊಟ್ಟರು ಅಡ್ಡಿಲ್ಲ ಸರ್, ನೋಟಿಸ್ ಕೊಟ್ಟು ಬಂದು ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ.
Get in.
Ultimately,
Page number 24, my lord, the notice was issued.
ಯಾರಿಗೆ 24?
24 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಪೇರ. ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ತೀರ್ಥಹಳ್ಳಿ ತಾಲೂಕುರವರು ಸಲ್ಲಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಮತ್ತು ಲಾಸ್ಟ್ ಪೇರ. ಅರ್ಜಿದಾರರ ದೂರನ್ನು ಪರಿಶೀಲಿಸಿ ವಿಚಾರಣೆಗಾಗಿ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಿ ವಿಚಾರಣಾ ಹಾಜರಾಗುವಂತೆ ದೂರುದಾರರಿಗೆ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟ ಭೂಮಾಪಕರು, ತಪಾಸಕರು ಹಾಗೂ ವಿಚಾರಣೆ ತಿಳಿಸಿ ತಿಳುವಳಿಕೆ ಜಾರಿ ಮಾಡಲಾಗಿದ್ದು ಅದರ
ಸರ್ವೆ ಫಸ್ಟ್ ಯಾರು ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ರು.
That is the complainant.
ಕಂಪ್ಲೇನೆಂಟ್ ಮತ್ತು ಸರ್ವೆ ಮಾಡಿದವರಿಗೆ.
If you were to make a statement that pursuant to annexure J, you conduct a survey after notifying him, I'll clarify that this order will not be considered as binding rights of the parties. The survey that you propose to conduct will determine the rights of the parties. Because here if you have decided something without notice to him.
Yes.
And in this survey that you conduct, if you say that, no, you already decided in your case, therefore I won't do anything.
Will take notice of it.
ನೋಟಿಸ್
You there are for a private party or
R4 private notice order. 1 to 3 you notice told.
You make the statement, I'll simply adjourn it, make the statement. List. 1st April, sir.
Date is on.
1st April.
Number 27.
In this matter, my lord, on
Preparing
12/3/2025, my lord.
10 days time for conducting the podium.
12/3/2025, my lord, this court directed to complete the podium durust within a period of 10 days, my lord. Since the records are not available, my lord, we have sent a letter to the committee, my lord, to reconstruct the records, my lord. May I make one submission, my lord? If the petitioner provides the certified copies of all the documents, we will take immediate action, my lord.
ಕೊಡ್ತೀರಿ ಅಂದ್ರೆ
Time will be saved for the petitioner also, my lord.
There, the Tahsildar report, kindly see the minute.
ಅವ್ರು ಕೇಳಿದ ಅರ್ಥ ಆಯ್ತು.
Report has submitted to DC. Minute, all records, minute.
ನೀವು ಏನ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ರೆ ಅವ್ರು ಪೊಡಿ ದುರಸ್ತಿ
Immediate
ಮಾಡ್ತಾರೆ ಅಂತ
ನಮ್ಗೆ
ಕೊಡ್ತೀರಾ
easy
ನೀವು?
Yes, minute, in my custody, minute, I will file all the documents.
The DGA submits that the podi and durasti as ordered on 12/3/2025 could not be carried out because the records were not available. And a letter in this regard has been addressed to the Reconstruction.
Reconstruction.
He also submits that if the petitioner were to furnish all the certified copies in his possession, the same would be examined and a podi and durasti would be conducted on the basis of those documents. Then counsel the petitioner submits that the petitioner would produce all the certified copies that are in his possession to enable the authorities to take appropriate action. They are directed to do so within a period of 1 week. Relist on 2 weeks on date.
7th.
Please.
Number 28. Madhusudan Rao.
Petitioner.
R6 to R9.
My lords, they are the private respondents, my lords, adjacent landowners. Are,
Stated that Messrs.
my lords, weeks time.
Karneshwara, Mrs. Law and Company have put up bills for R6 and R7. Office to change their name. R8 and R9.
My lords, weeks time, my lords, course of the day, I'll correct the notice and in weeks time, I'll ensure that it is served, my lords.
The extent is granted. In respect of fitting service on R8 and R9. I had permitted you personal service.
My lords, there was an oversight. Date may be fixed, my lords, in weeks.
First serve and then,
My lords, date, my lords, 10 days, my lords.
you first serve and then move, I'll take it up.
Number 29. Days.
Case, the notice was ordered to R1.
Who's R4 and R6?
R4 is the person who is said to have entered into an agreement with our respondent number 3. The contesting respondent hearing.
Service ಮಾಡಿ ಅವ್ರಿಗೆ.
So respondent number 3 is, respondent number 5 who has entered in appearance, she is the contesting one. She says she has got agreement from Balaraj, that is the respondent number 4.
Then why are you making R4 and R6 party? You don't want them.
They are not actually necessary parties. I mean, I'll file a
Him
memo.
choice. If you were to delete them, you do so at your risk.
She has filed, in fact, revision petition under section 136(3),
Or R4, huh?
R5. She has entered in caveat.
Who appears for them?
I think Mahendra advocate appeared last time. Revision petition was filed by her against
R4?
R4 is person who is said to have entered into an agreement with R5 for selling this particular property in her favor. And she has filed a suit, etc. That is what their contention.
R6?
R6, my lord, one of the legal heir of petitioner's father, that is Timothy Stella Marias. Petitioner's husband, Arugya Swami, daughter, correct.
Balraj is your brother.
No, he is nothing to do with our family at all. He is claiming that he is one of the, he is the legal heir of Arugya Swami. There is some dispute and he has not come forward filing any suit, etc.
Take out personal service, whatever you want to do, you serve.
Yes, I will do that.
Post out a service of notice to R4 and R6.
In the meanwhile, interim order may kindly be explained.
Petition is also permitted to take out notice on R4 and R6 through courier as well as personal. Interim order and earlier to continue.
If date is given, my lord, before that, I will do that, my lord.
For hearing on case number 30, Shri Bhojana KJ.
I filed an application for early hearing, my lords. The petitioner is 83 years old. This matter was coming up in the B group and never reached, my lords. So that is the reason behind filing his application is 83 years old, my lords. If he is not getting any fruits of this matter, I have challenged the order of the Deputy Commissioner, my lords, where the Deputy Commissioner has passed an order based on a copy of the partition deed, my lords, which is never a document before the Assistant Commissioner. And when I have a decree to that effect, without looking into that decree, the District Commissioner, Deputy Commissioner has passed an order. Lordship gets a Deputy Commissioner's order at page number 36, my lords, Annex E.
Who's opposing you?
Opposed by respondent number 3, my lords. She's my sister, elder sister.
Vinod Reddy. Where is he?
The copy has been served, my lords, they have not come. A date may be fixed, my lord, so that this matter may be disposed of. Otherwise, it may be referred to the mediation. There may be some settlement talks. We can take it forward, my lord.
Post in the group on date.
Second.
Second.
Great.
Obliged.
31. K.V. Narasimhan.
Lord, I appear for the petitioner in this matter. I'm filing my objections to the statement the IA filed for impleading applicants. Lord, the present petitioner, my lord, was,
What are you challenging here?
Lord, we have challenged the order of the DC, my lord, where my grant made in my favor was cancelled by the Assistant Commissioner after a period of 32 years. My appeal,
Who's the impleading applicant?
Lord, impleading applicants are the LRs of respondent number 1, that is 1 Gaurama. Originally, my lord, the land was allotted in my favor in the year 1979. Respondent number 1, my lord, after a period of 32 years, challenged the grant in my favor before the Assistant Commissioner.
She is the person who challenged the grant.
Please, my lord.
Why are you opposing the LRs to come on record?
Lord, my objection is, even in the AC order and in the Deputy Commissioner order, there is no,
Gaurama challenged your grant, isn't it?
please, my lord.
Gaurama succeeded.
Please, no, not succeeded. My lord. Assistant Commissioner set aside my grant, whereas the rights of Gaurama has not been identified by the Assistant Commissioner and in the Deputy Commissioner's order. So she has no locus in the present petition is my submission.
The application filed for impleading is allowed since it is noticed that the applicants are none other than the legal heirs of the first respondent Gaurama, who had challenged the grant in favor of the petitioner. Was still to be amended. What is this IA for direction? Who has filed this application for direction? We filed an affidavit. You were supposed to file an affidavit.
With respect to IA for directions.
Yeah, the IA for direction is to implement the order dated 14/3/2022, whereby you were directed to file an affidavit as to the truthfulness, otherwise of the above mentioned findings, that she had other lands, first respondent had other lands, that her husband was working in the PWD and that her father was working in the KEP.
Please, with respect to that, I'll take instructions and make my submission.
You are supposed to comply, you can't,
Maybe taken up for any other date. ma'am.
I'm going to seek for a week's time to comply with you to order dated 14/3/2022. That is, you will be filing of an affidavit. Fill list on, so on.
1st April.
Please.
Madam, your affidavit is not sworn to, that impleading application, get it sworn to.
Number 32, government advocate.
I appear on behalf of the petitioner for respondent R1, your lordship. A week's time may be granted. The arguing counsel is not keeping. No, I'm for respondent 1.
Second.
Okay.
Number 33, Shri Prakash T. Hebbar.
For the petitioner.
Lordship is directed to keep ready. But the issue is the deputy commissioner has rejected the application for review. Let the
Small
issue-
submission
the
before.
issue is, last time your lordship has heard and directed him to be prepared for the lordship would dispose of finally. The matter is very simple. My grandfather has filed an application for a grant of the land. During the pendency, he died, left two children, that is the petitioner and the ninth respondent. The deputy commissioner has, my lord, granted the land in the joint names of two brothers. That was challenged by the petitioner. And this honorable court declined to entertain the petition because there was a justifiable order. Both the children have got equal right in it. In that case, he withdrawn the case with the liberty to move before the deputy commissioner. He filed an application before the deputy commissioner of section 24 to review the order. On the ground that, my lord, I have executed a registered release deed in his favor. The deputy commissioner said that he is disputing the very document, the execution of the very document itself, and without having acquired the right in that property, he cannot also have execute the release deed, work out to the remedy elsewhere. That order has been challenged. Absolutely, there is no. You won't dispute the release deed.
No, I am disputing, seriously disputing.
So after you execute the registered release deed, you can dispute it.
No, but that the execution itself is disputed.
Correct.
And it was not made known, but he claims that it is executed in the 1983-84. For the
Ready.
first time, he has
Sure.
brought before the court in the year 2017.
Are you ready?
Mission, my lord. The senior is out of station, my lord. Please give 2 days time.
First step. Till 34th, SB Halli.
Respondent method, I filed the application, vacating the interim order. My lord, there is a registered sale deed in the name of my father in the year 1975. But revenue entry still remained not changed in the name of my father. After death of my father and mother, I approached the Tahsildar to get the revenue entries transferred into my name. The Tahsildar issued an endorsement stating that it is in the name of the petitioner before your lordship. Then I filed an appeal before the assistant commissioner. Assistant commissioner, based on the registered sale deed, ordered to transfer the revenue entries into my name. That has been challenged before the deputy commissioner. That has been dismissed. Against that, the present writ petition is filed by the petitioner. Their contention is that after this registered sale deed, there was an unregistered partition deed in their name between their family members. Based on that, they are entitled for the revenue entries. So this is the background of the case.
From 75, your name is not there.
From 75, my father being an illiterate man, he don't know how to apply for it. He has not applied. After his demise and my mother demise, I went to and approached the Tahsildar. Tahsildar gave an endorsement based on the unregistered partition deed. They obtained the revenue entries in their name. Actually,
revenue entry was standing in their name. And that has never been challenged.
that has not been transferred. That has not been transferred by virtue of the
You
registered
have
sale.
not challenged it also.
But our father, unaware about that one, he don't know the procedure being an illiterate.
Years.
That appeal filed in the year of 2015, Malada.
The Tahsildar, the assistant commissioner and deputy commissioner, they relied on unregistered partition deed. Actually, for my sale deed,
Where is your?
It is contrary to rule 16, Malada. Without filing application for seeking condonation of delay, Malada, appeal is filed, Malada.
Where is the order of the Tahsildar?
my lord.
No endorsement, Malada.
No, while filing an appeal before the assistant commissioner, it is stated that Tahsildar has issued an endorsement.
Where is that?
Deputy commissioner says, Malada.
That endorsement is not produced.
That assistant commissioner not say so thing, Malada.
That endorsement is not produced before the assistant commissioner also.
No endorsement at all.
That is, they are saying, but they are claiming on the unregistered partition deed, which is after 22 years of my sale.
No, please come to annexure.
Please.
You challenged. Your Jangabradi Tane.
Please, ma'am.
You challenged the
that RRT,
CR 107/1415, dated 15/4/2015, and IHC 3/2000.
Yes, yes, standing in there, them, standing.
Where is that?
That endorsement, I'll produce before your lordship. That endorsement is not with me. I'll ask the parties to produce. A date may be fixed.
Civil court ಹೋಗಿ.
So Lordship
Alas.
may kindly see that, there is
No,
no
no,
endorsement
no,
at all,
Rev-
Malad.
ಇಬ್ರು ಮಾತಾಡಿ.
One ನಿಮಿಷ. Revenue entries are in my name. Now, as of now, I am
Yes,
paying,
sir.
yes, I am paying the taxes based on the order passed by area code. That is by,
Order goes
yes,
from 1975, his father's name was
no,
there.
no, furthermore submission. Now, what they did, after the stay order obtained by this honorable court, they dispossessed me from the suit, even though I filed a suit for injunction before the jurisdictional court. No interim order has been granted by virtue of the stay order
No, you
produced by
challenge,
them.
you
No.
challenge the order of mutation made in the year 2015 and the inheritance order. You never sought for implementation of your sale deed in the RTC from 75. Neither your father did that.
That's true, true.
Then
That is true. My,
if the kata was in their name,
yes, please.
any mutation amongst the kata, any partition amongst the katadars, they'll have to accept it.
No, my submission is this.
Isn't it?
When there is a registered document,
You never sought for implementation.
true, but it is the duty of the officers concerned to transfer it. They have not did it.
Suppose I don't do it for 50 years, if you keep quiet, what is your?
That is my submission. That is my case before all the authorities saying that my father
challenge-
being an illiterate man, he has not taken any steps to get it transferred. That is, that be due to his illiteracy.
For the civil court, get a sale deed done on the
No,
piece of.
no, no.
Get the declaration done.
I may be permitted to produce the document before your lordship by fixing a date.
Correct.
Please.
Seal number 35, for BM.
4 and 5.
Native remedy, ACM, challenge.
ACDC there.
See.
My lord, senior is filed up in another court. Please kindly pass.
Pass over.
Seal number 36, PN Harish.
Basically, the violation of the grant conditions, my lord. Kindly, my lord, page annexure B. Page 15 kindly see. Lord, serial number 4 conditions ಅಲ್ಲಿ ಮತ್ತು ಪರಂತು ಹಕ್ಕುಪತ್ರದಲ್ಲಿ ಯಾವುದು ಸರ್ಕಾರಕ್ಕೆ ಅಥವಾ ಸದರಿ ಭೂಮಿಗೆ ಲಗತ್ತಾಗಿರುವ ಅಥವಾ ಅದರ ಹತ್ತದಲ್ಲಿರುವ ಭೂಮಿಯ ಮಾಲೀಕರಿಗೆ ಅಥವಾ ಇಡೀ ಗ್ರಾಮಸ್ಥರಿಗೆ ಸದರಿ ಭೂಮಿಯ ಮೂಲಕ ಅಥವಾ ಅದರ ಅಂಚಿನಲ್ಲಿ ಹಾದು ಹೋಗುವ ಎಲ್ಲಾ ರಸ್ತೆಗಳ ಮತ್ತು ದಾರಿಗಳ ಮತ್ತು ಹಳ್ಳಗಳ ಬಗ್ಗೆ ಇರುವ ಅಥವಾ ರೂಢಿಗತವಾದ ಹಕ್ಕುಗಳನ್ನು ಬಾಧಿಸತಕ್ಕದ್ದಲ್ಲ. ದಿಸ್ ಇಸ್ ಇಫ್ ಇಟ್ ಇಸ್ ವೈಲೇಟೆಡ್ ದಿಸ್ ಮೇಲೆ 6ನೇ ಲೈನಲ್ಲಿ ಆದಿಭೋಗಿಸಲು ಅನುಮತಿ ಕೊಟ್ಟಿದ್ದೇನೆ ಮತ್ತು ಕಂದಾಯ ಅಧಿನಿಯಮದ ಉಪಬಂಧಗಳ ಮೇರೆಗೆ ಅಪೀಲಿನಲ್ಲಿ ಅಥವಾ ಪುನರೀಕ್ಷಣೆಯಲ್ಲಿ ಅಪೀಲು ಮತ್ತು ರಿವಿಷನ್ ಅಲ್ಲಿ ಆಗಬಹುದಾದ ರದ್ದತಿ ಏನೇ ಮಾಡಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರು
Cancellation of grant ಇದು.
ಹೌದು.
ಇಟ್ಸ್ ಅ ವೈಲೇಷನ್ ಆಫ್ ಗ್ರಾಂಟ್ ಮೇಲೆ ಅಂಡ್ ದೇರ್ ಫೋರ್ ಮೇಲೆ ದಿ ಫಿಫ್ತ್ ರೆಸ್ಪಾನ್ಸ್ adjacent agriculture land holder ಮೇಲೆ ಅಂಡ್ ಆಲ್ಸೋ ಮೇಲೆ ಆಸ್ ಪರ್ ದಿ ಎನ್ಕ್ವೈರಿ
ಫೆನ್ಸ್ ತೆಗೆದ್ರೆ ಸಾಕು ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ ಹೇಳಿದ್ದೇನೆ ಏನಂದ್ರೆ 94A ಸೆಕ್ಷನ್ ಪ್ರಕಾರ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ 2 acres ಮಾತ್ರ ಅಂತ ಇಲ್ಲಿರೋದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಲೇಶ್ ಹೇಳಿದ್ದು, ಅವ್ರ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಹೋಗ್ ಬರಕ್ಕೆ ತೊಂದರೆ ಆಗಲ್ಲ ಅಂತಂದ್ರೆ.
ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ ಪಾರ್ಟಿ ಬಂದಿದ್ದಾರೆ, ಒಂದು ಸಬ್ಮಿಷನ್ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಕ್ಕೆ, ಒಂದು ನ್ಯೂ ಡೆವಲಪ್ಮೆಂಟ್ ಆಕ್ಚುಲಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹ್ಯಾಸ್ ಟು ಬ್ರಿಂಗ್ ದಿ ನೋಟಿಸ್ ಆಫ್ ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್ ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಆರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಗೊತ್ತಿಲ್ಲ, ಪೋಡಿ ಮಾಡಿದಾರಂತೆ. ದಿಸ್ 2021 ರಿಟ್ ಪಿಟಿಷನ್ ಇದು ಆಲ್ರೆಡಿ ಇವ್ರ ಗ್ರಾಂಟ್ ಆಲ್ರೆಡಿ ಕ್ಯಾನ್ಸಲ್ ಆಗ್ಬಿಟ್ಟು ಅದನ್ನು ಹೊಸದಾಗಿ ನ್ಯೂ ಗ್ರಾಂಟ್ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಪೋಡಿ ಮಾಡಿ
ಸರ್ಲಿಯರ್ ಆರ್ಡರ್ ವಿಲ್ ಸ್ಟ್ಯಾಂಡ್.
ಅಲ್ಲಿ ಈ ಸ್ಟ್ಯಾಂಡ್ ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಏನ್ ಅವರು ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರೋ ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಗಿವ್ ಎಫೆಕ್ಟ್ ಟು ದಿ ದೇರ್ ಗ್ರಾಂಟ್. ಆಕ್ಚುಲಿ ಅದು ಪ್ರಕಾರ ಹೋದ್ರೆ ಆ 1 acre 20 ಗುಂಟೆಲಿ ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಡಕ್ಟೆಡ್ ಆಸ್ ಪರ್ ಇವ್ರ ಪ್ರಕಾರ.
I already passed the order because you said you will be satisfied if they were to give an
ಅಲ್ಲ
undertaking.
ಇದನ್ನ ಒಂದು ತಾವು ಇದನ್ನ ಈ ಅವ್ರು ಹೇಳಿರೋ ಅಂತ
Scope, I will not give the scope to enlarge my order. Last time
ಮೈ
you-
ಸಬ್ಮಿಷನ್ ಇಷ್ಟೇ ಮೇ ಸ್ವಾಮಿ, ಅಫಿಡವಿಟ್ ಪ್ರಕಾರನೇ ಈ ರೋಡಿಗೆ ಏನ್ ಎಕ್ಸ್ಟೆಂಡ್ ಬರುತ್ತೋ ಅವ್ರು ಹೇಳೋ ಪ್ರಕಾರ 15 ಮತ್ತೆ 150 feet ಬರುತ್ತೋ ದಿಸ್ ಲ್ಯಾಂಡ್ ಇಸ್ ಟು ಬಿ ನಾಟ್ ಟು ಗ್ರಾಂಟ್ ಟು ದಿಸ್ ಪೆಟಿಷನರ್. 1 acre 20 ಗುಂಟೆಲ್ ದಟ್ ಇನ್ಕ್ಲೂಡ್ ಅಂತ ಅದು ರಿಮೈನಿಂಗ್ ಹಂಗೆ ಆಗ್ಬಿಡ್ತದೆ. ಇವಾಗ ಇಫ್ ಯು ಕನ್ಫರ್ಮ್ ಮಾಡಿದೆ ಆ ಗ್ರಾಂಟ್ ಆರ್ಡರ್
ವಾಟ್ ಅಬೌಟ್ ದಿ ಅವರೇ ಹಾಕಿರೋ ಅಫಿಡವಿಟ್ ನ ಕಾಂಟ್ರಾಕ್ಟರ್ ಆಗ್ಬಿಡ್ತದೆ. ನಾಳೆ ಇದು ಒಂದ್ ಕಡೆ ಅವರು ಈಗ 1 acre 20 ಗುಂಟೆ ಗ್ರಾಂಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ, ದಿಸ್ ಅಫಿಡವಿಟ್ ಸ್ಪೀಕಿಂಗ್ ಅಬೌಟ್ ದಿ ನಾಟ್ ಟು ಡಿಸ್ಟರ್ಬ್ ದಿ ಅಂತ ಹೇಳುತ್ತೆ. ಅದಕ್ಕೆ ದಿಸ್ ಏನ್ ವಾಟ್ 115 feet and 150 ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ, ದಿಸ್ ಇಸ್ ಟು ಬಿ ಗಿವ್ ಎಫೆಕ್ಟ್ ಟು ದಿ ಬೈ ಡಿಡಕ್ಟಿಂಗ್ ಇನ್ ಗ್ರಾಂಟ್ ಅಲ್ಲಿ ಮಾಡಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ರೀಗ್ರಾಂಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇರ್ ಕ್ಲೈಮ್ ಈಸ್
What is the extent of the road?
15 feet ಅಗಲ ಮತ್ತು 150 feet ಲೆಂತ್ ಆಗ್ತದೆ.
ತೋರಿಸಿದೀನಿ, ಕಾರ್ಡನೆ ಬರೆದಿದ್ದಾರೆ.
ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅವರು
15 ಅಡಿ ಇಂಟು 150 ಅಡಿ. 150 ಅಡಿ ಆಕ್ಚುಲಿ ಎಂಡ್ ಆಫ್ ದಿ ರೋಡ್.
ಅದೇ ವಾಟ್ ಈಸ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಎಕ್ಸಿಸ್ಟೆಡ್ ಅಂತ ಹೇಳ್ಬೇಕಾಯ್ತು, ಸರ್ವೇರೆ ಮಾಡ್ಬೇಕಾಯ್ತು, ಗೌರ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅವರು. ದೇರ್ ಸಬ್ಮಿಟಿಂಗ್ ದಿಸ್
15 into 150 feet.
ಹೌದು.
ಅದನ್ನು ಅಳತೆ ಮಾಡಿ ಇನ್ನು ವಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ಇಷ್ಟೇ ಇದೆಯೋ ಜಾಸ್ತಿ ಇದೆಯೋ ಮ್ಯಾಪ್ ಹಾಕಿದ್ದಾರೆ, ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಹಾಕಿದ್ದಾರೆ, ಮಾರ್ಕ್ ಏನೋ ಮಾಡಿ. According to them, Milad, road is existed, it's very clear.
Get instructions on this affidavit as to what is the extent of the road which they admit.
Please.
I will ask them to ensure that this road is not granted to them, others may be confirmed.
Please.
Modify the grant order, that is to be,
Be done.
please to order.
ಹೇಳಿ ಎಷ್ಟು ಕೇಳ್ಕೊಂಡ್ ಹೇಳಿ.
Affidavit.
ಕೊಟ್ನಲ್ಲ ನಾನು ಮೊನ್ನೆ ಕೊಟ್ನಲ್ಲ ಅಫಿಡವಿಟ್
Joint affidavit by the
ಅದೇ.
commissioner. Yes,
ಹೆಚ್ಚು ಕೊಟ್ಟಿದ್ದೀನಿ.
please.
ಕೇಳ್ಬಿಟ್ಟು ಎಷ್ಟಿದೆ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟು
Yes, ma'am.
that extent ಬಿಟ್ಬಿಟ್ಟು will modify the
Re-grant ಮಾಡಿದ್ರೆ that is,
list.
please.
First. Seal number 37, Shri Murali BS.
ಸೆಕೆಂಡಿಗೆ ಫಸ್ಟ್ ಸೆಕೆಂಡ್.
Murali BS.
Last occasion, Lord, my lords had heard the matter for some time. I requested for some time. But we'll make only one last endeavor, my lord, to
ಇದು
idirdu. Lord, the earlier grant order discloses clearly, my lord, 1 acre 34 guntas was reserved for katte and topu.
That is the land, my lord, to look
Yes.
after the.
Yes, adan annexure ಏನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ 1 acre 34 guntas was reserved for katte and topu. Along with that, my lord, to an extent of 2 acres 10 guntas was permitted to my grandfather to be looked after. Lord, I am not on that. Kindly see, my lord, the present order, impugned order is passed invoking section 71 and the relevant rule, my lord, will be 108I. Impugned order, my lord, is at annexure G.
next re ಅಲ್ವಾ?
Annexure E, sorry. Annexure E. ಎರಡನೇ ಪ್ಯಾರಾದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಸೋಮಸೂರವರು ಉಲ್ಲೇಖ 2ರ ವರದಿಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ಚನ್ನಪಟ್ಟಣ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಸೋಮಸೂರು ನೀಲಕಂಠನಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 35ರಲ್ಲಿ ಪಹಣಿಯಂತೆ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 10 ಗುಂಟೆ ಗೋಮಾಳ ಎಂದು ವರ್ಗೀಕರಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನನ್ನು ನೀಲಕಂಠನಹಳ್ಳಿ ಗ್ರಾಮದ ಸಾರ್ವಜನಿಕ ಸ್ಮಶಾನಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಲು ಗುರುತಿಸಿ ನಕ್ಷೆ ತಯಾರಿಸಿರುವುದು. ಈ ಜಮೀನು ಗ್ರಾಮದಿಂದ 1.5 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಚನ್ನಪಟ್ಟಣ ನಗರಸಭೆಯಿಂದ 5 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಇರುತ್ತದೆ. ಈ ಜಮೀನಿನಲ್ಲಿ ಇದ್ದ ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಲಾಗಿದ್ದು ಯಾವುದೇ ಋಣಭಾರಗಳನ್ನು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಫಸ್ಟ್ ಫ್ಯಾಕ್ಟ್ which is contrary to their own records that I am still there, but still my lord they say ಒತ್ತುವರಿಯನ್ನು ಇದು ಮಾಡಿದೆ.
You were permitted to occupy it on your own because you take care. You are not in unauthorized possession.
No, I am not.
Be there to take care of this particular land.
Yes,
You are not in possession.
Lord, I was my lord. With that, my lord, I will continue. My lord, I am not specifically on that. Next, my lord. ಈ ಜಮೀನಲ್ಲಿ ಇದ್ದ ಒತ್ತುವರಿ ಆಯ್ತು. ನೀಲಕಂಠನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಒಟ್ಟಾರೆ 158 ಜಾನುವಾರುಗಳಿದ್ದು ಈ ಜಾನುವಾರುಗಳಿಗೆ ಸಂಖ್ಯೆಯಲ್ಲಿ ಅನುಗುಣವಾಗಿ ಮೇವಿಗಾಗಿ ಮೀಸಲಿರುವ ಗ್ರಾಮದಲ್ಲಿ ಗೋಮಾಳದ ಜಮೀನಿನ ಕೊರತೆ ಇರುವುದರಿಂದ ಸ್ಮಶಾನದ ಹಿತದೃಷ್ಟಿಯಿಂದ ಗೋಮಾಳ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆಯಲ್ಲಿ ತಗ್ಗಿಸಿಕೊಂಡು ಸಾರ್ವಜನಿಕರ ಸ್ಮಶಾನಕ್ಕೆ ಕಾಯ್ದಿರಿಸಬೇಕೆಂದು ಅಭಿಪ್ರಾಯವನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಪ್ರಸ್ತಾಪನೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 158 ಜಾನುವಾರುಗಳಿದ್ದು ಅಂತ ಬರೀತಾರೆ ಅವರನ್ನೇ, ಅವ್ರಿಗೆ ಬೇಕಾಗಿರುತ್ತೆ ಅಂತಾನೂ ಬರೀತಾರೆ, ಆದ್ರೂ ಇದನ್ನ ಕಡಿಮೆ ಮಾಡಿ ಇದು ಕೊಡ್ತೀವಿ ಅಂತ ಬರೀತಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ my lord, rule it is passed my lord under section 171 my lord. Next page ನಲ್ಲಿ 97(4) and rule 97(4) my lord and section 71. Kindly see my lord 71 as well as rule 108J(I) my lord. For a moment.
17 was the assignment ಅಷ್ಟೇ ತಾನೆ?
Assignment. 97 4 ತಾವ್ ನೋಡಿ ಮೊದಲು.
Reduction of pasturage.
Reduction, not the. Providing free pasture, not at under rule 97. Government land shall be set apart for free pasture for the cattle of each village at the rate of 12 hectares for every 100 heads of cattle is the original rule. In calculating the heads of cattle and so on, so at the end, if there is sufficient forest area in the village concerned or in the adjoining village to enable the village cattle to graze, the area to be set apart as free pasture may be reduced correspondingly. There is no finding lot on that aspect. Next, if there is no grazing land available in a village or the land available falls short of the extent prescribed under sub-rule 1, the deficit may be made up by setting apart government land available in the adjacent village. Now, the deputy commissioner shall determine the.
Oh, exposing the cause of the cattle.
My lord,
Now you give up your right.
my lord, what I am submitting is, if this rule, my lord, if it is to be read in consonance, my lord, with rule 108, my lord, the deputy commissioner has no authority. Kindly see, my lord, the rule 108 also, my lord. 108I. Certain lands not to be granted, notwithstanding anything contained in this chapter.
Do not grant, so you can't bring.
ಹೇಳ್ತೀನಿ ಇದಕ್ಕೆ ಯಾಕೆ ಅಂತ ಹೇಳ್ತೀನಿ. Lands assigned for specific purposes under section 71 of the act and lands prescribed in the revenue records as Devarakadu, Urdwe, Gundutopu, Tank Bund, so and so, burial grounds and such lands which is in the opinion of the government is required for public purpose shall not be granted.
How is 108I applicable?
Not
It's not being granted to
it
anybody.
is already
Reserved.
described as a Gundutopu.
No. If it's assigned as a Gundutopi, it can't be granted. This is not be granted.
Alla,
This land is being reserved.
it cannot be used, my lord, for any other purpose other than the one which is required under. That is the rule, my lord. I have not one judgment of the division bench of this honorable court. Not make, my lord, that individual, my lord. Madam. Lord, it was a case, Lord, where an extent of land, my lord, was originally reserved for burial ground itself. That was sought to be reduced and it was sought to be allotted to a school. And
This is not being allotted to anybody. Even if it's a burial ground, the cattle can still graze on this very burial ground. See, therefore the cattle assets will not be affected by this burial ground being converted, this government land being converted into a burial ground. So I don't know how this judgment will apply. The
Not
bar
that.
is for.
Rule 108, yes, my lord. In that case, my lord, it was a grant, my lord, by reducing that area into that.
This is not even a grant. Therefore, I don't know why I should look at 108 at all.
It is not a grant, my lord. What the conjoint reading of those two provisions, my lord, would say that the original requirement, my lord, for what it was reserved, it cannot be taken apart by the deputy commissioner is all that I want to.
We'll hold that since it's a burial ground, it can be used, even if it's used as a burial ground, it can nevertheless not lose its character as a government land. It will nevertheless be used by the cattle. Therefore, even the question of reduction from 97 would not be required.
ಉಳಿಸ್ಕೊಳ್ಳೋಣ ಅಂತ ಏನಾರು ಅಂದ್ರೆ ಇವರಿಗೆ ಉಳಿಲಿ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಬರಿಯಲ್ ಗ್ರೌಂಡ್ಗೆ ದೇರ್ ಆರ್ ಮೆನಿ ಅದರ್ ಇದು ಅಂಡ್
The same argument we held against you because you are claiming an unauthorized occupation.
ಇಲ್ಲ ಅನ್ಆಥರೈಸ್ಡ್ ಆಕ್ಯುಪೇಷನ್.
All these rules will be held against you for you to claim that land. ನೀವು argument ಮಾಡೋದು will hurt you because you will have no right at all over that land. And nevertheless, it was granted to you. Andre right to take care of it. How could that have been done?
That was done in 1951 ನಲ್ಲಿ ಅವಾಗ ಮಾಡಿದ್ದು.
Order assigning 2 acres 10 guntas in cell number 35 as a burial ground is being called in question.
It's to be withdrawn, my lord, with
Not comes for the petitioner seeks permission.
otherwise it may affect, as my lords observed on the last occasion. I may only one request, my lord, I will file a memo, Lord, for 10 days, my lord, the interim protection, my lord, may be continued.
What did you do now after you withdraw?
Lord,
ಬೇರೆ ಏನಾದ್ರು ಫಾರ್ ಪಬ್ಲಿಕ್ ಪರ್ಪಸ್ ಅಂತ ಏನೋ ಇಫ್ ದೇ ವಾಂಟ್ ಟು ಡೂ
For
ಸಮಥಿಂಗ್.
public purpose only, my lord, all graveyard, and he is
Yeah.
not in position also, my lord, only taking care of that land he is in.
ಸುಮ್ಮನೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ಅಲ್ಲೇನ ಬೇರೆ ವರ್ಕೌಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾನು ಏನೇನು ಲಿಬರ್ಟಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ತಗೊಳ್ಳಿ, ಅಪೀಲ್ ಇದ್ದೇ ಇರುತ್ತೆ. You enjoyed it for almost 8 years. I think you should be satisfied.
ಅಲ್ಲ ಇದೆ, ಬಟ್ ಇಷ್ಟು ವರ್ಷ ಮಾಡಿನೂ ಅದನ್ನ ಸ್ಮಶಾನ ಕೊಡ್ತಾರಲ್ಲ ಅಂತ ಅವ್ರಿಗೊಂದು.
ನಿಮ್ ಪ್ರಕಾರ 12 ಸ್ಮಶಾನ ಇದೆಯಲ್ಲ, ನಿಮ್ದೇ ಇದೆಯಲ್ಲ.
ಇದಿದೆ, ಆ ಕಡೆ ಬದಿನಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಇದನ್ನ ಇದರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
WB dismisses withdraw.
Place this memo on record.
Serial number 78, my lord, all other HRP matters have been adjourned to 20th of April.
78 also HRP.
78.
Serial number 55, my lord. I am open for respond number R3, my lord. Week time, my lord. Week time, my lord.
ಅವ್ರ ತಾನೇ ಮಾಡ್ಬೇಕಿರೋದು.
My lord.
To secure the LND records, we have the land tribunal records, but the LND is a year of 1960. Just tracing out.
ನೋಡ್ರಿ.
My lord, serial number 56, my lords. Serial number 56, we have to produce a Tahsildar order, my lord, 10 days time may be granted.
ಏನ್ ಮೇಡಮ್ ಅದಿಲ್ವಾ? 56.
56.
56. My lord, we can take up matter.
ತಹಸೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರಂತೆ.
ಯಾರು ಇಲ್ಲ.
ಇವ್ರಿಗೆ
ಎಷ್ಟನೇದು? ಅರ್ಜನ್.
ಅರ್ಜನ
ನೀವಾ? ಅಯ್ಯೋ, ಇಲ್ಲ ಬಂದಿದಾರಲ್ಲ, ನಾವು ಕೊಡ್ಬೇಕಿತ್ತು.
ಇಲ್ಲೇ ಬರ್ದಿದ್ದಾರೆ. The petitioner is to produce the order of the Tahsildar.
ನಿಮ್ ಸೀನಿಯರ್ ಬಿಡಮ್ಮ, ಏನೋ ಒಂದ್ ಹೇಳ್ಬಿಟ್ಟು ಒಟ್ಟು ಟೈಮ್ ತಗೊಳೋದ್ರಲ್ಲಿ ಇವರು. ಸರ್, ಯಾವ್ದೋ ಒಂದು ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಸರ್, ಸಿದ್ದಪ್ಪ ಅವ್ರದಾ?
ನಮ್ದು ಒಂದು ಪಾಸ್ ಆಗಿದೆ ಸರ್.
ಎಷ್ಟನೇದಮ್ಮ?
35.
ನಿಮಿಷ.
ಅದು ವೆಕೇಟಿಂಗ್ ಆಫ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಇದಾ 316?
Second.
ಒಳಗಡೆ ಬರಪ್ಪ.
ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ
Sir,
ಯಾವ್ದಮ್ಮ? ತುಮಕೂರ್ದೊಂದು, ಇನ್ನೊಂದು ಯಾವ್ದು? ತೀರ್ಥಹಳ್ಳಿದೊಂದು ಮಾಡ್ಬೇಕು. ಎಸ್,
ಬ್ಯಾಂಗ್ಳೂರ್ ನಾರ್ತ್ ಬಂದಿತ್ತಲ್ಲ.
ಹಾ, ನಾರ್ತ್ ಬಂದಿದಾರ. ನಿಮ್ದು ಯಾವ್ದಪ್ಪ? ಕನ್ವರ್ಷನ್ ಅಲ್ವಾ? ಇಟ್ಕೊಳ್ಳಿ ನೀವು ಇರಿ. ನಿಮ್ದು DC ತುಮಕೂರ್ದು ಒಂದು ಕನ್ವರ್ಷನ್ ಮಾಡ್ರಿ. WP ನಂಬರ್
ಅಲ್ಲಿದೆ
WP ನಂಬರ್ ಹೇಳ್ತಾರೆ. ಒಂದ್ ನಿಮಿಷ, ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ನೋಡಮ್ಮ. ಜೊತೆಗೆ ಹೋಗಿ ಲಿಸ್ಟ್ ಆಗಿದ್ರೆ ಇರಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅದು ನೋಡಿ ಮೋಸ್ಟ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿರ್ಬೇಕು. ನಂಬರ್ ತಗೋಬಹುದು. ನಿಮ್ದು ಯಾವ್ದು? ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ 17ಕ್ಕೆ. ಇಲ್ಲೇ ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು. ಅಲ್ಲ ಸೀರಿಯಲ್ 64 ಅಲ್ವಾ? ಇರಿ ವೈಟ್, ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ತಲಕೆರೆದಲ್ವಾ? 56 ಈಗ ತೆಲ್ಕೆರದು ಈಗ ಅರ್ಜೆಂಟ್ ಆಯ್ತು. ಅವರು ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ನೀವು ತಂದಿಲ್ಲ ಅಲ್ಲ, ತಂದಿದ್ದೀರಾ? ಇದೆಯಾ ಇಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್? ಮುಟೇಶನ್ ಅವ್ರ ಫೇವರೇ ಮಾಡ್ತಿದ್ದೀರಾ? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ತಗೊಂಡ್ಬರ್ತೀರಿ ಇವಾಗ ಹೋಗಿ? ಅದ್ ತಹಸೀಲ್ದಾರಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ಲೇಬೇಕು ನೀವು, ಅದನ್ನ ಹೇಳಿದ್ದೀನಲ್ಲ. ನೀವು ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ಮಧ್ಯಾಹ್ನ. ಹಾ, ಏನಾಯ್ತು?
ರೆಕಾರ್ಡ್ಸ್ ತಂದಿದ್ದಾರಂತೆ.
ಹಾ.
ಅವರು ತಹಶೀಲ್ದಾರ್ ಹತ್ರ ಮಾತಾಡಿದ್ರು. ಅವರು ಹಳೆ ಲೆಟರ್ಗಳು ನಮ್ಗೆ ಬಂದಿಲ್ಲ, ಇನ್ನೊಂದು ರಿಮೈಂಡಿಂಗ್ ಹಾಕಿ ನಾವು ರಿಪೋರ್ಟ್ ಕೊಡ್ತೀವಿ. ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ರಿಪೋರ್ಟ್
ಯಾರ್ದು?
ತಹಶೀಲ್ದಾರ್.
ಹಾ.
ಅದ್ರ ಬೇಸ್ ಮೇಲೆ ಈಗ ಟೋಟಲ್ ನಾವು ಇದು ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ, ಇವ್ರು ಹೇಳ್ತಿರೋದು ಪಾರ್ಟಿಸ್ ನಾವು ಕೊಟ್ಟಿದೀವಾ ಇಲ್ವಾ ಅಂತ.
ಮೇಡಮ್ ಅವರು
DC ರಾಮನಗರ ಆಮೇಲೆ 53 ಇನ್ನೊಬ್ರು ಯಾರು ಬಂದಿದ್ದು?
ಯಾರು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 53 ಅಲ್ಲಿ ರಾಮನಗರ DC ಅಷ್ಟೇ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. ಅರ್ಬನ್ DC ಪ್ರೆಸೆಂಟ್ ಇದ್ರು, ಬೇರೆ ಕೇಸಿಗೆ 6 ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇದ್ರಲ್ಲ, ಹಂಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು.
ಅದೇ ಅದ್ರಲ್ಲಿ ಸಾಹೇಬ್ರು ಇಬ್ರು
ಹೇಳಿ, ಅರ್ಬನ್ DC ಅಂತ ಹಾಕಿ. DC ಅರ್ಬನ್.
DC ಅರ್ಬನ್
ಸರ್ವೆ ಹೇಳಿದ್ರು ಅವರು.
ಅರ್ಬನ್ ಅಷ್ಟೇ, DC ಅರ್ಬನ್.
4 ಜನ ಏನಿದ್ದಾರೆ ಅವರು ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್. 6 ಜನದಲ್ಲಿ ಇಬ್ರು ನಮ್ಗೆ ರಿಲೇಟಿವ್ ಅಂದ್ರೆ ಅವ್ರ ಫ್ಯಾಮಿಲಿಗೆ 3rd ಜನರೇಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಸರ್ವೆ ನಂಬರ್ಸ್ಗಳು ಇವ್ರ ಹೆಸರಲ್ಲೇ ಇದಾವೆ, ನಮ್ಮ ತಾಯಿ ಹೆಸರು ಇದಾವೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ನ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರಿಗೆ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಬಿಟ್ಟು ಕಳಿಸ್ತೀನಿ.
ಇದೆಯಾ ನೋಡಿ,
ಎಂಟೈರ್ ಫೈಲ್ ಜೆರಾಕ್ಸ್ ತಗೊಂಡಿದ್ದೀನಿ.
ಇದ್ರಲ್ಲಿ ಇಲ್ವಾ?
ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ಚೆಕ್ ಮಾಡಿ ತಗೋ. ಚೆಕ್ ಮಾಡಿ ಇವ್ರು ಏನ್
ಮಾಡ್ತೀನಿ. ಅವ್ರು ಏನ್ ಅವ್ರ ಹತ್ರ ಏನಿದೆ
ಈ ಕಾಪಿ ಅವ್ರು ಕೇಳ್ತಿರೋದು ಮೈನ್.
ಕೊಡದೆ ಮೇಡಮ್
ಜನ ಇರೋರು ಕೊಟ್ಟಿದೀವ ಅನ್ನೋದು ನಮ್ಗೆ.
ಆ ಸರ್ವೆ ನಂಬರ್ ವೆಂಕಟರಮಣಪ್ಪ ಅನ್ನೋ ಹೆಸರು ಇತ್ತು. ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಇನ್ನ 4 ಸರ್ವೆ ನಂಬರ್ ಅಡಿಷನ್ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ 4 ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ರಮಣಪ್ಪನ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ. ಅದನ್ನೇ ಸರ್ ಹೇಳಿದೆ ನಾನು. ಅವ್ರು ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಇದೆ ನೋಟಿಫಿಕೇಶನ್ ಅಂತ ಹೇಳಿದ್ರು. ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಮಾಡಿರೋದು ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಪ್ರೋಸೆಸ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರನು ಗ್ರಾಂಟ್ ಫೈಲ್ ಐತೆ.
ಅವ್ರ ನಂಬರ್ ಇದೆಯಲ್ಲ, ಲಾಯರ್ ನಂಬರ್
ಇದೆ.
ಫೋನ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ತರ್ಸ್ಕೊಂಡು ಯಾರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಚೆಕ್ ಆಗಿ ಅವ್ರು ಹೇಳಿದೆಲ್ಲ ಕೇಳಿ, ಆಮೇಲೆ ನಿಮ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿಲ್ವಾ, ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ರೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹಾಕಿ.
ಸರಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ನೆ ಅವ್ರ ಹೆಂಗ್ ಯಾಕೆ ಸುಮ್ನೆ ಮಿಸ್ಲೀಡ್ ಮಾಡ್ತಿದ್ದಾರೆ ಕೋರ್ಟ್ಗೆ ಅನ್ನೋದನ್ನ ಫೈಂಡ್ ಔಟ್ ಮಾಡಿ. ಅವ್ರ ಹೆಸರೇ ಇಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ, ಸುಮ್ನೆ ಅಂತಾನೆ ಹೇಳಿ ಆಯ್ತಾ. ಅಫಿಡೇವಿಟ್
ಚೆಕ್ ಮಾಡ್ಸ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ. ಸರ್ ಹತ್ರ
ಅಫಿಡೇವಿಟ್ ಏನ್ ಬೇಕಾಗೋದೇ ಇಲ್ಲ ನಮ್ಗೆ, ಜಸ್ಟ್ ತಗೊಂಬನ್ನಿ ನೋಡೋಣ.
ಸರಿ.
ಅಫಿಡೇವಿಟ್ ಹಾಕಂಗಿದ್ರೆ ಲೆಟ್ ಹಿಮ್ ಫೈಲ್, AC-ನೇ ಫೈಲ್ ಮಾಡ್ಲಿ ಅಥವಾ DC-ನೇ ಹೊರಡಿ ನೀವು.
ಸರಿ.
ಯಾವ್ದು? ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕೆಲ್ಲ, ಸರ್ಟಿಫೈಡ್.
ಅದ ಒಂದ್ ಸರ್ಟಿಫೈಡ್ ಕೊಡ್ಬೇಕು.
ಎಲ್ಲ ಸರ್ಟಿಫೈಡ್ ತಗೊಳ್ಳಿ, ನೀವು ಮಾಡ್ಕೊಡ್ತೀವಿ. ಎಲ್ಲ ಏನೇನ್ ಬೇಕೆಲ್ಲ ಅವ್ರಿಗೆ ಏನ್ ಕೇಳಿದಾರಲ್ಲ ಅಷ್ಟು ಪರ್ಸೆಂಟ್ ಕೊಟ್ಟಿದೀವಿ, ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ನೀವು ಬರ್ತಾ ತಗೊಂಬನ್ನಿ.
ಸರಿ ಮೇಡಮ್, ಕವರಿಂಗ್ ಲೆಟರ್ ಸಮೇತ ತಗೊಂಡ್ಬೇಕು ನಾನು.
ಹೌದು, ತಗೊಂಡು
ಟಕ ಅಂತ ಆಗ್ಬಿಟ್ಟು ಕೆಲಸ.
Notice. ಅರೌಂಡ್ ಸಕದ ಮಾಡ್ಬಿಟ್ಟವ್ರೆ ಕೆಜಿ ಅವ್ರಮ್ಮ ಅಲ್ಲೇ ಇತ್ತು ಈ ಕಡೆ ಗೊತ್ತಾ ಒಂದು ರೋಡ್ ಹೊಸ್ಕೋಟೆ ಕಾಣೋದೇ ಇಲ್ಲ ಹೊಸಕೋಟೆ ಕೆಜಿ ಎಫ್ನಿಂದ ಹೊಸಕೋಟೆ ಅರ್ಧ ಗಂಟೆಗೆ ಹೊಸಕೋಟೆ ಟೋಲ್ ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ಲ ಮಂಗಳೂರಿಗೆ ಹೋಗಿದ್ದೆ ಈಗ ಎಲ್ಲಿಗೆ ಎಲ್ಲಾಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ ಎಷ್ಟು ಹೊಸರು ಡೈಲಿ ಒಂದು ನಿಮಿಷ ನಾವು ಮುಗಿತಂದ್ರೆ ಇನ್ನೂ ಆ ಕಡೆ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಬಿಟ್ಬಿಟ್ಟವ್ರೆ ಹೋಗಿ ಬರೋಣ ಅಲ್ಲಿ ಮಧ್ಯ ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟವ್ರೆ ಹೋಗಿ ಬರೋಣ. ಪರ್ಸನಲ್ ನೋಟಿಸ್ ಆ್ಯಂಡ್ ಸಮನ್ಸ್ ಬರೆಯೋದು ಪೋಸ್ಟ್ ಆಫೀಸ್ ಸರ್ವಿಸ್. ಕರೆಕ್ಟ್ ಆಗಿದೆ ಫೈಲ್ passed over matters. Passed over matters. Serial number 2.
Krishna, my lord. It's the order of the KAT, my lord. I am challenging this filed this petition. It is the matter is regarding the survey sketch of the survey number 7 of 7/2 of the Basavanalli village, Kasvavali, Nelmangla Taluk, my lord. My lord, the respondent contention is that, my lord, they purchased the land in survey number 7, 2 acre 5 guntas. Under the sale deed dated, my lord, I produced that sale deed in page number.
It's only not of remand, isn't it?
My lord,
It's only not
remand
of-
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಏನಂದ್ರೆ there is a 2 declaratory suits are pending before the civil judge. ಇದರಲ್ಲಿ ಮಲ್ಟಿಪಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಗಳು ಆಗಿದೆ. ಅವ್ರಿಗೆಲ್ಲ ಸಪರೇಟ್ ಇಸಾ ಟಿಪ್ಪಣಿಗಳು RTC ಗಳೆಲ್ಲ ಆಗೋಗಿದೆ. 2004 ಆರ್ಡರ್ನ KT ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. 2010 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿತ್ತು. 2018 ಅಲ್ಲಿ ರಿಓಪನ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ನಮ್ಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ನಾವು ಎಲ್ಲಾರ್ಸ್ ಆಗಿ ಬರ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ. ಅಂದ್ರೆ my lord, they filed the declaratory suit seeking declare the respondent or the absolute owner of the survey number 7/2 ಅಂತ. ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಆಗಿರೋದು ಸರ್ವೆ ನಂಬರ್ 7 ಅಲ್ಲಿ. ನಮ್ದು ಸೇಲ್ ಡೀಡ್ 1982 ಸರ್ವೆ ನಂಬರ್ 7/2 ನಲ್ಲಿ. ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಸ್ವಾಮಿ ಮೆಜರ್ಮೆಂಟ್ ನೆಲ್ಲ ಅಡಿ ಲೆಕ್ಕದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ ಮೇಲಿನ ಸಹಿ ಅಡಿ ಅಳತೆಯಂತೆ 7.5 ಗುಂಟೆ ಲ್ಯಾಂಡ್ ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬರ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಪೇಜ್ ಆಫ್ ದೇರ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ. ಆದ್ರೆ ದೇ ಆರ್ ಕ್ಲೈಮಿಂಗ್ 2 acre 5 ಗುಂಟಾಸ್ ಅಂತ ಹೇಳಿ. ಒರಿಜಿನಲ್ಸ್ ಓನರ್ ಬಂದ್ಬಿಟ್ಟು ಕೂಡ ಅವರು ಕೂಡ ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. OS 260 of 2016. ನಾವು ಅವ್ರಿಗೆ 7.5 ಗುಂಟೆನೂ ಕೂಡ ನಾವು ಬರ್ಕೊಟ್ಟಿಲ್ಲ. ದಟ್ ಇಸ್ ಕ್ರಿಯೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನನ್ನ ಫಾದರ್ಗಳು ಯಾರು ಕೂಡ ಅವ್ರಿಗೆ ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತೇಳಿ. ಎಸ್ ಮೈ ಲಾರ್ಡ್, ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು ಈಗ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. 2012 ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಪರ್ಚೇಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ EC ಚೆಕ್ ಮಾಡಿದ್ದೀನಿ, ಸರ್ವೆ ನಂಬರ್ 7/2 ನಲ್ಲಿ ಯಾವುದೇ ಎಂಟ್ರಿ ಇಲ್ಲ. ಇವನ್ 1968 ಇಂದ ಕೂಡ RTC 7/1, 2, 3, 4 ಅಂತ ಸಬ್ ಡಿವಿಷನ್ ಆಗಿದೆ. ಇವರು 77 ಅಲ್ಲೇ ತಗೋಬೇಕಾದ್ರೆ 7ರ ಪೈಕಿ ಸರ್ವೆ ನಂಬರ್ 7ರ ಪೈಕಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದೇ ಕ್ರಿಯೇಟೆಡ್ ಎ ಸೇಲ್ ಡೀಡ್.
ಬಟ್ ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದಲ್ಲ, ಗೊತ್ತಾಗತ್ತೆ.
ಸರ್ವೆ ಸ್ವಾಮಿ, ನಾವು ಪೊಸಿಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದೀವಿ, ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದೀವಿ. ಅವ್ರಿಗೆ RTC ಮ್ಯೂಟೇಷನ್ ಕೂಡ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ ಆಗತ್ ಮುಂಚೆನೆ ಸರ್ವೆ ನಂಬರ್ 1, 2, 3, 4 ಅಂತ ಆಗಿತ್ತು. ತಹಸೀಲ್ದಾರ್ ಆಫೀಸಲ್ಲಿ ಅವರು ಸರ್ವೆ ನಂಬರ್ 7 ಇದ್ರೆ ಅವರು RTC ಮ್ಯೂಟೇಷನ್ ಎಂಟ್ರಿ ಮಾಡ್ತಿದ್ರು, ಲ್ಯಾಂಡೇ ಇಲ್ಲ. ಹಾಗಾಗಿ ಸ್ವಾಮಿ ಅಲ್ಟಿಮೇಟ್ until disposal of this suit.
Number 7.
Copy may be right. Adರಲ್ಲಿ the
Copy,
matter
sir.
was remanded on the ground that, my lord, the respondents are disputing that he has not, they are not the signatories to the survey, my lord. On that ground, my lord, it was remanded back, my lord.
I thought it was only-
ರಿಮೈಂಡೆಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಸೂಟ್ಗಳು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಕ್ಲೈಂಟ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಕೊಡ್ತೀನಿ.
KT ಮುಂದೆ ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರ?
ಹೌದು ಸ್ವಾಮಿ. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಸೂಟ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ರು?
ಸೂಟ್ ಬಗ್ಗೆ ಅವರು ಆಬ್ಸೆಂಟ್ ಸರ್ ಸ್ವಾಮಿ, ಏನು ಹೇಳೋದೇ ಇಲ್ಲ. ರಿಮೈಂಡ್ ಬ್ಯಾಕ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. ಫ್ರೆಶ್ ಡಿಸ್ಪೋಸಲ್ ಬೋತ್ ಸೈಡ್ ಡಾಕ್ಯುಮೆಂಟ್
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಹಂಗಾದ್ರೆ?
ನಾನ್ ಮಾಡಿದ್ದೀನಿ ಸರ್. ಆದ್ರೆ ಇಲ್ಲಿ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರು ಸ್ವಾಮಿ ಸ್ಪಾಟ್ ಬಂದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಕ್ ಬಂದ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ. ಪೊಸಿಷನ್ ಯಾರು ಇಲ್ಲ, ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಈಗೆಲ್ಲ ಬೀಳ್ಬಿದ್ದೋಗಿದೆ. ಹಾಗಾಗಿ ಪೊಸಿಷನ್ ಬಂದ್ರೆ ರಿಪೋರ್ಟು ಇವ್ರಿದ್ದಾರೆ ಅವ್ರಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾವ ತರ ಇನ್ಫ್ಲೂಯೆನ್ಸ್.
ಸರ್ವೆ ಮಾಡ್ಲಿ ಬಿಡಿ, ಏನಾಗತ್ತೆ ಅದು?
ಅಲ್ಲ ಸರ್ವೆ
ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಮಾಡ್ತಿರ್ತಾನೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 7 ಅಲ್ಲಿ ನಿಮ್ ಲ್ಯಾಂಡ್ ಇದೆಯೋ, 7/2 ನಲ್ಲಿ ನಿಮ್ ಲ್ಯಾಂಡ್ ಇದೆಯೋ ಅಂತೇಳಿ ಅದು ಫಸ್ಟ್ ಡಿಸೈಡ್ ಆಗ್ಬೇಕು. ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಅಡಿ ಲೆಕ್ಕದಲ್ಲಿ ಮೆಜರ್ಮೆಂಟ್ ಹಾಕಿದರೆ ಆ ಪ್ರಕಾರ 7.5 ಗುಂಟೆ ಬರ್ತದೆ, 2 ಎಕರೆ 5 ಗುಂಟೆ ಬರ್ತದೆ. ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ ನಿಮ್ದು ಲ್ಯಾಂಡ್ ಇರೋದೇ 7.5 ಗುಂಟಾಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದೆ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಅದು ಅಲ್ಲಿ ಅವರು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಕೂಡ ಮಾಡಿಲ್ಲ, ಯಾವುದೇ ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ ಕೂಡ ಹಾಕ್ಬಿಟ್ಟು ಒಂದು 2 ಎಕರೆ 5 ಗುಂಟೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಕೂಡ ತಗೊಂಡಿಲ್ಲ. ಹಾಗಾಗಿ ಈ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಬಂದಾಗ ಅವ್ರು ಯಾರ್ ಫೇವರ್ ಆಗಾದ್ರು ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ, ಬೈ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಆ ತರ ಎಲ್ಲ ಇರುತ್ತೆ. ಯಾಕಂದ್ರೆ ದೇರ್ ಸೇಲ್ ಡೀಡ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫಸ್ಟ್ ಡಿಸೈಡ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ, ಅವ್ರದೇ ಸೂಟು. ಸೇಲ್ ಡೀಡ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಸೇಲ್ ಡೀಡ್ ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 29 ಇಂದ ಓದಿ. 29.
ಪೇಜ್ ನಂಬರ್
All these records reveal. ಲಾಸ್ಟ್ ಒಂದು 4 ಲೈನ್ ಕೆಳಗಡೆ ನೀವು 4th ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ವಾ ಅಲ್ಲಿ?
ಹೌದು ಸ್ವಾಮಿ, 4th ರೆಸ್ಪಾಂಡೆಂಟ್
ಚೌಡಯ್ಯ ರಂಗಯ್ಯ.
ಹೌದು ಸರ್.
All these records related to land was verified. ಓದಿ ಅಲ್ಲಿಂದ.
ಕಾಲಮ್ ನಂಬರ್ 12(7).
Last 4 lines. All these show records related to
All
said
the
land.
shows records related to this said land has to be verified. The petitioner has not accepted this survey. Durastu ADL MPR 579798 and questioned the same in DDLR revision number 2 of 2223. The order passed by the DDLR dated 18/6/23 set aside ADLR survey Durastu number MPR 5798 and agreed by the DDLR order. The 4th respondent filed appeal to this tribunal. This tribunal held that the application filed by the 4th respondent is not maintainable and directed the 4th respondent to file a revision petition before the 1st respondent. The 1st respondent by his order dated 22/3/25 allowed the revision petition and set aside the order dated 18/6/23 passed by the 2nd respondent in revision number 2/2223 and restored the order in number ADLR MPR 57/9798. Petitioner is aggrieved by this order. It states that survey conducted by the ADLR is false survey and it was not conducted in his presence and state that he has not signed in the Mahazar. This shows that the petitioner has not been given opportunity. An opportunity has to be given to the petitioner to prove his case which will throw light upon the matter in dispute. Hence, this tribunal came to the conclusion that it is necessary to interfere with this order passed by the first respondent by setting aside the order dated 22/3/25 and remanded the matter to the respondent number 1 with a direction to afford to opportunity to both the parties to come forward.
He was not a party to the survey.
ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ನನ್ನ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು.
ನಿಮ್ಮ absence ಅಲ್ಲಿ, ಅವನ absence ಅಲ್ಲಿ.
ಅವ್ರ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರು.
ಅಬ್ದುಲ್
ಸೆಕೆಂಡ್
ಕರೀಂ ಸಾಬ್ absence ಅಲ್ಲಿ.
ಆದ್ರೆ ಅಲ್ಲೆಲ್ಲೂ ಕೂಡ ಅವ್ರದ್ದು ಸೇಲ್ ಡೀಡ್ ಕಾಪಿಗಳು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಇವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರ ತಗೊಳ್ಳಿ, ಇವಾಗ ಸರ್ವೆ ಆದಾಗೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗ್ಬಿಟ್ರೆ ಔಟ್ಕಮ್ ಆಫ್ ದಿ ರಿಸಲ್ಟ್ ಇನ್ OS ನಂಬರ್ 197 ಆಫ್
ಸರ್ವೆಗೂ ನಿಮ್ಗೆ ಸಿವಿಲ್ ಸೂಟ್
ನಾವು ಪೊಸಿಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಇವ್ರೇನ್ ಡಿಸೈಡ್ ಮಾಡಲ್ಲ, ಬರೀ ಸರ್ವೆ ಮಾಡ್ತಾರಲ್ವಾ ಆನ್ ದಿ ಬೇಸ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಬಂದಾಗ ಹೆಂಗ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ನಮ್ದು ಆಲ್ರೆಡಿ ಸರ್ವೆ ಎಲ್ಲ ಟೋಟಲ್ ಇವಾಗ 20 ಜನ ಪರ್ಚೇಸರ್ ಇದಾರೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ.
ಇದು ಯಾವತ್ತಿದ್ರು ರಿಸಲ್ವ್ ಆಗ್ಲೇಬೇಕು ತಾನೆ.
ಅಲ್ಲ, 197 ಔಟ್ಕಮ್ ಆಫ್ ದಿ ರಿಸಲ್ಟ್ 197 ಡಿಕ್ರಿ ಆಗುತ್ತೆ, ಜಜ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಅದ್ರ ಮೇಲೆ ಯಾರ್ದು ರೈಟ್ಸ್ ಅಂತ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
ಹಂಗಾರೆ ನೀವು OS ಆದ್ಮೇಲೆ RFA ಅದೆಲ್ಲ ಆಗೋರು ಯಾರು ಏನ್ ಮಾಡಂಗಿಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಅವರೇ ಹಾಕಿರ್ತಕ್ಕಂಥ ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ಸ್ ಅವ್ರದ್ದು ಸೇಲ್ ಡೀಡ್ ಓದ್ತೀನಿ ಸ್ವಾಮಿ, ಯಾವ ತರ ಇದೆ ಅಂತ ಹೇಳಿದೆ. ಫಸ್ಟ್
ಅಲ್ಲಿ ಇತ್ಯರ್ಥ ಮಾಡಕ್ ಹೋಗುತ್ತೆ, ಇವಾಗ ಇತ್ಯರ್ಥ ಮಾಡಕ್ ಆಗುತ್ತಾ? ಸರ್ವೆ ಒಂದು ಬೇಸಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸರ್ವೆ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ಇಲ್ಲೂ ಕೂಡ ಔಟ್ಕಮ್ ಆಫ್ ದಿ ರಿಸಲ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ವಾಮಿ, ಅದು ಅಪೀಲ್ ಗಂಟ ಹೋಗ್ಲಿ, ರಿವಿಷನ್ ಹೋಗ್ಲಿ, ಅದೇ ಮಲ್ಟಿಪಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಅವಾಯ್ಡ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಅಂದ್ರೆ ನೀವು ಸರ್ವೆ ಮಾಡಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ ನಿಮ್ ಪ್ರಕಾರ?
ಹೌದು ಸ್ವಾಮಿ, ಔಟ್ಕಮ್ ಆಫ್ ದಿ ರಿಸಲ್ಟ್
ಹೆಂಗಾಗುತ್ತೆ ಆ ತರ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ಗಳು ಅವರೆಲ್ಲ ಸರ್ವೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಲ್ಲ ಅದೇ ಇರ್ತದೆ. ಮತ್ತೆ ಅವರು ಪೊಸಿಷನ್ ಇಲ್ಲ, RTC ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ. ಅವ್ರು ಸರ್ವೆ ಮಾಡಕ್ ಬಂದ್ರು ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ಗಳೇ ನೋಡ್ಬೇಕು.
ಅವ್ರ ಇಲ್ವಾ?
RTC ಇಲ್ಲ ಸ್ವಾಮಿ, RTC ಕಾಲಮ್ ಅಲ್ಲಿ ಇದೆ, ಅವ್ರಿಗೆ ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಅಂತ ಇಲ್ಲ.
ಅದೇ ಇವಾಗ ಗೊತ್ತಾಗತ್ತಲ್ಲ, ಅವ್ರು ಸರ್ವೆ ಮಾಡಿದಾಗ ಅವ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡ್ ಮಾಡ್ತಾರೆ, ಅವ್ರಿಗೆ ಇದೆಯೋ ಇಲ್ವೋ ಜಮೀನು, ಕ್ರೊನಾಲಜಿಕಲ್ ಆಗಿ ಹೋಗ್ತಾರೆ. ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಯಾರ್ದು, ಸೆಕೆಂಡ್ ಸೇಲ್ ಡೀಡ್ ಯಾರ್ದು ಅಂತ. ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರ ಜಾಗ ಇದೆಯೋ ಅಂತ ಗೊತ್ತಾಗುತ್ತಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಸ್ವಾಮಿ ನಾನು ಇಲ್ಲ ಎಂಟೈರ್ RTCಗಳು 1968 ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಅವ್ರದ್ದು ಸೇಲ್ ಡೀಡ್ 77. 1968 ಅಲ್ಲಿ 7 ನಂಬರ್ 7/1, 2, 3, 4 ಅಂತ ಇದೆ. 77 ಅಲ್ಲಿ 7 ಪೈಕಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ ಇವಾಗ ಫಸ್ಟ್ ಅದ್ರ ಮುಂಚೆ ಯಾರು ತಗೊಂಡಿದ್ರಲ್ಲ ಅವ್ರ ಜಾಗ ಅಂತ ಗೊತ್ತಾಗುತ್ತಾನೆ.
ಆದ್ರೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವರು ಎಲ್ಲಾ ಬೌಂಡ್ರಿಗಳೆಲ್ಲ ಉಲ್ಟಾ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ
ಏನಾರು ಹೇಳ್ಕೊಳ್ಳಿ ಕಣ್ರಿ, ಸರ್ವೆ ಮಾಡಿದಾಗ ಈ ಕ್ರಯಪತ್ರಗಳು ಆಧಾರದ ಮೇಲೆ ತಾನೇ ಸರ್ವೆ ಮಾಡೋದು.
ನಮ್ದು 88 ನಮ್ದು ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಬರೋದಿಲ್ಲ. ಅವ್ರಾಗ ಬೇಕಾದ್ರೆ ಅದನ್ನು ಅವಾಗ ಮಾಡ್ಬೋದು, ಅವ್ರದ್ದು ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಅಂತ ಹೇಳ್ಬೋದು. ಆದ್ರೆ ಇದನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಲ್ಲ. ಹಾಗಾಗಿ OS ನಂಬರ್ 197 ಔಟ್ಕಮ್ ಆಫ್ ದಿ ರಿಸಲ್ಟ್ ಮೇಲೆ ಸರ್ವೆ ಆದ್ರೆ ಒಳ್ಳೇದು.
ಔಟ್ಕಮ್ ಆಫ್ ದಿ
ಡಿಕ್ಲರೇಟರಿ ಸೂಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಈ ಕೇಸಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರೇ ಫೈಲ್ ಮಾಡಿರೋದು, ನಮ್ಮ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ. ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದಿರೋದು 7 ನಂಬರ್ 7 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ, ನಮ್ದಿರೋದು 7 ನಂಬರ್ 7/2 ನಲ್ಲಿ. ಹಾಗಾಗಿ ಅವ್ರ ಟೈಟ್ಲ್ ನ ಅಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಅವರೇ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಇದು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಅನುಕೂಲ ಆಗುತ್ತಾನೆ, ಯಾರ್ದು ಎಲ್ಲಿದೆ ಅಂತ ಹೇಳೋದಕ್ಕೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ, ಅಧಿಕಾರಿಗಳು ಯಾವ ತರ ಇರ್ತಾರೆ, ಮಲ್ಟಿಪಲ್.
ನೀವು ಅಧಿಕಾರಿಗಳ ಜೊತೆ ಶಾಮೀಲಾಗಿ ನೀವು ಒಂದು ಸರ್ವೆ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರೆ ಮುಂಚೆನೆ, ಅದು ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗಲ್ವಾ?
ಯಾಕಂದ್ರೆ ನಾವು EC ಅಪ್ಲೈ ಮಾಡಿ ತಗೊಂಡಿದೀವಿ ಪ್ರಾಪರ್ಟಿ.
ನಿಮ್ ತಗೊಳ್ಳೋದಲ್ಲ, ನಿಮ್ಗೆ ಯಾರು ಮಾರಿದ್ರಲ್ಲ ಅವ್ರು ನಿಮ್ಗೆ ಮೋಸ ಮಾಡಿ ಸರ್ವೆ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರೆ ಇನ್ನೊಬ್ರು ಜಮೀನ್ ಮುಚ್ಚಿಟ್ಬಿಟ್ಟು, ಅದು ತಪ್ಪಾಗಲ್ವಾ?
ಅಲ್ಲ, ಇನ್ನೊಂದು ಸ್ವಾಮಿ, ನಂದು 1982 ನಲ್ಲಿ ನಂದು ಸೇಲ್ ಡೀಡು. ಆ ಸೇಲ್ ಡೀಡ್ ಆಗ್ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ MR ರೆಕಾರ್ಡ್ ಆಗೋದೇ ನನ್ನ ಹೆಸರಲ್ಲಿ.
ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಅವ್ರು ಕೊಂಡ್ಕೊಂಡಿರ್ತಾನೆ.
ನಾವು ಅವರು ಒರಿಜಿನಲ್ ಓನರ್ಸ್ ಕೂಡ ಒಂದು 260 ಅಂತ OS ಸೂಟ್ ಹಾಕಿದ್ರು. ನಾವು ಅವ್ರಿಗೆ ಬರ್ತೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, 7.5 ಗುಂಟೆನೂ ಕೊಟ್ಟಿಲ್ಲ, 2 ಎಕರೆ 5 ಗುಂಟೆನೂ ಕೂಡ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
The writ petition is filed challenging an order passed by the Karnataka Appellate Tribunal, whereby the Karnataka Appellate Tribunal has set aside the order passed by the JDA.
ಅದು ಸೇಲ್ ಡೀಡ್ ಒಂದು ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. 19th
the matter to the first respondent, the direction to afford an opportunity to both the parties to come forward with all available related documents and to take action in accordance with law. In my view, since the tribunal is only remanded the matter with a specific direction to the first respondent to consider all the materials that are placed before him before conducting the survey, there is no justification for interference with the said order. The petition is therefore dismissed.
Till number 5. Till number 5.
survey numbers were left out. For that reason that I have, instead of amending the same, I filed it. Otherwise, it is.
My lords.
Oh.
Bilu lands.
Bit-
Bilu lands. My lords, their case is that, my lords, in the earlier round of litigation, these two survey numbers were left out. And even in that, in respect of that, there is still no restoration done. In respect of the two survey numbers here in my lords, there seems to, it was forfeited, my lords, when it was belonging to Uregowda. In 1960 itself, it was forfeited. Thereafter, my lords, we had given multiple timelines for the purpose of applications, my lords, to be
I
made.
was keen on finding out who are you to give timelines?
Please, my lords.
Who are you to give timelines? You can sell the property for recovery of land revenue.
Please, my lords.
As and when they come and pay the money,
Please.
you will have to restore it. You have the right to sell it before that is done. If you don't sell it, are you going to say that, no, I have acquired it because you've not paid land revenue, you cannot get it restored at all?
No, my lords, in the earlier circulars actually provided a timeline, my lords. I get what my lords are saying. That I could not have fixed such timelines by virtue of a circular because it was an inherent right, my lords, in a tenure holder to come and say that at the end of the day, I'm paying the land revenue. Please, whatever fine if you are imposing, please restore my land. That, my lords, the problem is not about restoration, my lords, to the actually person who is entitled to that.
See the provision. It
Please.
says any person interested in the land.
No, my lords, there is some, my lords, in fact, in this matter, serial number 16 also, I'll be appearing, my lords. There, what is happening is this, there seems to be, my lords, some persons, my lords, who are trying to take advantage of this and trying to create records, my lords, and seek for restoration of lands. Because now they have also come to know, my lords, that these Bilu lands are liable for restoration. So I have spoken to the Revenue Secretary. We want to come up with some solution, my lords, before.
Can you look at the provision?
Please, my lords, I understand there's also a judgment, my lords, by they're relying upon in the earlier round of litigation. If my lords may see, my lords, the judgment also is available, where at annexure E, my lords, where this honorable court, my lords, has also given a finding that the intention, my lords, was if it does not exceed 10,000, the arrears of land revenue, at page number 24 only there. Kindly see page number
Read
24.
the provision first. Give the judgment. Read the provision.
163.2, my lords, may kindly see 163.2 and 87.
In fact, I think I've rendered one judgment saying that you cannot, there's no limitation fixed. The only limitation is auction.
Yes.
If it's already auctioned, sold,
Please,
then obviously the question of restoration would not arise.
please, and if it is already utilized, my lords, for other purposes.
How can you utilize it?
My lords, because that is what I was informed, that in some cases, my lords, if it is
Read
granted,
163.
please, my lords, forfeiture of occupancy of or alienated holding. The Tahsildar may declare the occupancy or alienated holding in respect of which an arrear of land revenue is due to be forfeited to the state government and sell or otherwise dispose of the same under the provisions of section 87 and 88 and credit the proceeds, if any, to the defaulter's account, provided that the Tahsildar shall not declare any such occupancy or alienated holding to be forfeited unless previously thereto he shall have issued a proclamation and written notices of the intended declaration in the manner prescribed under section 168 for effecting sales of immovable property, and until after expiration of at least 15 days from the latest date on which any of the said notices should have been published as prescribed under section 168. Provided further that notwithstanding anything contained in subsection 1 of section 87, the Tahsildar shall not declare any such occupancy or alienated holding to be forfeited to the state government where the arrears of land revenue due does not exceed 10,000 rupees. When any occupancy or alienated holding is declared forfeited under subsection 1, the Tahsildar may, before such occupancy or alienated holding is sold or otherwise disposed of, cancel the declaration of forfeiture if the defaulter or any person interested in the occupancy or alienated holding pays the entire arrears of land revenue due and all expenses incurred so far in the recovery proceedings as may be fixed by the
It
Tahsildar.
includes any person interested in the occupancy or alienated holding. Not necessary that the person in whose name the kata was standing alone should come and pay.
No, lords, if it is a successor in interest, if there is something,
Anybody, your job is to collect the revenue. If somebody is coming forward to come and pay the revenue, can you say that, no, you are not the person liable to pay, he is the person liable to pay? I won't accept.
lords, in fact, I wanted to point it out in serial number 16. It is a bit, it is, no, I'll just want
Relax,
to.
I'm not going to do anything. It's all right, relax. I will not do anything without hearing.
Lords, it is a Bilu land. Records have been created, my lords, and now they're seeking for restoration. That is a my lords, what is happening is we just it has come to the notice of the state, my lords, that there is some mischief that is going on with regard to restoration of Bilu lands.
We just, if it is a genuine case, my lords, I understand.
Not a question of genuine or not genuine.
Please, my lords,
You're in arrears.
please.
So you forfeit the land, government forfeits the land. I come and say, all right, take your money, I will satisfy your debt. Then you
Please.
say that, no, I will not allow you to satisfy the debt. I will, I have a right over this land and I'll keep it for myself, or I'll allow it to be used for any other purpose.
No, my lords, on
Acquisition then virtually.
No, my lords, on first principles logic, my lords, fine, my lords. But what happens is, suppose tomorrow, my lords, another the actual owner comes and says, I'm going
Take
to pay.
revenue from him also. If somebody is paying you revenue, why do you say no?
No, my lords, at the end of the day, it was not because it is in rupees and paises. My lords, no, the revenue, my lords, is not actually, it is not a question of collection of revenue at the end of the day, because it's a very small, meager amount, my lords, that is there. So payment, my lords, everybody is ready to do it because now they know that there is a bill of land and that revenue.
Can you use that as a tool to say that, no, now that there's an entry, even if you comply with the legal provision and pay the money, I will not allow you to enjoy your land?
No, my lords, for that, what we wanted to state before, my lords.
I still don't know as to what is the effect of saying below. Does it mean that you have dispossessed him? I am living in my house, I don't pay property tax.
Please.
And you make an entry in your register that is a defaulter. Does my house become your house?
No, my lords. I get it, my lords, that I think that illustration, my lords, that my lords just have given with regard to the house may not be applicable, my lords, in the context of the revenue.
How do you, let's assume that he is in arrears.
Please.
If you order forfeiture,
Please.
how do you dispose it? Again, you need to go back to section 39 only.
Please. No, my lords, insofar as,
You have take possession, then sell to recover ultimately your land revenue.
please.
And if somebody is coming forward to pay that amount, no, I will not, you're playing.
Lords, in fact, lords, in view of the second proviso to subsection 1, this honorable court, my lords, has also gone to the extent of saying, because we have used the word does not exceed 10,000 rupees, that it was the intention of the state to.
Subsection 2 operates independently.
Please.
Whenever they come and offer that money, you have no option.
Lords, we just, lords, I understand we have issued the earlier three opportunities were given. If they have not taken that opportunity, I understand, my lords, that my lords have taken a view that that right to get it restored, my lords, is not bound by any time limitations because the statute does not impose such a time limitation. Can we have a look at and come back, my lords? Because on this aspect, the state just wants to come out with something so that there is, my lords, I understand if it is a case, my lords, where it has to be restored, it is a restoration. We are not coming.
Not a question of you. It's you're telling us you're doing a favor to them by
No,
restoring.
not as a favor, my lords,
They are
but.
doing you a favor by giving you the revenue.
Lords, but if the amount is looked at, there is no favor there, my lords.
Then
It is
think
just
of the Land Revenue Act itself. The entire act is meant to collect revenue.
please, my lords.
The revenue that you collect is like a minuscule percentage of the money that you spend on payment of salaries to all your officials.
Please.
But then why do you want this act itself? To collect 1 rupee, 2 rupee?
Please, my lords. Maybe the book is, the cost of the book is more than
Why do you,
the assessment.
I fail to understand why you need to have this act. It's only being used to make money. Conversion fine is, that is all that is being done.
Lords, conversion is when we are, the user is sought to be changed.
I have my doubts, Ruben, as to my property.
Please.
How do you say how I should use it?
Lords, that
You can regulate it, you can regulate the usage. This is a master plan. But my land, I will do whatever I want with my land. Why should I ask your permission to use it for XYZ purpose?
Lords, regulatory approvals, my lords, it is just a
No.
matter.
Moment there's a revised master plan,
Please.
then you're right, automatically the use is gone by that particular master plan. Suppose there's no master plan. And I have some land somewhere where there's no plan. Why should I ask your permission to use it for some other purpose?
No, if you are deviating, my lords, from an agriculture to a non-agricultural.
Where is the very purpose of the Land Revenue Act is to ensure that you collect revenue. This was enacted in a time when there was no income, when this was the only source of income for the kings and for the government. So therefore they said, if you're going to convert it,
Please.
we will lose revenue. We will not permit you.
But by conversion, you get better revenue now.
No, if you want, no, forget about now context.
Please.
If you want to use it for another purpose,
Please.
you would collect what is known as a conversion fine.
Yeah, fine.
That is a fine for you depriving revenue to the government. You cannot get a right to say that you will use it only for this particular purpose. I don't want to use it for agriculture. I am just a lazy person. You say that no, you will have to use it for agriculture, or else I will do this, I will do that.
My lords, all we are saying is take a, because now it is used, now at best, my lords, it is being used as a regulatory approval, where for the purpose of, you want to deviate.
You're misusing the provisions of the act, isn't it?
No, my lords, I would, my lords, from the fact, I would not say it is a misuse of the provision, my lords. My lords are coming from first principles, my lords, trying to interpret it, my lords, in a particular manner. My lords, insofar as Bilu is concerned, we just want some short accommodation, my lords, will come back. Insofar as his case is concerned, he had earlier sought, my lords, for restoration, my lords, cancellation of the forfeiture in respect of several survey numbers. And now he says 2 survey numbers were left out. But in this, there are those 2 survey numbers. I don't know for what reason he leaves it out. 2 survey numbers. He has sought for restoration of around 15 survey numbers earlier. 2 survey numbers are left out. He has come with this petition. But any which way, my lords, I will just place, my lords may take a view, my lords, this way or the other on that.
What are you taking a view? I'm only reiterating that view.
No, I will have a look at that judgment, my lords. I'll come back to that.
ಅವರೇ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಿಟ್ಟೋಗಿರೋದು ಒಂದು ಅದಕ್ಕೋಸ್ಕರ
ಅಲ್ಲ, ಅದು endorsement ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ವಿ, you file an application, but the provision for application is not there. So I think
this court has negated that contention and directed Tehsildar to accept it. What is more then can be done?
No, no,
Say 163.
lords, if insofar as his case is concerned,
I'm sure that this is the only case where people are coming for a desperately pay you money and you're saying, no, I will not take your money.
no, if it was a substantial, maybe we spend more money collecting that amount than rather the amount that gets collected.
I think you're wrong. Day after tomorrow.
My lords, weeks, my lords, 1 week's time. Maybe next Thursday, my lords. 10 also, no?
Which is yours?
Lords,
Same.
that is a case of Bilu, but it is a case of fake grant, my lords. We have got the records. They have inserted.
As the fake grant, bro.
They are claiming that they are grantees. We have got the grant records. Even in the index of land,
In the revenue records, it's shown as below.
it is shown, my lords. Earlier, my lords, it was Bilu, even in the index of lands. Before the provision of the Land Revenue Act came into force, even in the index of lands, it was shown as below. Then, my lords, it was given to the forest. It was taken back from the forest land. That was a mutation, my lords, on the basis of which
What is
RTC
the
sent.
exact meaning of below?
Lords, it is actually,
Below.
lords, in this, we are filing our statement of objections. So, can we file it, my lords, take it on the same day?
Give him a copy. He's filing objections. Take a look at it.
I will also file in your documents.
Bill number 10.
Lords, same. Lords, on the same day, my lords, all 3 matters.
Same. Number 10.
Lords, can it be taken on the same day, my lords, all 3? Grateful.
You're the other,
Number 10.
And also. Grateful. lords.
Third day.
Bill number 19.
Already Deputy Commissioner was passed an order in the serial number 10.
10.
10.
Iನ್ನು same.
Sarkari bill, it is
Same day.
published.
Bill number 19.
Somshekhar. Village map, madam, village map ಕೊಡಿ. Village map. Give me that village map that you enlarge ಇದೆಯಾ ಅದು? This one. Point has to be taken again. H to box of box. BB. When you have BB. Started point here. On top of them. They have to take. ಯಾವ ಅದರ ಮೇಲೆ ಇಟ್ಟಿದ್ದಾರೆ? ಅವ್ರು ಇಲ್ಲಿಗೆ ತಗೊಂಡಿದ್ರು ಪಾಯಿಂಟ್ ಇಲ್ಲಿಗೆ ಬರಬೇಕು, ಇಲ್ಲಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ. ಈ ಪಾಯಿಂಟ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ತೋರ್ಸೋದಕ್ಕೆ ಸೇವ್ ದಿಸ್, ಈ ಪಾಯಿಂಟ್ ಇಲ್ಲಿಗೆ ಬರಬೇಕು, ಇಲ್ಲಿಗೆ ತಗೊಂಡು ಈ ಪಾಯಿಂಟ್ ಇಲ್ಲಿಗೆ ರೈಸ್ ಮಾಡಿದ ತಕ್ಷಣ ಇಲ್ಲಿಗೆ ಬರ್ತದೆ. ಇಲ್ಲಿ ತಗೊಂಡ್ರೆ ಇಲ್ಲಿ ಈ ಸ್ಕೆಚ್ ಪ್ರಕಾರ 3B ಬಾಕ್ಸ್ 3B ಅವರೇ ಮಾಡಿರೋ ಸ್ಕೆಚ್ ನಾವು ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಇದ್ದಿಲ್ಲ. ಈ ಬಾಕ್ಸ್ ತಗೊಂಡ್ರೆ ಇಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ಪಾಯಿಂಟ್. ದೇ ಹ್ಯಾವ್ ಟು ಆಕ್ಚುಲಿ ಟೇಕ್ ಇದು ಎಂಡ್ ಪಾಯಿಂಟ್. ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಶಿಫ್ಟ್ ಮಾಡಿದ್ರೆ ನನ್ನ ಮನೆ ಇಲ್ಲಿದೆ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ತಗೊಂಡೋಗಿದಾರಲ್ಲ, ಇಲ್ಲಿ ಜಾಯ್ನ್ ಆಗಿದೆ. ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದ್ರೆ ಇದು ಇಲ್ಲಿ ಇದ್ರ ಮೇಲೆ ಸ್ಕೆಚ್ ಅದರಲ್ಲಿ ಇಲ್ಲೇ ಗೊತ್ತಾಗಿದೆ ನೋಡಿ. ಇದೇ ಸ್ವಾಮಿ 3B ಬಾಕ್ಸ್, ಈ ಬಾಕ್ಸ್ ಕರೆಕ್ಟ್. ಈ ಬಾಕ್ಸ್ 3B ಅಲ್ಲ, ನಾನು 3B ಅಂತ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ ಸ್ಕೆಚ್ ಅಲ್ಲಿ. ಈ ಪಾಯಿಂಟ್ ನ ಇವಾಗ ಇವರು ರೋಡ್ ಅಂತ ತೋರಿಸಿದಾರೆ, ಇಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ, ಇಲ್ಲಿಂದ ತಗೊಂಡು. ಇಲ್ಲ, ಅದು ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದ್ದೀರಾ ಅಂತ ನಂಗೆ ಅರ್ಥ ಆಗ್ತದೆ. ಆಧಾರದ ಇವ್ರು ಸ್ಕೆಚ್ ಮೇಲೆ, ಇವರು ಮಾಡಿರೋ ಸ್ಕೆಚ್ ಮೇಲೆ ಗೂಗಲ್ ಮ್ಯಾಪ್ ನ ಇವ್ರು ಪ್ರಿಪೇರ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ಅಲ್ಲ, ನಾನು ಹೇಳಿದವ್ರಿಗೆ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ವಿಲೇಜ್ ಮ್ಯಾಪ್ ನ ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿಲ್ಲ. ಅದನ್ನ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಮಾಡಿದ್ದೀನಿ. ಅದಕ್ಕೋಸ್ಕರ ಅದ್ರ ಮೇಲೆ ಆಧಾರದ ಮೇಲೆ ಇದ್ರ ಆಧಾರದ ಮೇಲೆ ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿಗೆ ಬರಲ್ಲ, ಸ್ವಲ್ಪ ಪಾಯಿಂಟ್ ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ. ಇಲ್ಲೇ ಹೇಳ್ತಿದೆಯಲ್ಲ ನೀವು, ಅದು ಹೇಳೋ ಅದು ಸಂಶಯಗಳಿಗೆ ಅದಕ್ಕೆ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದ್ದೀರಾ? ಅಲ್ಲ, ಅವ್ರ ಸ್ಕೆಚ್ ಆಧಾರದ ಮೇಲೆ, ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಆಧಾರದ ಮೇಲೆ. ನೀವು ಎಕ್ಸ್ಪರ್ಟ್ ಅಲ್ಲ, ಸರ್ವೆ ಎಕ್ಸ್ಪರ್ಟ್ ಅಲ್ಲ, ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಪಾಯಿಂಟ್ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಆಯ್ತಾ. ನೀವು ಅದು ನಿಮ್ಮ ಅನುಕೂಲಕ್ಕೆ ತಕ್ಕಂಗೆ. ಇಲ್ಲಿ ನನ್ನ ಅನುಕೂಲಕ್ಕೆ ಏನಿಲ್ಲ, ಅಲ್ಲೇ 3B ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಇದು 3B ಬಾಕ್ಸ್ ಇವ್ರು ಹಾಕಿರೋ ಬಾಕ್ಸೇ. ಅಲ್ಲಿ ತಗೊಂಡೋದ್ರೆ ಈ ಮನೆಗಳೆಲ್ಲ ಹೊರಟೋಗ್ತವೆ ಸ್ವಾಮಿ. ಈ ಪಾಯಿಂಟ್ ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ. ನನ್ನ ಪ್ರಕಾರ ಇವ್ರು ಹಾಕಿರೋ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಈ ಮನೆಗಳೆಲ್ಲ ಹೋಗುತ್ತೆ. ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಈ ಬಾಕ್ಸ್ ನ ಇವ್ರು ಇಲ್ಲಿಗೆ ಹಾಕಿದ್ದಾರೆ, ಆಕ್ಚುಲಿ ಈ ಬಾಕ್ಸ್ ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕು. ಬಾಕ್ಸ್ ಇಲ್ಲಿಗೆ ಬಂದ್ರೆ ಈ ಬಾಕ್ಸ್ ಇಲ್ಲಿರೋ ಬಾಕ್ಸ್ ಇಲ್ಲಿಗೆ ಬಂದ್ರೆ ಅದು ಇಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಸ್ವಾಮಿ. ನಮ್ಮ ಮನೆ ಹಿಂದೆನೆಲ್ಲ ಹೋಗುತ್ತೆ, ರೋಡ್ ಇದೆ ಅನ್ನೋದು ಕರೆಕ್ಟ್. ಇಲ್ಲಿಗೆ ಹಾಕಿದ್ದಾರೆ. ಈ ಬಾಕ್ಸ್ ಇರೋದು ಇದು ಇಲ್ಲಿಗೆ ಬರಬೇಕು, ಇದು ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ. ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಕಮಿಷನರ್ ಕ್ಯಾನ್ ಬಿ ಅಪಾಯಿಂಟೆಡ್ ಫೈಂಡ್ ಔಟ್ ದಿಸ್. ಅವರು ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ ಸರಿಯಾಗಿ, ಅವರು ಹೇಳ್ತಾರೆ ದಟ್ ಕ್ಯಾನ್ ಬಿ ಅಪಾಯಿಂಟ್ ಕಮಿಷನರ್. ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಈ ಪಾಯಿಂಟ್ 3B ನ ಅವರೇ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ರು ಇಂಟ್ಯೂನ್ ಸ್ಕೆಚ್. ಈ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಪಾಯಿಂಟ್ ಸ್ಟಾರ್ಟ್ ಆಗದೆ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಅವರು ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಇಲ್ಲ ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿಲ್ಲ. ಇದನ್ನ ಇವ್ರು ಸ್ಕೆಚ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರೋದು. ಇದು ಗೂಗಲ್ ಮ್ಯಾಪ್ ನಲ್ಲಿ ಸ್ಕೆಚ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ, ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿ. ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ, ನಾನೇ ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡ್ಕೊಂಡು ಸಿಕ್ಕಿರ್ತಾವ.
Whatever the sketch they are showing, ಇದು ಬಂದು ವಿಸಾ ಸರ್ವೆ. ಇದರಲ್ಲಿ ಟು ಸ್ಕೇಲ್ ಇರೋದಿಲ್ಲ. ಇದ್ರಲ್ಲಿ ಏನು ಅವರು ವಿಸೆಗಳು ಮಾಡ್ತಾರೆ ಅದನ್ನ ಮಾತ್ರ ತೋರಿಸಿರ್ತಾರೆ, ಟು ಸ್ಕೇಲ್ ಇರೋದಿಲ್ಲ. ಇದನ್ನ ನೀವು ಸರ್ವೇಯರ್ ಹತ್ರ ಕಮಿಷನರ್ ಹತ್ರನೂ ನಾವು ಅದನ್ನ ತಗೊಳ್ಬೋದು, ಕ್ಲಾರಿಟಿ ತಗೊಳ್ಬೋದು ಮೇಡಮ್. ನಾವೇನು ಈ ಗ್ರಾಮ ನಕಾಶೆಯನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡ್ತೀವಿ, ದಿಸ್ ಇಸ್ ಆಫ್ ಇಯರ್ 1912 ಅಂತ. ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ದಿಸ್ ಯೆಸ್ಟರ್ಡೇ ಆರ್ ಟುಡೇ. It has been existing right from 100 years, more than 100 years. All this has been existing. Whatever is there on the village map, the same has been superimposed. In fact, this image is not even Google image. It is Dishank image right from Survey Settlement Department ಇಂದ ತಗೊಂಡು ನಾವು ಅದರ ಮೇಲೆ some directions ಮೇಲೆ ನಾವು ಇದನ್ನ superimpose ಮಾಡಿರೋದು. And it is whatever we have done, it is to scale also. One more ಹೌದು my lord,
ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ. ಈ ರೋಡ್ ಏನ್ ಸ್ಕೆಚ್ ಮಾಡಿದ್ದಾರೆ ನಾನು ಹೇಳಿದ್ದು, ನೀವು ಏನಾರು ನೀವು ಈ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ ಮನೆ ಅರ್ಧ ಭಾಗ ಆಗುತ್ತೆ. ನೀವು ಅಪಾಯಿಂಟ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಅಥವಾ ಕಮಿಷನರ್. How did you construct this house on road? Whose permission to construct the house?
There is no license, there is no permission.
You have taken a panchayat.
No. This is right from the panchayat PDO, which says that ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ ಇದೆ ಅಂತ ಗಲ್ಲಿ ಇದೆ.
ಸೈಟ್ ನ ಸೇವ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಇಲ್ಲಿವರೆಗೆ ತರ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
Let's kindly see the produced the sale deed, my lords.
I don't understand. ಇಲ್ಲೂ ರೋಡ್ ಇತ್ತು, ನೀವು ಸಡನ್ ಆಗಿ ಬಂದು ಇಲ್ಲಿ this is a new structure. ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಇದನ್ನೇ ನಾನು ಹೇಳ್ತಾರೆ. ನಾನು ಸದ್ಯಕ್ಕೆ you remove this. Or else I'll ask him to demolish.
This is the structure.
I'll ask him to demolish it temporarily. In the event whatever you say is found to be true, I'll ask him to reconstruct for you. Then decide ಮಾಡೋದು. ಇವಾಗ ಅವ್ರಿಗೇನ ಜಾತ್ರೆ ಇದೆ ಅರ್ಜೆಂಟ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ, ನೀವೇ ತೆಗೆದ್ರೆ ನೀವು ಆಲ್ಟರ್ನೇಟಿವ್ ನಿಮ್ಮನ್ನ ಕೇಳ್ತಿಲ್ಲ, ಅದನ್ನ ತೆಗಿರಿ. ಇವಾಗ ನಾನು ನೀವು ಗೆದ್ರೆ I will direct restoration. I'll pass it on.
another submission, my lord.
They say there is a jatri tomorrow.
Let's kindly see the photographs I have produced.
ಜಾತ್ರೆ ಇವಾಗ 6-8 ತಿಂಗಳ ಇವಾಗ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ತುಂಬಾ ಹಳೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್
ಇಲ್ಲ madam.
ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿದೀನಿ ಅಂದ್ರೆ ನಾನು ಆಯ್ತು ಬಿಡಿ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ.
My lord, ಇದು 1912
ತುಂಬಾ ಅನ್ಯಾಯ ಆಗುತ್ತೆ ಅಂತ. ಈ ಕಡೆ ಹೋದ್ರೆ ನೋಡಿ
ಎಲ್ಲಿ ನಾವು ಮಾರ್ಕ್ ಮಾಡಿದೀವಿ
ಅವ್ರು ನಾನು ತೋರಿಸ್ತಾ ಇರೋದು ಈ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಇಲ್ಲಿಂದ ಬರುತ್ತೆ. I'll pass an order. I'm giving you a chance. Once I pass an order, there's no question of restoration.
ಈಗ ಮುಂಚೆ ಫ್ರೀ ಇದ್ದಿದ್ರು my lord. ಇವಾಗ in the month of September they have constructed this one. And despite so many requests from the villages also, ಅಕ್ಕಪಕ್ಕದಲ್ಲಿರೋ villages it is a waste of time, my lord. They're doing it on purpose simply elongating the time.
ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀವಿ ಇಲ್ಲಿಂದ ಈ ಪಾಯಿಂಟ್ ಇರೋದನ್ನ ಈ ಪಾಯಿಂಟ್ ಇಂದ ಈ ಪಾಯಿಂಟ್ ತಗೊಂಡು. What are you challenging here?
I do, my lord. And ನಮ್ಮ ಹತ್ರ ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ my lord. ಅವಶ್ಯ ಬಂದ ದಾರಿಗಳನ್ನು ತಹಸೀಲ್ದಾರ್ ಒತ್ತುವರಿನರಿಂದ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ my lord ಗವರ್ಮೆಂಟ್ ಇಂದ. Acting on the basis of the circular.
ಹೇಳಿ.
Lord, petitioner is purchased the land in the year 1999 as per annexure A. Lord, 1.3/4, 1.3 gunte.
1999.
99, my lord.
Make sure.
A, my lord. 26/1999, page 9. The schedule, my lord, page 12. One point 3/4, 1.3 gunte. Lord, then my lord, we have purchased the property in the survey number 11-3A1.
What is this number?
11-3A1, my lord. 11-3A1 is totally measures, my lord, 13 guntas. Lord, annexure B, your lordship kindly see page 14. Next page. Annexure B, page 14.
Yes.
There are total extent, my lord, 13 guntas. Out of which, my lord, port karab 1 guntas. There is no ba karab. And remaining 12 guntas.
Out of 13 guntas, you purchased 1 and 3/4 guntas.
1.12, 1.3. Alle ide.
To the south was the road, to the west.
West, my lord.
Where is the road in this map?
West, my lord. West ide. West. ige.
Where is that Google map road?
Sorry. West ige. That is the west facing.
Bar 3A1.
West ಪೂರ್ವಕ್ಕೆ ವೆಂಕಟರಮಣನ ಹೆಂಡತಿ ಚೆನ್ನಮ್ಮನ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ಉತ್ತರಕ್ಕೆ ಚೆನ್ನಿ. The west facing is a road. The concrete road was formed by the panchayat.
11/3A1 is this property at the corner. You're arguing about this 11/3B, the 11/3A1 is at the intersection.
11-3A1.
That is at the intersection.
ಹೌದು ಸರ್.
So then this has got nothing to do with the property here.
11-3A3 ಅದು ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಇರೋದು. 11-3A
ಸೇಲ್ ಇರೋದು ಯಾವ್ದಕ್ಕೆ?
11-3A1A. 11-3A1. 11-3A1.
This is this property. 11/3A1. Intersection ಇದೆಯಲ್ಲ, ಎರಡು ರೋಡ್ ಇಂಟರ್ಸೆಕ್ಷನ್ ಅಲ್ಲಿ, ಅದ್ರ ಪ್ರಕಾರ 11/3A1.
3A3 ಸ್ವಾಮಿ ಬಾಕ್ಸ್ ಇರೋದು 3A3.
ಇಲ್ಲ 11/3B ಮೇಲ್ಗಡೆ 11/3A ಅಂತಾನೆ ಅದು.
ಹೌದು, ಅಲ್ಲಿ ಮೇಲೆ ಅಂತ ಹಾಕಿದಾರೆ ಅದು.
ಸೊ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಇರೋದು ಅಲ್ಲಿ, ಇವಾಗ ಹೇಳ್ತಿರೋ ಬೇರೆ ಪ್ರಾಬ್ಲಮ್.
ಇಲ್ಲ, ಅಲ್ಲಿ ತಪ್ಪು ಮಾಡಿದ್ರಿ. ಇಲ್ಲಿ ನನ್ನ ಸ್ಕೆಚ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್
ನಿಮ್ ಸರ್ವೆ ನಿಮ್ ಸೇಲ್ ಡೀಡ್
11/3A1 ಕರೆಕ್ಟ್.
11/3A1 ಟ್ಯಾಲಿ ಆಗುತ್ತೆ, ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ರೋಡ್ ಟ್ಯಾಲಿ ಆಗುತ್ತೆ.
ಹೌದು, ಟ್ಯಾಲಿ ಆಗುತ್ತೆ.
ಇವಾಗಿರೋ ಜಮೀನ್ ಸಂಬಂಧನೇ ಇಲ್ಲ ಅದು.
ಅವ್ರು ತೋರಿಸಿರೋ ಪ್ರಕಾರ ಟಾಪಲ್ ಇದೆ, 3B ಗಿಂತ ಮೇಲಿದೆ, ಟಾಪಲ್ ಇದೆ. Your Lordship kindly see the annexure E, my lord. I have produced in the year 1993.
Annexure
E, my lord, annexure E, page 17. The prepared by ADLR in the year 1993.
No. In this 11/3A1 is not shown at all.
They have not shown in the that Google map, my lord. I in top of the.
Check about Google map. We'll go by your document.
ನಂದು 3A1 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಅದೇ 11/3A1. 3A1 is my property.
3A1 is a larger extent, correct?
13
13 kuntas, my lord.
Total
13
extent
kuntas.
is 13.
In this 11/3A1,
Yes, my lord.
how do you, where do you say your 1 acre, 3.5, 3/4 guntas?
Not
is
1
situated?
acre, my lord, only 13 kuntas.
Where is it situated in this 3A1 according to annexure E? You are admitting.
Annexure E, my lord, there is a box, triangular box, my lord. This is where our property situated. Western portion is west.
Yeah, 3B ಅಂತ ಇದೆಯಲ್ಲ ಅದ.
ಅಲ್ಲ, ಟಾಪ್ ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಇಲ್ಲಿ ಒಂದು ಬಾಕ್ಸ್ ನಾನು ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಟ್ಟೆ. ಅದು ಟ್ರಯಾಂಗಲ್ ಶೇಪ್ ಅಲ್ಲಿ ಇದೆ.
ಯಾವ ಆಧಾರದ ಮೇಲೆ ಇಡ್ತೀರಾ ಅದು, ಅದೇ ನಿಮ್ ಜಾಗ ಅಂತ?
ಇಸ್ ನಾವು ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಇವಾಗ.
ನೀವೇನ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಸೇಲ್ ಇಟ್ ಪ್ರಕಾರ. See, when you purchased 11/3A1,
Yes, my lord.
after you purchased, you have not conducted any durasti.
They have not, no.
Then how do we say on a large extent of 13 guntas, your land is situated in this particular area?
Lord, now is south facing, my lord.
ಅಲ್ಲ, ನೀವು ಅಲ್ಲೇನ ಮಾಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಸೇಲ್ ಇಟ್ ಪ್ರಕಾರ ಹೋದ್ರೆ ಈ 13 ಗಂಟೆಲಿ ಎಲ್ಲಿ ಬರುತ್ತೆ ನಿಮ್ ಜಮೀನು?
Lord, is not identified, but now as per construction is made, my lord.
Then
That is
if I
sketch.
go by your sale lead, I'll simply say that the sale lead does not tally with the actual position and the fact that there's a road going.
Lord, note survey. Apart from that, my lord, your lordship kindly see this is the sketch, annexure E. Lord, before preparing, your lordship kindly see the annexure, my lord, F, page 21. They have prepared, surveyor has prepared. I have produced typed copy. Lord, I shall read, my lord, page 23.
Yes.
ಕುಣಿಗಲ್ ತಾಲೂಕು ಹುತ್ರಿದುರ್ಗ ಹೋಬಳಿ ನಾಗರನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11/3A1, 11/3A2, 11/3A3 ರಲ್ಲಿ ಕಾಲುದಾರಿ ಒತ್ತುವರಿಯಾಗಿರುವ ಬಗ್ಗೆ ಅಳತೆ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸಲು ಆದೇಶಿಸಿದಂತೆ ಸಂಬಂಧಿಸಿದ ರಾಜಸ್ವ ವೀಕ್ಷಕರು ಹಾಗೂ ಗ್ರಾಮಾಡಳಿತ ಸ್ಥಳಗಳ ಸಮಕ್ಷಮ ಜಂಟಿ ಅಳತೆ ಕೈಗೊಂಡು ಸ್ಥಳ ಪರಿಶೀಲಿಸಿದಾಗ ಮೇಲ್ಕಾಣಿಸಿದ ಸರ್ವೆ ನಂಬರ್ನ ಕಾಲುದಾರಿ ಒತ್ತುವರಿಯಾಗಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು, ನಕಾಶೆಯಲ್ಲಿ ಕಂಡಂತೆ ಒಂದು ಮೂಲ ದಾಖಲಾತಿಯಂತೆ ನಕಾಶೆಯಲ್ಲಿ ಕಂಡ ಕಾಲುದಾರಿಗಳನ್ನು ಗುರುತಿಸಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ಲಗತ್ತಿಟ್ಟು ಮುಂದಿನ ಕ್ರಮಕ್ಕೆ ಕರೆದಿದೆ. No notice has been issued by surveyor, only in the presence of RIVA. My lord, that is a sketch, my lord, page 22. I have typed page 22 or 24, my lord, page 22. Your lordship kindly see the sketch. Only kacheri upayogakke. Not, there is no notice. Nothing, no notice has been issued. Based on this, my lord, the VA submitted a report to the Tahsildar, my lord. That report is on.
Go by page 22.
Yes, ma'am.
In this page 22, how do you say that your house is situated? In which particular portion? Northern, southern, eastern, western?
Western portion, my lord.
What basis do you say that? Because your boundaries indicate something else.
Lord, my boundaries is a revenue land, my lord, agriculture land. We have constructed 1.5 guntas I have purchased, my lord, is in agriculture land as on that.
So it could be anywhere.
Lord,
May I submit?
13, please wait. It could be anywhere in the 13
Lord, it
guntas.
cannot be anywhere, my lord, because
You tell me where, because after you purchase, you have not conducted a durasti.
Lord, everybody is constructed because Bandidari is
Concerned about
past.
everybody has not come to the court. You have come to the court.
Yes, my lord.
So you should tell me where your 1 3/4 guntas is situated.
Lord, out of 3, I agree, my lord, 13 guntas, there is total extent in 3A1. My lord, out of which I have purchased the property. We have constructed house, but exactly is not where identified because all are constructed, my lord, in southern side, my lord, my relative, his uncle is property situated.
Your structure is again illegal.
Lord, is one house can be constructed by virtue of, my lord, property.
purchase, my lord. Then, my lord, there was no notice, my lord, that he's prepared page 22, your lordship kindly see.
All right, when did you put up your house? When did you construct your house?
On 20 years,
Plan idea?
no plan,
Then,
no plan.
and when did you obtain a plan for this structure?
So, ಇದು ಆಗ್ಲೇ ಒಂದು 5 years, 10 years ಆಗ್ಬೋದು ಗೊತ್ತಿಲ್ಲ.
Show me proof that you put up 5 years ago.
Lord, at least they could have issued notice to hear, give an opportunity to file objections, my
You
lord.
remove this, I'll permit them to conduct a
Lord,
survey in your
Lord,
absence.
your lordship kindly see next, my lord, they have submitted report. Based on this surveyor sketch, my lord, VA submitted report, your lordship annexure G, my lord. Based on this report, they have straight away submitted to the
Next year,
annexure G, my lord. A typed copy I have produced, my lord, page 26. Second paragraph, ನಾಗನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11 ನಕಾಶೆ ಕಂಡಂತೆ ಕಾಮಗಾರಿ ಇದ್ದು ಸರ್ವೆ ನಂಬರ್ ಸಂವತ್ಸರದಲ್ಲಿ ಖಾತೆದಾರರು 10-30 ಮಾಡಿರುವುದಾಗಿ ತಾಲೂಕು ಮೋಜಿನಿಂದ ವರದಿಸಿದ್ದಾರೆ. ಸರ್ವೆ ನಂಬರ್ 3 ರಲ್ಲಿ ಚೆನ್ನಿಗಪ್ಪ ಬಿನ್ ಚೆನ್ನರಾಯಪ್ಪ, ಎಸ್ ಲಿಂಗಣ್ಣ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮರಣ ಹೊಂದಿದ್ದು ವಾರಸದಾರ ಚೆನ್ನಮ್ಮ ಬಿನ್ ಎಂ ಲಿಂಗಣ್ಣನವರಿಗೆ 11-382 ರಲ್ಲಿ ರಾಮಚಂದ್ರಯ್ಯ ಬಿನ್ ತಿಮ್ಮರಾಯಪ್ಪರವರಿಗೆ 11-383 ನಲ್ಲಿ ಚೆನ್ನಬಾಯಿ ಭದ್ರವರಿಗೆ ನಕಾಶೆ ಕಂಡಂತೆ ಕಾಲುದಾರಿ ಇದು ತೆರವುಗೊಳಿಸುವ ಸಂಬಂಧ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಲು ವರದಿ ನೀಡಿದೆ. They have issued notice. Based on this, my lord, they have submitted, my lord, annexure H was issued. No notice has been issued before passing this order. My lord, this order was passed on 14/3/2025. Signed on, my lord, your lordship kindly 17/3.
yes.
Page 27. Signed on 17/3. My lord, immediately we came to know that, my lord, we have moved these writ petitions. Lord, as per 104, your lordship kindly see 104. Summary eviction of person unauthorizedly occupying land. Notwithstanding anything contained in the Karnataka Public Premises Eviction of Unauthorized Occupation Act 1961. So any person unauthorizedly occupying or wrongfully in possession of the any land which is covered under the section 67 or 71 of the act may be summarily evicted by the Tahsildar. That was amended by, my lord, it was inserted as deputy commissioner. Any crop including trees raised in the land shall be liable to be forfeiture, or any building or other constructions erected thereon shall also, if not removed by him after written notice, as the Tahsildar may deem reasonable, be liable to be forfeiture or summary removal. Lord 67-71, your lordship kindly see 67 is that is Kaludari, Bandudari, my lord, that is 67, my lord. 71, 67, my lord. 67 of land revenue, section 67. Public roads, etc. on all lands which are not the property of other belongs to the government. 71 also, my lord, land may be assigned for special purpose when assigned shall not be.
The area shown in, so the area shown in the village map is the government land. And
They
since
have
you
to initiate, my lord, 104.
are not able to identify your 1.131 guntas,
Yes,
you
my lord.
can't claim definitely it is part of this particular.
At least they give notice and hear and identify whether this land I have encroached or put up
You have
construction.
put up a construction in accordance with law after obtaining license. I'll agree with whatever you say. You put up a construction on a land of 13 guntas in which you own only
Not,
1.34
not
guntas
in Guntas.
without anybody's approval.
Poor people, my lord, have purchased the property, landless
Because you are
and
poor
houseless
people are-
persons, they have put up construction.
Because you are poor people, I was prepared to examine this matter and see that no injustice is done. But if you think you can control everybody by this attitude. of
Not,
yours,
my lord, not like that. They are not strong, my lord. They are, his father is there, his daughter is now residing, my lord. Father is expired. Now, daughter is residing in that house, my lord. They have no land also, my lord.
You are
except that
inviting a
property.
finding from me regarding your entitlement as to where exactly your house is situated.
Lord, that is reason, my lord, I humbly request this honorable court, by any person can be appointed. As per village map, they can submit and
Why should I
report.
entertain your petition on a speculative basis? You don't know where your land is situated. Wherever you feel, you're saying there is a pathway. Why should I take your word for granted? I'll go with the authorities. There is a village map which indicates that there's a Kaladari.
My lord, in the village
All
map,
that they are doing is they're ensuring that this Kaladari remains a Kaladari, which is their property.
my lord, there is not in existence in the village map, my lord. That is why if we enlarge one, my
Village
lord,
map is here, I'm satisfied.
Lord, otherwise, my lord, if they have given opportunity, we will file objections and show that, my lord, a competent authority, this is the road, my
Hey,
lord.
Somshekar, I gave you a choice. Remove it first. I assured you that it will be subject to restoration if you win.
430.
If you don't want to do it,
430
you
may be called, my
I will give a categorical finding that this is a road and you encroach upon the road.
I will ask.
I will go by the Google photograph and give that finding.
I will
ಆಮೇಲೆ
ask.
ಇದ್ದೇ ಇದೆ ನಿಮ್ಗೆ ಏನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
4:00.
Notice has been issued, my lord.
4:30. I want him to remove it by himself so that in the village,
That's,
there won't be any unnecessary,
may permit me to submit, my lords.
you are not yet impleaded, wait.
No, my lords, annexure, I have produced, my lords, I have purchased earlier in the year 91, 92, my
Please
lords.
wait, let him get back at 4:30.
Seal number 21.
There's some mistake. Yes, they'll find out and rectify. This file relates to 1P Venugopal. But the number shown is 8564 only.
Yes, ma'am. I understand, ma'am. No problem.
ಇದು ಈ ಹೆಸರು ಹಾಕಿದ್ರೆ ಹಂಗೆ ಬರುತ್ತಾ?
ಬಂದು ಕೇರಳ.
ಏನ್ ಮಾಡೋದು? ಈ ಆರ್ಡರ್ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್ ಪೊಸಿಷನ್ ಹೋಗ್ಬೇಕು. I'll get it posted before the appropriate court. First, let me find out what exactly is there. ಇಲ್ಲ ಅದು ಆ ಫೈಲ್ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಈ ಫೈಲ್ ತೊಂದರೆ ಆಗೈತೆ ಅದು.
Seal number 24.
Secretary for the petitioner. 24/5/2004 notes. Government executed a lease deed. Favor of the petitioners not for.
What is annexure E?
Notes annexure E, page 50 notes. Now show cause notes order is passed, cancelling my grant notes.
For what ground?
Not initially notes on 10/1/2022 at page 41 they issue a show cause notice.
What is the order?
Notes
that
they
is-
have cancelled my lease notes.
On what ground?
Not that the concession has not been put within 2 years.
Construction not put up within.
Put 2
Please
years.
read
Not
that portion.
notes annexure B notes. In fact, I had proceeded with the construction.
Please read page 52.
52, please notes. ಮಂಜೂರಾದ ಭೂಮಿಯನ್ನು ಭೌತಿಕವಾಗಿ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಜಮೀನು ಸಾಗುವಳಿ ಆಗುತ್ತಿರುವುದನ್ನು ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಸದರಿ ರೈತರಿಂದ ಸ್ವಾಧೀನಕ್ಕೆ ಪ್ರತಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ರೈತರೊಂದಿಗೆ ಸ್ಥಳೀಯ ಮುಖಂಡರ ಮೂಲಕ ಸಂಧಾನ ನಡೆಸಿ ಸ್ಥಳೀಯವಾಗಿ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಸ್ಥಾಪನೆಯಿಂದ ಆಗುವ ಅನುಕೂಲಗಳನ್ನು ಮನವರಿಕೆ ಮಾಡಿ ಅಂತಿಮವಾಗಿ 2009 ಸಾಲಿನಲ್ಲಿ ಸಂಪೂರ್ಣ ಭೂಮಿಯನ್ನು ಭೌತಿಕವಾಗಿ ವಶಕ್ಕೆ ಪಡೆದು ವಾಚ್ಮನ್ ಶೆಡ್, ತಂತಿಬೇಲಿ ಇತರ 3 ಕಟ್ಟಡಗಳು ನಿರ್ಮಿಸಿ ಪ್ರಸ್ತುತ ಸಂಸ್ಥೆಯ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತದೆ. ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ರಾಜಾಜಿನಗರ ಶಾಖೆಯಿಂದ ದಿನಾಂಕ 9/3/2009 ಪ್ರಸ್ತಾವಿತ ಜಮೀನಿನಲ್ಲಿ ಕಾಲೇಜು ಕಟ್ಟಡದ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ರೂಪಾಯಿ 100 ಲಕ್ಷ ಸಾಲ ಮಂಜೂರಾಗಿದ್ದು ಹಲವು ಅನಿವಾರ್ಯ ಕಾರಣಗಳಿಂದಾಗಿ ಗುತ್ತಿಗೆ ಹಣ ಪಾವತಿಸುವುದಿಲ್ಲ. ಹೊರತಾಗಿ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಅಥವಾ ಆರ್ಥಿಕ ಸಂಕಷ್ಟದಿಂದ ವಿಳಂಬ ಮಾಡಿರುವುದಿಲ್ಲ. ತಮ್ಮ ಸಂಸ್ಥೆಯ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಸೇರಿದ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯಾಗಿದ್ದು ಸೋನ್ಸ್ ಹಾಗೂ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಶಿಕ್ಷಣ ಹಾಗೂ ಶ್ರೇಯೋಭಿವೃದ್ಧಿಗಾಗಿ ದಶಕಗಳಿಂದ ಶ್ರಮಿಸುತ್ತಿದ್ದು ಸದರಿ ಜಮೀನನ್ನು ತ್ವರಿತವಾಗಿ ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ಸಿದ್ಧವಿದ್ದು ಗುತ್ತಿಗೆ ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆಯಂತೆ ಸಮಜಾಯಿಷಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 6 ಸರ್ಕಾರದ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್. ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಗೌತಮ್ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನ ಮತ್ತು ಟೆಕ್ನಾಲಜಿ ಬೆಂಗಳೂರು ಇವರ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 7ರಂತೆ ಸಲ್ಲಿಸಿರುವ ಸಮಜಾಯಿಷಿ ಕುರಿತು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ಇವರಿಂದ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 8ರಂತೆ ವರದಿ ಪಡೆದು ಪ್ರಸ್ತಾಪಿತ ಸಂಸ್ಥೆಗೆ ಗುತ್ತಿಗೆ ನೀಡಲಾದ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ದಾಸಂಪುರ ಹೋಬಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 100ರಲ್ಲಿ 6 ಎಕರೆ ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕೆ ಬಳಸಿದೆ
ಗುತ್ತಿಗೆ ಷರತ್ತು ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದು ಸದರಿ ಗುತ್ತಿಗೆ ರದ್ದುಪಡಿಸಿ ಪ್ರಸ್ತಾವಿತ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ಮರುವಶಕ್ಕೆ ಪಡೆಯುವ ಶಿಫಾರಸಿನೊಂದಿಗೆ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 6ರ ಸರ್ಕಾರದ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಸೋ ಅಂಡ್ ಸೋ ಬೆಂಗಳೂರು ಇವರ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 7ರಂತೆ ಸಲ್ಲಿಸಿರುವ ಸಮಜಾಯಿಷಿ ಮತ್ತೆ ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 8ರಂತೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ಇವರ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ವರದಿಯನ್ನು ಪರೀಕ್ಷಿಸಲಾಗಿದೆ. ಗುತ್ತಿಗೆದಾರರು ಸಂಸ್ಥೆಯ ಗೌತಮ್ ಸೋ ಅಂಡ್ ಸೋ ಮಂಜೂರು ಮಾಡಲಾದ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಉತ್ತರ ತಾಲೂಕು ದಾಸನಪುರ ಹೋಬಳಿ ದಾಸನಪುರ ಗ್ರಾಮ ಸರ್ವದ 100 ನಲ್ಲಿ 6 ಎಕರೆ ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನು ವಾರ್ಷಿಕ ಗುತ್ತಿಗೆ ಹಣವನ್ನು ಸಕಾಲದಲ್ಲಿ ಪಾವತಿಸದೆ ಮತ್ತು ಗುತ್ತಿಗೆ ನೀಡಲಾದ ಜಮೀನನ್ನು 2 ವರ್ಷದ ಒಳಗೆ ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕೆ ಬಳಸದೆ ಗುತ್ತಿಗೆ ಆದೇಶದಲ್ಲಿ ಷರತ್ತು ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದು ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮಗಳ 25(2) ಅನ್ವಯ ಗುತ್ತಿಗೆಯನ್ನು ರದ್ದುಪಡಿಸಲು ಮತ್ತು ಸದರಿ ಜಮೀನನ್ನು ಎಲ್ಲ ಋಣಭಾರಗಳಿಂದ ಸರ್ಕಾರಕ್ಕೆ ಮರುವಶಕ್ಕೆ ಪಡೆಯಲು ನಿರ್ಣಯಿಸಿ ಸರ್ಕಾರವು ಈ ಕೆಳಕಂಡೆ ಆದೇಶಿಸಿದೆ.
You had not used the land within 2 years.
No, I couldn't use it, my lords, because there was a protest from the farmers. I couldn't.
Then ಬಿಟ್ಬಿಡಿ ಹಂಗಾರೆ.
ಅಲ್ಲ ಇಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಹೇಳ್ತೀನಿ. Only one sentence I will make. 2022 the issue a show cause notice to me, telling that a similar show cause notice was issued to me, stating that we will take back the land. Thereafter, what happened, my lords, there was a communication between the Tahsildar, Deputy Commissioner and the government. This land should be cancelled and it should be given to the playground for the government school. Otherwise, by collecting the balance lease amount, it should be continued to me. Lords, if your lordship have to kindly see, my lords, at page number 48 for amendment, my lords. This is on 1/8/2022.
Now talking from 2009. 2009, the land was granted to you on a lease basis.
2004 land was granted. From 2009 to 17, my lords, I struggled a lot to get the possession. I have put up a construction. Annexure B, my lords, photographs I have produced. These are the constructions, my lords, which I have. Not, I have independently settled with the farmers. I compensated them for taking this possession. And I put up,
What is the lease amount that you have paid?
not 5,000 rupees per acre, my lords, for every per annum.
That is all.
No, that is the government, my lords, that was in 2004. Not now,
Free it is.
not now difficulties, my lords. They didn't take any or they didn't pass any orders. From 2022, my lord, they said we'll collect the lease amount and we'll continue. They didn't pass any orders officially. I was waiting.
What prevented you from paying the money?
Not, I have paid it.
Where?
Page number 48, my lords. Page number 48. No, this was the communication by the Tahsildar. Kindly see at page number 49.
Let us assume there was litigation. From 2010 till 2022, for 12 years, you didn't even pay the.
22, I have paid, my lords.
Yavag 2022.
22, they only take a decision. My lords, from 18 to 2000.
What prevented you from paying the money every year?
Not the government didn't collect it, not they have to issue a challan. Even for 23-24, they issue the challan, I have to go to treasury and I have to pay it, my lords.
ಬೇಡಬೇಡಿ ಯಾಕೆ ನಿಮ್ಗೆ ಇಷ್ಟು
ಅಲ್ಲ.
ಕಷ್ಟ ಯಾಕೆ
ಅಲ್ಲ, that's one not.
ಇಷ್ಟು ಕಷ್ಟ ನಿಮ್ ಪಾಪ ರೈತರ ಮೇಲೆ ಜಗಳ ಆಡ್ಬೇಕು ಬೇಡ
ರೈತರೆಲ್ಲ ಜಗಳ ಮಾಡಿ ಸರಿ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. We have paid them a compensation amount.
ಬಿಡಿ ಯಾಕೆ ಸುಮ್ಮನೆ ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ
Not- Not now, not only on the principles of natural justice. ಇದರಲ್ಲೂ ಶೋಕಾಸ್ ನಾನು ನೋಟಿಸ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ.
Institute,
Please, my lords.
what do you plan to do?
Education purpose, my lords.
What education?
Lords, I'm running
Medical college.
medical ಎಲ್ಲಾನು ಮಾಡ್ತಾ ಇದೀವಿ. All
For
such-
that you can't pay 30,000 per
we
year?
are paying it, my lords. My lords, as I said, my lord, they wanted to take a decision. Till they have not taken a decision and they have not communicated. ನಮ್ ಕಡೆಯಿಂದ ಏನು ತಪ್ಪಾಗಿಲ್ಲ. ಅವ್ರು ಡಿಸಿಷನ್ ತಗೋಬೇಕಾಗಿತ್ತು. ಅವರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ 2022 ಅಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ರು.
ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಮಾಡಕ ಇದು?
ಪ್ಲೀಸ್, my lords.
This is given for you to set up a medical college.
Yes, my lords, for education purpose ಅಂತ ಕೊಟ್ರು.
Education ಏನಕ್ಕೆ ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಲೀಸ್ ಅಲ್ಲಿ ಬರೀ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್ ಅಂತ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. Annexure page 15, my lords.
You don't want the land, ಸುಮ್ಮನೆ ನಿಮ್ಗೆ ಯಾಕೆ ಅಷ್ಟು ಕಷ್ಟ ಕೊಡೋದು ನಿಮ್ಗೆ? Why should
Not only, I'm only on the principles.
burden you, Papa, you can't pay the lease, you can't put up construction.
Not, I have proceeded with the construction. Not, I have proceeded with the construction. They didn't take the decision. They wanted to take a decision. They didn't take the decision. Then they issue a show cause notice. They call upon me to remit the amount. I pay the amount. Once again, they didn't take the decision. Had they taken the decision and they have communicated, I
How
will.
much did you pay?
Please, my lords.
How much did you pay?
Not
ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ?
5,000 rupees per hectare ಅಂತ ನಾನು ಕೊಡ್ತಾ ಇರೋದು ಅಷ್ಟೇ. That is the only consideration.
ಅಲ್ಲ ನೀವು ಕಾಸ್ಗೆ ಇವಾಗ ಎಷ್ಟಿದೆ ಬಾಕಿ ಕೊಡ್ಬೇಕು?
Not only 24, 25 ಕಟ್ಟಬೇಕು. 23, 24 ಕಟ್ಟಬೇಕು. ಅವ್ರು ಚಲನ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
Then why do you keep it for so many years?
Lots of B series have produced, C series have produced so many communications between the Tahsildar, Deputy Commissioner and the government. They didn't take any decision. Ultimately, they didn't take decision. Once they will say we'll cancel it, they will allot to government for government school. Then again, they will say we'll continue the lease with you. And they call upon me to pay the lease amounts.
Yeah.
No, there is a clause in the lease agreement for that. Clause 9, my lords. Lessee may erect building in accordance with the plan hereto annexed. Further, lessee can raise the loan for construction of buildings.
Raised the loan in 2009.
No, that I've raised, my lords. ನಾನು ಆಗ್ಲೇ loan raise ಮಾಡಿದ್ದು.
3 rooms. According to you is one building.
No, 2009 ಅಲ್ಲೇ ನಾನು loan apply ಮಾಡಿದ್ದು. The statement which I read.
ನೀವು ಕೊಟ್ಟಿರೋ ಫೋಟೋಗ್ರಾಫ್ ಒಂದೇ ಒಂದು ಸ್ಟ್ರಕ್ಚರ್ 6 ಎಕರೆ ಜಾಗದಲ್ಲಿ.
No, thereafter they didn't permit to construction. They said we will cancel it. ಅಲ್ಲಿಗೆ stop ಮಾಡಿ.
Did you give a plan? For what did you give a plan?
The plan I have not produced it, my
Going
lords.
to be taking the government for granted and
No,
the
no,
government
my lords.
is
Plan-
very, very generous to you.
Lords, plan I have not produced. I will produce it, my lords. But in accordance with the plan, we have put up the construction.
I am not inclined. Why should they be so benevolent to you?
Lords, as I said, my lords, the government didn't, my lords, permit me to proceed with the construction. With my difficulty, I took the possession. 2004 in the, my lords, with the farmers, I fought with the farmers. I compensated them. I took the land. I compounded the land. I started with the concession. When I started with the concession, they say we will cancel it. We will allot to the government school.
When did the issue notice cancelling the proposition cancel?
First one, my lords, 10/1/2002, annexure page 41, my lords,
Page?
41.
That is 2022.
Yes, my lords. They issue this,
From 2009 up to 2022.
but then they didn't take decision. Only on 1/8/2022, they call upon me to pay the,
From 2009 up to 2022, you
Yes.
took a loan of 1 crore
yes, my
in
lords.
2009.
Yes, my lords.
From 2009 to 2022, what is the explanation?
Not 2009 to 17, that with construction, we proceeded with the construction.
Where? What is there to show that you proceed the construction?
No, that documents I can produce it, my lords.
Produce it.
Day after tomorrow. Not till such time, my lords, now
Nothing,
entries, are-
they will not touch you at all.
but entries, my lords, entries change.
ಆಗ್ಲಿ ಬಿಡಿ ಏನಂತ ರೆಸ್ಟೋರ್ ಆಗತ್ತೆ. ನಿಮ್ಗೇನು ಭಯನೇ ಇಲ್ಲ ಅವ್ರು ಕಂಡ್ರೆ ಅಂದ್ರೆ ಏನು?
ಇಲ್ಲ ಇಲ್ಲ ಭಯ ಏನಿಲ್ಲ.
26.
Not till such time like that not proceeded.
ಏನಾಗಲ್ಲ.
Number 35.
Find out is anything due. Yes, sir.
No,
136, huh?
Please.
136. As per the partition deed, my name is, our name is mutated.
Page
in the
58
twin-
ನೋಡಿ, 58 ಹೌದು, page 58.
Page
58. ಲಭ್ಯ ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
ಲಭ್ಯ ದಾಖಲಾತಿ. ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಜಾನಕೊಂಡ ಗ್ರಾಮದ ಈ ಸರ್ವೆ ನಂಬರ್ 90/2, 9 ಎಕರೆ 27, ಕರಾಬು 1 ಎಕರೆ 5, ಜಾತ ವಿಸ್ತೀರ್ಣ 8 ಎಕರೆ 22, ಬೊಮ್ಮಪ್ಪ ಬಿನ್ ಬಾಸ್ತಪ್ಪ ಇವರ ಹೆಸರಿಗೆ ಖಾತೆ ಇರುವುದು ಪಹಣಿಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ. SR ನಂಬರ್
2045/71/72 ದಿನಾಂಕ 25/11/71ರಲ್ಲಿ ಲೀಸ್ ನಂಬರ್ 90/2ರಲ್ಲಿ 2 ಎಕರೆ 20 ಜಮೀನು ಬೊಮ್ಮಪ್ಪ ಬಿನ್ ಮಾಸ್ತಪ್ಪ ಸಣ್ಣರಂಗಪ್ಪ ಬಿನ್ ಬೊಮ್ಮಪ್ಪ ಇವರಿಂದ ರಾಮಪ್ಪ ಬಿನ್ ಗಿಡ್ರಾಮಪ್ಪ ಇವರಿಗೆ ಕ್ರಯವಾಗಿದ್ದು SR ನಂಬರ್ 165/71/72ರಂತೆ ಖಾತೆ ಅಂಗೀಕರಿಸಿಕೊಂಡಿರುತ್ತದೆ. ತದನಂತರ SR ನಂಬರ್ 1872/72-73 ದಿನಾಂಕ 11/10/72ರಲ್ಲಿ ರೀಸರ್ವೆ ನಂಬರ್ 92/2P ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಬೊಮ್ಮಪ್ಪ ಬಿನ್ ಮಾಸ್ತಪ್ಪ ಮತ್ತು ಸಣ್ಣರಂಗಪ್ಪ ಬಿನ್ ಬೊಮ್ಮಪ್ಪ ಇವರಿಂದ ರಾಮಪ್ಪ ಬಿನ್ ಮಾದರಾಮಪ್ಪ ಇವರಿಗೆ ಕ್ರಯವಾಗಿದ್ದು MR ನಂಬರ್ 15/93/94ರಂತೆ ಅಂಗೀಕರಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತುತ ಸರ್ವೆ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ 92/2P 5 ಎಕರೆ 22 ಎಕರೆ ಜಮೀನು ನೋಂದಾಯಿತ ಪಾಲು ವಿಭಾಗ ಪತ್ರದ 12/78/95/96 ದಿನಾಂಕ 7/8/95ರಂತೆ ಭೀಮಪ್ಪ ಬಿನ್ ರಂಗಪ್ಪ ಇವರ ಇಸ್ಸಿಗೆ ಬಂದಿದ್ದು MR ನಂಬರ್ 28/99/2000ರಂತೆ ಮ್ಯೂಟೇಷನ್ ಅಂಗೀಕರಿಸಲಾಗಿದೆ. ಭೀಮಪ್ಪ ಇವರ ಮರಣ ನಂತರ MR ನಂಬರ್ 37/2011-12 ದಿನಾಂಕ 7/12/11ರಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ವರ್ಗಾವಣೆಗೊಂಡಿರುತ್ತದೆ. ಆದರೆ ರೀಸರ್ವೆ ನಂಬರ್ 92/P ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಬೊಮ್ಮಪ್ಪ ಬಿನ್ ಸಣ್ಣರಂಗಪ್ಪ ಇವರಿಂದ ಮಾರಾಟವಾಗಿರುವ ಬಗ್ಗೆ ದಾಖಲೆ ಇದ್ದು ಮೇಲ್ಮನವಿದಾರರಿಗೆ 5 ಎಕರೆ 22 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಹೇಗೆ ಪಾಲು ವಿಭಾಗಕ್ಕೆ ಲಭ್ಯವಾಯಿತು ಎಂಬ ಅಂಶವನ್ನು ಮೇಲ್ಮನವಿದಾರರು ಸೂಕ್ತ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಸಾಬೀತುಪಡಿಸುವಲ್ಲಿ ವಿಫಲರಾಗಿರುತ್ತಾರೆ. ಈ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಧೀನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ MR ನಂಬರ್ 23/99/2000 ಮತ್ತು MR ನಂಬರ್ 37/2011-12ರಲ್ಲಿ ಮ್ಯೂಟೇಷನ್ ವಜಾಗೊಳಿಸಿ ಬೊಮ್ಮಪ್ಪ ಬಿನ್ ವಾಸ್ತಪ್ಪ ಮತ್ತು ಸಣ್ಣರಂಗಪ್ಪ ಬಿನ್ ಬೊಮ್ಮಪ್ಪ ಇವರ ಹೆಸರಿಗೆ ಪಾಣಿ ಇಂಡೀಕರಿಸಲು ಹಕ್ಕು ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡು ನಿಯಮಾನುಸಾರ ಮ್ಯೂಟೇಷನ್ ಪ್ರಕ್ರಿಯೆಗೆ ಕ್ರಮ ವಹಿಸಲು ತಹಸೀಲ್ದಾರ್ ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಇವರಿಗೆ ನಿರ್ದೇಶಿಸಿರುವ ಕ್ರಮ ಸರಿ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡ ಆದೇಶ. That is the order. Well, this
You're claiming under the partition.
Huh?
You're claiming under the partition deed.
It was earlier it was purchased under a registered sale deed.
When?
What is an extent it is there? Total according to them mentioning is 3 acres 20 guntas it was purchased. It mentioned here. Now the entire extent they have set aside. If according to them 5 acres 22 guntas is in excess of what I have purchased.
What is your interest is what I want to know.
Huh?
What is your interest? On the basis of the partition deed or on the sale deed?
Originally it was sale deed. They also admit it as they have sold property to us
When?
in the year
There are two sale deeds
1971.
There are 2 sale deeds that are referred to, 70-71, 71-72. One
I
is
have
for,
produced annexure A sale deed.
one is for 2 acres, 20 quintas, the other is for 1 acre.
2 acres, I have purchased the property under a registered sale deed, annexure A, from the ancestors of the respondents. And the another is 72, another sale deed, 1 acre. So comes to 3 acres, 20 guntas were purchased under a registered sale. Even in the objection statement, they have admitted that fact. The question remains with regard to 1 acre and odd. So how you have got in the partition deeds? So the partition deed, it is mentioned.
Sir.
Huh?
2 acres, 5 ಎಕರೆ 22 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದು.
ಇಲ್ಲ ಅದರಲ್ಲಿ 3 ಎಕರೆ 20 ಗುಂಟೆ ಅಂತ ಟೋಟಲ್.
3 ಎಕರೆ 20 ಗುಂಟೆ ಕೊಂಡ್ಕೊಂಡಿದ್ದು ಭಾಗ ಮಾಡ್ಕೊಂಡಿದ್ದು 5 ಎಕರೆ 22 ಗುಂಟೆ.
ನಮಗೆ ಬಂದಿರೋದು ರಿಜಿಸ್ಟರ್ ಡೀಡ್ ಪ್ರಕಾರ 3 ಎಕರೆ ಚಿಲ್ಲರೆ ಬಂದಿದೆ.
3 ಎಕರೆ
ಇದ್ರ ಪ್ರಕಾರ ಸೇಲ್ ಡೀಡ್ಗಳ ಪ್ರಕಾರ 1 ಎಕರೆ ಚಿಲ್ಲರೆ ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ ಅದು ಹೆಂಗ್ ಬಂತು ಅಂಬೋದು ನೀವು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಮ್ಯೂಟೇಷನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಈಗ ಅದು ಮ್ಯೂಟೇಷನ್ ಆಗಿರೋದು 1999 ಇಸ್ವಿಯಲ್ಲಿ. ಅವರು 2014ರಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
91ರಲ್ಲ?
99.
MR ನಂಬರ್ ಯಾವುದು?
1999ನಲ್ಲಿ ನಮ್ಗ ಮ್ಯೂಟೇಷನ್ ಆಗಿದೆ.
ಯಾವ ಆಧಾರದ ಮೇಲೆ ಆಗಿದೆ ಅದು? ಯಾವ ಆಧಾರದ ಮೇಲೆ? ಇದು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಮೇಲೆ.
ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಮೇಲೆ 99ನಾಗ ಆಗಿದೆ ನಮ್ಮ ಫಾದರ್ ಹೆಸರಿಗೆ. ನಾವು ಮಕ್ಕಳು 2011ರಲ್ಲಿ ಅವ್ರು ಸತ್ ಮೇಲೆ ನಮ್ಮ ಹೆಸರಿಗೆ ಪಾವತಿ ಖಾತೆ ಆಗಿದೆ. ಈಗ 1999ನಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ದನ್ನ ಅವರು 2014ರಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ. ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ನಿಯರ್ಲಿ 14 years. from the date of the mutation. And without filing any application for seeking condonation of
What
delay.
was the extent shown when it was prior to partition in the name of your father? Prior to the partition, what was the extent shown in the RTC? Your father purchased 2 acres 20 guntas. ತಾನೆ?
ಹೌದೌದು ಅದು
So the extent according to this MR 165/71/72
ಇದು
was only 2 acres 20 guntas.
that was in the purchased in the name of Bomma Pamalan. That with regard to that, with regard to entries, I have not produced the RTC mutation extract for the, that,
No, you are claiming under Bommappa state loan, isn't it?
ಹೌದು ನಮ್ಮ ಅನ್ಸಿಸ್ಟರ್ ಅವರು.
So Bommappan 2 ಎಕರೆ 20 ಗುಂಟೆ ಇದ್ರೆ ಅದ್ರಲ್ಲಿ ನೀವೇನ್ ಬೇಕಾದ್ರೆ ಭಾಗ ಮಾಡ್ಕೊಳ್ಳಿ. 2 ಎಕರೆ 20 ಗುಂಟೆ ಇದ್ದು ನೀವು 5 ಎಕರೆ 22 ಗುಂಟೆ ಭಾಗ ಮಾಡ್ಕೊಂಡ್ರೆ ಹೆಂಗ್ ತಾಳೆ ಹೊಂದುತ್ತದು?
ಇಲ್ಲ ಅದು that is correct. I am not disputing. The question before your lordship is, now they are challenging the order and disputing the fact that it was there belongs to them. We are claiming under the registered document partition, whether legal or illegal, that is a different aspect. Whether, my lord, as per the full bench judgment, the authorities can gone into the registered document. If it is gone into, what is the limit? So limitation is prescribed under the act. They have to prepare, and even if they agreed, they can file an appeal within 60 days from the date of the mutation. Now the mutation is being effected in the year 1999, 2000, and it was challenged in 2014. So the 14 years, no, they have not made an application to condone the delay also. So without condoning the delay, whether the assistant commissioner get the jurisdiction to entertain the appeal. If your lordship holds that even without their making an application, without there being anything, he is having a power to entertain, that is different aspect. Because it is the full bench judgment of the Sambal court has clearly held that if it is any delay without making an application, without condoning the delay, the assistant commissioner does not get any jurisdiction at all. Now it is a fact that there is no application before the assistant commissioner for condoning the delay for inordinate delay of 14 years. If you are not, that being the fact, the order passed by the assistant commissioner, well, is in eye of law, whether valid or not. According to me, so as per the full bench judgment of the Sambal court, that order passed by the assistant commissioner is without jurisdiction. As he has not condoned the delay, there is no application for seeking condonation of delay at all. So appeal itself is not maintainable without there being accompanied with an application for condonation of delay.
What was your objections before the AC? Let us see your objections. Your averment was ಎದುರುದಾರರು ಪೂರ್ವಿಕರಿಗೆ ಮೌಖಿಕವಾಗಿ ಬಹಳ ಹಿಂದೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ.
ಅವರು ಕೇಳಿದ್ದಾರೆ ಮೌಖಿಕ ಮಾರಿದ್ದಾರೆ ಅಂತ, ಅದನ್ನ ನಾನು ತಮ್ಮ ಮುಂದೆ ಕ್ಯಾನ್ವಾಸ್ ಮಾಡ್ತಿಲ್ಲ. ನಾನ್ ಲೀಗಲ್
ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಾಗ
ನಾನು ಅದನ್ನು ಕ್ಯಾನ್ವಾಸ್ ಮಾಡ್ತಿಲ್ಲ. ಇಟ್ ಈಸ್ ಎ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಟು ಡಿಸೈಡ್ ಇಟ್ ವೆದರ್ ದೇ have perfected the title by adverse possession or not. It is a matter of the trial before the civil court.
your entitlement is only your
That is, my lord, I am not disputing 2 acres and that it is there, it is there. The question before your lordship is, so with this type of appeals are filed after lapse of 15 years, 20 years. If I goes on entertaining, if that they agreed, they can approach, they can prove that it is your only land is sold to us is so and so.
full bench ಕೊಡಿ district.
Full bench judge. ಇಲ್ಲ, ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತಂದಿಲ್ಲ, ಸೈಟೇಷನ್ ನಾಳೆ ಕೊಡ್ತೀನಿ.
ಇದ್ಯಾವ ನಂಬರ್ ನಂಬರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ನಂಬರ್ ಆಗಿದೆ ಇದ್ಯಾವ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ ನಂಬರ್ it is noticed that this petition pertains to General Miscellaneous Roster. General Miscellaneous Roster. Office Director was to the 21. It is also noticed that by mistake, the writ petition filed by P. Venugopal, FR 8446/2025, has been wrongly stated to pertain to WP 8564/2025. Registry is directed to scrutinize the WP for 8446/2025 filed by P. Venugopal. Assign the proper number and thereafter post it for the court. Move direction FR number ಕೊಟ್ಟು ಇದನ್ನ ಸ್ಕೂಟರ್ ಮಾಡಿ ನಂಬರ್ ಕೊಟ್ಟು ಪೋಸ್ಟ್ ಮಾಡಿ ಹುಷಾರಾಗಿ ಕೇಳಿ
For hearing on IA, seal number 38, Sri Jairaj DS.
Kindly pass all the matter, senior counsel is engaged in other.
ತೊಳ್ಳು ಆಮೇಲೆ ಮಾಡಲ
ನಮಗೂ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
Seal number 39, Sri Nagaraja S.
ಏನಾಯ್ತು?
Yes, I'm offering the petition. This farm number 57 has been filed, madam. It was filed in the year 2018, madam.
ಏನ್ ಮೇಡಮ್
That was my lord. 39 ಅಲ್ವಾ sir? 39.
ಬಿಟ್ಟಿನೇ ರೆಡಿ ಇಲ್ವಾ
My lord, in sections, my lord, 57 was rejected, my lord. That is the reason. That was my instructions, my lord.
Regarding that, my lord, I have no idea. If it is rejected, my lord, I will not press, my lord. But let them submit. That's my request for a date, my lord.
ಯಾವತ್ತು ಬೇಕು ಮೇಡಮ್
Next week, my lord, any day.
Please.
Fourth. Seal number 40.
I pay for petition, madam.
Who
The
do you want to
proposed
plead?
applicant is a purchaser of the land in question, my lord. During the pendency of the RTS dispute, he has purchased the land under a registered sale deed. So I made application to implead him as a
notice on I1/25.
much.
Seal number 41. Keshgiri Rao.
Respond. In this case, my lord,
Accommodation.
my application,
Senior was in out of station, short accommodation.
In auto station.
next week it will be taken.
List.
Date may kindly be.
Interim order may be extended.
My lord, there is a fraud as observed by the Tahsildar.
Now,
Kindly date may be. Next week.
Seal number 42, Sri Vinod Gowda.
Here I challenge the annexure.
Lord, this is
Yeah, my
demanded
lord.
to Tahsildar, my lord. That has been challenged here, my lord. To conduct survey spot and
Annexure J.
Will,
Please.
J, my lord. Will,
KP 43, my lord.
I got property through will. On the basis of the will, I had changed kata. The respondent has challenged the same before the deputy commissioner. The deputy commissioner, I dispute they are the legal heirs of one Chikka Iranna. The deputy commissioner has ordered, kindly see page number,
Now, in whose name was the Kata standing?
my name, Chikkirappa.
ನೀವು ಚೆನ್ನಪ್ಪ
Channappa, sorry, Channappa. Chikkirappa executed a will in favor of me. On the basis of will, kata has been changed.
ಅವ್ರು ರಿಲೇಟೆಡ್ ಚಿಕ್ಕಿರಪ್ಪ
Nam Chikkappa.
That is what, my lord.
They
There
are,
is a
they are
dispute.
contending their legal heirs. But we are disputing, he is died without issueless.
On what basis do you say that you are the
My
children
lord,
of?
we are the children of Chikkirappa, my lord. We have produced the documents to show that Chikkirappa had 4 children. So, or Chikkirappa died in the year 1999. They are saying that Chikkirappa died in the year 1957.
ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ನಿಮ್ಮ ಮಕ್ಕಳು ಅಂತ
ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. Now I had filed PNDC. I had made them also party.
When was your name mutated?
2018.
18.
Oh.
That was challenged when?
2018 it was
Immediately. ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಇಲ್ಲ?
ನಾವು ಅಪೀಲ್ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಇವ್ರು ಅಪೀಲ್ ಹಾಕಿದ್ವಿ. ನಾನು ಚಿಕ್ಕೀರಪ್ಪನ್ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ.
ನೀವು ಮಕ್ಕಳು ಅಂತ ಹೇಳ್ತೀರಾ ನೀವು?
ಹೌದು ಮಕ್ಕಳು ಅಂತ ದೇ ಆರ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಿ ವಿಲ್. Now I had filed PNDC. I had made them also party. Let them prove.
Produce that you are the children?
Children, Swami, documents. Documents included.
Whereas the Chikvirappa's marriage invitation card we had given, and then marriage invitation card of Chennamma and Rajabhadraya, that is daughter. And then school transfer certificate of Hemavati, who is also a respondent before your lordship.
Yes.
And the last one is the death certificate of Chikvirappa. Two things, my lord. One is whether we are the LRs of Chikvirappa, for that, that's one aspect. Second is he came there and said, I have got a will in my favor. Based on that, the entries were mutated in his name. The settled law is that based on the will, they could not have done it and they should have delegated him to the civil court. And as far as we are concerned, my lords, the court.
Anyhow is before the civil court with the PNDC.
ಹೌದು.
ಅಲ್ಲ ಅವ್ರದ್ದು.
He has filed it.
ಹೌದು.
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
Until then his name was in the records until you challenge.
That's my lords. The law is otherwise, my lords. The.
No, I will hold that, let his name continue till the decision of PNDC. Whatever happens.
Our name has to, that's where.
What is there to show that you were the children at some point of time?
Chikvirappa, that's where, my lords, I have produced the document. Now, what the court has ordered here is, kindly see the DC's
Doesn't
order.
reminded the matter.
DC's order, your lordship may kindly see, my lords. The DC's
Is it a
order,
registered will or unregistered will?
unregistered will of 1965, which he
65
says.
will.
ಹೌದು 65.
65, that he says 65 and date of death of father is also wrongly mentioned. According to him, my lords,
ಬೇರೆ ಬಿಡಿ, ನಿಮ್ ಗೆದ್ರೆ ನಿಮ್ಮ ಹೆಸರು ಬರ್ಲಿ.
ಅಲ್ಲ let them prove in the our will ಅದು.
ನೀವು ಹೋಗಿದ್ದೀರಾ ಕೋರ್ಟ್ಗೆ?
ಹೌದು.
ವಿಲ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಕೊಂಡು.
ಹೌದು.
ನಾನು ವಿಲ್ ಏನು ರೀಸೆಂಟ್ ಅಂತ ಅನ್ಕೊಂಡೆ. 65ನೇ ಇಸ್ವಿ ವಿಲ್ಲು ಈ ಡೈಡ್ ಇನ್ ವೆನ್ 1999 ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು.
ಅಲ್ಲ
And the ಖಾತೆ has changed in 2018.
2018.
based on.
ಅಲ್ಲ let them prove the will is fabricated ಅಂತ let them.
ನೀವು 18 ವರ್ಷ ನಿಮ್ಮ ಹೆಸರು ಇರಲಿಲ್ಲ ಖಾತಾ.
ಅಲ್ಲ we are in possession, they are not in possession.
ನಾನು ಹೇಳ್ತಿಲ್ಲ. From 1999 up till 2018 your name was not there.
ಅಲ್ಲ we are in the possession.
Possession ಬಗ್ಗೆ ಬೇಡ, ಖಾತಾ ಅಂತ
Till today, even today I am in the possession, they are not came to the
to
possession.
enjoy your possession. I will not say anything about possession.
Okay.
I will say that the revenue entries will abide with the result of your PNDC if you succeed. Until then it will go back to the name of Chikkiraya.
ಅಲ್ಲ ಚಿಕ್ಕಿರಯ್ಯ.
Anywhere before the court, isn't it?
ಹೌದು.
ನಿಮ್ಮ ಹೆಸರು ಬೇಡ, ಅವ್ರ ಹೆಸರು ಬೇಡ, ಹಂಗೆ ಖಾಲಿ ಬಿರ್ಲಿ ಬಿಡಿ.
May I just take your lordship for a minute, madam?
ಆಯ್ತು.
May I just take your lordship? The law is that, my lord.
I'm setting aside the order. I'm not upholding his name. It will go back in the name of Chikkiraya depending on who succeeds.
One is Chikviraya is that person, I have no objection.
No, the reason why is if you had admitted that you are the LRs, you have directed your name to be entered. He is disputing your entitlement also.
That's where.
Now, if the matter goes back, the Tahsildar will give a finding as to whether you are the LR or not. That he cannot do.
They had not made us a party.
ಇಲ್ಲ ಮಾಡಿದ್ವಿ.
Therefore, we will go back to the original position.
Now,
Both of you litigate.
that's where, my lords, what the DC has ordered is the revenue, he has to get his, title established before a civil court of law. That's one part of it. They have not said enter my name. The DC has correctly ordered as
Now,
per.
now that he is disputing your entitlement as the LR, the remand would become unnecessary because the Tahsildar have to give a finding as to whether you are the LRs or not.
Inquiry is what they say.
ಬೇಡ, ಅದಕ್ಕೆ ನೀವು ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಅದ್ರಿಗೂ ನೀವು ಅವ್ರ ತೀರೋದ್ರಲ್ಲ ಅವ್ರ ಹೆಸರೇ ಇರ್ಲಿ.
let there be a status quo, my lord.
ಬೇಕಾದ್ರೆ ಇಬ್ರು ಕಂದಾಯ ಕಟ್ಟಿ, ಕಂದಾಯ ಗವರ್ಮೆಂಟ್ ಹೇಳ್ತೀನಿ, ನೀವು ಇಬ್ರದ್ದು ಇಸ್ಕೊಳಕ್ಕೆ.
ಎರಡು citation ತಮ್ಗೆ ಓದ್ತೀನಿ ಆಮೇಲೆ ತಾವು ದಯವಿಟ್ಟು
ಕೊಡಿ.
I have given ಕೊಡಿ ಸಾಹೇಬ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಟ್ಟಿದ್ದು.
ಹೇಳಿ.
ಕಂಪೈಲೇಷನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಯಾವ citation?
ಬೇಸ್ಡ್ ಆನ್ ಬಿಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಫಸ್ಟ್.
That I'm accepting.
ಅದೆಲ್ಲ
I'm accepting it.
ಸರ್ ಫೋರ್ತ್ ಒನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ. Fourth one, 26 and 27. Page 26 and 27, your lordship. The propounder of a will has to para 8, your lordship may kindly go, Millers. Para 8.
Page?
If page is 26.
In fact, the full bench.
In fact, adralli, if
I'm
prima
accepting
facie
your
the-
argument.
Allala, if prima facie he is able to establish that he is brother, then the propounder of will is required to prove the same before the court. So prima facie we have established because of this TC and other things. Even for that matter, your lordship may kindly come to next judgment.
When
Which is-
did this gentleman die?
He died in
According to us-
1999.
Huh?
99. According to us, according to
1999, you also did not move a little finger
No.
to get your name entered.
no, we did not.
So both of you are guilty of 18 years latches. So both of you will have to wait till your rights are adjudicable to the civil court. All these judgments are in a different context.
One more judgment I'll just take last final. This one, this may your lordship may kindly say. Fifth judgment, Millers. Page 28 and 30.
Yes.
Para 6 and 8 Millers. In view of the above said full bench.
That's why I said, if you had admitted that you were his children, I had no hesitation in directing your name to be entered. You keep quiet for 18 years. So whether you are the legal heir or not, he is disputing. So let all these issues be thrashed out in the civil court. Until then, let the name of Chikkereya continue.
Now, in the document that I have produced before your lordship, Millers, of course, now this court, I mean,
And you're running a risk. Suppose you go to the Tahsildar and he were to say, find something wrong with the TC or whatever, and say that you're not the children. You're again going to go to the civil court.
anyhow, his case is pending there. We will have to go, we will go. Till then, the question here is, should it be in the name of a dead person or should it be in the name of the
Because
person?
it has been in the name of dead person for 18 years.
It had been in the name of the dead
Dead
person
continues
for
for another
18
10 years.
That's what Millers. But pramana patra, idu TC ella ಕೊಟ್ಟಿದೀವಿ ನಾವು.
ಆಯ್ತು 18 ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ
ಈಗ
ಪೊಸೆಷನ್ ಗೆ ಬಂದಿಲ್ಲ ಅವರು ಇದುವರೆಗೂ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. Now what happened is
ಮಾಡ್ಕೊಳ್ತೀರಿ ಇವಾಗ.
ಅಲ್ಲ now what happened is the property is acquired by BDA for ಕೆಂಪೇಗೌಡ layout. Now they had come. ಅಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದ್ರೆ ಮತ್ತೆ they utilize. Let it be a status quo ಅಂತ ನಾನು.
This is one Millers.
If you want, I'll ask him to deposit the money into the civil court. Where P&S is,
deposit ಮಾಡಿಲ್ಲ.
that way your money is safe.
P&S ಇದು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ.
ಹಾಕಿದ್ವಿ
P&S ಹಾಕಿದ್ದೀರಾ will ಮೇಲೆ 1965 will ಮೇಲೆ. That we do not know, Millers. I thought that he should be going to a civil court for a declaration of the property. ಅದರಲ್ಲಿ will ಹೇಳಿದ್ದಾರೆ ಅಂತ ಅನ್ಕೊಂಡೆ ನಾನು. P&S ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹಾಗೆ ನೋಟಿಸ್ ಆಗಿದೆ.
We do not know. One more read kodi doctor. The only question here is, can we, I was just on a larger perspective. ಎರಡು ಮೂರು ಕೇಸ್ಗಳಲ್ಲಿ ಈ ತರದೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. Can we ask the name to be continued in the name of a dead person?
That's why I said I'll make it clear. The very purpose of your name in the being in the RTC is to enable you to pay the revenue. Nothing more, nothing less. Both of you pay revenue. There's no difficulty.
The question is, that's not the.
That is not a document of title. So how does it matter if it's a name?
That's the only thing. Now, Millers, it is a will of 65. 2018, he says will is executed in the year 1965, unregistered will.
ಅವರು ಮಾಡ್ತಾರೆ ಬಿಡಿ, P&S ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲೇ ನಿಮ್ದು ಡಿಸೈಡ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ಲಿ.
Let them prove they are the legal heirs.
ಅಲ್ವಾ ಅಂತ ಇವ್ರು
ಅದ್ರಲ್ಲಿ ಬೇಡ, ಅವ್ರು ಹಾಕ್ತಾರೆ, ನಾವು ಹಾಕ್ತಿವಿ, ಕೋರ್ಟ್ ಅವ್ರು ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ. ನಮ್ದು ತಾವು ಇದನ್ನೇ
is not in dispute.
ಒಂದೇ ನಿಮಿಷ ತಾವು DC ಆರ್ಡರ್ ಫೈನಲ್ ಇರೋದ್ರಲ್ಲಿ Page 43, 1 second, ನಮ್ಮ objections ಅಲ್ಲಿ ನೋಡ್ಬೋದು. Page 43, writ petition ಅಲ್ಲಿ. ಗ್ರಾಮದಲ್ಲಿ ತನಿಖೆ ಮಾಡಿ ಮಹಜರ್ ನಡೆಸಿ ಒಂದು ವೇಳೆ ಆತನ ವಾರಸುದಾರರೆಂದು ಕಂಡು
That
ಬಂದ
according to me is wrong. He is virtually giving him the right of the civil court.
ಎರಡು ಡಿಸಿಷನ್ ಅಲ್ಲಿ ಅದೇ ತರ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ. That is the process to be adopted ಅಂತ ಎರಡು ಡಿಸಿಷನ್
But given in the background of the fact for 18 years you kept quiet. There's a.
That's there. But as your lordship said, there is an element of risk associated with it. If the Tahsildar says
Okay.
that there may be an risk element of risk.
ವ್ಯಾಪಾರ ಕೇಳಿದ್ ಬಿಡ್ತೀರಾ ಅದು ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಹೋಗ್ಬಿಡುತ್ತೆ ಅದು.
ಈ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ that is the right process ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಾನು ತಮ್ಮ ಮುಂದೆ
It
ಕೊಟ್ಟಿದ್ದೆ.
is not in dispute that the revenue entries were standing in the name of Chik Veeranna alias Chik Veerappa. It is the case of the petitioner that Chik Veeranna alias Chik Veerappa had no issues and he had executed a will in favor of the petitioner on 16/6/1965. And on his death, by virtue of the said bequest, the petitioner had inherited the property. And consequently, his name is entitled to be registered as the Katedar. The petitioner contends that this plea was accepted by the Assistant Commissioner rightly, and the name of the petitioner was ordered to be entered. Next part. It is a case of the contesting respondents, that is respondents 5 to 8, that they are the children of Chik Veeranna alias Chik Veerappa. They deny the assertion of the petitioner that Chik Veeranna alias Chik Veerappa had no legal heirs, and they specifically contend that they are the legal heirs of Chik Veeranna and Chik Veerappa, and consequently their names are entitled to be entered in the revenue records. It is also contended that a claim for entry in the revenue records on the basis of a will cannot be entertained at all unless a civil court gives an appropriate declaration in this regard. Next one. As already stated above, it is not in dispute that the Kata stood in the name of late Chik Veeranna alias Chik Veerappa. The will said to have been executed by Chik Veeranna Chik Veerappa under the petitioner is disputed. In the same way, the petitioner also disputes that respondents 3 to 8, 5 to 8 are the children of Chik Veeranna alias Chik Veerappa, and it is contended he had no legal heirs at all. Next paragraph. It is also not in dispute that though it is also contended by the petitioner that Chik Veerappa alias Chik Veeranna died in 1999.
According to
1974. According to them, 1990.
Died in 1974, whereas it is a case of respondents 5 to 9 that he actually died in the year 1999.
We have produced this death certificate also.
The learned counsel of the respondents placed reliance on a death certificate to indicate that he passed away in the year 1999. Be that as it may, it is clear from the documents produced that though Chik Veeranna died a long time ago, that is either in 74 or in 1999, the name of Chik Veeranna alias Chik Veerappa continued in the revenue records till the year 2018. And for the first time, the name of the petitioner was entered on the basis of the will. In other words, for 18 long years, the name of Chik Veeranna continued as the Katedar, even though he was no more. Learned counsel for the petitioner submits that the petitioner has instituted a P&SC in
PCA number 44 of 2023. PNDC.
44 of 2023.
23.
In which he is seeking for validation of the will executed by Chik Veerappa. It is clear that unless the civil court declares that Chik Veeranna alias Chik Veerappa had executed a will in favor of the petitioner, the petitioner cannot have a right to have his name entered in the revenue records. So, though in the normal circumstances, the legal heirs of the Katedar would have, the name of the legal heirs with the Kadatar would have to be entered in the revenue records, comma, in this particular case, comma, that course of action would be impermissible. Because for about 19 years, the respondents 5 to 9 took no steps to get their name entered in the revenue records. And they only chose to challenge the offers in favor of the petitioner. In that view of the matter, comma, in my view, it would also not be appropriate to permit the name of respondents 5 to 9 to be entered on the basis that they are the legal heirs, especially when the assertion of theirs that they are the legal heirs is seriously disputed by the petitioner. In the result, in the peculiar facts and in this case, comma, it would be appropriate to direct the revenue entries to be continued in the name of the deceased Chikvirappa alias Chikvireya until the civil courts take decision regarding the entitlement of either the petitioners or the respondents in respect of the land in question. To this extent, the order of the authorities are modified. W is accordingly disposed of.
Till number 43, the PN Harish.
But OD is conducted, joint survey with the forest department is conducted. Joint survey with the forest department is conducted. The survey number consists of 153 acres, out of which 7.3 acres.
What is the prayer here?
Prayer is a mandamus, my lord. The RFO is not signing the joint survey and not completing the POD one.
My lord, annexure F, my lord, annexure E, my lord, page 25, my lord. Page 25. They have not submitted any documents, my lord, and also it says a report, Varadi Nidivutara.
25.
Page 25, my lord, second paragraph. ಸದರಿ ವಿಷಯವಾಗಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಮುಂಚೆ ಹೋಬಳಿ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಸಾಗರ ವಿಭಾಗ ಸಾಗರ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯ ದುರಸ್ತಿ ಮಾಡಲು ಕಳಿಸಲಾಯಿತು. ಆದರೆ ಉಲ್ಲೇಖ 3 ಸರ್ವೆ ನಕ್ಷೆ ಕಡತ ಲಭ್ಯವಿಲ್ಲ ಪ್ರಯುಕ್ತ ದುರಸ್ತಿ ಮಾಡಲು ರಹವಿಲ್ಲವೆಂದು ಕಡತವನ್ನು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಈ ವಿಷಯವಾಗಿ ಮೂಲ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಮೂಲ ಕಡತದಲ್ಲಿ ನಕಾಶೆ ಇಲ್ಲದಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಅನುಭವದಂತೆ ಅಳತೆ ಮಾಡಿ ನಕಾಶೆ ತಯಾರಿಸಿ ಈ ಕಚೇರಿಗೆ ವರದಿ ನೀಡಲು ಕೋರಿದೆ. Further
POD is because of that reason only POD is sought.
records, my lord, and also, my lord, annexure F, we have issued notice, my lord, they have not submitted any records. And also Taluk office, there is no records available anta kadata ಲಭ್ಯವಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. There is a grant.
ಈಗ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಕೇಳ್ತಿರೋದು?
That is granted to me. It is granted. Grant certificate I have produced.
Granted, my lord, there will be.
Kindly see annexure here.
Suppose they have granted forest land to you, then what is it to be?
It is not a forest land, blood. That is the reason. There is a joint survey. The forest departments have conducted, along with the revenue department, conducted a survey. They found that one extent of 145 acres is the forest land. This is out of the forest land. Kindly see, my lord, the report is to that effect only. 7 acres 30 guntas is landed to 3 persons.
Forest department rented that?
I'll find out, my lord, that.
That they are not,
Not there, my lord, I'll find out, my
that
lord. I'll
kindly
call
see
the
annexure H, my lord.
Not a party. We have to call the records from the party.
Party there.
Either.
All of them are party.
Then I'll seek.
Range
inspection,
forest
my
are
lord.
blood. Annexure H may kindly be seen. Annexure H once all noted.
The list.
And Revenue department and forest, my lord, everywhere it is a conflict, my lord, also.
Annexure H ಅಲ್ಲಿ there is a clear ಆಗಿ ಹೇಳ್ತಾರೆ. ಅದೇ ಒಂದೇ ಒಂದ್ಸಲ ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ.
ಹೇಳಿ, ಹೇಳಿ.
ಬ್ಲಡ್ ಈ ಬಗ್ಗೆ ಉಪವಲಯ ಅರಣ್ಯಾಧಿಕಾರಿ ಹುಂಚ ಶಾಖೆಯವರು ದಿನಾಂಕ 10/5/2021 ಸದರಿ ಜಾಗದ ಜಂಟಿ ಮೋಜಣಿ ಆಗಿದೆ ಎಂದು ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿರುವುದರಿಂದ ತಾವು ಜಂಟಿ ಮೋಜಣಿ ಬಗ್ಗೆ ಕಡತವನ್ನು ನೀಡಿದಲ್ಲಿ ಅಭಿಪ್ರಾಯ ನೀಡಲಾಗುವುದೆಂದು ಉಲ್ಲೇಖ 1ರಂತೆ ತಿಳಿಸಿರುತ್ತೀರಿ. ಪ್ರಯುಕ್ತ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 10/5/2021 ಜಂಟಿ ಮೋಜಣಿ ನಕಾಶೆ ಮತ್ತು ನೋಟಿಸ್ಗೆ ಅವರೇ ಅಧಿಕಾರಿಗಳ ಸಹಿ ಅವಶ್ಯಕತೆವಿದ್ದು ಸದರಿ ಸಹಿಯೊಂದಿಗೆ ವರದಿ ನೀಡಲು ಕೋರುತ್ತಾ ಸದರಿ ಕಡತವನ್ನು ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. This is letter written by Tahsildar to the RFO to kindly confirm and put your signature so that the proceedings, POD proceedings could be completed. It is not been acted upon.
ಇಲ್ಲ,
Let us see the
ಕಡತ ಅಂತಾನು
forest
ಹೇಳ್ತಾರಲ್ಲ, which annexures?
Annexure H.
I'll check.
Forest department ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Yes, ma'am.
9th, madam. Till number 44.
18th, not there. The 21st, my daughter's wedding is there.
Right, ಯಾವ್ದು?
22nd.
27.
22nd.
Lord, I appear for the respondent. You will also order a last document, my lord, of remand to the land tribunal. The entries, my lord, would be subject to result of any order, my lord, that is likely to be passed in before the land tribunal.
Who was set for TI?
No, that I have already, your lordships have already noted that the compound wall, my lord, which was being put up by me, that I would not make any further constructions, my lord, is the sufficient.
In Vardhajan?
There are 2 or 3 subtle points in the matter. Let's kindly take the application that I have filed for temporary injunction. And point
Your
out,
lordships, my lord, observed that the main matter would be disposed of that. Entries, my lord, would be subject to result of the.
he has had his say, let me, court is asking some question, let me answer that. Why should he interfere in the middle? Now kindly come to the interim application that I have filed. Certain documents I have filed along with my interim application. Adರಲ್ಲಿ kindly come to annexure M.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ application?
Application is filed.
1911. What is the main matter about? What is the
Let's
tenant?
main matter is this. Let's the revenue entries for standing in my name as far as column number 12 is concerned, showing me as the tenant of the land.
136 ena?
Ah,
136.
130. Showing me as the tenant of the land. Then farm number 7 is pending before the land tribunal. And the Admur Sati dispose aitu, High Court bantu, remand aitu. The last order is annexure J passed by, so your lordship. Position liddaga. Let's he, after 25 or 28 years after the regrant, let's say approaches the Tahsildar and obtains a khata in his name. That is in 2006 or 7. I challenge that before the AC. AC says on the basis of the regrant order, khata is passed in his name. It's fine, okay. DC also says that. Let's my grievance is this. Let's kindly come to the RTCs that I have produced. That I have produced along with.
So the order is impugned or order is saying that there's not a regrant in his favor. Therefore, his kata should stand in his name.
Anta heli, that is the other. But let's, the question is this. Kindly come to the RTCs that I have produced along with my application. Injunction application hakidini. Adr jotege I have produced the RTCs.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ TI application?
The date is 1911. 1911-2024. 1911-2024.
Additional evidence ಅಂತ ಇದೆ. Yes.
Page number 11. Now page number 11. Kindly come to page number 12. 11 in the Shuruvagi. 71, 72, 72, 72, 72, 73. Gangadharaya, that is petitioner's husband. Then the next document. 73 in the 73, 74, 74, 75. Gangadharaya.
And tribunal is yet to decide on your application.
Yes. Well, the question is this. These are the entries which decide the fate of farm number 7.
No, but
On the appointed date. If I am shown as the tenant in the RTCs.
that will not be changed, isn't it?
No, that's right. That is one thing. This will not be changed ಅಂತಂದ್ರೆ ಈಗ RTC ಎಲ್ಲ ಅವರ ಹೆಸರಿಗೆ ಬಂದು ಹೋಗಿದೆ, AC ಮಾಡಿದ್ದಾರೆ, DC ಮಾಡಿದ್ದಾರೆ ಅಂತ
You
ಹೇಳಿದ್ರೆ
clarify that.
that is one thing. Then let's kindly turn to page 24.
Yes.
ಇವರು ಇವಾಗ ಒಂದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ ಫೇವರ್ ಆಫ್ ಎ ಥರ್ಡ್ ಪಾರ್ಟಿ. ದೇರ್ ಇಸ್ ಎ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್.
Registered lease agreement. Sale agreement.
And next turn to the photographs that I have produced. ಇದು ಲೇಟೆಸ್ಟ್ ಫೋಟೋಗ್ರಾಫ್. ಅಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತಾರೆ ಕಾಂಪೌಂಡ್, ಆ ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ ನಾವು, ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ ಬಿಟ್ರೆ ನಾವ್ ಇನ್ನೇನು ಮಾಡಲ್ಲ ಅಂತ. ದಿ ಲೇಟೆಸ್ಟ್ ಫೋಟೋಗ್ರಾಫ್. Construction. So it's an agricultural land as on that appointed day, my rights as on that day has to be adjudicated. Adanna avaru they want to change the nature drastically. That's putting it into a commercial use. This is the reason I filed. Then kindly turn to annexure P, a representation given by the 4th respondent's father.
You're putting up any further construction?
No, my lord.
We have not been doing any, on the contrary, my lord, he files a suit for injunction, he loses it, he files a MA is also dismissed.
You give an undertaking that you will not put up further construction.
That is because, my lord, in fact, my lord, I did not give such an undertaking, but the court recorded, my lord, I said. okay.
ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಅನೆಕ್ಷರ್
ಇರ್ಲಿ.
ಅನೆಕ್ಷರ್ P1
ಅಲ್ಲಲ್ಲ, ಇರ್ಲಿ.
Annexure- Annexure P1 ನೋಡಿ ಒಂದ್ಸತಿ.
ಅಲ್ಲಲ್ಲ, ಈಗ that itself shows that I am in possession.
Let's
ನಿಮ್ಮಿಬ್ಬರ ಜಾಗದಲ್ಲಿ why are you blaming the court saying that?
I am sorry, my lord, I am not going against.
let's kindly.
Then I will pass a positive order that you will not put up any further construction.
No, definitely not. Definitely not.
Let's
At this-
kindly come to annexure P, a representation given by his
And
father.
fresh suit, he is also filed a fresh suit.
ಅಲ್ಲ ಸೂಟ್ ಅಲ್ಲ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಮ್ಯಾಟರ್ ಇದು ಏನು ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ. Let's I am been foolish enough to file this suit in the respect of a tenanted matter. Civil courts ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ tenanted matter. But
I have-
kindly come to one letter that he has written, annexure P.
I will not decide your form number 7, isn't it?
That's right. No, ಅಲ್ಲ ಯಾತ್ ಪ್ರೈಮ ಫೇಸಿಗೆ ನಾ ಹೇಳ್ತಾ ಇರೋದು injunction ಗೆ. The matter will be disposed of, await the decision of the
He
land
has no
tribunal.
objection.
ಅಲ್ಲಿವರೆಗೂ ಏನು ಮಾಡಬಾರದು, ಸೇಲ್ ಡೀಡ್ ಮಾಡಬಾರದು.
He has no objection. I'll
No.
grant you.
Kindly come to annexure
I will
P.
grant you an injunction. That's what I'm telling him. Why are you arguing?
ಸೇಲ್ ಡೀಡು ಮಾಡಬಾರದು, no construction until farm number 7 is decided. And these entries, effect of these entries will not be taken away by the impugned orders. ಇದು ಮೂರಾದ್ರೆ I am so grateful to.
He is not supposed to dictate, my lord, what I should do.
I am
what
making
should
a
do.
request, I am not dictating.
Now that aspect of the matter will be decided by the land tribunal.
That's these,
Based upon the entries, my lord, which are already in existence. If it is in his favor, it is for the tribunal, my lord, to take into consideration that.
ನಾನು ಅಷ್ಟೇ ಕೇಳ್ಕೊತಾ ಇರೋದು.
ಅಲ್ಲ, ಇದು ಯಾಕೆ
Effect of
ಹೇಳ್ಬೇಕು?
these-
ಇದು ಯಾಕೆ ಹೇಳ್ಬೇಕು? ನಿಮ್ಮ
Effect-
petition ನಲ್ಲಿ.
Effect of these entries should not be
No,
taken away
why-
or erased.
Proceedings have
This
remanded
is-
the matter.
This is number one.
That matter will be decided
This
on
is-
merits.
This is number one. Then no sale deed, then no sale deed or construction.
Sale deed, I am not going to sell the property, my lord. That is one aspect of the matter.
That is
But
what I'll
even
say.
then,
I'll record these two submissions of yours
no,
that you will not put up.
what
any-
I am saying is that if, for assuming for a moment that I am going to sell the property, it is a less pendens. That transaction has no validity at all
So
in law.
The intention is apparently clear there.
I will relieve that burden. I will pass a positive order that you will not sell, you will not put up any further constructions till the matter is decided with the land tribunal. Yeah, why do you want to take it up on yourself?
Allah, is true, my lord, but what I am saying is that let him not dictate what
ಅವ್ರ
right
ಕಡೆ
I have
ನಾನ್
got.
ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ, ಅವ್ರೇ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ಕೆ ನಾನ್ ಮಾಡ್ತೀನಿ.
Allah, let him not dictate to me, my lord, as to what I should
No,
do. in
I will
respect of the
dictate.
property
Don't worry about it.
belonging
The
to
court,
me.
court will give the dictation.
I am only saying that,
On
what, all right.
18/12/2024, this court took note of the undertaking given by the counsel for the fourth respondent that a compound wall has been constructed on the boundary and is further undertaking that you would not put up further construction till the next date of hearing. So this undertaking was continued on 24/3/2025. Non-counsel, the petitioner, however, seeks to contend that despite this undertaking, efforts are being made to put up the construction and an agreement of sale has also been executed by the fourth respondent. It is not in dispute that the entailment of the petitioner for conferment of occupancy rights is pending consideration of the land tribunal. And this writ petition arises out of a change in the revenue entries based on an order of regrant. Since the question of the petitioner's entitlement for being conferred with the occupancy rights is pending adjudication before the land tribunal, it is obvious that status quo as it exists today will have to be maintained. Consequently, the fourth respondent is directed not to put up any further construction. He is also restrained from alienating the property till the disposal of the matter before the land tribunal. Relist. ಅದು ಯಾವತ್ತಿಗಿದೆ land tribunal ದು?
ಅಲ್ಲ, ಮೊನ್ನೆ ಇತ್ತದು, ಮೊನ್ನೆ 24th ಇತ್ತು.
ಯಾವತ್ತಿಗೂ ಇತ್ತು?
ಇವಾಗ
ಅದು ಇದೆ. ಟ್ರೈಬಲ್ ನಾವು ಅಪೇರ್ ಆಗ್ತಲ್ಲ, ಬೇರೆ ಯಾರು ಇದ್ದಾರೆ ಹೇಳುವನ್ನ.
If you give me the date,
last day when the matter was listed, my lord, the case before the tribunal was listed on that.
What
day.
is the stage?
Next date.
what is the stage?
ನಾವು ರಿಮೈಂಡ್ ಮಾಡಿದ್ಮೇಲೆ ನೋಟಿಸ್ಗಳು ಬರ್ತಾ ಇದೆ.
Notice ಬರ್ತದೆ.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಗಿರ್ಲಿಲ್ಲ, ಇವಾಗ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ.
Constitute ಆಗಿದೆ, commence ಆಗಿದೆ
No,
proceedings.
the reason why I asked is I will issue a direction to the land tribunal to dispose them at expeditiously.
My lord, well.
And depending on that, I will, this order becomes easy.
Month or two, your lordship may say that, my lord, or 3 months, 6 months, whatever your lordship.
Expeditious disposal, absolutely. He cannot have any objection. I will not also have
Once
any.
the parties are represented before this court and also before the land tribunal, having regard to the controversy at hand, it will be better to direct the land tribunal to dispose of the petitioner's application seeking confirmed occupant rights within a period of 3 months. Immediate receipt of a copy of this order.
These impugned orders will not erase the effect of those entries. which I
ಅದೆಲ್ಲ
cited.
ಇಟ್ ಸಾಕು ಸಾಕು ನಿಮ್ ಪ್ರೊಡಕ್ಷನ್ ಆಗಿದೆ.
ಇವಾಗ 3 months. Your lordship kindly say, dispose.
Disposal pending ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. Because if land tribunal passes an order in his favor or rejects in his favor, rejects his application, I'll simply confirm the order. No, if the writ petition is allowed in his favor, Kate will have to go in his name.
No, not
If it is rejected,
because that is subject to.
ವಿಷಯ ಕೇಳಿಸ್ಕೊಳ್ಳಿ. If it is rejected, it will continue your name. Train ಸಲ ಹೋಗ್ತಾರೆ ACDC ಹತ್ರ.
My lord, that my entry, my lord, has been there since 2004.
Therefore, if you get case form number 7 rejected, I'll confirm this order and dispose of writ petition.
Not be.
ನಿಮ್ಗೆ ಒಳ್ಳೇದಲ್ವಾ?
I don't know.
My submission is that, let me have my say in the matter. What I am saying is that your lordship may dispose of the writ petition. Dispose of the writ petition in whatever direction you would have given, because my lord, we do not know the land tribunal stage as on date.
We don't know
As
what.
on date, 3 months or 6
What-
months, that is one aspect of the matter. Second is that your lordship may kindly dispose of the writ petition.
What is his apprehension with this order? I don't understand.
6 months, your lordship.
The writ petition, let it be pending.
3 months.
Court will be monitoring the situation.
Number 45.
Survey for the petitioner. But this is Tahsildar notice, my lord. After 20 years, 30 years, father farms the site, he sells to 30 persons. And at the instigation of this, one of
Is
the
annexure F?
annexure F, my lord.
Annexure F, my lord.
64.
The last occasion the matter had come up, my lord, the
Lordship examined the
attention is
provision.
that, my lord, the respondent, the Tahsildar has no power to issue this notice. My lord, may kindly see this, my lord.
Because
the
before that, my lord, sir,
notice.
document.
ನೀವು ಸೈಟ್ ಅದ್ರಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ರೆ ತಾನೆ?
ಇವರೆಲ್ಲ ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಪ್ಪ ಮಾರಾಟ
ಇಲ್ಲ, ನಮ್ದು ಜಾಗ ಇದೆ ಇನ್ನೂವೆ. There is
ಏನಿಲ್ಲ. ಸೈಟ್ ಮಾಡಿ ಎಲ್ಲ ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
there is still land available, your lordship, that is my father ancestral property. Kindly see the annexure R6, my lord, which I have produced, which is under notice. There are about 20 notice, my lord, of similar nature has been issued. Last occasion,
I will quash all the notices,
my lord.
even without having
I leave it to
petition filed.
I leave it to your lordship, my lord, but I want to convince your lordship on the ground that the contention of my petition, my lord, before this honorable court, the Tahsildar under law, my lord, has no authority to issue this notice, my lord. That was his argument. Kindly see annexure R6, my lord, similar notice which was issued to the other persons, my lord, same notices, my lord, to show that there is a delegation of power given to the Tahsildar. What could be exercised by the deputy?
So may under the Provincial Land Revenue Act,
Yes.
what is the power of the Tahsildar?
Tahsildar, no, my lord, the deputy commissioner has issued the notice, my lord, notice, the
For what?
deputy commissioner has issued, he can kindly see 96(1), your lordship may kindly see. 96(1) of the act. Penalty for using agricultural land for other purposes without permission. It is an admitted fact, my lord, it is a revenue land. Belong to my great grandfather. And without authority of law, without sanction of plan, my lord, with illegally, site must have been formed and illegally construction must have been done. That will not give a right, my lord, is my,
Within the master plan.
my lord.
This comes within the master plan, isn't it? ಎಲ್ಲಿರೋದು ಈ ಜಾಗ?
This area is in, my lord, Dasanpura,
Dasanpura.
That comes
Hobbli
within the master plan.
Shivnapura.
It comes
master
within
plan.
the master plan.
ಈಗ
Therefore,
ಬಂದಿರಬಹುದೇನೋ.
Therefore, the planning authority is the competent authority. not the
1995 ಅಲ್ಲಿ ಆಗಿರೋದು ಇದು 1995 ಅಲ್ಲಿ. That's what their case, my lord. I want to show you to your lordship, my lord, whether the notice issued is in accordance with law or not is the question, my lord, before this honorable court. The
2000
petitioner before this honorable court, instead of answering to the notice, my lord, has rushed to this court. All that it is said, my lord, ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಆದ ನಿಮಗೆ ಮೂಲಕ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ದಾಸನಪುರ ಹೋಬಳಿ ಶಿವನಪುರ ಗ್ರಾಮದ 104/2, 104/5 ಕೃಷಿ ಜಮೀನಾಗಿರುತ್ತದೆ ಮತ್ತು ಹಸಿರು ಪಟ್ಟಿ ವಲಯದಲ್ಲಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಲ್ಲಿ ನೀವು ಅಕ್ರಮ ನಿವೇಶನ ಕ್ರಯದಾರರಾಗಿದ್ದು
ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 23 ಗುಂಟೆ ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನನ್ನು ಕೃಷಿಯೇತರ ಉದ್ದೇಶಕ್ಕಾಗಿ ಎಂದರೆ ಅನಧಿಕೃತ ಬಡಾವಣೆ ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ ಹಾಗೂ ಬಡಾವಣೆಯ ನಿವೇಶನಗಳನ್ನು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಿಂದ ನೀಡಲಾಗಿದೆ ಎನ್ನಲಾದ ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಣಿಯಾಗಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಕಾಯ್ದೆ ಕಾಲಂ 96(1) ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಪ್ರದತ್ತವಾಗಿರುವ ಅಧಿಕಾರವನ್ನು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ LN ರಂತೆ 18/8/20 ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಅಧಿಕಾರವನ್ನು ಪ್ರತ್ಯಾರೋಹಿಸಿ. My learned friend client contention is that
that notification.
notification my learned friend has to produce. It is referred to in this 18/8/2020.
Give me that notification.
ಅವ್ರಿಗೆ ಫೈಲ್ನೇ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. 18/8/2020 delegation of power ಕೊಟ್ಟಿದೆ. Accordingly has acted your lordship. What is wrong in it is the question. That's what I wanted to highlight you to your lordship on the last occasion.
Now, after a complete layout is formed, the entire.
Who formed the layout is the question.
Father,
Who formed
2004. I put
layout
same
formed,
date.
whether it is approved, whether there is a sanction of law.
You are the Katedar, correct? Your father was the
Yes.
Katedar.
Yes, my lord.
So you are the person to be prosecuted.
Yes.
No. We have not done any.
So unauthorizedly use your land for a purpose other than agriculture.
That is one issue, your lordship.
Therefore, you have to be prosecuted.
That is one issue, your lordship.
Able.
That is one issue.
That is the main
There is-
issue.
No, there is, why, this case is precisely, my lord, on a simple issue, my lord. Whether this notice is issued, whether this court requires interference is the question, my lord. Their contention is, my lord, though it is.
Things
No,
initiated
At the instance.
in your absence,
That's-
without going against you first, would be improper. So let them go against you, let them remove all your structures that you have put up and then go against them, because you are the Katedar. ನಿಮ್ದೇನೆ ಜಮೀನ್ ಅದು
ನಮ್ದೇ ಜಮೀನ್, ಅದ್ರಲ್ಲೇನು ಎರಡು ಮಾತು.
ಮನೆ ಓಡ್ಸಕೋಣ ಫಸ್ಟ್,
ಅಲ್ಲ,
ಆಮೇಲೆ ಅವ್ರ
ಇಲ್ಲಿ ಅಲ್ಲ, ಇಲ್ಲಿ ಕ್ವಶನ್ ಇರೋದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. ಐ ಆಮ್ ನಾಟ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ,
ಲೆಟ್ ದೆಮ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ರೆಕಾರ್ಡ್ ಮೇಲೆ, ಲೆಟ್ ಅಸ್ ಸಿ my lord. Let them produce.
ನೀವು
ಅಲ್ಲ, there is a suit also, my lord, which has been filed by us, my lord, for
ಏನಕ್ಕೆ
declaration, where all these people are party before the civil court.
GP ಅದರ ಮೇಲೆ ಮಾಡಿದೆ.
ಇಲ್ಲ partition.
Partition and separate position, and also for declaration we have sought your.
Simply close the saying that this is a proceeding as an outcome of your complaint, and you cannot maintain such a complaint after having sold the property. Therefore, close the proceedings for the present.
No, they have not taken the contention, my lord, that saying that this
ನಾನು
notice is
building
issued
plan ಎಲ್ಲ
without authority of law, my lord. There is no ground taken, my lord.
ನೀವು ಅದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರೆ ನಾನು ಅದೆಲ್ಲ ಹೇಳ್ಬೇಕಾಗತ್ತೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಅದೊಂದು 18/8/20 ಒಂದು ನೋಟಿಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ ನೋಡೋಣ ಅಂತ ಅಷ್ಟೇ.
ಬಟ್ ಆಮೇಲೆ ಅಲ್ಲಿ ಡೆಲಿಗೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅದು.
Then I'll have to ask
That is
them to
number
go
one.
against you
Or the
also.
ಅದಕ್ಕೆ
ಬೇಕಾದ್ರು.
ಐ ಲೀವ್ ಇಟ್ ಟು ಯು ಲಾರ್ಜ್. ಅಲ್ಲ, ಅದ್ರ ಸೂಟ್ ಎಲ್ಲಾರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಒಂದ್ ಸ್ವಲ್ಪ ಬೇಗ ಮುಗಿಸೋಕೆ.
I'm the third purchaser.
The petition is directed. The
Petition. What?
issuance of amicus by the Tahsildar purported to be in the excess of pass under section 96(1),
ನಂದಿದು.
probably under section 25 and section 96(1) of the Land Revenue Act. In the notice, it is contended that the petitioners had formed a layout illegally in land banks number 104/2 and 104/3, measuring 1 acre 23 guntas. And therefore, they were required to file their explanation to the notice. Learned counsel for the petitioner points out that these proceedings are as a result of the complaint lodged by the proposed respondent Gangamma, who's already instituted a suit in verse 511/2022, seeking for a declaration. Gangamma ta nim client ಹೆಸರು.
ಗಂಗಮ್ಮ.
Declaration that he is the absolute owner of the property and for a grant of a decree of injunction. Learned counsel for the petitioner has placed on record the copy of the tax paid panchayat receipt, building license by the panchayat, and also building license issued in respect of similar sites. In the light of the fact that the petitioner has been permitted to put up a structure by the panchayat, who is the regulatory authority over the lands coming within a panchayat area, the tahsildar would not be right in issuing a notice saying that the layout is illegally formed. So it is also to be noticed that the proceedings are admittedly initiated at the behest of Gangamma, who has already filed a suit against the petitioner. And therefore, the intent of the tahsildar is basically the intent of Gangamma. In that view, it might not be appropriate to permit the tahsildar to challenge, to initiate proceedings in the purported exercise of SPAR under section 25 and section 96 bar 1. Consequently, the reputation is allowed and the interim order is quashed.
Direction may be issued, my lord. There is a suit pending, your lordship.
But
Could
that
be
they are
the
collusive
report of
suits,
exposition.
that they are collusive, they filed other partition suits also. ಅವರವರೇ suit ಹಾಕೊಡ್ತಾರೆ.
ಬೇರೆ ಒಂದಿದೆಯಾ?
ಇಲ್ಲ.
ಇನ್ನೊಂದು suit ಹಾಕಿದ್ದಾರೆ, partition suit
ನಾವು
ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಹಾಕಿರೋದು
ಅವರೇ compromise
OS
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
511 of 2022, wherein I have sought for declaration, declaring that I am the owner of the property.
Dispose of the suit as expeditiously as possible, subject to both the parties cooperating.
Number 46, Sarvana is.
In this, I appeal for respondent. I have filed this application for vacating of the interim order.
Lords, the 136 ಏನಿದೆ?
Lords, 136(2) in 136(2) proceedings, the Assistant Commissioner declares the extents of properties to which the parties are entitled to title, and he says that accordingly the entry should be made. Lords, the property in question measures 2 acres and 37 guntas, 4 acres and 37 guntas.
Where is the order of the AC?
Lords, page number 39 and the relevant portion your lordships may kindly see at page 43, para 12. ಅಲ್ಲ ಅವರು ಓದಿದ್ರೆ
You
ಗೊತ್ತಾಗುತ್ತೆ.
are the appellant, huh?
Lords, ಅಲ್ಲ, Lords, the sale deed of 1988 entries are made pursuant to 88.
You are the second respondent.
I am the second respondent. Podi takes place, Lords, in the year 1992. Then because of the subsequent entries, Lords, the MRs are affected because of the death and all in 2006, 2007. 2015 appeal is filed. No,
Now, I didn't understand the first paragraph.
That's,
Page 41.
page
Challenging the
43,
order dated
Lords, the order,
Para 2, my lord, kindly.
Lords, page number,
Page 41.
the delay is condoned by one line order, para 1.
What
This
was
is-
the appeal against?
Lords, the appeal was against the entries which were standing in the names of the family of Chennigappa through about 5 to 6 mutation entries because there was Lords, a partition, there was a death, there was a,
Please come to page 41.
please, 41 Lords.
Challenging order dated 25 to 2008 in RRT number so and so and
Yes.
number 75/0708, number 25.
20 by 2002, affect the mutation in the names of the appellants in respect of property in survey number 52/2,
So
measuring 26 guntas.
what happened under these three mutations?
Lords,
RRT
under
50,
these 3 mutations, the property which was originally belonging to me because of the Podi proceedings which took place, dividing 52/2 into 52/2A and 2B. For 52/2A, the entries was carried out to an extent of 3 acres, 3 acres, 23 guntas. 3 acres, 23 guntas.
Do you have a copy of this MR 75 and
That's not produced.
I have
Lords.
filed my synopsis, my lord, may kindly get that synopsis.
Lords,
Briefly, I
if you
have
all-
stated history of the
Lords, may I
case.
just make, Lords, it is like this, Lords. Chennigappa sold a portion of the property. The portion of the property which was sold by Chennigappa was in favor of the contesting respondents' predecessors in title. Sale deed indicated it is an extent of 2 acres. They in turn sold the property in favor of an Umapati. So when Umapati got this land measured and the survey was fixed, it was found that the property which is actually in his occupation is only 1 acre, 14 guntas. I produced a copy of the sale deed. Not even a square inch of property was retained, Lords, by this, by the predecessors in title of the present contesting
ಇನ್ನು
respondent.
fail ಮಾಡಿದ್ದೀನಿ.
After 25 years, 30 years, they come back and say, what we purchased is 2 acres, what we sold is 1 acre, 14 guntas. We still have another 26 guntas, therefore make mutation in my name by cancelling all the mutation entries, which is taken place between 1988 to 2015. So how the Assistant Commissioner does this is, Assistant Commissioner says, correct,
going by numbers, what the Chennigappa's family sold is 2 acres. And 2 acres should have been there in the name of this Gangappa and Muddamma. But what is found is they sold this entire extent of property because I have the SAID I have produced in favor of the purchaser, that is purchaser is Umapati. Purchaser is Umapati. Now Umapati's name is reflecting only for 1 acre 14 guntas. Therefore 26 guntas should be made out in the name of this Gangappa and Muddamma. That is the legal heirs of Gangappa and Muddamma. This is what says para 12 if your lordships were to see me lords. Page 43. How the assistant commissioner deals with this. Further on perusal of the RTC extracts, it's also clear that the new survey number 52/2B has been assigned to the property measuring 2 acres belongs to Gangappa. Thus, it is clear that the new survey number 52/2A has to be assigned with the remaining extent of 2 acres 37 guntas, which was retained by Chennigappa in survey number 52/2. But on perusal of the computerized RTC in respect of survey, in survey number 52/2B and 2A, it shows that 52/2B has been assigned only to the property measuring 1 acre 14 guntas, which was sold by Gangappa in favor of Umapati. Now the same is standing in the name of his son Niranjan, and has not mentioned the remaining extent of 26 guntas, which was retained by the said Gangappa. On the contrary, 26 guntas has been included in survey number 52/2A. Even though Chennigappa had retained an extent of 2 acres 37 guntas in survey number 52/2, after assigning new survey number and after entering revenue entries in the computerized RTCs, first respondent authorities committed a grave mistake by entering 2 acres 23 guntas in the name of the said Chennigappa in survey number 52/2B instead of 2 acres 37 guntas, and the remaining extent of 26 guntas ought to have been entered in the name of Gangappa, which he had acquired from the said Chennigappa under the registered sale deed. Therefore, the said Chennigappa was having right over the property measuring 2 acres 37 guntas in survey number 52/2A, and hence the response 2 and 3 are entitled only for an extent of 2 acres 37 guntas in survey number 52/2A of Machualdi village, and remaining 26 guntas is belong to the father of Gangappa, and since he is no more, appellants being their heirs are entitled for 26 guntas.
Your sale deed was for 2 acres.
My sale deed was for 2 acres, but when they sold the property, their sale deed I have produced, my lords, because they are saying we have retained an extent of 26 guntas. That is their case.
Your Gangappa sold it to you.
Lords, Chennigappa sold it to Gangappa. I am Chennigappa's successors in interest.
Chennigappa sold it to Gangappa.
Gangappa and Muddamma purchased from Chennigappa. Chennigappa sold it to Gangappa and Muddamma. Gangappa and Muddamma, without retaining even a square inch of property, they sold it in favor of Umapati.
You are claiming on whom?
Lord, Chennigappa.
You had purchased 2 acres.
Lords, I was having 4 acres 37 guntas.
The entire survey number.
Entire survey number. Now, the property which was sold in favor of Gangappa and Muddamma reflected an extent of 2 acres.
The remaining 2 acres was yours.
Was mine. But after Gangappa and Muddamma, when they wanted to sell the property in favor of Umapati, what was actually with them, despite this, is only 1 acre 14 guntas. Therefore, they conveyed 1 acre 14 guntas in favor of Umapati, not retaining any extent. Page number 37 is the schedule.
You cannot have any right over and above 2 acres.
Lords, it is reflected. Lords, I am not claiming.
Not a question of reflection. If you admit that you own the 4 acres and not, and you sold 2 acres, obviously your entitlement for the revenue entries is for remaining extent.
Lords, that is the reason why I said, Lords, the revenue entries are there from the past for 25 to 30 years. It is not that the first time the revenue entries came to be made. Now, the question is, after 30 years, they come back and say, we have retained 26 guntas. Now, which portion? Let us assume they have retained 26 guntas. Which portion of 26 guntas? This is not a question which could have been gone into.
26 guntas do you own now?
That is the reason, Lords. Which portion is already reflected because a PODI is carried out. 52/2A and 52/2B. Lords,
PODI will confer title on you.
Lords, PODI is carried out for the purpose of identification of the property which is in my possession.
Let us assume you're in possession of 2 acres 26 guntas. How can you get the Khata for 2 acres 26 guntas?
Lords,
so maybe an unauthorized possession.
Lords,
but how can you get the Khata on the basis of that?
Lords, that is the reason why I am submitting, Lords. Now, how will he claim title? Because he was the one who went to the assistant commissioner. He should show he has a semblance of right over the property to claim that he has retained some extent of property when he has admittedly sold the property. Similar situation which your lordships are posing against me. The state of affairs which existed for 30 years is sought to be disturbed at his instance. This is a question which has to be asked to him at the first instance, Lords, as to where did he retain the property? This is essentially the question, Lords. Where did he retain the property? In the sale deed which he has executed in favor of Umapati, which your lordships will find at page number 35. He sold the entire extent. If he has made any mention, because if he had retained any portion of the property while selling the
Question that gentleman has to come and question it. You can't do anything.
so far as that gentleman is concerned, he is happy with the entries which is standing in his name. He is not questioned. A person who has lost right to the property without retaining any extent, he comes with the assistant commissioner after 30 years, on which basis the entries are sought to be changed. There is a reasonable time principle. Appellate power also cannot be exercised after a period of 3 decades.
Basically reflect the title owners, isn't it?
Pardon me?
The RTC should basically reflect the people who have title. You have title only for how much?
2 acres.
No, I just.
2 acres only.
The whole difficulty is, this was 5 acres, 4 guntas, along with 7 guntas of kharab.
How much did you purchase?
4 acres, 37 guntas.
When was this?
This purchase, this is by means of a gift in 1919. 1919.
And when did you sell that?
Gangappa and Muddamma I sold in 1956.
1956. To Gangappa and Muddappa.
Yes. And then, this is what is very important.
Muddappa.
Muddamma. Gangappa and Muddamma.
You sold 2 acres.
Yes. Here what is important, my lords?
For retained 2 acres.
Let us not go by the numbers for the present, my lords. I wanted to say this. When this sale took place between 56 to 88, when the property was sold, I wanted to mention this because what property was sold in favor of Gangappa and Muddamma was assigned with survey number 52/2B as measuring 1 acre 14 guntas. I am speaking about 1956. Then it was mentioned as 1 acre 14 guntas. Then 52/2A was again mentioned, my lords, as 3 acres 23 guntas. This is the podi which took place. 3 acres 23 guntas.
So can the kata be made out on the basis of the podi?
Lords, now
Ignoring the title deeds?
Lords, the title deed is there, but the available extent of property within the boundaries, if they find that this is the only extent of property and if this is the podi affected, Lords, I am speaking about 5 decades. Then 1988 is what is very important. The property which was ported as 52/2B was transacted by Gangappa and Muddamma without retaining any extent of property in favor of one Umapati.
Entire 1 acre 14 guntas sold.
Yes. Now, kindly have a look at page number 35, minutes is the sale deed. There is no property which is retained. They say that the entire property which has come to them under the sale deed is 1 acre 14 guntas which we are selling it. If I were to, now the question is this, can all these things be looked into by the assistant commissioner?
Whatever you are arguing, can all this be gone into? Can the Tahsildar say that 1 acre, he purchased 2 acres, he sold 1 acre 14 guntas, had not written any property, therefore I am not going to get his name changed. It's open for him to say that.
They had already accepted the mutation entry and acted upon the mutation entry by selling the property.
Can the Tahsildar say that he had purchased 2 acres, kata was in his favor for lesser extent, and the extraction would go to the other person?
Whatever is retained by me within the boundaries is what is reflected after a podi in 1950s.
Once you mention a particular extent in the survey number, in your sale deed, the RTC should reflect that.
If you are absolutely no difficulty, my lords. Now the question is this, my lords. Once they accepted the podi and their property is measuring 1 acre 14 guntas, kindly have a look at page 37.
Then your argument essentially is that the kata should be made only on the basis of the podi, not on the basis of title.
I am standing by the statement that the khata should be made on the basis of the registered instrument to which they are the parties. They are the parties to the sale deed of 1988. They say what we got is only 1 acre 14 guntas and we are selling 1 acre 14 guntas. Kindly have a look at the sale deed. Whether the interpretation of a document of the kind should be undertaken by the revenue authorities is the question, because this is a registered instrument. The same thing applies, my lords. If a registered instrument says that they are the owners of this portion of the property, can the Tahsildar or the assistant commissioner or for this honorable court would come and say, no, let them be given a larger extent of property than the one which they have exceeded to? Kindly have a look at page number 35, minutes.
Yes.
Lords, so and so. 16/9/88 ವಿಜಯನಗರ 3ನೇ so and so, my lords, I will just skip this. ಅದಾಗಿ ತಾರೀಕು 1/5/56ರಲ್ಲಿ ನೆಲಮಂಗಲ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಕಚೇರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆಗಿ ನಂಬರ್ ಆಗಿ ಪತ್ರದ ಮೂಲಕ ನನ್ನ ಸ್ವಾಧೀನಕ್ಕೆ ಬಂದಲಾಗಾಯಿತು. ನಾನೇ ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ಟಬೇಕಾದ ಕಂದಾಯ ವಗೈರೆ ತೆರಿಗೆಗಳನ್ನು ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಅನುಭವಿಸುತ್ತಿದ್ದು, ಈ ಕೆಳಕಂಡ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಜಮೀನು ನನ್ನದರ ನಿಮಿತ್ತವಾಗಿ ಅಂದ್ರೆ ಕುಟುಂಬದ ಖರ್ಚುಗಳಿಗಾಗಿ ಮತ್ತು ಇದರೇ ಸ್ವಂತ ಖರ್ಚಿಗಾಗಿ ಬೇಕಾಗಿದ್ದು. So and so, Milords, this I will skip all these things and come to page number 37 where there is a description of the schedule. It's almost in the middle of the page. 14/3/1976 ಅಂತ ನ್ಯೂಮರಿಕಲ್ಸ್ ಇದೆ. ಅದಾದ್ಮೇಲೆ 6 ಕಾಯ್ದೆಗಳಿಗೂ ವ್ಯತಿರಿಕ್ತವಾಗಿರುವುದಿಲ್ಲ. ಶೆಡ್ಯೂಲ್ ಜಮೀನು ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ದಾಸನಪುರ ಹೋಬಳಿ ಮಾಚವಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 52/2B 52ನೇ ನಂಬರ್ 2B ನಂಬರ್ ನಲ್ಲಿರುವ ಪೂರಾ 1 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದಿ. ಅದ್ರಲ್ಲಿ ಅವ್ರದ್ದು ಯಾವ್ದು ಜಮೀನ್ ಇಲ್ಲ. Not this is what they are referring to as 52/2B is 5 decades old.
And they purchased in 56. What was the 7 number that they purchased?
52/2.
So therefore, 52/2 could have been 52/2A and 52/2B.
No, it's 52/2.
They may sell one portion of their particular purchase.
Where is the retaining extent in the sale deed is what I am asking myself, Milords.
This you want the Tahsildar to determine.
Milords, this is essentially what the Assistant Commissioner has done. Assistant Commissioner says, now this is my case. Milords, I will assume a situation of this kind. They will come and say that, no, I have retained 26 guntas. I'll produce the sale deed to them and say that from the sale deed, they have not indicated any extent is retained by them. Pura swatana or marktare ಅಂತ ಹೇಳಿದ್ದಾರೆ. 1 acre 14 guntas is there. Podi is there, Milords, indicating the name of this.
This is what I said. If I go back to the 56 document, you only sold 2 acres, retained only 2 acres 37 guntas. How can the kata be in your favor? In rest of 3 acres 23 guntas.
Milords, that's the reason why I'm submitting, Milords. After a lapse of 50 years, I can understand that. Your Lordship is asking me this question, Milords, of what has transpired about 75 years back. But the same question was to be asked by the Assistant Commissioner that the state of affairs has continued for 75 years. Even had they gone to the civil court, would they have entertained a civil court suit of the kind is the question. This is, Milords, essentially, if your Lordship were to see, Milords, the boundaries. ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 52/2B ಈ ನಂಬರ್ ನಲ್ಲಿ ಪೂರಾ 1 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ ತಿರುಮಲಯ್ಯನವರ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಇದೇ ನಂಬರಿನ, ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದಟ್ Milords, ಇದೇ ನಂಬರಿನ 52/A ಚನ್ನ ವೆಂಕಟ ರಾಮಚಂದ್ರ ಇವರ ಜಮೀನು. 52/A is the property belonging to me, is something which is there in this instrument. I am not trying to say more than what he has already said in his instrument. I am not building a case, from what I am saying. This is what is contained in his instrument, where he says 52/2A is the property of Chinna Venkata Ramachandra. Having said that, now if your Lordships were to see the entries which is challenged at page number 41. (2007, 2008, 2010, 2011). Notes from 2007, 2008 could not have been maintained because the entries pertaining to 52/2A and 52/2B are in existence right from 1960. And the name of the legal representatives of this Channigappa is maintained since 1960 for 52/52/2A. Now the entries are sought to be made. Now what he does is, Assistant Commissioner says, you enter the name of Channigappa's LRs along with the LRs of this Muddamma and Gangappa to an extent of 26 guntas in 56/2A. He never claimed ownership for 56/2A. Now, can this question be gone into, Milords, in a revenue proceedings is the precise question. That is the ground which I have raised. Number one, delay, Milords, is of more than 4 to 5 decades from the time on which 52/2A was.
40 records.
I'll produce it, Milords. 40 records we have. Yeah. Ivaginda, avagindu.
When it became 52/2A and 52/2B.
Milords, this was at any rate prior to, Milords, I have produced at page 29. Adu date.
The survey has been conducted, report has been submitted, it is with the
Date.
government.
1959 ಮೇಲ್ಗಡೆ ಇದೆ ತಾರೀಕು, ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ. 22/10/1959. 2A 2B ಅದರೊಳಗೆ ತೋರಿಸಿದ್ದಾರೆ. 52/2 ಪೂರಾ ಹಿಸ್ಸೆ ಚನ್ನಿಗಪ್ಪ ವಂದನಪ್ಪ ಇವರಿಗೆ ಸೋನ್ಸೋ ಮೇರೆಗೆ ಗಂಗಪ್ಪನ ಅವರಿಗೆ ಖುಷ್ಕಿ ಅನುಭವದಂತೆ ಮಾಡಿ 2A 2B ಹಿಸ್ಸೆಗಳು ವಿಂಗಡಿಸಿರುತ್ತದೆ. IL ರೀಸರ್ವೆ ನಂಬರ್ 52/2 ಬಂಡಿದಾರಿ ಬಗ್ಗೆ ಕಾಣಲು ಸೋನ್ಸು. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹಾಕಿದ್ದಾರೆ ಚೆನ್ನಿಗಪ್ಪ ಬಿ ನಂದನಪ್ಪ 2A, 2B ಗಂಗಪ್ಪ. It's 1959. Entries are there from 1959 and onwards till date. At least the body proceedings which has been conducted, identifying the property which is in my possession, which is in his possession. If it is sought to be challenged for the first time, I can understand. But there is an acceding to the state of affairs which existed in 1959 by executing a sale deed saying that 52/2A does not belong to him. 52/2B whole of property belongs to him. He is selling it to Umapati. There is something called a estoppel, for a person to come before the revenue inspector, revenue authorities and say that he still owns any portion. And he doesn't give any boundaries of what he wants to claim is having been retained. It is not about mathematics or arithmetics. It's about the entries having been made for about 5 decades, 6 decades, 7 decades. Now, if we are computing it from 1959, it's the 7th decade. After 7 decades, to undo whatever has happened, is something.
After the sale, it was executed. What is the MR that was done?
Pardon,
So the sale, it was executed by this, what's his name? Gangappa, alva?
Umapatiga,
Gangappa Muddappan yaar mariddu?
Chennigappa.
Where is the 56? The sale was made.
Alla, idu order alli onde one second.
Forge ಮಾಡಿದಾರು.
If your lordships were to see the orders dated 22nd April 2024,
56 was the sale deed, isn't it?
56.
Where is the MR pursuant to that sale deed?
ಇದೆಯಾ ನಮ್ಮ ಹತ್ರ?
There are no MRs.
ಇಲ್ವಾ? ಅಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ರು ಅದಕ್ಕೆ. Pay, Milord's orders dated 22nd April 24. The question therefore is whether the property is purchased by Gangappa and Muddana was
Does the
assigned with.
MR with you pursuant to the sale deed of the 56 to Gangappa and Muddappa?
No, that MR is not with us, your lordship. It is forged one, your lordship. That MR which they say, my lord, which is forged one by them.
ಯಾವ MR?
ಯಾವ MR?
MR one, MR,
Must not you have the copy of this MR?
MR number.
ಏನದು? ಏನ್ರಿ ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀಗ? ಇಲ್ಲ, ಇದನ್ನ ಕೊಟ್ರಲ್ಲ. ಅಷ್ಟೇ ನಮ್ಮ ಕೇಸ್. ಇಲ್ಲ ರೀ, ಇದ್ರಲ್ಲಿ ಮುಂಚೆಯಿಂದನೂ ಅಷ್ಟೇ ಇದೆ. ಇದೆ ಕೊಡಿ. ದಾನಪ್ಪ ನನಗೆ ಹೆಂಡತಿಗೆ ದಾನ ಇದಲ್ಲ.
1956 ಆದ್ಮೇಲೆ ಅವ್ರ MRA ಇಲ್ಲ ಅವ್ರು.
ಅವ್ರದ್ದು ಇರ್ಬೇಕಿತ್ತು.
I need the MR pursuant to the sale deed.
ಇಲ್ಲ.
Because 56, if the sale was conducted, whatever was the MR that happened, that should be reflected. Not the podi should not reflect the title deed, isn't it? You are going by the podi records.
Revenue records are maintained.
Tomorrow another podi is conducted. Then his extent is reduced, let's say from 2 acre 37 guntas to 2 acres. Will you change the MRs also accordingly?
ಇದರಲ್ಲಿ
Monday.
ಎಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
I need the MR pursuant to the sale deed of the year 50.
ಆಯ್ತು, ಅವ್ರು ತೋರಿಸ್ಕೊಳ್ಳಿ ಬಿಡಿ.
The order of the deputy commissioner and the Tahsildar, assistant commissioner are concurrently held, your lordship, on facts and on the basis of document. Whatever 26 guntas which was retained after selling the property, my lord, it has been restored to us, that's all, my lord.
No, no.
If at all, if he has agreed, my lord, he can file a suit. There is already a suit.
Get that MR.
There is one suit, my lord, where is a party already. Suit is filed, my lord,
By whom?
by us, my lord. There is already a,
Okay.
yes, my lord. The 252 of,
For what?
for declaration of all the properties are 68, my lord, may kindly see, declare that the plaintiffs are the absolute owner of the property,
ಅದು ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
wherein they are also the parties
Get
in
that
respect of the
MR.
property in question.
Get that MR.
The synopsis which I have filed, my lord,
ಇಲ್ಲಿ ಬಿಡಿ. ಇಲ್ಲಿದೆಯಲ್ಲ.
230 mode matter. Serial number 1, Shri A.V. Nishant.
Lord, the interim order needs to be extended in that pattern also, please.
Lord, a notice has been issued by the Tahsildar. Tahsildar has no jurisdiction. Lord, can I persuade you, Lord, to look at page 13? 1-3. 104 ಅಲ್ಲಿ notice ಕೊಟ್ಟಿದ್ದಾರೆ. At the top, your lords get it. ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 1964 ಕಲಂ 104 ಅಡಿ ಒತ್ತುವರಿ ತೆರವು notice. Please come to my lord the amendment which has been brought about to the Land Revenue Act, my lord, at page 15.
Only a show cause notice, isn't it?
Just show
Lord,
cause notice.
would your lordship look at page 15 for a minute? Please come to 16.
Page
15 at 16, my lord, there's been an amendment to the Land Revenue Act in the year 2025. In January, please come to 16. 67, amendment to 67.
Yes.
Subsection 2, the word deputy commissioner or survey authority officer not below the rank than the deputy commissioner. The words assistant commissioner or survey officer not below the rank of assistant commissioner shall be substituted. Then please come to my lord 4. Amendment to section 104. In the Principal Act, in section 104, the words and figures not transferable by virtue of any condition lawfully annexed to the tenure under the provisions of section 91, 98, 99, words and figures which is covered under section 67, 71 of the Act shall be substituted. So, my lord, 67, only the my lord, assistant commissioner can issue a notice. This is without jurisdiction. There's no point in my going there.
That objection to this reply itself, isn't it?
My submission to your lord,
They say that you have no jurisdiction.
my lord,
If he passes an order, then you can challenge it. Why do you
again,
want
my lord,
to-
I'll have to come before your lordships. If you have no jurisdiction, let the proper authority issue a notice. I'll reply, no difficulty. I have all the records. From 1985, my lord, I have purchased. Eagalla. And my lord, please look at it.
No, there is an amendment, my lord, which
And my lord,
empowers the
he has already
Tahsildar.
held. Please come to my lord, page 13 ಅಲ್ಲಿ. He has already held that I am, my lord, an encroacher.
No, he says, this is my view. Give me the
ಕೆಳಕಂಡು
explanation.
ಇಲ್ಲ ಮೇಡಮ್, ಒಸ್ತುವರಿ ಮಾಡಿರುವುದು ನಕ್ಷೆ ವರದಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತೆ. ನಾನು ನಕ್ಷೆನೂ ಮಾಡಿಲ್ಲ.
That is what, that is the information that he has. Therefore, he's giving you a chance to give
Lord.
your objections.
Please look at it. He has already decided. ಒಂದು. ಎರಡನೇದು, my lord, he has no jurisdiction at all.
Said it, he has been informed by that survey that you are in unauthorized occupation. Therefore, he's asking you for an
My lord,
explanation.
there must be some, my lord, notice to me. ಇದು ಯಾವ್ದ್ರದ್ದು ಒಂದ್ರದ್ದು ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಇದು ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. Doesn't matter. But then what I am submitting before your lordships is jurisdiction ಇಲ್ಲ. Please look at, my lord,
No, no,
section
there
4.
is a jurisdiction insofar as Tahsildar is concerned, my lord. I'll place that amendment. Now, after all, my lord,
Amendment
we
ಅನ್ನ
have,
ತೋರಿಸಿರೋದು ಇಲ್ಲಿ,
their
2025
grievance is,
January.
Lord, their grievance is that documents have not been supplied, Lord. They can appear and we'll furnish all of those documents. Now, kindly see, my lord, there is a contempt proceedings which they have referred in para 4, my lord. There is a contempt, CC number 674 of 2020, my lord. In para 4 of the writ petition, the petitioner has referred to the contempt proceedings. Now, my lord, in this contempt proceedings, the court directed that all the government lands which have been encroached must be taken back. There is a committee which has been constituted by the state government, my lord. It's a special investigation team.
I've got it. Please look at
You
it.
have challenged
I'm
this
not
order to the Supreme Court?
before
Now,
the
they say they have challenged and the contempt court
Court is
is,
asking me a question, my learned friend is keeping on. Please have a look at this, my lord. Contempt order, my lord, is challenged before the Supreme Court. Matter is pending. We have filed it. I am not even a party here in the contempt. Contempt, I am not even a party, but that's,
not a party, my lord, but the
think, you know,
court.
my learned friend will have some patience.
All right.
When he argues, my lord, I did not even open my mouth. Please look at it, my lord. Question is, my lord, whether Tahsildar has jurisdiction, or if he has no jurisdiction, my lord, can it be, my lord, can he issue a notice? That's a short question for my lord's consideration. Please look at, my lord, the amendment. Amendment specifically says 67, it's only the deputy commissioner or the assistant commissioner who can issue the notice. 104 ಅಲ್ಲಿ, there has been an amendment to
My
104.
feeling is you can raise this contention there.
My
They
lord,
will pass some order.
again, my lord, he will pass some order. Again, my lord, in the highlight, let them, my lord, let the proper authority issue a notice. I'll reply, no difficulty
lord,
about it. Why are they shirking shy of, my lord, not issuing a notice through the proper officer? Is it that they want to, my lord, know what I want?
Let's find out.
Lord, section 39 empowers the deputy commissioner to issue notice.
No, you refer to.
104 now empowers the Tahsildar. I'll place that amendment before the court. It has been
Speech to-
amended, my lord. There, maybe I'll place the right copy, my lord.
Right copy?
The Tahsildar
Does
has
it
now
package
been
it up
empowered
there?
specifically to take action. It can be delegated. I'll place all those before the court, my lord. After all, there is 7 days time given for them to respond, my lord.
They can appear before the Tahsildar and say whatever they want to say. The survey has been carried out. Kindly see annexure, my lord. B, notice was given on 11th of March 2025.
No notice, nothing is given.
Survey
to
has
me.
been carried out. They are found to be encroaching nearly to the extent of
What is
6
this?
acres.
Kachariya Tiruluke Patra, Sambasanke, 11/3/25, what is this?
The survey by Tahsildar, there are two surveys which have taken place, my lord.
That
One
was-
by the committee which was being constituted pursuant to the GO, my lord. It consists of 5 members. A special investigation team has been constituted, my lord, headed by the regional commissioner, to look into all the encroachments insofar as the survey numbers are concerned. That committee has issued notices and survey has been carried out. 2 surveys have been carried out, my lord. I'll place that survey sketch also before this honorable court. And it is found that the petitioner has encroached nearly 6 acres of land. Some of it is water bodies, car track. So survey has been carried out. This notice has been issued pursuant to the survey sketch. I'll place it before your lordship.
And what is your contention on merits? What is your contention?
Section 16, my lord, he does not have jurisdiction at all.
That is on.
I've got, my lord, sale deeds of 1985. Grant certificate, my lord, made. All that, my lord, will place it before the assistant commissioner, no difficulty. Let the assistant commissioner issue notice. Why is he shirking shy?
No,
That's
104
all.
specifically authorizes Tahsildar. That is because of the recent amendment, my lord. I'll just get instructions in that regard, my lord.
Gazette
Lordship may kindly
notification ಹಾಕಿದ್ದೀನಿ
have it
ತಮ್ಮ
on Monday, my lord.
All right, till then, let them not take any precipitate action.
Allah, they have to just appear before the.
They will not take, because this notice only says they're asking you to furnish instructions.
Lord, please look at this. If, my lord, even if,
Would you do anything before Monday?
Nothing, my lord. Apart from asking them to come and
let
appear.
it be recorded, my lord, no difficulty.
Accepts notice on behalf of the respondent and seeks for time to secure instructions regarding the power available in the Tahsildar to issue the impugned notice. Since it is contended that it is only the assistant commissioner who has the power to issue the notice pursuant to the amendment of the year 2020,
2025, my lord,
2025.
January.
He also submits that he requests the matter be posted on Monday, and also states that no course of action will be taken pursuant to the impugned notice till then. Relist on.
Use that for the.
Lord, in the meanwhile, if there, suppose 7 days time is given, my lord, at only 2 more days are left, they can respond to the
Lord,
Tahsildar.
Please look at it. They, my lord, issue an.
No coercive steps will be taken.
Want I have it on Thursday?
Thursday, my lord. Yes,
Here in
Yes.
Thursday.
7th.
correct.
4:30 PM matters. Seal number 83. Hemant Raj.
ಇವ್ರು ಮುಚ್ಬಿಡಿ ಸೋಮಶೇಖರ್ ಏನ್ ಮಾಡ್ತೀರಾ?
Lord, as your lordship is observed, subject to result of my lord, it may be passed judicial
Number
order.
19.
Undertaking ಕೊಡೋದು ಕಷ್ಟ ಆಗತ್ತೆ ನಾನು.
ಇಲ್ಲ, ನಾವು ಕ್ಲೋಸ್, ನೋ ಕೀಪಿಂಗ್ ದ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್.
ಅಲ್ಲ, ಸಮಸ್ಯೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ, let them ತಹಶೀಲ್ದಾರ್ place on record this sketch along with affidavit, my lord. I will file detailed rejoinder, because otherwise, my lord, ಇವಾಗ ನನ್ನ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಲ್ಲಿ ಕೊಟ್ರೆ ಅವರು ಇದ್ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಇಟ್ ಮೇ ಬಿ ಪಾಸ್ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್, ಮೈ ಲಾರ್ಡ್.
No, I will
If I succeed, my lord, if I
I
succeed,
will simply say that you are not able to establish where your land is situated for you to raise this contention.
Lord,
The village map indicates there is a road.
Lord, your lordship, there is no dispute with regard to the property in structure of the building. There only dispute regarding the road, ಕಾಲುದಾರಿ ಅಂತ ಅಷ್ಟೇನೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು. ನಾವು ತೋರಿಸ್ತಾ ಇರೋದು ಇದು, ದಿಸ್ ಇಸ್ ದ ಪ್ರಾಬ್ಲಮ್. ಈ ಸ್ಕೆಚ್ ಏನ್ ಹಾಕಿದ್ದಾರೆ, ಸೂಪರ್ ಇಂಪೋಸ್ ಮಾಡಿ ವಿ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಎನ್ಲಾರ್ಜ್ ಮಾಡಿ ಹಾಕಿದೀನಿ.
Like I said, the sale deed will not help your case. The sale deed is going to make your case weak.
ಇಲ್ಲ,
Cannot.
ಆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಎಂಟೈರ್ ಇದೆ. ನೀವು ಕೇಳಿ ಸ್ವಾಮಿ, 31A1 ಅದೆಲ್ಲ 31B ಬಿಟ್ಟು ಇದೆಲ್ಲ ಫುಲ್ 13 ಗುಂಟಾಸ್ ಅಲ್ಲಿ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಏನು ಸಮಸ್ಯೆ ಇಲ್ಲ. ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ದೇ ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ಎನಿಬಡಿ ಎಕ್ಸೆಪ್ಟ್ ರೋಡ್ ಬಿಟ್ರೆ ಪ್ರಾಪರ್ಟಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋದು
Absence of any building license for that structure.
ಇದೆ ಅಂತ. ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇದೆ ಅಂತ ಸ್ವಾಮಿ, ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್. ಅದಕ್ಕೆ ಅದನ್ನೆಲ್ಲ ಪ್ಲೇಸ್ ಮಾಡ್ತೀನಿ, ನಿಮ್ಮ ಮುಂದೆನೆ ಪಾರ್ಟ್ ಹೆಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಲೆಟ್ ದಿಮ್ ದಿಸ್ ರೆಕಾರ್ಡ್ ಮೇ ಬಿ ಪ್ಲೇಸ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಅಫಿಡವಿಟ್ ಬೈ ತಹಶೀಲ್ದಾರ್. This superimposed village map.
Are you saying that there's a license for this particular Holobic structure.
ಇಲ್ಲ ಅದು ಮನೆ ಕಟ್ಟಿರೋದಕ್ಕಿದೆ ಆಲೋ ಬ್ರಿಕ್ಸ್ ಅಂತ ಇಲ್ಲ, ಮನೆ ಕಟ್ಟಿರೋದಕ್ಕಿದೆ ಅಂತ ಹೇಳಿದ್ರು, ಲೈಸೆನ್ಸ್ ಇದೆ ಅಂತ ಅವಾಗ ಹಿಂದೆ 20 ವರ್ಷದ ಹಿಂದೆ ಕಟ್ಟಿ
ಇದು ಕೊಟ್ರಲ್ಲ ಮೇಡಮ್ ಅದು.
ಅದನ್ನ ಅಲಾಂಗ್ ವಿತ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಅದನ್ನ ಲೆಟ್ ದೆಮ್ ರಿಮೂವ್ ಸಬ್ಜೆಕ್ಟ್.
ಇದು ಕೊಟ್ರು ದೃಢೀಕರಣ ಪತ್ರನೇನೋ ಕೊಟ್ರು.
If any, if petitioner succeed, my lord, let them rebuild by the cost of the Tahsildar. Otherwise, subject to result.
I would have done that provided if you had undertaken. I was prepared to protect.
ಅವ್ರು
you, but you
ಕೇಳಿದ್ರೆ
can't
ನಾನ್
admit-
ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡೋದಕ್ಕೆ ಅದಕ್ಕೆ
And I dismiss your petition, holding that there's a road and you put up a structure on the road. That is the ದೃಢೀಕರಣ ಪತ್ರ by the panchayat. ದಕ್ಷಿಣಕ್ಕೆ road ಅಂತಾನೆ ಇದೆ. So obviously, even if you had obtained a building license, you would have shown the southern boundary as road.
ಇಲ್ಲ ಗಲ್ಲಿ ಅಂತ ಇದೆ ಸಮಯ, ಅದು ರೋಡ್ ಅಂತ ಇಲ್ಲ.
ದಕ್ಷಿಣಕ್ಕೆ ನೋಡಿ, ಪಶ್ಚಿಮಕ್ಕೆ
ಅದೇ ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ನಮ್ದು ಪಶ್ಚಿಮಕ್ಕೆ ಇರೋದು,
ದಕ್ಷಿಣಕ್ಕೆ ಇದೆ ನೋಡಿ.
ಗಲ್ಲಿ ಅಂತ ಇದೆ. ಉತ್ತರಕ್ಕೆ ಮತ್ತೆ
Gully is
ದಕ್ಷಿಣಕ್ಕೆ
not your property.
ಗಲ್ಲಿ ಅದು ನಮ್ಮ ದೊಡ್ಡಪ್ಪನ ಮನೆ ಮತ್ತೆ ನಮ್ಗೆ ಬಿಟ್ಕೊಂಡಿರ್ತಕ್ಕಂತ 3 ಅಡಿ ಜಾಗ ಸಮಯ. ಅದನ್ನ ಅದು ಟೆಂಪರರಿ ರಿಮೂವ್ ಮಾಡ್ಬೋದು, ಯಾಕಂದ್ರೆ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಮಾಡೋದು ರಿಮೂವ್ ಮಾಡ್ತಾರೆ ಅವ್ರನ್ನ.
ನಾನು ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಮಾಡ್ರೆ ಫೈನಲ್ ಆರ್ಡರ್. ನೀವು ನೀವು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೂಡ ನೀವೇ ತೆಗೆದ್ರೆ ನನ್ನ ಪ್ರಕಾರ ಹಳ್ಳಿಯಲ್ಲಿ ಒಂದು ಅಟ್ಮಾಸ್ಫಿಯರ್ ಇರುತ್ತೆ. ಆಮೇಲೆ ಐ ಡಿಸೈಡ್ ದಿಸ್ ಕ್ವೆಶ್ಚನ್ ಅಂಡ್ ದೆನ್ ಪರ್ಮಿಟ್ ಯು ಟು ಪುಟ್ ಅಪ್ ಅ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಟ್ ದೇರ್ ಕಾಸ್ಟ್.
ಲೆಟ್ ದೆಮ್ ದಿಸ್ ರೆಕಾರ್ಡ್ ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ ಸಮಯ, ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಲೆಟ್ ದೆಮ್ ರಿಮೂವ್ ದಟ್ ಸ್ಟ್ರಕ್ಚರ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಮಿಲಾಡ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ವಾಟ್ ದಿ ತಹಶೀಲ್ದಾರ್ ನೌ ಶೋಸ್ ದಟ್ ಮಿಲಾಡ್ ಲೆಟ್ ದೆಮ್ ಪ್ಲೇಸ್ ಅಲಾಂಗ್ ವಿತ್ ಅಫಿಡವಿಟ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೂಪರ್ ಇಂಪೋಸ್.
You will voluntarily remove.
ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಪಿಟಿಷನ್ ವಿಲ್ ರಿಮೂವ್. ನನ್ನ ಅಂಡರ್ಟೇಕಿಂಗ್ ಬೇಡ.
Either petitions before the court.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಬರಕ ಲೇಡಿ ಅವ್ರು.
The prayer in the writ petition is to quash notice issued by the Tahsildar informing the petitioner that she has encroached upon a pathway which is required to be removed immediately. The Tahsildar who was present before the court places on record the village map and also Google, this is Dishank alva? This, and a picture extracted from the Shishank app in which the village map has been superimposed on a Google image. It is stated that the portion marked in green color is the structure put up in hollow bricks right in the middle of the pathway and thereby obstructing the pathway.
Disputed path.
The contention that the portion where the hollow brick structure has been put up is a part of the pathway is however strongly disputed. The image produced would indicate that the village map in which a pathway is shown, the image that is produced would indicate that the hollow brick structure erected is on the pathway which is superimposed in the Google image. The Tahsildar also places on record a confirmatory letter of the Panchayat dated 24/3/2025 to put forth the argument that to the south of the petitioner's house, it has been shown as a gully, meaning a pathway. This position is also seriously disputed by the learned counsel of the petitioner. And an argument is sought to be made that the superimposition of the village map on the Google image is improper since it's a fundamental error in the placement of serial number 11/3A1. Correct? Yes, he however submits that in order to avoid any controversy, he has secured instructions from the petitioner and the petitioner would voluntarily remove the hollow brick structure indicated in green color in the image which is furnished by the Tahsildar. Subject over the condition that in the event of the petitioner's success in this writ petition, the Tahsildar would at the cost of the state, restore the construction.
ಏಟ್ಸ್ ಅಂತ ಬೇಡ ತಹಶೀಲ್ದಾರ್ ಸ್ಟೇಟ್ ದುಡ್ಡು ಬೇಡ.
ಎರಡು ಒಂದೇ ತಾನೆ.
ಅಲ್ಲ ಅದು ಪರ್ಸನಲ್ ಅವ್ರು ಕೊಡ್ಲಿ ಸ್ವಾಮಿ. ಇಫ್ ಸಬ್ಸಿಡಿ ಇಸ್ ಒನ್ ಪಾಕೆಟ್ ದೇ ಹ್ಯಾಡ್ ಟು ಪೇ ಬಿಕಾಸ್ ಸ್ಟೇಟ್ ಅವರು
ಯಾಕ್ರಿ ಅವ್ರ ಪಾಕೆಟ್ ಇಂದ ಕೊಡ್ತಾರೆ, ಯಾರ ಪಾಕೆಟ್ ಕೊಡ್ತಾರಲ್ಲ, ನಿಮ್ ಮಾಡ್ಕೊಟ್ರೆ ಆಯ್ತಾ? Will restore the structure. The petitioner shall forthwith remove the structure, since it is contended by the state that this is the only pathway to access the temple in which a jatra is being scheduled. Yavattu? Tomorrow.
ನಾಳೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ 26.
Next, it is made clear that if the petitioner does not abide by the undertaking, it will be open for the Tahsildar to dismantle the structure by herself. Relist on, when do you want it?
ವೀಕ್ ಆಫ್ಟರ್ ಒನ್ ಹಿಂಗಿದ್ರು ಅದು ರಿಮೂವ್ ಮಾಡ್ತಾರೆ.
My impleading my lord.
You ಸದ್ಯಕ್ಕೆ ಬೇಡ ಬಿಡಿ.
Because my lords,
File it along with the memo.
ಇಲ್ಲ ಬೈ ವೇ ಆಫ್ ಅಫಿಡವಿಟ್.
Memo ಹಾಕ್ಲಿ ಬಿಡಿ, ನಾನ್ ತಗೊಂಡಿದ್ದೇನಲ್ಲ.
ಅಲ್ಲ ಅಫಿಡವಿಟ್ ಇದ್ರೆ ಕೋರ್ಟ್.
No, she has filed it with the memo. How can she go back on that?
Second, that order may be given. And
a copy of us.
Into permit.
Impeding application.
If we don't remove it, she'll remove it tomorrow.
11 o'clock
Time may be
communicate.
ಇವತ್ತೇ ಸಾಯಂಕಾಲ ಸಿಗುತ್ತೆ. ಲೋಡ್ ಆಗುತ್ತೆ.
4:30 PM matter, seal number 83. Yar Hemant Raj.
The previous occasion, I have made a submission that the authorities, before conversion of the land in question and before approval of the layout plan, they have conducted twice, they have done the survey of the scheduled
Annexure A, my
property.
lord, that is survey.
They have conducted the twice the schedule of the property.
ತಿಳುವಳಿಕೆ
When
ಪತ್ರ.
the authorities are after the conversion order, they frequently visited the scheduled land, they trying to the survey of the land. That junction find a suit. Kindly last occasion for the copy of the plan.
The burial ground.
Kindly seek encroachment.
ಇಲ್ಲ, ಇಲ್ಲ, ಅದಲ್ಲ.
Atharalla.
This is only for survey, my lord, annexure A, page
Kindly take
22, my lord.
para number 14.
Page
When
20.
the frequency conduct the survey, that junction will find a suit for injunction against the state government making a party as a Tahsildar. Kindly take page number 14, para number 14.
Yes.
Para number 14. The defendant number 1, thereafter again based on the false complaint of the some of the road elements is making the spot inspection of the lands in survey number 515 without any authority law. The acts and conduct of the first defendant in making a repeated spot inspection of the land in survey number 15 creates a serious doubt among the purchaser of the sites from the plaintiff. Though the plaintiff is lawful owner of the land in survey number so and so.
So you
the-
file a suit and also the file the writ petition.
No, Your Worship, kindly seek, that is not correct, Your Worship. I filed a suit and obtain injunction order. Kindly take, Your Worship, page number 42.
And date of the notice, my lord, annexure
One
A,
second.
2017, my lord.
Page number 44, Your Worship. The
Page number
page number,
44.
one second. Your Worship. Page number 54, sorry. Page number 54, injunction order.
Then
Page number 54, para number 15.
In page 11, my lord.
This court as careful, Your Worship, not got it. Page number 54, Your Worship.
yes.
Para number 15. This court has carefully perused the survey sketch produced by the defendant number. Your Worship, they are also produced the survey sketch. They produced the survey sketch. Now you are not producing the survey sketch. Defendant number 1, survey number 536. After perusal of the same, it appears that this court that towards the eastern side of the survey number 536, the existence of the road is shown and thereafter survey number 514, that is the social property is shown. That is my property. It means as per the document relied upon by the defendant number 2, towards the western side of the social property, there is a road and thereafter survey number 536 is in existence. They are alleging that you are encroaching property. In between there is a road. In the said survey sketch, survey number 536, the Tahsildar opinion that there is no encroachment in survey number 536. Hence, the apprehension of the defendant number 2 that the plaintiff is encroaching burial ground is existing in survey number 5 does not hold water. That is the findings of the learned trial court judge. Just agree. One second,
My lord,
madam.
1 second, 536, my lord, but.
No, one
A
second,
issued file under
So I'm not
19.
going to suppress anything. Please, madam. You should agree with this order. Then you should they filed appeal before the district court. You should district court also should dismiss their appeal. Now, Your Lordship, last occasion, Lordship expressed that, Your Lordship, let the survey conducted. Your Lordship, there are two consequences are follows. The first consequences, Your Lordship, First, you obtain the injunction order against the state government because they are repeatedly conducting survey. This is the fourth survey. Then your lordship has the dismiss or writ petition against your lordship. Now, your lordship, the indirect your lordship is going to frustrate the order of trial court order.
Why?
Lordship, there is injunction order. They should not your lordship interfere.
But of what survey number?
Same survey number 519.
By conducting a survey, how will it amount to interfere the opposition?
Well, that is my case, your lordship.
No,
Before
how
the
you
trial
tell me
court,
how?
your lordship, the pattern.
How, if a survey is conducted, how does it interfere with the
Yes,
opposition?
that is the lordship. That is the reason lordship. I will suit your lordship.
Is there any injunction in the trial court asking them not to conduct a survey?
Correct, your lordship. Kindly see, that is your lordship. Not interfere. That is the reason you filed a suit.
Difference between interfering with your position and to conduct a survey.
The reason, reason for filing the suit is para number 2. I am already sure, lordship. Because of the repeated lordship comes for the survey of the suitable property. Thus, juncture only I filed a suit. Otherwise, there is no cause of action for me to file a suit. That is the reason. The trial court has granted an injunction order. First appellate court also approved the injunction order. Now, the question for consideration is, lordship, the annexure C, kindly take lordship annexure G, survey sketch.
Next year.
Annexure C, page number 32. This is the survey sketch.
Yes.
This survey sketch, lordship, they are issued before conversion of the order, before approval of the layout plan, they issued a survey sketch. Now, lordship, their case is, lordship, this is not a correct. They are complaining about the annexure C. Now, lordship, what is the mechanism under the Land Revenue Act, lordship? If there is agreed by any survey, lordship, kindly there is an appeal provision, section 49. Lordship. Section 49, appeal from the original orders.
This is not a statutory survey. Pursuant to the order.
This is quasi judicial order, already conducted survey. This is the findings.
Show me under section 95. Where is the requirement of conducting a survey before issuing an order of conversion?
Pardon, lordship.
Where is the provision under section 95?
So independently, lordship, this is the lordship, independently they have conducted the survey.
Section 49 appeal is a survey conducted statutorily after notice to all the parties.
Correct, lordship.
A sketch prepared at the time of granting an order of conversion
Correct,
does
lordship.
not amount to an appealable order.
Yes, this is appealable. Kindly see 49, lordship. May read, lordship. May read, lordship.
Then you answer the first question. Annexure C is a sketch, correct?
Sketch, lordship. They conducted
Sketch
spot
is a-
inspection.
Sketch is
Survey sketch.
Is it prepared after notice to everybody as contemplated under the provisions of
They themselves conducted survey sketch.
themselves prepared? Survey antandre, there should be an application given, all the concerned persons should be notified, they should be heard and then a survey be conducted.
Yes, sir.
You make an application for grant of conversion. That is considered and granted. While doing that, they give a sketch enclosing it to the order of conversion.
Correct,
That
lordship.
does not amount to a survey.
Lordship, this is survey because you kindly see section 49, lordship, for a moment, kindly see what is the appealable order. Section 49, appeal from the original orders. Appeal from the original order. Kindly take, lordship, the subsection E. Lordship, for a moment.
Really.
If such a order is passed by a survey officer below the rank of an assistant director of land records or assistant director for settlement to the assistant director of land record, assistant director of settlement, case may be appeal shall lie. Now, lordship, their survey settlement.
Not an order.
This is a quasi judicial order, your lordship.
No, this is a survey sketch prepared for the purpose of facilitating your order of conversion.
Otherwise, you should kindly take their statement of objection. There is a one more sketch also. Their annexure R2.
You're inviting a finding from me regarding all this. Simply go and appear. I'll clarify that this order of injunction will not be disturbed. The order of injunction will still prevail, notwithstanding the survey that will be conducted. That will be a better option for you. If you argue like this, then I'll give them.
Alla, one second. R2 nodibidi Swami.
Let me
R2
tell-
already our conduct.
ನಾನು ಎಲ್ಲ ಕೇಳ್ತೀನಿ ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಆಮೇಲೆ ಡೋಂಟ್ ಆಸ್ಕ್ ಮೀ ಟು
Otherwise, lordship, the indirectly, lordship, my injunction order will become frustrating.
I'll make it clear that using this survey, they will not interfere with their position. And this or notice only entitle them.
Allah, that is the reason, lordship, I filed a suit, lordship. Frequently, lordship, they conducted this spot inspection survey. Under this ground, that is a cause of action, file a suit. Otherwise, I don't have any cause of action. Lordship, I have produced this survey, plaint also.
I'll consider which is the first survey according to you, this annexure.
Lordship, this is the first survey, annexure C. Then, your lordship, there is another survey. Kindly take annexure R2. There are statement of objection. Innೊಂದು ಮಾಡಿದ್ದಾರೆ ಅವರು. Annexure R2. ಇದು 4ನೇ ಸರ್ವೆ ಈಗ ಮಾಡ್ತಾ ಇರೋದು. Lordship, kindly take annexure R2 ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಕೆಳಗಿಂದ 5ನೇ ಲೈನು. ದಿನಾಂಕ annexure R2 ಪೇಜ್ ನಂಬರ್ 10.
R2.
ದಿನಾಂಕ ಕೆಳಗಿದ್ದ 5ನೇ ಲೈನ್ ದಿನಾಂಕ 25/8/2015 ಸರ್ಕಾರಿ ಸ್ಮಶಾನ ಸಭೆ ನಂಬರ್ 533 ಅಳತೆಗಾಗಿ ಅರ್ಜಿ ಬಂದಂತೆ ಶ್ರೀ ಬೀರಪ್ಪ ಭೂಮಾರ್ಕರವರು ಮೋಜಿ ತಂತ್ರಜ್ಞಾನದಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಪಡೆದು ದಿನಾಂಕ 26/8/2001 ಗಣಿತ ಕಾರ್ಯ ಪೂರೈಸಿದ್ದು ಸದರಿ ಸರ್ವೆ ನಂಬಲ್ಲಿ ಯಾವುದೇ ಒತ್ತುವರಿ ಇಲ್ಲ ಎಂದು ನಕ್ಷೆ ತಯಾರಿಸಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದ ಸೆಕೆಂಡ್ ಸರ್ವೆ. ಅರ್ಲಿಯರ್ ಫಸ್ಟ್ ಸರ್ವೆ ಆಯ್ತು, ಇನ್ನೊಬ್ರು ಯಾರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು, ಸೆಕೆಂಡ್ ಸರ್ವೆ ಮಾಡೋದು, ಥರ್ಡ್ ಸರ್ವೆನೂ ಮಾಡ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಫೋರ್ತ್ ಸರ್ವೆ ದೇ ಇಶ್ಯೂಡ್ ದಿ ಚೆಕ್ ಹೌಸ್ ನೋಟಿಸ್. Frequently they are going to issue a service. Next juncture, we filed a suit for injunction, making the Tahsildar, survey officer and the state government as a party to obtain the injunction order. Then after injunction, they have suffered injunction order, they issued these impediment notices. You are going to one more Sunday. What is the lordship, the purpose of getting an injunction order? Otherwise, lordship, you will become indirectly frustrating the order of injunction order. That is my grievance.
The writ petition is filed.
May make one submission. In case your lordship is going to held against us or going to withdraw the writ petition.
And counsel, the petitioner seeks permission to withdraw the writ petition. Petition is accordingly dismissed as withdrawn.
Number 84, the Raghavendra S.
Lord, I have filed my synopsis and written statement. And also, my lord, I have given list of citations.
Yes.
Citation list.
Written submissions. Written submissions.
Written submission. Lord, primarily what I would like to submit. When, my lord, this amalgamation order was sought to be obtained, they have suppressed the fact that there existed a road between the two properties belonging to the respondent contesting, my lord, seventh respondent. There is a suppression. The order of amalgamation itself says, if there is any suppression, it automatically stands cancelled. It is undisputed fact that there exists a road between the two properties belonging to the R7. Originally, my lord, his predecessor in title obtained an amalgamation order by suppressing, and then when I filed objections, the authority, my lord, has called for and said, you have filed a different sketch, and the petitioner, that is the objector, has filed a different sketch. Therefore, Tahsildar to go and verify. In the meantime, the amalgamation order was kept in abeyance. Thereafter, my lord, they sell the property in favor of seventh respondent. He makes an application, my lord, for amalgamation. My lord, amalgamation of two properties should be adjacent to each other and belonging to the common owner. There can't be any other property in between. Admittedly, there is a road in between the two properties, and therefore the order of amalgamation itself is bad. Number two, my lord, as seen from the sketch, there is a clear violation of, my lord, the setback portion, which they have never left. If your lordship would see the sketch also, my lord, it will make it very clear, no setback is shown on either sides. That is towards its right and just behind the building where there is a ramp which goes to the, my lord, basement. That road is in between his main property facing the main road and my property, my lord, behind it. Next to my property is another property of his, and he sought to amalgamate. Even when he sought a building license and a sanction plan, he did not show the existence of the road. All these things are made with connivance and collusion of the authorities. Such an order is being made that was questioned. The revisional authority, they come forward and say, today, in the sense last week, they gave me a copy of their memo. They say that during the pendency of the revision, it is modified to show the road. If only the road is shown and modification takes place, will not the entire setback, etc., will get altered. Nothing is done to that effect. These are all primary defects in collusion with the authorities. My lord, the town planning authority has not filed any affidavit, has not denied the allegations I have made that this is obtained by suppression. Before the Udupi municipality, my lord, also they say they have filed, my lord, in my revision, they have filed a statement to the effect that they were not aware of it. My lord, when they have sanctioned the plan, and both at the time of granting amalgamation, as well as of sanctioning the plan, my lord, they have categorically said they have inspected the spot. If they have inspected the spot, it's, my lord, it's a naked truth that there is a road in existence. How can they ignore, or how can they forget, or how can they close their eyes to these facts? If this be the position, my lord, this is admitted, is my respectful submission. My lord, if this is the position, kindly see a few photographs which I have produced with the petition and subsequently also. With the writ petition, if your lordship would kindly take page 141. Photos are at 142.
Yes.
Before that 141 ತಾವು ನೋಡಿದ್ರೆ ಇದರಲ್ಲಿ the predecessor in title Muhammad Yusuf had obtained, my lord, a amalgamation plan. Kindly take the 4-line endorsement that is given.
Page.
Page 141, my lord. Annexure T.
Yes.
Annexure T. My lord has that. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಡುಪಿ ತಾಲೂಕು ಸೋನ್ಸೋ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಎಕರೆ ಜಾಗಕ್ಕೆ 27 ಸೆಂಟ್ಸ್ ಎಕರೆ ಜಾಗಕ್ಕೆ ಈ ಕಚೇರಿಯಿಂದ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ನೀಡಲಾಗಿರುತ್ತದೆ. 27 ಸೆಂಟ್ಸ್. ಆದರೆ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ರವೀಂದ್ರ ನಾಯಕ್, ಹೂ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ಮೈ ಲಾರ್ಡ್, ಇವರಿಗೆ ರಸ್ತೆ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುವರು. ರವೀಂದ್ರ ನಾಯಕ್ ಇವರು ಸಲ್ಲಿಸಿದ ಸರ್ವೆ ನಕ್ಷೆ ಹಾಗೂ ತಾವು ಸಲ್ಲಿಸಿದ ಸರ್ವೆ ನಕ್ಷೆಯು ಒಂದಕ್ಕೊಂದು ವ್ಯತ್ಯಾಸವಿರುತ್ತದೆ. ದೂರುದಾರರು ಸಲ್ಲಿಸಿದ ಸರ್ವೆ ನಕ್ಷೆಯಲ್ಲಿ ಉತ್ತರ ದಿಕ್ಕಿನಲ್ಲಿ ಪಶ್ಚಿಮದಿಂದ ಪೂರ್ವಕ್ಕೆ ರಸ್ತೆ ಕಾಣಿಸಲಾಗಿದೆ. ಆದರೆ ತಾವು ಸಲ್ಲಿಸಿರುವ ಸರ್ವೆ ನಕ್ಷೆಯಲ್ಲಿ ಸದರಿ ರಸ್ತೆ ಕಾಣಿಸಿರುವುದಿಲ್ಲ. ಭೂ ಪರಿವರ್ತನಾ ಆದೇಶದೊಂದಿಗೆ ಇರುವ ಸರ್ವೆ ನಕ್ಷೆ ಬಗ್ಗೆ ಮರುಪರಿಶೀಲಿಸಿ ವರದಿ ನೀಡುವಂತೆ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಇವರಿಗೆ ಪತ್ರ ಬರೆಯಲಾಗಿತು. ಈ ಮೇಲಿನ ಕಾರಣಗಳಿಂದ ಉಲ್ಲೇಖ 1ರಿಂದ ನೀಡಿದ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯನ್ನು ತಾತ್ಕಾಲಿಕವಾಗಿ ತಡೆಹಿಡಿಯಲಾಗಿದೆ. It's thereafter he sells it to him and he obtains, my lord, as per Annexure B.
This was like it was kept in abeyance temporarily.
Temporarily till
What
that,
happened afterwards?
my lord, by then he has sold the property to R7.
Then what happened? So subsequently, did anything happen?
Nothing happened. R7 made a fresh application on which, my lord, the order is made. My lord gets it at page 48, Annexure B.
Annexure?
B. B for Bombay, Bangalore. Page 48.
Yes.
They have levied certain conditions. I will only take your lordships to that. Para 12. ವಿನ್ಯಾಸವನ್ನು ಅಂಗೀಕೃತ ನಕ್ಷೆಯಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿ ಗುರುತು. My lord has 49 page.
This is in the year 2024.
Yes, that is under challenge. First time it was challenged, there was an interim order. Then I was asked to go and file a revision. My lord, I filed a revision. In the revision, my lord, my revision is dismissed. and against which, my lord, I have come, though a coordinate bench, another learned single judge of this honorable court has held, as against that there no revision lies. But I have crossed that stage already, having filed the revision. My lord, now it is too late to retrace whatever it is. Para 12. ವಿನ್ಯಾಸವನ್ನು ಅಂಗೀಕೃತ ನಕ್ಷೆಯನ್ವಯ ಸ್ಥಳದಲ್ಲಿ ಗುರುತು ಮಾಡಬೇಕು. ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ರಸ್ತೆ, ಬಯಲು ಪ್ರದೇಶ ಮತ್ತು ನಾಗರಿಕ ಸೌಲಭ್ಯಗಳಿಗಾಗಿ ಮೀಸಲಿರುವ ಪ್ರದೇಶಗಳ ಅಳತೆಗಳನ್ನು ಕಡಿಮೆ ಮಾಡಬಾರದು ಮತ್ತು ಇತರ ಆಸ್ತಿಗಳ ಮೇಲೆ ಅತಿಕ್ರಮಣ ಮಾಡಬಾರದು. ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಪೂರ್ವಾನುಮತಿ ಇಲ್ಲದೆ ವಿನ್ಯಾಸದಲ್ಲಿ ಯಾವುದೇ ಬದಲಾವಣೆಯನ್ನು ಮಾಡಬಾರದು. 13. ಏಕನಿವೇಶನ ಭೂ ವಿಜನೆ ಒಟ್ಟುಗೂಡಿಕೆ ಮಂಜೂರಾತಿಯಂತೆ ರಸ್ತೆಯ ಜಾಗವನ್ನು ಯಾವುದೇ ಪ್ರತಿಫಲಾಪೇಕ್ಷೆ ಇಲ್ಲ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗೆ ದಾನಪತ್ರದ ಮೂಲಕ ವಹಿಸಿಕೊಡುವುದು. ಪ್ರಶ್ನಿತ ಜಮೀನು ಮಾಲೀಕರು ಜಮೀನನ್ನು ವಿಭಜಿಸಲು ಬಯಸಿದ್ದಲ್ಲಿ ನಿಯಮಾವಳಿಗಳಂತೆ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ಪೂರ್ವ ಅನುಮತಿ ಪಡೆಯಬೇಕು. Kindly come to my lord 17, 18 and 19. ರಸ್ತೆ ವಿಸ್ತರಣೆಗಾಗಿ ಕಾಯ್ದಿರಿಸಿರುವ ಜಮೀನನ್ನು ನಿಯಮಾನುಸಾರ ನೋಂದಾಯಿತ ಪರಿತ್ಯಾಜನಾ ಪತ್ರದ ಮೂಲಕ ಸಮಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಹಸ್ತಾಂತರಿಸಕ್ಕದ್ದು. ವಿನ್ಯಾಸದಲ್ಲಿ ಯಾವುದೇ ಕಟ್ಟಡಗಳನ್ನು ಕಟ್ಟುವ ಮೊದಲು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಮತ್ತು ಪಂಚಾಯಿತಿಯ ಅನುಮತಿಯನ್ನು ಪಡೆಯಬೇಕು. 19 is important. ವಿನ್ಯಾಸ ಅಂಗೀಕಾರ ಕೋರಿಕೆ ಸಂಬಂಧ ಸಲ್ಲಿಸಲಾಗಿರುವ ದಾಖಲೆ ಅಥವಾ ಬೇರೆ ಯಾವುದೇ ಮಾಹಿತಿಯು ತಪ್ಪಾಗಿದ್ದಲ್ಲಿ ವಿನ್ಯಾಸಕ್ಕೆ ನೀಡಿರುವ ಅಂಗೀಕಾರ ತಾನಾಗಿ ರದ್ದುಗೊಳ್ಳುತ್ತದೆ. In this, my lord, next page is the sketch which my lord is granted along with this, which he has filed along with this amalgamation order. There is absolutely no road in existence shown.
This is only the approval for
Amalgamation.
a single plot.
Single plot, amalgamation, which, my lord, is impermissible when they are separated by some other property. There can't be amalgamation of one property there, one here.
Why do you say this amalgamation? There's nothing about amalgamation here. They have shown it as one plot. The
Yes,
planning
that-
authority has granted approval for this formation of a single plot.
Correct. It is as good as amalgamation of these two.
No, under this order,
Yes,
there's no amalgamation. They have granted approval for the formation of a single plot
single plot.
as
It-
against formation of multi-plots in a layout. This is a single plot layout.
It
This
can't
only-
be for the simple reason, there can't be any other property in between the two properties. It can't be a thing. My lord, next to my property, there is another piece of land belonging to me. I can ask for a single plot, my lord, and get a license, and then also, my lord, sanction plan to construct.
My understanding of a single plot was if it's an agricultural land, you go to the planning authority. If you want to develop that particular area, either as a single plot or as a layout, you have to get their approval. If it's a single plot, they will grant you a single plot approval. You will thereafter have to go to the concerned authority to obtain a building plan.
How does
So all
it?
that has been done is they've granted a single plot approval under section 17. Alva, that is all.
Whole conclusion is, there is no road, not as per the revenue. Road is mentioned only in the OS. In the OS, road is right of way only.
That's the second aspect. But there's no amalgamation granted here. This is an approval for the formation of a single plot.
Single plot cannot be formed, my lord, of two different plots.
So I'll take it that this approval was illegal according to you because there was an existing road there and they could not have considered a single plot. That is the argument.
It can't be, my lord, I understand this as an amalgamation or a single plot.
Now, for you to consider as an amalgamation, the order should say there are two different plots which the authority is approving to be amalgamated to one plot. That is not the tenor of this order.
That happens, my lord, provided there are two adjoining plots. What he has done is, one is the main plot, the other one is behind. In between, there is a road. Without showing that, he wants these two properties to be amalgamated. I humbly request that to be taken, or call it as a single plot. That is done by suppression of material facts. Even if it is a case of a single plot, it can't be done because he can't have the whole thing as one unit or a single plot. There cannot be, because there cannot be a property in between. That is a right of way which is kept open from 1956 for the use of all the owners there. It is not that I got such a right only under the decree of a civil court. When there was disturbance, I filed an injunction application suit and an application. He also does it. On a compromise, my lord, his suit is dismissed. My suit is decreed. The 12 feet wide road is kept open for utilization because just behind the main house is my house. Therefore, my lord, question of amalgamation or single plot cannot arise at all. Assuming the worst against me,
Compromise does not talk about a road.
it does not.
This does not talk about a road.
Nowhere in this order or in
The
this.
compromise petition, there's no reference to the formation of a road.
No, it is only a road in existence which is recognized. Therefore, even assuming, my lord, there exists a road, there can't be a single plot, my lord, between the two plots. It can't be made into one plot. It is impermissible in law. How can it be a one plot? That is because they treat it as one plot and then get a building license and, my lord, a sanctioned plan to construct as if it's a one single, my lord, building plan. There is no separate building plan for the portion behind his portion separated by a road, which is adjacent to my property.
The approved plan is annexure K, alva?
Sorry, my lord.
Approved plan is annexure K.
Next, sir. This is the building license. Huh? Annexure K, page
79.
page 70, 79. Yes. Kindly see that, man. Where is the existence of the road? This is the building sanction plan.
No, but in the plan, they have specifically said space reserved as per compromise decree in using the only
No,
for.
that is later during the pendency of the revision.
No, the annexure K is the approved plan, isn't it?
Revised.
They insisted to mention the road. As per the
Next,
earlier papers,
page
there
number?
was no road mentioned.
50.
They insist to mention the road.
Page
Plan,
53.
approved plan.
Page 53 ತಾವು ಇದ್ರ ಹಿಂದೆ ಇದೆಯಲ್ಲ. Oh, 53 page. And that's what I have kept. Is 50 of them.
It was shown as a setback. Now they made it clear. It is space reserved for as per compromise decree. The original plan did not indicate that this space should be reserved for as per the compromise decree. The revised plan indicated it should be reserved.
Revised plan during the pendency. Once it is revised, then the whole mathematics will change regarding setback, etc. And basically, when you take something and then subsequently revise it because I raised an objection, Lord, then you say that that portion is only left open, that is coming from the main road. And then it takes a turn, my lord. That portion is not shown even in the revised plan, annexure K. 53 ತಾವು ನೋಡಿದ್ರಲ್ಲ.
Ramp ತೋರಿಸ್ತಾರಲ್ಲ, ramp ತೋರಿಸ್ತಾರೆ. They are showing a ramp in the revised plan.
ಹೌದು, ಅಲ್ಲಿ ರೋಡೇ ಇಲ್ಲ. ರ್ಯಾಂಪ್ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಒಳಗೆ ಬರುತ್ತೆ. ಆ ರ್ಯಾಂಪ್ ಆದ್ಮೇಲೆ ರೋಡ್ ಬರಬೇಕು, ಅದಾದ್ಮೇಲೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಬರುತ್ತೆ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಬರುತ್ತೆ.
Alright.
That portion of the road is not shown. And 53 ಒಳಗೆ ಅದು ತೋರಿಸ್ಲೇ ಇಲ್ಲ. ಹೌದು, ಪೇಜ್ ನಂಬರ್ 80 ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿಯಲ್ಲಿ ಹಾಕಿದ್ದು 80 ನೆಕ್ಸ್ಟ್ ಕೆ ಎಲ್ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಕೇಳಿದ್ರಿ ಸ್ಕೆಚ್ ಎಲ್ಲಿದೆ ಅಂತ ಕಾಂಪ್ರಮೈಸ್. ಪೇಜ್ 8 ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್? ಓಕೆ, 80 ಅನೆಕ್ಸ್ಚರ್ ಕೆ ಆದ್ಮೇಲೆ ಎಲ್ ಅಂತಿದೆ.
Yes.
ಅಲ್ಲಿ 84 ಹೀಗೆ ಶೇಪಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಮೇನ್ ರೋಡ್ಗೆ ಹೋಗುತ್ತೆ. ನಮ್ಮ ಜಾಗ ಇದು ಮೇನ್ ರೋಡಿಂದ ಹೀಗೆ ಬಂದು ಹೀಗೆ ಬರುತ್ತೆ. ಒರಿಜಿನಲ್ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನು ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅಲ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ ಇದು. ಸೊ ಆಲ್ಸೋ ದಿ ಅಮಾಲ್ಗಮೇಷನ್ ಸ್ಟ್ರೋಕ್ ಸಿಂಗಲ್ ಪ್ಲಾಟ್.
The house that you have is in the front portion, isn't it? This house, the photographs that you showed,
Yes,
this front portion is the house. There's one other property behind the house.
yes.
So this compromise is essentially to that particular area.
ಈಗ 142 ಪೇಜ್ ತಾವು ನೋಡಿದ್ರೆ
La page 80 ಅಲ್ಲಿ
88 ಅಲ್ಲಿ
84 and 120/15A3 ಅಂತ ಇದೆಯಲ್ಲ,
ಹೌದು.
that is the area earmarked as right of way for you.
Yes,
Then this area shown as 120/15.
ಅದರಲ್ಲಿ ತಿರುಗುತ್ತೆ. ಎಸ್,
And the area shown as 120/15C.
ಹೌದು.
The house that you have,
This
and
portion.
behind that is another property.
This is my property, my lord. ತಾವು ತೋರಿಸಿದ್ರಲ್ಲ, ಇದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ.
120/15C. Correct?
120/16.
15A.
ಎ ಆ ಮೇನ್ ರೋಡ್ ಅಂತ ಲೆಫ್ಟ್ ಸೈಡ್ ರೋಡ್ ಅಂತ ಇದೆಯಲ್ಲ, ಅದು ಮೇನ್ ರೋಡ್ ಇಂದ ಈಗ ಬಂದ್ಬಿಟ್ಟು ಟರ್ನ್ ಆಗಿ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಕಡೆ ಹೋಗುತ್ತೆ.
This property 120/15, 120/15D, 120/15F and 120/E. All of them are now becoming one plot.
Yes, all single 35 centimeter.
So that single plot was basically creating this one plot
Yes.
along with this plot 120/5B.
No, only 2 plots.
7, there are 7 small plot, my lord.
7
120, 15, E,
ಎರಡಕ್ಕೆ
48, 15F, 15D, A1 and
No.
15B and 150, 15C, all are single one.
Other main.
Road is mentioned as per the decree, madam.
ಅಲ್ಲ,
We are not
road-
part in
road-
the decree.
Right of pathway, you can't call it as a road, right of pathway.
Owner is
Actually,
seven-
actually, I am the owner of
7
the
plus
right of way which I have given in the compromise.
No.
He did not have any right over this property, it belongs to me. But for this compromise, my lord, I have given up that right of pathway to him to reach his property, that is 120/15A and 120/15(2A).
Can you show me the right of way to my property?
Otherwise, he would not have
Otherwise-
entered into a compromise petition at all. He agreed, there is a specific word, right of pathway. It is not road. Rashma, kindly see the compromise petition at page 122. If at all it was a road, he would have insisted to mention it as a road. Page 122, my lord, annexure Q.
In this compromise decree, the serial numbers shown are different and in the single plot approval, the numbers are different. Here it is 120/15A1, 15.
ಎಲ್ಲಿ
C, 15D, 15E, 15F, and 15B. Here it is shown as 120/41, 42, 43, 44, 54, 55, 56, and 57. They are different.
After this compromise, my lord, renumber has been given. Plotting ಆಗಿದೆ.
ಅದು ಅಮಾಲ್ಗಮೇಷನ್ ಆದ್ಮೇಲೆ ಸ್ವಲ್ಪ ನಾನು ಮುಗಿಸ್ತೀನಿ, ಆದ್ಮೇಲೆ ತಾವು ಹೇಳ್ಬೋದು.
Conversion time ಅಲ್ಲಿ ಆಗಿದೆ.
Because this interference, my lord, is
Yes. Yes.
ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ತಾವು 137 ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಿ ಆ ಬ್ಲ್ಯಾಕ್ ಪೋರ್ಷನ್ ಏನು ಅಂತ ಅಲ್ವಾ?
Yes.
ಅದು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇತ್ತು, ಅದು 1956 ಸೇಲ್ ಡೀಡ್ ಇಂದ ಇದೆ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಇಟ್. ಐ ಕ್ಯಾನ್ ಶೋ ಇಟ್ ಇಫ್ ನೆಸೆಸರಿ ಟು ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್. ಅದನ್ನ ಸ್ಲೈಟ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ, ಬೈ ಎ ಫ್ಯೂ ಫೀಟ್. It is not that I am getting it for the first time. 1956 ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನಾವು ಹಾಕಿದ್ದೀವಿ, ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ವಿತ್ ಯಾವುದು ಮೆಮೋ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಆ ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಟೈಪ್ ಮಾಡಿ ಹಾಕಿದ್ದೀವಿ. 1956 ಇಂದ ಇದೆ ಇದು ರೈಟ್ ಆಫ್ ಪಾತ್ವೇ is given.
Where is the compromise petition?
122, man.
Next Q 122.
The portion shown in yellow is the portion where you are granted right of way, correct? The portion shown in yellow.
In the sketch, that is the right of way. ಆ ಡಾರ್ಕ್ ಇತ್ತಲ್ಲ ಅದು ಒರಿಜಿನಲ್ ಇತ್ತು, ಅದನ್ನ ಸ್ವಲ್ಪ ಪುಷ್ ಮಾಡಿದ್ವಿ.
You went to the edge of the property.
I went a little further.
To the edge.
Yes. It's not that I got this right under the decree for the first time. I had this right of way to reach my house. My lord, if it is only a pathway, I can't take my car also.
Yes.
It becomes impossible. Look at the photographs, my lord. At page 142, ತಾವು ನೋಡಿದ್ರಿ.
Yes.
This is how it existed. On the left side, your lordship sees the building. That is my building. A main road in the tar road barutte, then it takes a turn. When I filed the original writ petition, this was the state of affairs. Since there was no interim order, the Lord, they just went on constructing. There are two possibilities. One is hyper-technical to say there was no interim order, so I am free to do it. Number two, my lord, in such a situation, whatever you do is subject to the ultimate result of the writ petition. Next page, ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ how the construction has commenced, how they were doing it. These are all photographs at that time. Construction. Lot of them, your lordship will see at 147 page.
Yes.
ಅಲ್ಲಿ ಟ್ರಕ್ ನಿಲ್ಸಿದ್ದಾರೆ. They get all their goods. They, my lord, they have dug a sink pit, my lord, for the sewage pit. And if there is some little problem, they open that whole thing. I can't, my ingress and egress is totally blocked. I can't take my car in and out. Now, my lord, your lordships have seen that in the original sanctioned plan, there was no road left, and it is shown as if there are two adjacent properties and they are taking a common sanctioned plan and a building license. These are all undisputed. Production. Yes. If your lordship would see that memo with the production of documents that was filed on 10th of February, 11th February.
Yes.
My lord has that. Page 7 of that memo.
Yes.
Lord, I'm sorry, I'm a bit slow,
No,
but having regard to my present situation.
please.
ಆ ರೋಡ್ನಲ್ಲಿ ಹೇಗೆ ಅಗ್ದಿದಾರೆ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ. ಸೆಂಟರಲ್ಲಿ ಸೋಕ್ ಪಿಟ್ ಹಾಕ್ತಾರೆ. Any small problem there, the road gets blocked because they have to get the, my lord, necessary equipment to clear that block. And next page ಅಲ್ಲಿ maximum plot coverage, floor area ratio and road width as per the zoning regulations, my lord, applicable to the Udupi municipality. That your lordship will get at page 8.
Yes.
And this is for a commercial purpose. The last one in that table, lot area is over 1,000 square meters. And then, my lord, commercial, if your lordship would come, 50%.
Yes.
And minimum road width ಅದು meters ಅಲ್ಲಿ 12. ಇಲ್ಲಿ 50% ಮಾತ್ರ permitted to construct. ಈ ಅವ್ರದ್ದು ಸ್ಯಾಂಕ್ಷನ್ ಇದೆಯಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಡಬೇಕು ಅಂತ ಇನ್ನೊಂದು 1 minute, my lord, I'll show the document. Annexure, sanction plan, C, page number.
51.
Kindly have a look at page 51, my lord.
51 of?
Writ petition.
Yes.
ಕಟ್ಟಡ ಪರವಾನಿಗೆ, my lord gets that.
Yes. Good.
ಕಟ್ಟಡವನ್ನು ಜಾಗದ ಎಡಭಾಗದಲ್ಲಿ 2.01 ಮೀಟರ್, ಬಲಭಾಗದಲ್ಲಿ 2.79 ಮೀಟರ್ಸ್, ಹಿಂಭಾಗದಲ್ಲಿ 15.47 ಮೀಟರ್, ಮುಂಭಾಗದಲ್ಲಿ 7.32 ಮೀಟರ್ ಜಾಗವನ್ನು ಬಿಟ್ಟು ಕಟ್ಟಿಕೊಳ್ಳಬೇಕು. Now their constructions, which your lordships have seen, photographs, come up to the edge of the road. Last time ತಾವಂದ್ರಿ ಅಲ್ಲಿ ರೋಲಿಂಗ್ ಶಟರ್ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ, ಸ್ಟೆಪ್ಸ್ ಇಲ್ಲ ಮೇಲ್ ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ. 1 week ಒಳಗೆ ಅಲ್ಲಿ ಸ್ಟೆಪ್ಸ್ ಹಾಕಿ ಮೇಲ್ ಹೋಗ್ಲಿಕ್ಕೆ ಶಾಪ್ಸ್ ಆ ಕಡೆ ಮಾಡಿದ್ದಾರೆ. Entry is made from the road side.
That is facing the main road.
Side road, right side.
Main road. Not the side road, main road.
ಅಲ್ಲ ಎರಡು ಇದೆ.
No,
ಸೈಡ್ ರೋಡ್ ಅಲ್ಲಿ
there's nothing on the side road. That is right of way that is disputed. There's nothing on that road. It's only on to the
there are shops with rolling shutters. Picture ತಾವು ನೋಡಿದ್ರಿ.
And there's a balcony in front of them. There's a
Correct.
passage
And there are steps to get into that area.
from the main road, not from the side road.
Yes, from the main road, they come there. What I am trying to submit is, my lord, they come, they park their vehicles there, create a nuisance for me. That is one aspect of the matter. The second one is, my lord, more crucial. If any sanction plan is obtained, or if amalgamation stroke one plot, single plot permission is obtained, contrary to bylaws and suppressing material facts, it is liable to be demolished. And the fact that they have already constructed involving certain amount of money is not a matter, and they have got to be demolished, are a series of citations which I have given for your lordship's consideration. ಒಂದು ಓದ್ತೀನಿ, ಮಿಕ್ಕಿದೆಲ್ಲ ಐಡೆಂಟಿಕಲ್ ಇದೆ. Take the first of the judgments. Copies are served on the other side. Paragraph 19th only. Para 20. 19. Please see 19. Three. Yes. Ink page 12, my lord.
Yes.
In a catena of decisions, this honorable court has categorically held that illegality of unauthorized construction cannot be perpetuated if the construction is made in contravention of the acts or rules. It would be construed as illegal and unauthorized construction, which has to be necessarily demolished. It cannot be legitimized or protected solely under the ruse of passage of time or citing inaction of the authorities or by taking recourse to the excuse that substantial money has been spent on the said construction. The following decisions are of relevance and hence cited herein below to drive home the point that unauthorized construction must be dealt with an iron hand and not kid gloves. ಇದರಲ್ಲಿ setback ಬಿಟ್ಟಿಲ್ಲ ಅವರು. On my side, that is the road between main building and my building, ಆ ರೋಡ್ ವರೆಗೂ ಬಂದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ರ್ಯಾಂಪ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಎಡ್ಜ್ ಆಫ್ ದಿ ರೋಡ್ ಅಲ್ಲಿ the ramp. There is absolutely nothing shown as, my lord, the hind portion. There is nothing shown except coming up to the plot, my lord, the road. Sideways also ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ. On both sides.
They basically use the right of way as a setback. Yes.
In a way, they
Is
think,
all that-
in a way, they think that that is the setback. Even that is not in conformity with the zonal regulations, which I read. I can leave a copy for my lord's kind consideration also. Idral several judgments are, my lord, cited, not trouble your lordship reading all that. Come to para 21, my lord. Therefore, in the larger public interest, we are inclined to issue the following directions in addition to the directives issued by this court in Re versus Directon in the matter of demolition of structures. 3, my lord. Item 3 there. Upon conducting personal inspection and being satisfied that the building is constructed in accordance with the building planning permission given and there is no deviation in such construction in any manner, the completion or occupation certificate in respect of residential or commercial building be issued by the authority concerned to the parties concerned without causing undue delay. If any deviation is noticed, action must be taken in accordance with the act and the process of issuance of completion or occupation certificate should be deferred unless and until the deviations pointed out are completely rectified. 5. Even after issuance of completion certificate and deviation or violation, if any, contrary to the planning permission brought to the notice of the authority, immediate steps be taken by the said authority concerned in accordance with law against the builder or owner or occupant and the official who is responsible for issuance of wrongful completion or occupation certificate shall be proceeded departmentally forthwith. Then, my lord, next is a coordinate bench. I said I'll skip that because at the moment it doesn't so much. Then MI Builders, para 73 and 81. paragraph 73. My lord gets it at page 104, ink page 529 of the citation. The High Court has, my lord has that.
Or not?
104,
Para 73.
para 73. The High Court has directed dismantling of the whole project and for restoration of the park to its original condition. This court in numerous decisions has held that no consideration should be shown to the builder or any other person where construction is unauthorized. This dicta is now almost bordering the rule of law. Stress was laid by the appellant and the prospective allottees of the shops to exercise judicial discretion in molding the relief. Such a discretion cannot be exercised which encourages illegality or perpetuates an illegality. Unauthorized construction, if it is illegal and cannot be compounded, has to be demolished. There is no way out. Judicial discretion cannot be guided by expediency. Courts are not free from statutory fetters. Justice is to be rendered in accordance with law. Judges are not entitled to exercise discretion, wearing the robes of a judicial discretion, and pass orders based solely on their personal predilections and peculiar disposition. Judicial discretion, wherever it is required to be exercised, has to be in accordance with law and set legal principles, as will be seen in molding the relief in the present case and allowing one of the blocks meant for parking to stand. We have been guided by the obligatory duties of the Mahapalike to construct and maintain parking lots. 81 million. A number of cases come to this court pointing to unauthorized construction taking place at many places in the country by builders in connivance with the corporation and municipal officials. In a series of cases, this court has directed demolition of unauthorized construction. This does not appear to have any salutary effect in case of unauthorized construction coming to this court. While directing demolition of unauthorized construction, the court should also direct an inquiry as to how unauthorized construction came about and to bring the offenders to book. It is not enough to direct demolition of unauthorized construction where there is clear defiance of law. In the present case, but for the observations of the High Court, we would certainly have directed an inquiry to be made as to how the project was conceived and how the agreement dated so and so came to be executed. We direct so and so in that case. The case. The next case. In the next case, my lord, at 107, kindly see paragraph 28 and 29. My lord gets it at page number. At 114, on the left-hand side bottom. An illegal construction of a cinema building, my lord gets that, materially affects the right to or enjoyment of the property by persons residing in the residential area. The municipal authorities owe a duty and obligation under the statute to see that residential area is not spoiled by unauthorized construction. The scheme is for the benefit of the residents of the locality. The municipality acts in aid of the scheme. The rights of the residents in the area are invaded by an illegal construction of a cinema building. It has to be remembered that the scheme is a residential area, means planned orderliness in accordance with the requirement of the residents. If the scheme is nullified by arbitrary acts in excess and derogation of the powers of the municipality, the courts will quash the orders passed by the municipalities. Paragraph 29. The court enforces the performance of statutory duty by public bodies, an obligation to ratepayers who have a legal right to demand compliance by a local authority with its duty to observe statutory rights alone.
The scheme here is for benefit of the public. There is specific interest in the performance of the duty. All the residents in the area have their personal interest in performance of the duty. The special and substantial interest of the residents in the area is injured by the illegal construction. The High Court was not correct in holding that though the impeached resolution sanction plan for conversion of building into a cinema was in violation of the town planning scheme, yet could not be disturbed because R3 is likely to have spent money. An excess of statutory power cannot be validated by acquiescence in or by operation of an estate. Therefore, under no circumstances, paragraph, there are 6. Next judgment at 116. Para 116, page 116, para 6. That is filing a suit by suppression of material facts. I will not read the para and trouble your lordship. Kindly make a note is my request. And the last one is amalgamation, my lord, by a notification. There are regulations made. Adu memo jate hakidi. Memo for additional documents.
Page number 9.
Ink page 9.
Yes.
To amend the zonal regulations, so and so, so and so, kindly come to definition. Amalgamation means clubbing of 2 or more building sites into one.
When was the plan approved?
Before this date.
The single
This
plot
23, this 24 ಅಲ್ಲಿ, after this date. After this date, next year B.
Okay.
After this date, 2024 ಅಲ್ಲಿ.
2nd April 2020. 2nd April 2024.
All right.
Building sites having road width of 6 meters and above shall only be amalgamated. Think page 11. Condition E there. My lord gets that. General conditions applicable for amalgamation and subdivision, etc. Otherly E. Building sites having road width of 6 meters and above shall only be amalgamated. ಅಂದ್ರೆ ಅವರು ಪ್ಲಾಟ್ ಅಲ್ಲಿ 6 meters ಬಿಟ್ಟು ತೋರಿಸಿದ್ರೆ ಅಮಾಲ್ಗಮೇಷನ್ಗೆ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು.
ಇಲ್ಲ, ಅವು 2 ಸೈಡ್ಗೂ 6 ಮೀಟರ್ ರೋಡ್ ಆಕ್ಸೆಸ್ ಇರಬೇಕು.
ಅದು ರೋಡ್ 2 ಸೈಟ್ ಒಂದರಿಂದ ಒಂದು ಕೂಡ ಇಲ್ಲ.
Suppose the width of the road in front of the site is less than 6 meters, you can't amalgamate it. That is all. If it's more than 6 meters, then amalgamation is permissible.
Yes, but here they have taken that amalgamation and one plot illide, one illide.
But the road facing the main plot,
Yes,
that should be more than 6 meters is all the condition that is required.
yes. They should leave that much of room, but they have not left there.
Yes.
And the last one is this copy, my lord, I got it just yesterday. May I just pass it on to you? Our copies, give them copies. I'm sorry, my lord, it's not being filed with a memo, but copies I'm giving. This is BBMP, my lord, under the municipal corporation. Municipal corporation. Condition 1 and 2. All these conditions are mentioned there.
ಯಾವ್ದು ಇವರು ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಇವಾಗ ಕೊಟ್ಟಿರೋದು ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿರೋದು. ಇವ್ರು ಕೊಟ್ಟಿರೋದು But the municipality itself says they are not aware and it was not brought to their notice. Page 40 ಅಲ್ಲಿ 1 to 3rd para ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯವು ಪ್ರಸ್ತಾಪಿತ ಪ್ರದೇಶಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೊರಡಿಸಿರುವ ತೀರ್ಪು ಎರಡನೇ ಎದುರುದಾರರ ಗಮನಕ್ಕೆ ಬಂದಿರುವುದಿಲ್ಲವೆಂದು ಹಾಗೂ ಏಕನಿವೇಶನ ವಿನ್ಯಾಸದಂತೆ ಕಟ್ಟಡ ಪರವಾನಗಿಯನ್ನು ಕೋರಿ ಎದುರುದಾರರ ಅರ್ಜಿಯನ್ನು ಮೂರನೇ ಸಲ್ಲಿಸಿದ್ರಿಂದ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಅನಂತರ ನಿಯಮಾನುಸಾರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿರೋ ರೋಡ್ ಕಾಣಿಸ್ತದೆ. ಅವ್ರು ಕೂಡ ಇನ್ನೊಂದು ಕಡೆ ಹಾಕಿದ್ದಾರೆ, ನಮಗೆ ನಾಲೆಡ್ಜ್ ಇಲ್ಲ. Existence of a road, I have no knowledge, but I have done spot inspection. They go contrary to each other. But if there is anything called for in reply, grateful to your lordship for your attention.
Can you see page 91, my lord, the prayer, the suit, my lord, page 91.
91.
Yes, my lord.
91 is the writ petition.
Writ petition. After describing a scheduled property, my lord, the above immovable properties,
91 is what?
I'll plain copy in our prayer ಹೇಳ್ತಾ ಇದ್ದೀನಿ of writ petition, 91 of writ petition. Page 91, my lord, of the writ petition.
Prayer column.
After the description of the plaint, my lord, page 90 top ಅಲ್ಲಿ ಇದೆ.
That is annexure. Prayer law.
M. Annexure M ನಲ್ಲಿ
There is a suit filed by them.
ಹೌದು.
Yes.
After description, the above immovable property situated in so and so village of Udupi Taluk with right of way in R. Rashmi can see the under right of way. It doesn't claim it is a road. Right of way in R road and the right to draw water in W well consisted of RCC residential house bearing Udupi municipal number so and so along with electrical fittings and all appurtenance. Now, Rashmi, kindly come to the compromise, my lord. As per the both the suits came to be compromised as per annexure Q at page 122. Both the suits came to be compromised.
Yes.
The parties are referred as plaintiffs defendants as per the rank in OS number so and so. Under this compromise, although OS so and so is clubbed with it, plaintiffs OS number 487 of 2016 have been granted the right of way in the B scheduled property as per the sketch annexed in the compromise petition. The said right of way is absolute. Consequently, the counterclaim in OS number 309 of 2018 is to be decreed as per the terms mentioned above. Defendant number 6 is permanently restrained from disturbing, blocking, or interfering in the right of way granted to the plaintiffs in OS number 487 of 2016. Consequently, OS number 487 of 2016 is to be decreed under these terms. The annexed sketch shall be part of compromise decree. The suit against defendant 1 to 5 in OS number so and so may be dismissed as not pressed. The defendants invoice number 309 of 2018 are restrained from obstructing or interfering in the development or obstruction in plain A schedule property by the plaintiffs except using the right of way shown in annex sketch. So of the plaintiff is to be decreed in terms of the set condition. The defendant number 6 invoice number 487 of 2016 shall carry out construction in B schedule property strictly as per municipal bylaw approved sketch issued by the local authority. If any violation is reported, is liable for action under law. The defendant number 6 invoice number so and so, plaintiffs in so and so shall close the old well existing in the property shown in B and A schedule property in both the suits. Ashima, kindly see the sketch, my lord. I will pass on the sketch. I think I obtain the sketch. Definite copy of the yellow portion is the road.
There, it's already there.
Kodi, that court officer.
The same thing.
No, so, my lord, here, my lord, actually this yellow portion actually belongs to me. That portion, that building property belongs to me. But for the compromise, my lord, I agree to give the right of way in this portion. This is not a road. No documents were produced to show that it is a road in terms of any old documents at all. This is my property.
What was the prayer in his suit?
The suit, my lord, the permanent injunction at page, my lord.
What is the name of the petitioner?
1 minute.
Ravindra Naik.
Ravindra Naik. Page 89, my lord.
Only for an injunction.
Page 89. Plaintiff there got it, my lord.
And what was the counterclaim?
Counterclaim by me, my lord.
By me.
Page 101, my lord, counterclaim. For grant of perpetual injunction restraining the defendants, their men, servants, agents, and all those persons climbing through or under them from trespassing into the plaintiff A schedule property and obstruct the plaintiffs from carrying out any development work except making use of P-way road by the defendants exist in the plaintiff A schedule property or any way interfering with peaceful possession and enjoyment of the plaintiff A schedule property by the plaintiff. The prayer in his suit, my lord, is at page 89.
Yes.
For grant of perpetual injunction restraining the defendants 1 to 4, their men, servants, agents, and all those climbing through or under them from blocking, obstructing, interfering, or closing or digging the earth on the road or existing in the plaint A and B schedule property. For the grant of perpetual injunction restraining defendants 1 to 4, their men, servants, agents, and all those climbing through or under them from interfering or obstructing the plaintiffs from using the water from the drinking water from the well W, either by installing electrical pump or through fully in the plaint B schedule property or from damaging or altering or closing the W well. This is the prayer. Lashma kindly similar. They challenged the action before Lashma kindly say, take my state of objection. The sanction plan was called in question by preferring appeal before the regional commissioner. The prayer there, my lord, at page 11. The prayer is at page, my lord, page 16. Statement objective.
Failure objections. Objections.
Just a minute. Objection had to copy has been sorry, my lord. The copy has been served upon my lord.
Yes.
They insisted only, my lord, as per the compromise, the pre-lodgement condition, the prayer portion. As per the compromise, the right of way only they insisted. They had not questioned the amalgamation or whatever the arguments which has been addressed before lordship, my lord. That is not the question before the regional commissioner. Only, my lord, they insisted about the right of way as per the compromise petition. Except that, my lord, there is no other prayer before the regional commissioner.
Yes.
Then, my lordship, kindly see, my lord, there is no challenge at all to the regarding amalgamation. No, my lord, the affidavit has been filed by the town planning as well as the commissioner that the construction is as per the sanction plan. And amalgamation, my lord, there is a conversion of lands. And after conversion of the land, my lord, the single plot plan has been sanctioned by the competent authority.
Yes.
Lordship, kindly see the affidavit filed by the commission, my lord. Page 2 of the affidavit filed by the commissioner.
Yes. Note that.
At page, my lord, paragraph 4 at page 3, my lord. Paragraph 4.
I read that.
In view, all this development as per the oral direction of this honorable court, I deputed by an officer, the assistant executive engineer, Sri Durga Prasad, and junior engineer, K. Divakar, to the place of construction and submit report. Both the aforesaid engineers visited the place of construction, inspected and prepared a report and submitted to me. As per the report, there are no setback violations, and a copy of the said report is produced and marked as Annexure R1. Thereafter, I also directed the engineers inspect and give report regarding the right of way of the petitioner, and after inspection report was submitted to me and said report is produced and marked as Annexure R2. Thereafter, I personally visited the place of construction and found that the ingress and egress to the petition's property is intact and there is no construction in the pathway. In the meanwhile, the builder, the seventh respondent herein, applied for occupancy certificate to
Wait, I
occupy
read
the
that.
building. And so
Yes, next.
the competent authority is, my lord, whether there is any violation of the sanction plan is the competent authority. Now, my lord, he has filed an affidavit to the effect that there is no violation of the license. And therefore, my lord, the contention, my lord, the judgments which my learned friend has relied upon, if there is illegal construction, my lord, here I have, there is a conversion order, there is a sanction plan, and the single plot plot has also been agreed. And now, my lord, we have left the road as per the compromise petition. If at all, if there is violation of the compromise petition, my lord, the remedy is elsewhere. Lordship, kindly see the sanction plan I have produced along with the complaints affidavit. I have filed a complaints affidavit on 4th January 2025.
Yes.
I have produced 12 feet, my lord, in the sanction plan, it is shown that the 12 feet of pathway as agreed in the compromise I have left. In addition to that, my lord, I have given the 10 feet of setback towards that pathway.
No, but his argument is that you should leave your setback and thereafter the 12 feet. pathway.
12 feet bittidine. There is a
But is it a-
setback with a setback, my lord.
And ಪ್ರಕಾರ ಎಷ್ಟಿದೆ setback?
3.43 meters. Yes. Hello? 3.46 setback, my lord. In addition to that is pathway.
3.48 is the setback,
ಹೌದು. Lordship, can this is the plan.
3.66 is
The
the,
space, Lordship, the space reserved as per compromise decree only for using enjoyment, right, mentioned
the
in
pathway,
compromise
the
decree.
pathway is not the setback.
ಅದಲ್ಲದೆ
Pathway is not the
pathway
setback.
ನಾನು setback ಬಿಟ್ಟಿದ್ದೆ. This is a modified plan. My lord, my learned friend has laid upon some of the photos. These photos, my lord, before construction. Lordship, can this is thereafter, my lord, the tar road has been put up in that road and
Yes.
ಇವಾಗಿನ ಪರಿಸ್ಥಿತಿ ಹೀಗಿದೆ. 2 cars can be easily.
ಹಾಕಿದಾರಲ್ಲ ಅವ್ರು, ಪ್ರೈವೇಟ್ ಹಾಕಿದಾರಲ್ಲ, ಅವರೇ ಹಾಕಿದಾರಲ್ಲ.
ಹೌದು. ಅದು ಮೊದಲು ಕೆಲವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡುವಾಗ ಅದು ಇದ್ದಂತಹ ಪರಿಸ್ಥಿತಿ.
He has himself produced photographs today.
So therefore, madam, even ಒಂದು ಲಾರಿ ಬೇಕಾದ್ರೆ ಇಲ್ಲಿ ಮೂವ್ ಆಗ್ಬೋದು ಅಲ್ಲಿ.
Okay. ಯಾರಿದ್ಯಾ?
I will find that. It is the authority, my lord, what is plain is in between there are 7 properties, there was a road. We are based on the survey sketch, my lord, we have sanctioned, but it is a only single. Respect of 7 properties, 7th respondent is the owner. In between, my lord, that's no mention about any road. Subsequently, they insisted that as per the compromise decree, they have to show the road. We are not the party in the OS.
Where is the order of amalgamation? The single plot approach?
So only single, first thing.
Separate act.
They are given 2, 4, 24 months. Annexure B.
Abdullah.
When I inspected the building and inside, my lord, there is no violation as per the sanction plan building.
They have filed the report and the affidavit.
I'll give this afterwards.
Only one sentence. There is another memo which we had filed, from which I have shown a couple of documents. Memo for production of documents.
Yes.
ಅದರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದ್ದೀನಿ. ಅದರ ರೆಗ್ಯುಲೇಷನ್ಸ್ ತಾವು ನೋಡಿದ್ರಲ್ಲ, ಅದೇ ಮೆಮೊಲ್ಲಿ.
Page?
Page 50.
Page 9.
ಅಲ್ಲ, ನಾನು ಓದೋದು ಪೇಜ್ 50. ನಾನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
15 of their memo. In our memo.
ಅವ್ರ ಮೆಮೊ filed on 11/2/25. ರೆಗ್ಯುಲೇಷನ್ ಎಲ್ಲ ಅದರಲ್ಲೇ ಇದೆ.
You have filed this, isn't it? 11/2/25.
Yes,
ಯಾವ್ದು ಓದ್ಬೇಕಾದ್ರೆ?
page 15 ನೋಡ್ಬೇಕು.
Partition deed.
ಇಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ನಾನು ಕೊಂಡ್ಕೊಂಡಿದ್ದು. ಅದು ಸೇಲ್ ಡೀಡ್ ಹಾಕಿದ್ದೀನಿ. Relevant portion I have typed and given at page 50. I have fully typed copies. I will also furnish that.
Yes.
ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ 5-6 lines. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 120/15 ಪೈಕಿ ನಕ್ಷಾ ನಂಬರು A1 ನ ಸ್ಥಳದಲ್ಲಿ
Page number
50 ಆ ಕನ್ನಡ ಸೇಲ್ ಡೀಡ್ ಒಂದಿದೆ. ಅದರ ಆದ ತಕ್ಷಣ
I don't have a page 50 here. Maximum I have is page 29-30. It says relevant portion of typed copy. Ada?
ಹೌದು.
That's page 30.
I'm sorry. My apologies, my lord, for the.
ಐಟಮ್ 4 ನೋಡಿ.
Yes.
ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 120/15 ಪೈಕಿ ನಕ್ಷಾ ನಂಬರ್ A1 ನ ಸ್ಥಳದಲ್ಲಿ ಆ ಸ್ಥಳದ ಬಡಗು ಬದಿ ಮರ ಕಲ್ಲು ಪಾಗರಕ್ಕೆ ತಾಗಿ ತೆಂಕು ಪಾರ್ಶ್ವದಲ್ಲಿಯೂ ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಅದ್ರಿ 3 ಗಡಿಗೆ ತಾಗಿ ಪಡು ಸೋನ್ಸೋ ಲೈನ್ ಪೈಕಿ ಪಡು ದಿಕ್ಕಿನ ಲಿಂಕ್ಸ್ 17 ಬಿಟ್ಟು ಉಳಿದ ಲಿಂಕ್ಸ್ 123 ಲೈನ್ಗೆ ತಾಗಿ ತೆಂಕು ಸೋನ್ಸೋ ಶೆಡ್ಯೂಲ್ಗಳಿಗೆ ವಿಂಗಡಿಸಿದ ಸ್ಥಳಗಳಿಗೆ ಅದು ಮೇಲೆ 17 ಬಿಟ್ಟು ಉಳಿದ ಲಿಂಕ್ಸ್ 123 ಲೈನಿಗೆ ತಾಗಿ ತೆಂಕು ಸೋನ್ಸೋ 12 ಫೀಟ್ ಅಗಲ ದಾರಿಯನ್ನು ಕಾಯಂ ಆಗಿ ಹಿಡಿಯತಕ್ಕದ್ದು. ಆ ದಾರಿಯು ಮೂಲಕ ಪಡುಬದಿ ಸರ್ಕಾರಿ ರಸ್ತೆಯಿಂದ ABC ಶೆಡ್ಯೂಲ್ಗಳಿಗೆ ವಿಂಗಡಿಸಿದ ಸ್ಥಳಗಳಿಗೆ ಆಯಾ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿರುವ ಅವರ ಸಂತತಿ ಪ್ರತಿನಿಧಿಯರು ಮತ್ತು ಅವರೆಲ್ಲರ ಜಾನುವಾರುಗಳು ವಾಹನಗಳು ಮುಂತಾದ್ದು ಶಾಶ್ವತವಾಗಿ ದಿನಂಪ್ರತಿ ಆಮದು ರಫ್ತಾಗಳಲ್ಲಿ ಒಬ್ಬರಿಗೊಬ್ಬರು ಸೋನ್ಸೋ. In that sale deed of 1956, which I purchased, the original owner is the one single owner.
That was shifted to the edge now, under the compromise.
No.
12 feet. pathway.
Compromise petition 12 feet road ಸ್ವಲ್ಪ ಶಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ I said, all right, it might help you ಅಂತ. But even then fully violate ಮಾಡಿ ರೋಡ್ ವರೆಗೆ ಕಟ್ಬಿಟ್ಟಿದ್ರೆ. It is not as if under the decree I am getting 12 feet right of way. I have got it in 56, even before he was born, vis-a-vis this property. ಇನ್ನೊಂದು ಸ್ವಾಮಿ, ಸಾರಿ, ಮೈ ಅಪಾಲಜಿ. ರಿವಿಷನ್ ಮುಂದೆ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ನಾವು ಏನು ಕೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ತಾವು ದಯವಿಟ್ಟು ಅವರ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 16.
Yes.
ಜಸ್ಟ್ ನೋಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ. ಪ್ರಾರ್ಥನೆ 1 ಮತ್ತು 2ನೇ ಎದುರುದಾರರು ದಿನಾಂಕ 2/4/24. That is, my lord, that single plot or amalgamation. ಅಂದು 1ನೇ ಎದುರುದಾರರ ಹಿಂಬರಹ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋ ಮತ್ತು 57 ಸಾರಿ ಸೋ ಏಕವಿನ್ಯಾಸ ನಕ್ಷೆಯನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸರ್ವೆ ನಂಬರ್ ಸೋ ವಿಲೇಜ್ ಕಟ್ಟಡ ಪರವಾನಗಿ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಪರವಾನಗಿಯನ್ನು ರದ್ದುಗೊಳಿಸಿ ಮೇಲೆ ಹೇಳಿದ ಪ್ರಶ್ನಿಸಿದ ಆದೇಶದ ಕಡತವನ್ನು ಸೋ. My learned friend said, I have not prayed. There is a specific prayer in the revisional, before the revisional authority. Para 8, I have fully described my contention. I won't read here, my lord, it's already too late. Paragraph 8, ಅದೊಂದು ತಾವು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರಿ. ಈ ಪ್ರೇಯರ್ ಜೊತೆ ನಾನು ಏನು ಹೇಳಿದ್ದೀನಿ ಅಂತಿದೆ ಡೀಟೇಲ್ಸ್. Grateful to your lordship.
Kind but page 63 with sorry my lord, page 63 they had approached this about earlier my lord, page 63.
This is the sort.
It is not maintainable. Go file a revision. You have not.
Two my lord. Accordingly, respondent 4 Udupi Town Municipal Council and respondent 6 are directed to ensure that the construction shall not be commenced for a period of 2 weeks in the road margin as decreed in the OS 487 of 2016. In the meanwhile, the petition may file an appeal and secure any interim order. Page 63. Thereafter, they preferred an appeal before the regional commissioner. The regional commissioner dismissed that. 79. All matter, my lord.
What matter?
Yes, my lords are questions, proceedings against the other appeals. I'm ready to.
My lords, serial number 38, my lords.
The time of COVID, permission has been given to the arrest order. Officials, my lord, against them.
My lords,
51.
Serial number
51.
79.
My lords, serial number 38, my lords. Kindly accommodate on short date within a week, my lords. 38, serial number 38, my lords.
Serial number
51, my
49.
lords. Serial number 58.
Lord, my lord, 58, I am appearing for respondent, my lord.
Yes.
Next week, my
Last
lord,
week-
from
last week
tomorrow
I-
onwards, I will
sometimes-
not be in station.
ಹೇಳ್ರಿ ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ.
ಆಯ್ತು.
Date, short date, maybe.
ಇನ್ನೊಂದ್ ವಾರ ಇರ್ಲಿ ಅಂತ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕೊಳ್ತೀನಿ.
ಆಗ್ಬೋದು, ಮಂಡ್ಯ ಹಾಕ್.
51, my lord, 51. I am for respondent 4 to 10.
Yes.
Next week, after the second, any day. Second onward.
My lord, serial number 71.
51, right? 51.
After second.
Serial number 49.
Golf.
My lord, serial number 71, already my lord decided matter. Now second round of litigation, my lord kindly 71. Oh, that accusation, my lord remaining action to, is with the petitioner is concerned. But, it can be listed, my lord, under the caption of further hearing. But because my lord has already passed the order, said order was confirmed by the division bench.
That Lalbagh, that corporation.
Please, my lord.
Serial number
Next Monday.
My lord, interim order. Interim order.
Serial number 49, your lordship, that's out for modification of the interim order. Honorable court has directed parties to maintain status quo. But I've already constructed a building, 90% of the construction has been done. The interim order goes against the petitioner. But for modification, tomorrow.
After tomorrow.
Seal number 47, please, my lords, for the petitioner's matter. My lords, there's urgency in this matter, may be kindly be taken up on 26th. 47, please, my lords. For MJ Alva.
24. Date code.
Serial number
Serial
77,
number
my lord.
66,
I had
my lord.
mentioned it in the morning that it should be posted in preliminary hearing, my lord.
Who's for the respondent?
I am the respondent.
Who's for
Respondent
the
number.
petitioner? In matter.
Mahabaleshwar Rao.
Is there an interim order in their favor?
No, my lord, there is a oral instruction to the government advocate saying to maintain the status quo, not to mutate any, enter the mutation. That's why, my lord, that is the urgency, it should be
Post and
heard.
preliminary hearing.
Serial number 80, my lord.
My lord, it should be posted.
Preliminary hearing
Yes.
Serial number 80, my lord. Interim order may be extended.
will extend.
Serial number 66, my lordship. Kindly may we have it tomorrow, my lordship. The matter pertains to ex-service man. Kindly may we have it tomorrow.
Date code.
Serial number?
66.
I moved a memo for being spoken to your lordship, told me to file written arguments. Written arguments along with the judgment of this honorable court. I saw the other side.
79. The disposable.
Page number 62 is the order passed by the, my lords, my lords. 61 miles, 61 my lords, annexed D. Page number 63 is the,
ನೀವೆಷ್ಟು accused ಇದ್ರಲ್ಲಿ?
my lords, I am appealing for A3, A8, A14, 15, 16 and 17. 3 and 8 are the husband and wife.
A3, A8, A14.
15, 16, 17.
So this was by?
My lords, this was by A2, A6, A7, A11, A12, A13, my lords.
So it's not in dispute that the proceedings insofar as it relate to annexure, accused A2,
A2, A6, A7, A11, A12, A13.
were quashed by this court on 25th of June 2024 in criminal petition number 7808/2021. This petition is filed by accused number 3, 8, 14, 15, 16, and 17. Since this court has already quashed the proceedings in respect of the aforementioned accused for the same reasoning, this petition also have to be allowed. Consequently, the proceedings as against accused number 3, 8, 14, 15, 16, and 17 are also quashed.
Second.
Sir, 51. Sir, date on this. 51. Sir, 51, no, 7ನೇ ತಾರೀಕು. 7th of April, 51. 7th April. 7th April, 51. ಆಯ್ತಾ ಸರ್? ಆಗಿದೆಯಲ್ಲ ಸರ್?
ದೀಪಕ್ ಅವರು
Same, ನಮ್ಮವರೇ.
ಅವ್ರ petitioner.
ಅವ್ರ petitioner.
ಇದ್ರು serial number 38.
ಹಾಕಿದ್ರ 7th?
Serial number 38. 38.
ಹೇಳ್ಬಿಡೋಣ.
ಬುಧವಾರ ಕೊಟ್ರೆ ತುಂಬಾ.
I think so.
38 ನೋಡಿ ಸರ್.
ಸರ್ 7th ಕೊಟ್ಟಿದ್ರಲ್ಲ?